at 12:23 a.m. on 1/29/2022. 12:32 a.m. I reversed those two digits. 12:32 a.m. on 1/29/2022. It was actually Karen Reed's three-point turn when Karen and John arrived at the house on Fairview Road. Our YouTube friends are here. Hello, YouTube friends. Good morning. My name is Grant Smith Ellis. It is so great to see each and every one of you. Give me 1 second, little towels. Why did that happen? Hold on. Oh. I see. All right, give me 1 second. I got a plan, little towels. Hold on, I'm the man with the plan. It was just that my preview video, I'm not going to not have your comments on the screen. That would literally be sacrilege. Not really, but I'm being sardonic. I'm pulling a Alley 90211. Kim Cordeau, Ange Whittick. It's so good to see you, dear friends. Now, of course, give little towel just a second here, dear friends. I'm not being gratuitous. I am centering your comments on the screen. As we know, Little Towel cares so much about making sure your comments are front and center, and that is exactly what we have done. All right, now, folks, we got a lot to go over. There was a big cliffhanger yesterday at the end of the John O'Keefe and Karen Reed trial. If you missed it, we're going to watch it right now. The moment that Hank Brennan's expert started to provide the bombshell opinion testimony that all of the data in the case, all of the different segments of the testimony, etc. Ladies and gentlemen, all of it came together yesterday in the testimony. I'm not surprised Turtle Voice looking for to try to take some shine. I think he got that because a former judge, Judge Jack Lew, was commenting on Twitter, and he was like, the implications of the Kearney case are much more intense. And folks, by the way, did you know Aidan Kearney has a criminal trial on June 9th, 2025? That is in just over 10 days. Going to reach out to the court, see if we can get facilitated live stream access, some kind of Kearney cam for that district court trial. It should be a one-day trial. It's related to a restraining order violation involving named victim Lindsay Gattani. That was an alleged violation of restraining order held by Gattani, and the violation was on 2/26/2024. So the hearing, as I mentioned, the case, the trial, Aidan Kearney's first trial on his he has a litany of charges, most of them in Norfolk Superior Court, related to witness intimidation and wiretapping. So again, Lindsay Gattani and other victims in the other named victims in the who are witnesses in the Karen Reed case are actually the named victims in the Norfolk Superior Court felony cases. But in district court on June 9th, June 9th, just a few days away, Aidan Kearney is going to be going to trial on the first charge. That's a misdemeanor charge of an RO violation. So, folks, please, if you watch other channels, make sure you're reminding them, all the towel friends, let them know, are you covering Aidan Kearney's case, the criminal trial on June 9th, 2025, with the named victim Lindsay Gattani? And if they say no, ask why. Ask why people are trying to not cover this trial. I know there are some folks, oh my goodness, Sig Girl 22, the Super Towel themselves are here at 4 a.m. God bless you. But yes, folks, got a lot of developments going on. We're going to talk more. And by the way, ladies and gentlemen, we have to give a special towel shout out to the Super Towels themselves, Kiki and Riri. Kiki and Riri, I just want to let you know, you are super towels, and your mom, Drew Drops, is a very special towelette. And Kiki and Riri, if you can hear this all the way across the pond, you know that your mom loves you very much, and you absolutely should show some appreciation, Kiki and Riri, and you should go over to your mom and you should say hello and give her some kind of expression of love. I'm not really sure how that works in your language, Kiki and Riri, but I'm sure you will figure it out. God bless you, special towels. I hope you heard that, Kiki and Riri. Yep, that is Towel himself saying hello to you. Yep, you too. That is you two little wonderful super towels. That is Towel saying hello to you, Kiki and Riri. God bless you, super towels. There you go, ladies and gentlemen. What a wonderful moment for Super Towelette, Jew Drops, and Kiki and Riri, who I'm sure are having a wonderful morning. But yeah, so great to see all. Oh, look at the doggo emojis. Oh, yes. And by the way, folks, we are going to get fully caught up on the day's developments, ladies and gentlemen. We are going to get fully caught up on yesterday's developments and the testimony leading in to today. And thank you, as always, folks, for sharing resources and links and otherwise in the chat. It is very good to see you all this morning. And, of course, Lucy in the Sky, what a wonderful username. I actually had to pause as I thought for a minute about how wonderful that username was, and then I added you to the ranks of the honorary towels. But yes, Dr. Judson Welcher's testimony yesterday. Let's look at how it ended, folks, and then let's take a look right away. Let's take a look at the motion hearing. Then I'll explain to you how bad that motion hearing was for the Reed defense, and then we'll talk about the cases Bob Alessi cited, and then we'll go through it. But this is how yesterday's testimony ended, okay, ladies and gentlemen? Dr. Welcher was giving his opinion about the data indicating a collision between Karen Reed's Lexus and John O'Keefe right at 12:32 a.m., between 12:32 a.m. and 4 seconds and 12:32 a.m. and 9 seconds. That's right when the window is, which is just a few seconds before John O'Keefe's phone stopped moving for the last time on the front lawn, 7 feet from the road or so, at 12:32 a.m. and 16 seconds. Ladies and gentlemen, it was devastating. And then we're going to watch the motion hearing that occurred after that, and that's how the day ended. The reason why we're watching this first is this is what we're going to get a decision on, ladies and gentlemen. At 10 a.m., this is the first thing Judge Cannoni is going to rule on. So Mandy Strong, you honorary towel spouse, folks, get ready. We're going to get ourselves caught up. There was a cliffhanger yesterday, and the cliffhanger, ladies and gentlemen, had to do with this segment of testimony we're about to watch. Oh, ladies and gentlemen, little towels here. You're here. We're getting caught up. It's one of those days. Great to see you, Chair Bear. Great to see you, Tom Christ. Oh, look at all the wonderful super towels in the chat. Here we go.
Based on all the evidence you considered, could you share with the jury what your opinion is to a reasonable degree of engineering certainty about whether the defendant's Lexus struck Mr. O'Keefe on January 29, 2022, around 12:32 a.m.?
Objection, Your Honor.
I can answer.
Yes, based on the totality of the evidence, DNA, everything I've talked about, that is consistent with that happening. With a reasonable degree of scientific certainty, that is what happened.
Objection, move to strike, Your Honor.
So I'm going to strike that. I'm going to see counsel's have just.
Ladies and gentlemen, that was it.
Yeah, I'll do that.
All right.
Did Dr. Welcher leave?
Dr. Welcher can step down. I know he has to come back and have his equipment.
So just leave everything here.
And then you'll come back in 5 minutes.
Roger.
All right. Yes, please. All right, so Mr. Alessi, I will hear you as to your objection. Right there is fine, and let's try and wrap this all up by 4 because I've already heard you at sidebar.
We'll do so, Your Honor.
That means both of you I'll hear from within the next 5 minutes. Go ahead, Mr. Alessi.
Thank you, Your Honor. The point number 1 is the question of whether, based on a reasonable degree of scientific or engineering certainty, he has an opinion whether a collision occurred. I'm going to give a dramatic and accurate example that happens in courts all the time equivalent. So, by analogy, if the issue is whether or not a defendant has stabbed an individual and caused a certain event, that is the ultimate question for the jury. That question is never permissible in a trial. By analogy, this is the exact analogous situation. The question of whether there was a collision is the ultimate question for the jury. That is why we are having this trial. The defense strongly asserts there was no collision, and there is substantial evidence to that. We are going to cross-examine Dr. Welcher. We are going to put in our own strong case to demonstrate no collision occurred. That's no surprise. It was in our opening statement. This witness cannot, by precedent for years, opine on the ultimate question that is going to the jury. I accept, subject to evidentiary issues, the true questions that a biomechanist always answers in these situations. Is the damage to the vehicle consistent with a pedestrian hitting the vehicle? And are the injuries to the individual consistent with being hit by a motor vehicle? Those are the questions that are permissible, not the collision question. It is resoundingly improper in this trial, in any trial where that is the ultimate conclusion for the jury. Yes, an expert can offer opinions, but every expert is bounded by the extent of their opinion, and that opinion on whether there was a collision would invade the province of the jury and the whole purpose why we are here, Your Honor. Thank you.
All right, Mr. Brennan.
So what Mr. Lisi is arguing is that in their opening statement, they repeatedly invaded the province of the jury because they must have asserted vehemently over and over again there was no collision, over and over and over again. And he just told you that when his expert takes the stand, they'll have abundant evidence that there was no collision. This case is about the collision, but that is not the ultimate issue. The ultimate issue is manslaughter or mens rea for second-degree murder, not collision. They don't get to define the prosecution's case. They do not get to define or limit the prosecution's opinions. They have no case law. They have no study. They have no jurisdiction or jurisprudence to say what we are limited to. He's entitled to an opinion. His opinion is not limited to whether or not the defendant struck Mr. O'Keefe. That evidence is obvious. It's not whether or not there's damage to the car or Lexus. That evidence is obvious. He also is an enormous part of a biomedical engineer and an accident reconstructionist. He studied the tech stream data. They didn't, he did. And he's entitled to give an opinion. The tech stream data, based on fact and science and data, tells us when, if you put it together with other evidence, and where, when you contribute it with other evidence, this collision actually occurred. We don't have to play peekaboo and close our eyes to the reality of the fact that the evidence supports the conclusion to a reasonable degree of engineering certainty that the defendant struck Mr. O'Keefe with her Lexus in front of Fairview Road. I am not interjecting the defendant. I always refer to her car, so it is sanitized, her Lexus. I've been careful about that. I don't have to, but I'm very careful about it. He is relying on the test stream data, the physical evidence, his independent studies. He is allowed to offer an opinion about whether the injuries are consistent with the damage to the car, whether the damage to the car is consistent with the injury to Mr. O'Keefe, and he's also allowed to answer, in his opinion, the issue of a collision. Putting aside the fact that that was emphasized and repeated in the opening statement, and it's going to happen again when other people testify. It's not our fault that ARCA didn't testify or look into the tech stream data or they don't have an expert for it. It doesn't belittle or limit that evidence. We expect to ask Dr. Welcher, does he have an opinion to a reasonable degree of engineering certainty whether the defendant's Lexus collided with Mr. O'Keefe on January 29, 2022 around 12:32 a.m. That is one of the opinions we're going to ask him. Nothing to do with the ultimate opinion of guilt or innocence or whether it's manslaughter or there's mens rea for second-degree murder.
And what was your second? You said that's one of the opinions you're going to ask him. What else are you looking at?
I will also ask him about the consistent with, whether the injuries are consistent with.
With what?
I'm going to ask him after this part about the difference between a clip or a sideswipe as opposed to a full-on injury, pedestrian collision from a front or back of a bumper, and there are further slides to emphasize that point. And so there'll be an opinion regarding that as well.
And you...
Consistency with a sideswipe or a clip.
Okay, so this is not the end of Dr. Welcher's testimony. He's just moving on to another area.
It's close, but it's not the end.
Okay. Go ahead. Yeah.
Your Honor, here's a case. Attorney Brennan said, throw that case on. Here it is. Commonwealth v. Coleman, 366 Mass 705. And it stands for the proposition exactly that I articulated. I won't repeat it. Secondly, Your Honor, we practice what we preach. I have the ARCA report right in front of me. and I have the report of...
Is that a new one or is that a...
This is the new one.
Okay.
It's also, the old one is the same. So I can... Either one is the same. They do not... Mr. Brennan incorrectly said what our experts are going to do. I don't know why he did that, because he has these in writing. Neither Dr. Wolf or Dr. Rentschler talk about a collision or conclusion. It's consistency. So those two questions I said in sidebar. And for reference, Your Honor, for the most recent, is page 15. There is no...
I don't have that report, so I'd like a copy of that report.
Your Honor, a copy, and I also, Your Honor, refer Your Honor to ARPA's existing report, which I'm going to do from memory. I think it's February of 2024 that was done for the U.S. Department of Justice and FBI, where they basically said and gave opinions on those two items I spoke to you at sidebar. So Attorney Brennan is incorrect when he says what our experts are going to say or not. We've already committed in writing to what they're going to say. We're consistent, we practice what we preach.
All right, so we will discuss this tomorrow before we start. I'll tell you my ruling tomorrow before we start. I need to go back and see what exactly came in to evidence today.
Whoa.
All right, so I'll see you in the morning.
All right, so let's talk about, I know folks were really, first of all, I don't understand why folks are frustrated with Judge Cannoni. She is an incredible judge. She is being incredibly fair. She's making incredibly amazing rulings. And Hank Brennan's going to win this, okay, folks? So the cases Bob Alessi cited to, first of all, I am not a lawyer. I am a towel. Nothing about this is legal advice. Get a lawyer if you have questions about the law. I want to show you, though, folks. So I went and got the cases, okay? It was actually Sig Girl 2022 who was so kind to help us locate the cases. Well, Sig Girl 2022 didn't help us locate the cases. They brought up the specific citations, and then I was able to bring up what we needed. So we have Commonwealth v. Lannon, and then what was the other one, the one that he actually cited? I just went to it, right, didn't I? I think it's this one. 705 and 480. Yeah, Coleman. Okay, so I have both of them. So let's take a look. All right, folks, I'm going to bring these up for you. I'm a little towel. You're a little towels. Watch this. I actually went and got the cases. Good morning, Christina Towel. Yes, it's all very interesting. And, folks, I just want to explain to you. First of all, Judge Cannoni saying she's going to take this under advisement is not a bad thing. There's nothing. Bob Alessi has the right to object and ask for a ruling on this, but he's just going to lose. Like I'm telling you right now. So sometimes I wouldn't say I get frustrated, but it's just I think you all would be well. Just remember that there's a lot of procedure. Dewdrops, because you want to, what Judge Cannoni was saying is she needs to, one, review the evidentiary record to see what the witness testified about to determine if there's a proper foundation based on everything he laid out, which we'll review his full testimony. We have 2 hours. Whether there was a proper foundation based on everything the witness testified to over yesterday, which I have fully recorded, for the witness to render the conclusion about the collision between Karen's car and John's body, and then also the distinction between the injuries that would be sustained in a sideswipe impact with the back of a car and a frontal collision, okay? So that's what Judge Cannoni's thinking about, that foundational. That's number one. And the reason she's doing that is for the expert to render his opinion. I think it's like Rule 706 or something. There's very specific, 701, there's very specific rules about expert opinions, okay? You can be qualified as an expert. The way it works is an expert is different than a regular witness. A regular witness can only testify to what they saw, heard, etc., okay? But an expert witness can testify to their opinion. Okay? To testify to your opinion, it has to be within the range and scope of your qualified expertise. So the procedure is at the beginning of your testimony, either by stipulation or through a process, you get qualified as an expert. Once you're qualified as an expert, you can give an opinion. But you can't just get on the stand because you're an expert after laying the foundation for your qualifications and then give an opinion. You have to lay all the foundation for the opinion that you're going to give, because what the judge is really doing is a 401 and 403 analysis, okay? So for something to come in as evidence, not only only does it have to survive the threshold opinion rule for 701 for an expert, okay, but also it has to be admissible and it has to survive the 401 and 403 balancing act, okay? So when we're talking about evidentiary admissibility in the form of an expert witness testimony, we're talking about the way FRE, the Federal Rules of Evidence, and it's codified as the Mass Rules of Evidence for our purposes, 401 and 403 and 701 all work together. Threshold analysis: is the person an expert witness? Have they laid a proper evidentiary foundation for the opinion they're about to render? And then, is the opinion they're about to render in line with the scope of their qualified admissibility, their qualified opinion testimony as a qualified expert, and then not a qualified opinion testimony, their opinion testimony as a qualified expert by the court, in line with the facts and the scope of their qualification, permissible, okay? And the analysis there is, we're going to look at the two cases. It's Coleman and Lannon from 73 and 74. Is the expert witness trying to invade the providence of the jury by testifying on a legal conclusion? Bob Alessi's argument is terrible. His argument's like, the witness, by saying this, by applying his opinion about the collision to the facts and saying that Karen's car struck John, is tantamount to saying that this witness thinks a homicide occurred. Now, the reason why I know Bob Alessi's argument is so weak, and we'll analyze the Coleman and the Lannon case in a second, is the Coleman and Lannon cases were situations where a medical examiner literally used the word homicide during their testimony, and the appellate court still ruled against the defendant on appeal. They didn't find error. So, ladies and gentlemen, using the word homicide is much more direct as to the legal conclusions of the case than this instance where the witness is opining based on his expertise, qualified by the court as an expert, and then also the factual record, and then all the data he collected in his testing, whether there was a collision between Karen and John, or whether that collision was the result of a sideswipe versus a head-on collision. Now, ladies and gentlemen, so what Judge Cannoni's really doing, I don't even think she's going to reach the issue that Bob Alessi's arguing. I think she's going to rule in Hank Brennan's favor on that. It's very clear to me based on the precedent. I'm a lay towel. I'm not a lawyer. None of this is legal advice. But if you look at Coleman and Lannon, I'll just bring it up on the screen right now. Bob Alessi stands zero chance. I don't know why he even brought up those cases. Oh my goodness, it's Murder by Maestro and Alley 90211. There is nothing that makes Little Towel happier. Eva, oh my goodness, it's a fist bump emoji. Ladies and gentlemen, folks, let's just say thank you to that super towel emoji. Wait 1 second. I'm going to go scroll back, but before I do that, I have to do this, ladies and gentlemen. Yes, I have to bring up Commonwealth v. Coleman because we're doing legal analysis, although I'm a lay towel and none of this is legal advice, and I'm not a lawyer. But, ladies and gentlemen, I am a law student. I think that counts for, some form of lay experience. That does not mean that I'm a lawyer, though. In fact, I'm very clear that I am not a lawyer, and I don't think I'm ever actually going to become a lawyer. I think I want to take my JD and either use it to teach or use it to help engender, coach, and public discourse by doing exactly what I'm doing now. Now, ladies and gentlemen, you know what else I'm doing right now, though? I'm bringing this up on the screen. Can we just all say thank you while I zoom in for a second to the wonderful Super Towel Eva, not just for all of Eva's insights, not just for all of Eva's comments, not just for all of Eva's support, but because of the fact that Eva knows that Little Towel is working hard and we have a lot going on. There is nothing that will make Little Towel giggle quite as much as Eva or anyone sharing an emoji of a pair who's a super towel with a headband giving Towel a fist bump. Oh, you little super towel. I'm giving him a little rub on the head. I'll give you a fist bump, little super towel. You are a super towel. God bless you, Eva. It means so much to me. Your support, all your comments. You are appreciated. You are acknowledged. You are recognized. And ladies and gentlemen, look at all the towel friends saying thank you to Eva. Eva has friends here. And ladies and gentlemen, we all appreciate that wonderful, wonderful, wonderful analysis of the pair emoji. I was like, did the pair emoji actually do an analysis? No, I did an analysis of the pair emoji. All right, ladies and gentlemen. Oh, corrections. Yeah, all right. So here we go, ladies and gentlemen. I think that's fair. If you want to understand how we're going to look at a case, right? One, the cases have multiple holdings, all right? So what you want to do is, as you break down the holdings of the cases, one, you're looking for the section of the case that applies to what we're talking about. We're going to find that in this case, it's Section 2, subparagraph A, okay? But you also have to remember that for each section of the case, for each holding, you want to analyze it in an issue, rule, application, conclusion format, IRAC, okay? So what we're looking for here is what is the issue about under the narrow scope of a 701 analysis about proper opinion testimony from an expert witness related to the legal conclusions the jury has to make versus applying the witness's opinion to the facts, okay? And what's permissible. We're going to look at that. Now, this is on appeal, and it's from 73 to 74, so the language is a little archaic. It's not as bad as reading appellate cases from the 30s, 1930s. That's very convoluted. When you read Massachusetts appellate cases from the 1930s, they use technical procedural language like to describe the posture of the case that does not even make sense to a learned scholar of like Massachusetts case law. It's very hard to understand. But anyway, okay, so we're going to scroll down a little bit here. Little tells. Oops, sorry about that. I expanded your comments. So look at what I said, right? We're going to talk, first of all, we have to figure out what we're talking about, right? Which is Commonwealth v. Frank Coleman, which is 366 Mass 705. That's what Alessi cited, okay? So is this, we go to section 2A. This was, I'm pretty sure this is the right one. It was Coleman that he cited. So we look for section 2, right? Oh, no. Wait a minute. That might actually be the wrong part. Hold on. Yep, this might be the wrong case because he might have cited to Landon. No, I thought it was Coleman he cited to. Yeah, here it is. 2. Okay, here we go. 2A. Look at this. Testimony of medical examiner. So this is what Alessi's working on. This is what he wants Judge Cannoni to buy to limit the scope of Brennan's expert testimony about the nature of Karen's car data, John's injuries, all of that testing that the expert did, being tantamount to the legal conclusion the jury needs to make. Do you understand? That's the core issue. So we're isolating the issue. Now, what's the rule? Okay, here's the rule. We need to parse this out to find the rule. The medical examiner testified that in his opinion, the cause of death was homicide. We observed in Commonwealth v. Lannon, which we're going to read in a second, which is 364 Mass 480, 482, that's the pin site 1974, that the better course was to exclude such opinion testimony, but here it was innocuous. That means that even though the medical examiner said homicide, and even though the better course, so the rule here, if you notice what the court's saying, the appellate court, though, and this might be the SJC, the rule in Massachusetts is that it's better practice not to say the word homicide, which is why now you see the MEs they shouldn't say the word homicide. But here it was innocuous. In the Lannon case, accident was offered, accident was offered as a defense, and homicide could be taken to contradict that defense theory. Here, homicide does not seem to have such a contradictory implication as to the defense theory of self-defense. We should add that in the present case, the medical examiner went into detail about the autopsy procedure he had followed to reach the conclusion of death by gunshot wound to the chest, massive hemorrhage, and homicide, and the jury could not have imagined he was expressing an expert opinion on how the shot came to be fired as opposed to the result of the shot. So do you see how bad that case law is for Alessi? All that is talking about is if you have someone who's getting up there and literally saying, I think this was a homicide, ladies and gentlemen, and you heard the testimony from the expert. He was not saying this was manslaughter, this was second-degree murder. He was saying this was a collision. And then, by the way, if you think Lannon will save Alessi, absolutely not. So we go to Commonwealth v. Lannon, which is 364 Mass 480, which was argued in 73, decided in early 74. And I think this was the SJC. No, I don't think it was. Yeah, it might be the SJC. But anyway, so we take a look, ladies and gentlemen, and we go to the section. This part's even worse. This was about a defendant who had shot his wife. And so here, when the court's saying the defendant is signed as error, that's what you have to have a error of law or fact by the lower court to get review by the appellate court. So the appellate court saying the defendant assigned as error two of the judge's ruling which admitted certain evidence. So the defendant's argument is the judge made two errors. The defendant argues that this evidence undermined his defense of accident. Dr. George W. Curtis, the medical examiner for Suffolk County, who performed an autopsy on the deceased, testified that it is my opinion that Nancy Lannon came to her death as a result of gunshot wound of chest homicide. The defendant's motion to strike the last word of this response was denied and an exception taken. A death certificate signed by Dr. Curtis was also admitted in evidence. The form contained the printed words accident, self-harm, or homicide specify, and a line on which was written Dr. Curtis's response, homicide. The defendant accepted to this denial of his motion to strike this word. We have ruled below in this opinion that there is no error here because the judge in his charge effectively struck the word homicide from the evidence with reference to both the death certificate and the ME's testimony. Nevertheless, we consider it useful to discuss the merits of the defendant's argument on these difficult issues. Preliminarily, we observe at least that the better course would have been to exclude the term from evidence when it was originally offered. Okay? Do you see what I'm saying? They're only these two cases. Alessi didn't actually cite to Lannon, but he cited to Coleman. But Coleman and Lannon stand for very similar principles. And we looked at the issue. We pulled the rule out of these cases, which is you can't say as an expert something like I think it was a homicide. Okay, but now we think about the application to our situation. Did Dr. Welcher go anywhere near saying this is manslaughter, this is second-degree murder? No. It's very similar to saying there was a gunshot and the bullet hit a person, okay? It's not saying it was a homicide. It's saying applying the underlying data with a conclusion, not to the legal result, but to the facts. Okay, so that's why I think Hank Brennan is 99.999999999% likely to win this motion, because this was a very weak argument examining, and this is why Judge Cannone would read it overnight. You don't just say, okay, let me just look at this case on the bench and make a ruling. No, you do what we just did. You go read the two cases. Well, first Alessi didn't even cite Lannon, so you have to read Coleman. Then you have to see that within Coleman, it's actually an interpretation of the precedent established in Lannon. So then you have to read Lannon. Then combining Lannon and Coleman on the issue that we're talking about, the narrow issue of the admissibility under 701 of expert testimony and the line of demarcation between the legal conclusions at issue in the case, like a word like homicide in a murder case, versus an expert testifying about something in a manslaughter or a second-degree murder case that is not related to saying this is a homicide or second-degree murder or manslaughter, but instead saying this is this injury was the result of a collision between a car and a body. Do you see what I'm saying? Neither Coleman nor Lannon stand for the proposition that an expert is not permitted to testify about their opinion that the cause of injury was, or the not even the cause of injury, that the underlying wounds to John or injuries to John and the damage to Karen's car indicate, and the data from Karen's car and the backup event and John's phone stopping cessation of movement, ladies and gentlemen, indicate a collision between the car and John. That is not talking about the legal conclusion the jury has to make. Do you see the distinction? And so that's why these cases, that's why Alessi loses on that argument. So the only thing that Judge Cannone is thinking about, in my opinion, she rejected this is my analysis of how Judge Cannone was thinking at that moment. She already knew that Coleman and Lannon were not going to work for Alessi. She knew it. She didn't have to read them. She was like, no, that is not what those cases do not stand for that proposition. You don't understand what you're talking about, Bob Alessi. But I do think Judge Cannone was like kind of helping the defense in the sense that she was like, however, I do need to look at under 701, 401, and 403, whether not only this is proper opinion testimony, she's going to check the box and say it's okay, but then whether the expert has laid a proper evidentiary foundation through his 2 hours of testimony, which we're going to watch right now, to render this conclusion. That's why Judge Cannone said I have to watch back. She really is going to watch back his testimony, okay, or read the transcript, okay, because that's the key issue. Bob Alessi is going to lose on the Coleman and Lannon issue, so it's coming in under 701. The question is, has the expert laid a proper foundation to answer these questions? And I think the answer is absolutely yes. So does everybody understand? Are we all caught up? I just want to make sure everybody's feeling comfortable. We've done what's called an IRAC analysis. Whoever asked for it earlier, I hope the IRAC of Coleman and Lannon was helpful. I want to watch a little bit more of I want to now watch the actual testimony from Dr. Welcher, okay? And we're not going to do his background. We're going to start right with the substance of the testimony about the backup event, analyzing John's car, the injury to John, all of the testing, because it all crescendos up to this question of whether he can, Dr. Welcher can render this opinion, and we're going to get our answer at 10 o'clock this morning. So, ladies and gentlemen, my name is Grant Smith Ellis. Thank you so much for being with me. We are waiting for the start of session in today's John O'Keefe and Karen Reed trial. And as you noticed, we got a cliffhanger yesterday. And as you just heard me do the analysis, Judge Cannoni isn't reading these two cases overnight. No, she's looking back. She already knows Hank Brennan's winning on these two, on this argument. Bob Alessi made a terrible argument and didn't really understand, in my opinion, the case law he was trying to apply, and he looked like an idiot. I'm not saying that in an insulting way. It's just, Bob Alessi, read the case. Read the case first. They're short cases. One of those opinions was 2 pages. The other was like 4 pages. I read it in like 30 seconds when Sig Girl and I were talking in real time on stream yesterday. Read the cases. They don't stand for that proposition, so you lose on that. Your only hope is that, and you're going to lose on this too, your only hope is Judge Cannoni reviews the transcript and the evidentiary record during the testimony of Welcher and says that because he didn't provide sufficient foundation, he can't testify to these conclusions. That's not happening. Of course he provided sufficient evidentiary foundation. Yes, ladies and gentlemen. So I think this is a open and shut win. Exactly, Sigra. I just don't think he understood what he was citing. Like, if you do a cursory read, or if someone just told you to cite it, which I think like either Eliza Little or Jackson or Yannetti just slipped him a piece of paper and was like, cite this and say it stands for the proposition you're arguing. But if you actually, like what we just did, like actually explicate the case or shepherdize it or do the IRAC, you're going to see on the very narrow issue he was trying to argue, it does not stand for what he was arguing at all. And judges, part of the job of a judge is to like say, okay, one side's telling me a case means this, another side's saying that it means this. I'm going to go read it and I'll tell you what it means because I'm the judge. And I'm not a judge, I'm not a lawyer, I'm a towel. But in my lay opinion, that's exactly, Judge Cannoni didn't need to read those cases because she knew Coleman and Lannon offhand and was like, no, Alessi, sua sponte. She basically, Judge Cannoni, she talks quick. You got to understand the language of lawyers. It's called legalese. But Judge Cannoni didn't say like, okay, I'm disregarding that. But she was like, okay, Mr. Alessi. And then she was like, I really need to review what the expert testified about. And it's because she was immediately moving on to the evidentia. Oh my goodness. God bless you. Small acts of kindness, says Eva. Look for a reason to help homeless veterans today. But yes, the reason that I wanted to show you that, folks, it is very, very important. And we're going to just put Eva's kind comment back up on the screen, because look for reasons to help folks. Look for reasons to help folks. No, folks, I'm home today. As you noticed, like, to be able to do this, to be able to play the clips, to be able to do the coverage of the court, like I absolutely had the opportunity to be there today. I just couldn't. We have to sit on steel chairs. It hurts, little towel. My physical body is not doing that well. My brain, thank God, is, and God willing, will continue to be okay and is okay. But just to be able to do this, to live stream, to show you the clips, to review the testimony, to lay out the case law, I have to be here. I cannot be, to do it in court is almost impossible. I can't talk. I can do it. I can stream the Karen Cam, do the simulcast, etc. But we don't get any commentary on break. You wouldn't get a pre-show. And the John DePetro's there, so we get information as he's reporting about what's going on in court. And then also, like, standing outside of court, like, it's obsequious. Like, there's no way to get her to answer any questions. I've asked her 90 questions over the years. I don't need to keep asking questions that I've already asked without getting answers. So, yes, ladies and gentlemen, God bless Eva for her support of Towel Channel and for her reminder to folks to look for a reason to do small acts of kindness. Have you donated to homeless veterans recently? Maybe you don't. Maybe you can't donate. That's absolutely okay. Have you liked to post on a homeless charity helping veterans who are homeless? You can do that, ladies and gentlemen. We look for reasons on this stream to do small acts of kindness, and you can see all the Towel friends, folks. They know exactly how to go about those small acts of kindness. They are kind to each other. They are kind to Little Towel. They always have nice things to say. Hey, no, get out of here, Volcano Joe. I don't think you lasted very long. I think somebody got you. All right, ladies and gentlemen, it's time for us to watch the testimony, though. I know that's what you've been waiting for. So we're going to skip Burgess's, Burgess was last week. We're going to skip Dr. Welcher's intro, and we're going to go right into the substance of the testimony. We have about, 96 minutes until court comes into session this morning, and we are waiting for the big ruling, ladies and gentlemen. We are waiting for the big ruling, and it is going to be quite an interesting morning. I tell you what, ladies and gentlemen, I tell you what. So let's take a look at Dr. Welcher's testimony, the big moments of Dr. Welcher's testimony yesterday. This is what Judge Cannoni reviewed overnight, ladies and gentlemen. I feel like we are well, first of all, take a look at this. This is one segment that we're going to take a look at in Dr. Welcher's testimony of the impact between the car and John's arm in a simulated environment. But first, ladies and gentlemen, we're going to actually look at Dr. Welcher's substance. So hold on. I actually have to get to the thread. So I did a whole thread with part 1, 2, 3, 4, 5, and we're going to pick up at about part 3. We didn't get to do a full overview yesterday because I don't know if you saw, folks, we actually did a 12-hour towel stream yesterday. So I ran out of time because if you don't end the YouTube stream within 12 hours, the YouTube stream does not actually record. So ladies and gentlemen, here we go. We go through the background. Now here is where we review this is the key evidence that Welcher reviewed. Karen Reed's 3-point turn, okay, at 12:23. We're going to look at just one clip about that. Then the backup event at 12:31 to 12:32, okay, and then the fact that Karen's car could not have caused, Karen's car bumping into John could not have caused the damage to her taillight at 5:07. Okay, ladies and gentlemen. Now, before we do that, we actually got a request earlier from a Super Towel friend to take a look at one thing, okay? And that was this thing that Super Towel Val found the other day, which is a potential dual tire tracks in the snow, showing that Karen may have actually attempted to back into John O'Keefe's car before 5:08 a.m. And we know 17 of the 18 ring videos from between 12:37 when Karen got back to John's house roughly and 5:07 were deleted. And the question is, were one of those videos Karen staging, trying to do this backup into John's car to stage preemptive reasonable doubt about what caused the damage to her taillight? But the way I think about it, ladies and gentlemen, is that those ring videos are very interesting, and if we're going to get testimony from the ring keeper of records, we have to keep that in mind. So let's take a look at what Super Towel Val found here. Take a look at this on the far left of the red circle. There's a tire track heading into that towards John's car that is not from Karen's backup that you're going to see on the video. It's an extra tire track, as if Karen had staged a bump into John's car and didn't like how it looked and then deleted it and tried again. Now let's take a look. So that's Val's image she analyzed. Now this is the video. It'll be clearer. Take a look. You see the car backing up. Now we zoom in. Now you see when the car backs up, Karen's car, it's very slow speed. There's no way it causes any damage to John's car or Karen's car. But also that tire track is already there. And Karen does not go anywhere near that tire track that is already there in the snow. In fact, she goes very far to the right of it. Well, right of it on our screen. Left of it if you were looking at the back of Karen's car. And then, of course, you can see Karen's taillight's clearly broken there. And then she puts the brake light on. You can see it's even more broken because that is why we are back. Hello, are we back? Do you see me? Do you hear me? Okay, Mike should be back. Thank you so much. I appreciate your indulgence, little towels. I am so sorry for that crash. Yes, I know you can hear the mic now, but listen, I apologize for that. We were watching very important testimony and I got pulled off track. I know that I did that on my own, but yes, I don't want to leave. I know the sound is back. It takes about 20 seconds. I don't want to leave super towel Macy just floating in the wind there. But I don't want to continue watching that video because, one, I feel like it's a bad omen that it caused a stream crash, and two, you can find that video on my Twitter, and we also will hear more about the 5:08 a.m. bump, which did not cause the break in Karen's taillight. No one thinks it does. Karen's not going to argue that. There's no evidence of it, but you hear it analyzed during Dr. Welch's presentation. But yes, my name is Grant Smith Ellis. I pray all of your what? No, it's fine. I know it's working fine because I'm watching it on my end. You may have to refresh your feed, but yes, I'm watching it. It seems to be working just fine on this end, and I'll continue to monitor, folks. Just remember, we had a stream crash this morning, and it was only about 60 seconds of delay, and I beg your forgiveness as we continue to get prepared. Oh, God bless you, Mandy Strong. I love that little towel emoji. But yes, I'm so glad we're back. I'm so glad we're back, folks. I missed you all over that 60 seconds, and I pray your indulgence. And as I mentioned, thanks to the towel friends, we were able to get caught up. And also, that is an adorable little note from the Honorable Towel Spouse, Mandy Strong. God bless you, Mandy Strong. All right, here we go. Yeah, the media. Oh, folks, you want to see Karen walk out of court yesterday? Oh, goodness. Amber Am, I'm going to regret this. I know it might cause a crash after the last incident we had. But here we go. Here we go. Let's see Karen walking out of court. I have the video of it. It was right here. All right, let's watch it. Let me grab this. Everyone's like, oh, no. Oh, no. I'll see you soon, Mandy Strong. God bless you for the work you do, towel friend. You are a super towel in so many ways. So let's watch the clip of Karen walking out of work. Walking out of work. Oh, goodness. No. Well, it is her work, I guess. She's not a lawyer, though.
Karen, did you think Dr. Welch's recreations were good with the test dummy and the glancing glove?
And the grease paint on his arm? No.
Karen, did you?
And he backed up into himself at 2.2 or something miles per hour. So he tried to dress identically to John, but didn't do anything else to mimic what the Commonwealth is accusing me of.
So did you go in reverse 24 miles an hour, 53 feet?
The data is what the data is. And
She admits it. She admits it. The data is what the data is.
it's going to come out cleanly, more cleanly in our case in chief. I think it's important to demonstrate what is the Commonwealth accusing me of. The speed, the positioning, recreate that for us. Back up into the crash test dummy at 24.2 miles an hour in the arm and see what happens. That's what I would want to see if I were you.
Do you recall that at all, Karen?
No, because it didn't happen.
Any update on if you're calling Proctor, given that his friends are now witnesses on your list?
No comments. There are one of these four new witnesses. Say anything about them? No comments. Are you going to take the stand? No comments.
No comments.
That was literally it. Then Alan Jackson's like, don't you want to ask me about like basketball or the Red Sox or something? I don't know. But the point is, Karen did not have a lot to say, ladies and gentlemen. She was like, I'm screwed. Karen was like, I'm screwed. Exactly. She basically admitted murder by Maestro. Now, listen, we have to watch the recap of this testimony, folks. And the reason why we have to watch the recap of the testimony is and first of all, she's not calling Michael Proctor. She was never going to call Michael Proctor. People were like, oh, she could make him a hostile witness. No, he'd have to get up on the stand. They'd have to ask questions. He'd have to be combative. Then they could maybe make him a hostile witness. But otherwise, they'd have to direct him, the defense, open-ended questions. They will never in a million years call Michael Proctor. I'm telling you, Michael Proctor will not be testifying in this trial. Mark my words, write it in stone. But yes, let's take a look at Dr. Welch's testimony. Now we're going to start with the three-point turn at 12:23 a.m. and then we're going to talk about how that leads to the backup event 7 minutes later after Karen Reed and John O'Keefe sit outside the home for 7 minutes. So let's take a look at the transition from the three-point turn to the backup event. So this is an 8-minute overview of the three-point turn. Then we're going to watch the backup event. Oh, it's big, ladies and gentlemen.
Dr. Welch, could you take us to slide 30? white photograph and the text under the right. Okay. You were explaining to us the time relevance of 12:23:38. And could you tell us again, remind us, what is 12:23:38 referring to?
12:23:38 is syncing the text stream time to real world time. So we know how long the text stream is on. We know when the vehicle was turned on. So we're adding those two together. So if you add the 12:12:36 to, for example, 11 minutes, 2.8 seconds, for when the end of the trigger is, that gives you 12:23:38. So the end of the trigger in real world time, no longer in the running clock, is now 12:23:38.
Based on the infotainment clock?
Based on the infotainment clock.
And that's from the Lexus?
From the Lexus.
Your Honor.
Sustained.
And where's that from?
The Lexus.
Thank you. The 12:23:58 number, what's the significance of that?
So that is Mr. Keefe's cell phone data at point 154. Again, from the original data we had just at 154 and 155 and not the in-between points. So.
And at the bottom in parentheses, explain to us what that means.
Sure. If you look at where the text stream math works out to be, 12:23:38.8, and compare that to 12:23:58, the difference between those two is 19.2 seconds.
The difference between which clocks?
Between what the text stream infotainment system would show compared to what point 154 on Mr. O'Keefe's cell phone is.
And based on new data, do you now have information about what the variance, the difference is between the clock on the Lexus infotainment and the clock on Mr. O'Keefe's cell phone?
Yes.
And what is that?
Objection, Your Honor.
Going to allow that.
You need to advance the text stream clock 21 to 29 seconds.
You need to advance it 21 to 29 seconds for why? Why do you need to do that?
Because the cell phone is ahead 21 to 29 seconds.
After you advance the text stream ahead 21 to 29 seconds, can you then compare the information, the time that's coming from the infotainment system Lexus to Mr. O'Keefe's cell phone from his iPhone?
Correct. That's what you need to have an apples to apples comparison. You need to get them on the same time clock.
Thank you. You can proceed.
So I think we left off here. So that's 1162-1. So what we have is we have the cell phone data, the original cell phone data on the right-hand side. And then from that text stream data, we have whether it's going forward, we have the speeds, and we have the steering angles. So from that information, we ran a simulation to show you what the text stream data means. This is what the 10 seconds of data is. And again, just because the simulation stopped, that's just where the text stream data ends. Again, as we showed you earlier, the car's still moving. That's just the last data point we have. So what that text stream data shows is matching a 3-point turn on that Cedar Crest Street. So we have the vehicle motion, the timing data consistent with the interview statements about making a turn, 3-point turn.
Can you take us back to the data chart and show the 2 points that you just mentioned, the turning? Where's that reflected in the data?
Sure. So you can see
You'll have to enlarge that. I'm sorry, Doctor.
column N, that's the ship position. So that's looking, we start off going forward right here. And you can see at the start of the simulation, we're going about 9.94 miles an hour. And then as you start a 3-point turn, you generally start, in this case, if you're going to the left, with the left turn. So you can see we have this steering angle here, then the transmission. So again, we have the brake application. So you're coming in, but you're slowing down, and you get down to a speed of approximately 0. Shift into reverse, back up, and then start to turn the other direction as you're backing up. So again, you want the rear to go to the right, you turn the steering wheel to the right, right is negative, and then as you start to pull around and pull forward, you turn back to correct for the steering, and so that's what this shows. So again, if you put it all into a simulation program, the speeds, the shifting, the distance, keep in mind we only have that 10-second window of data, and the steering angle for that Lexus, that's what it indicates.
Can you enlarge the photograph on the right with the data points and explain to us the significance of that?
Sure. So again, what we're trying to do is we have the infotainment, we have the text stream. We're now trying to see how that correlates to Mr. O'Keefe's cell phone. So we had originally very coarse data points, 154 and 155. There's additional data points between here. So we're looking at how well does our predicted time compare to those two. So with the cell phone correction, you end up with the text stream data at 12:23:59 to 12:24:07. So that's actually right in between these two data points. And so we know 154 was closest, but it's on the right-hand side of the road. 155 is when it's turned around and heading back in the southerly direction. So the cell phone data corroborates the text stream timing data in conjunction with the infotainment system data.
Thank you. Please continue.
Okay, so we talked about 1162-1. That's the first trigger on the text stream. So we're going to go to 1162-2. So I've highlighted that in yellow. So we're now talking about the second trigger. So this is on the same ignition cycle. It's on ignition cycle 1162. We have that same continuous running clock, but we've now synced it to real world clocks.
My microphone is back. Hold on. Sound is back. Sound is back. Hold on. Sound is back. Sound is back. Sound is back. It'll take about 15 seconds. Okay, so we're gonna hold on. We're gonna listen to. Thank you. I know. It takes about 20 seconds after the sound goes out. The sound is back. I promise you. Once I say the sound is back in about 10 to 15 seconds, you will hear it. Okay. I know. Thank you for letting me know. Thank you. Just keep an eye on the comments. As soon as I say the sound is back, it's because I've looked at the back end. Now in about 10 seconds, I should see a bunch of comments popping up saying, indeed, the sound is back. And then there's just going to be a flurry of comments being like, the sound is back, the sound is back. Yes, thank you all. I appreciate your monitoring. We are back. All I was saying in there, it was only about 5 to 10 seconds you missed. Literally, all I was saying was that you heard, and I was talking a little bit about how it's not so much about the experts, the providence of the jury argument. Alessi already lost that. I looked at the case law. In my opinion, I'm not a lawyer. I'm a lay towel, but Alessi already lost that. So what this really has to do with, ladies and gentlemen, is fundamentally whether under the rules, under the rules of evidence, this witness has testified to enough evidentiary foundation. His reports, the damage to Karen's car, the witnesses testing, the videos that the witness put together, the Karen's own statements to the media, John's injuries, all of the testing that the witness has done. Whether that witness has properly established a foundation that survives a MRE 401 and 403 balancing analysis. And so the balancing test is the evidence relevant? Is it probative? We know it is. So therefore, is it prejudicial to the defendant in a way that would outweigh its probative value? No, not at all. Would it confuse the jury? No, not at all. Would it be judicially inefficient? No. And so then it's really a question of just a pure probative value analysis. Has the witness established enough evidentiary foundation, which is why we're watching this testimony back, ladies and gentlemen. And by the way, great point, Suzanne. I do think a lot of people know what I'm saying and would understand it, but they want to continue getting attention and donations for supporting Karen. People believe, in my opinion, some people know Karen Read is probably guilty, but continue to promote the myth that she's not guilty because it makes them money. And then because it makes them money, they continue to promote that view. It's a dangerous, cyclical, recursive loop that's very undermining of human autonomy. But also people need to live. I understand. They're trying to feed their family. I just wish they could be more authentic to self. If I did not believe Karen Read was guilty, I wouldn't say it. I truly believe Karen Read is responsible for John O'Keefe's death. That's why I'm so firm in my convictions, and that's why I don't care. I'm not doing this because people watch. I'm sure more people would watch if I held a different opinion. It's not what I think about. I'm thinking about what do I believe, what do the facts say, and what does the evidence confirm. And in my opinion, Karen Read is guilty. However, just remember, we're watching this testimony because Judge Cannoni's decision at 10 o'clock, by the way, if you're just tuning in, my name's Grant Smith Ellis. We're waiting for the start of testimony at 10 a.m. in the Karen Read and John O'Keefe trial, day 23. And Judge Cannoni is going to come out the gate, the horse racing official herself, Judge Cannoni, with a decision on whether this expert, Dr. Judson Welcher, will be able to testify that Karen Read's car collided with John O'Keefe at 12:32 a.m., right at the moment that John's phone stopped moving for the last time at his final place of rest on that lawn in a blizzard. And that, too, this was a collision, a sideswipe collision, not a frontal impact collision. Ladies and gentlemen, this is big, and we are listening very carefully to what Judge Cannoni was reviewing overnight, which is the testimony from Dr. Welcher, because we know it's not going to be, unless he's going to lose on the Coleman argument related to the providence of the jury. That's not what this witness is doing. It's different than saying this is a second-degree murder or homicide. That's not what this witness is saying. Saying there was a collision is not a legal conclusion that the jury's making. That's something when you say, like, this was a homicide. The witness did not say that. The second thing is, therefore, we're looking at whether there's a proper and full appropriate evidentiary foundation based on the witness's testimony over the past day for that conclusion to be made. Judge Cannoni's going to come out of the gate, and the first thing she's going to do is rule in favor of Hank Brennan. Mark my words. And I listened to all that testimony yesterday. I even reviewed the 15 minutes I missed. This all leans in Hank Brennan's favor. So let's watch the testimony about the backup event. We have just an hour, ladies and gentlemen, and 9 minutes to go until the start of session. I know so many of you are anticipating this. This was a a true cliffhanger at the end of yesterday's John O'Keefe and Karen Reed trial. We don't know how Judge Cannone is going to rule. I think it's almost a guaranteed 100% ruling in favor of the prosecution on the basis of my analysis. But let's continue. Remember, we're watching this testimony from Dr. Welcher for one reason. Is there appropriate evidentiary foundation for Dr. Welcher's conclusion that Karen Reed's Lexus collided with John O'Keefe in a sideswipe collision at around 12:32 a.m. and 4 seconds to 12:32 a.m. and 9 seconds on 1/29/22, which was just 7 seconds or so before John O'Keefe's phone stopped moving for the last time at 12:32 a.m. and 19 seconds. But yes, ladies and gentlemen, let's watch, because this testimony is important. Judge Cannone will be thinking about it, and I'm a towel.
5 seconds either side of that. So between 18 minutes, 57.6 seconds to 19 minutes, 7.5 seconds.
Could you enlarge that, please?
Which part?
That part where your arrow is. You were speaking about the clock. Could you explain that so the jury can see?
Sure. So again, this is continuous from when the time comes on. I just converted it to minutes and seconds here so you can see how long it's been on. This is the mileage. These are the speeds over here. And this is some information on how far it traveled. Again, we have the plus minus on the steering. That gives us some information on the steering. Really, there's very little steering going on at this point. Slight leftward steer.
Dr. Welcher, did you determine how long after the first trigger, that 3-point turn, that this second trigger occurred?
Yes. 3-point turn occurred about 8 minutes after.
You said the 3-point turn occurred
I'm
after...
sorry, this event, I misspoke. 11.2 occurred about 8 minutes after.
After the 3-point turn?
Correct.
Okay, thank you. Can you walk us through this data?
Sure. Okay. So we have the accelerometer data here. I've highlighted a shift from drive to neutral to reverse.
I'm sorry, you're going to need to zoom that in so we can see it.
Absolutely. We have information on the brake switch, brake oil pressure. We have the acceleration data here. And then
Maestro, it did it again, my dear friend. Hold on, folks. It's not you. Murder by Maestro, the same thing happened again at a crucial time on the lawn crime feed.
Because the wheel speed is simply telling you the speed of the wheel. It's like if you're stationary burning rubber, the speedometer reads a certain speed, but you're not going anywhere. But the accelerometer tells you how much the vehicle's moving. So from all that information, we get information on how far the vehicle's traveled. We've done it in terms of total travel distance. We've done it relative to the start position.
I'm going to ask you to start on the columns on the left and take us through the information that you have regarding this second triggering event. So if you can scroll all the way to the left.
All the way to the left?
Yep. Okay. So the first column regarding time, could you remind us again what that is?
So again, that's the continuous running clock.
And the second column in blue?
That's where I take that time and convert it to what we more commonly use, minutes and seconds.
And now we have a key cycle event different than the 3-point turn. What's the number?
So this is now 1162-2. So again, it's technically in the system the same key cycle. I've called it 1162-2.
And the red number next to it to the right?
That's the mileage. So it's actually at the same mileage as 1162-1. So we know, obviously, they're within the same mile.
If you can scroll over a couple of columns. from your data, can you tell during that event how far the Lexus traveled during
Yes.
that event?
Yes.
And how do you do that?
So we have accelerometer data. We have velocity data or speed data back here. I've corrected for what you see down here is, and I go through this on a later slide, but right here you can see a significant increase in RPMs, but yet the acceleration is dropping. So what that means is if your RPMs are going up and the speed's going up, that means you should be accelerating more. But what happens because the acceleration is dropping, that means what's actually happened is the wheel's slipping. So what I've done is I've used the accelerometers data to calculate the speed once the vehicle is put into reverse. And once we know the speed, again, feet per second, we know every data point is half a second. So speed times time tells you how far you moved. Feet per second, feet divided by seconds times seconds gives you feet. That's how far you went. So you get how far you went in each interval, then you get the total distance traveled. And so this is relative to the start. So 0 is the start. The vehicle goes forward about 34 feet. Then you see it basically stops in this area here, then begins to back up and ends up backing a total of 53 back from where it originally started. So if you add 53 to 34, you get 87. So the total motion, 34 forward, 53 back, the Lexus moved 87 feet total.
Dr. Welcher, when you say the Lexus moved 83 feet total, is that according to the data or is that the entirety of the movement of that Lexus?
No, that's just from when the data starts to when the data ends. So if you look at when the data starts, you can see that the vehicle is actually going 13.67 miles an hour. When the data stops, the vehicle is still going 23 miles an hour. And you can see,
I'm sorry.
you can still see that it's still at 74% throttle. So, you know, this is 3/4 of full throttle in reverse.
So to start with the distance traveled, if you can go to the top, we see that the speed is 13.67. Is that where the data gets picked up?
That's where the first data point is. Again, the trigger is here. This is 5 seconds before the trigger.
Are you able to tell how fast or slow the vehicle is traveling before that data point of 5 seconds before the trigger?
No.
And likewise, on the bottom, the speed. At the end of the 10-second data points at 23.61, can you tell whether or not that speed stayed the same, increased, or decreased?
I mean, considering you're at 74% throttle, it likely increased. How much, I don't know. And you can see that up here, she's on the brake. Down here, she's not on the brake. And so she's not on the brake and at 74% throttle.
And what is the percentage of throttle that has to be initiated to cause a triggering event?
For a shift into rear and a rapid throttle application, is 30%.
If you look at the next column over, if you can go to the top heading for the jury to see the engine RPM data, could you explain that?
Sure. Again, that's the engine RPMs. And so, as I mentioned, you have this jump in engine RPMs and a very dramatic jump in the reported speed of the vehicle. But when you look at the acceleration is actually dropping. So again, that's a telltale sign that the tire's spinning because the vehicle's not being accelerated. And so I've used the accelerometer data. Again, if you just, a process called integration, you integrate the accelerometer data, it will give you the velocity. So what I've done is, it's called piecewise integration to get the speed data that takes into account the tire slippage, and from there calculated the speeds or the position at each interval going across the top here.
If I could stop you at your column that says JBW speed at each time step.
Yep.
If you go to the bottom, please. So does your data indicate that the speed is changing at the end of this 10-second event?
Objection, Your Honor.
Sustained.
Is the speed changing at the end of this event?
Yes.
How so?
Well, again, you can see it's increased about 2.7 miles per hour. And again, we know from what I already stated that that last time step, you're still at 74% throttle and you have 0 brake application.
Is it possible from the data to tell how far the Lexus went forward before it went in reverse in total as far as feet?
Not in total, no. We just have this 10-second window. I can tell you what it did during this 10-second window.
Is it possible to tell how far it continued after the data?
No.
The shift position changes from 1 to 0 to 2. Can you again explain to us what that means?
Sure. 1 is drive, 0 is neutral, 2 is reverse. And then brake switch status, again, a 1 is you're on the brake pedal, enough to activate the brake lights. 0 is you're off the brake pedal.
Each one of those indicators, 1, 0, 2, how much time is for each of those?
0.5 seconds.
So can you tell how long the Lexus was in neutral for?
So again, it only occurs at one time step. And again, there's a little timing issue. Like we only have data every half second. You don't know exactly where in that time it was.
Okay, you can continue, Dr. Welcher.
Next slide or continue on this slide?
Unless there's something else you want to point out to the jury on this slide. You
No,
can
I'm
move to
good.
the next.
So similarly, using this information to then try to tie it back to the cell phone data to make sure we have the real-time information. Again, this was written back in January before I got the additional information. So what you can see is, I'll zoom in. Again, we're now talking about trigger 1162.2. We know that that's 18 minutes that the vehicle has been on, 18 minutes, 57 seconds, 19 minutes, 2 seconds. This is the range. Again, the plus or minus 5 seconds. The 19 minutes, 2 seconds is when the trigger occurred. Infotainment system, adding those two together, 12:36, plus the 19:7.5 indicates the end of 1162-2 is at 12:31:43.
That 12:31:43, is it based on the Lexus clock from the infotainment system?
It is. It would need to be corrected to the O'Keefe cell phone data.
And when you reconcile that variance of 21.29 seconds, what is the time?
You end up with 12:32:04. So if you simply take this and add 21 seconds to it and add 29 seconds to it, so you get between 12:32:04 and 12:32:12.
When you reconcile the two clocks and you have that range of 12:32:04 to 12:32:14.
12:32:12.
I'm sorry, 12:32:12. Does that simply accommodate the window of data, but not before and after?
Correct. So, again, even on John's O'Keefe's cell phone, even within his cell phone, there's somewhere between 21 to 29 seconds difference on his cell phone. So even that one piece of instrumentation has some variance to it. So we know it's between 21 to 29 seconds at this approximate time. So this is taking into account that variance.
So the only time window that you have is based on the data, and that's reflected in the 12:32:04 to 12:32:12?
Objection, Your Honor.
Sustained.
Is there any other window you can accommodate with the data you have other than that 10-second window?
Yes.
What's that?
So I was given information about a final lock event on the phone.
Let's stick with this window if we can.
Okay.
Since you only have 10 seconds of data, is it possible from the Lexus clock data to have a larger window than this 10-second window?
No, the text stream will only give you a 10-second window, but it doesn't tell the whole story because the vehicle's still moving.
Understood. Okay, continue, please.
So I have this other event, a lock event, and the information I was given that at 12:32:09, and so we have the text stream data ending at somewhere between 12:32:04 and 12:32:12, which puts this number right in the middle of that, more or less.
We go to lunch here.
Is this a good place to?
So, folks, first of all, my name's Grant Smith Ellis. We're just 53 minutes away, ladies and gentlemen, from the start of session in the John O'Keefe and Karen Reed retrial. And we are going to get a ruling at 10 a.m. on a big motion, and I think Hank Brennan's going to win this motion, ladies and gentlemen. But as we get ready for that to happen, can we just take a second to thank Super Towel Monty? I wanted to leave it up on the screen, not just because it is so generous, but because I just want to take the time to express I share Monty's sentiments. This is an amazing community. So many of you are wonderful. All the people who help out, the super towels in the chat, people constantly thinking about each other. It means so much to me, and I wanted to highlight that message, not just because Monty is an amazing person, supporter of the channel, and friend to Little Towel, but because the sentiment Monty is expressing embodies everything I believe that this towel can be, this towel community can be at its very best. It's eudaimonia, as the ancient Greeks would say. It's summum bonum in the Latin. Ladies and gentlemen, Monty gets it, and I hope you all appreciate it as well. God bless you, Super Towel Monty. Towel appreciates you. But yes, ladies and gentlemen, as a result of leaving that on the screen for a very long time, I want you to know that I will not forsake you. There are many towel comments that loaded up in the interim, and I'm going to click the button. I'm going to load all of them up. Oh, it is going to get very mad at me. Don't get too mad at me, Little Towel computer. It's not my fault. The towel friends have a lot to say. The towel friends have a lot to say. So as you can see, going back to Monty's comment, ladies and gentlemen, you all had a lot to say in the interim. Got to scroll it slowly, just as if you were all making comments as we were going. So let me do that for you. Oh, yes, ladies and gentlemen, the towel friends, even in the 60 seconds that I wanted to just point out how much Towel appreciates dear Super Towel Monty, had a lot to say. Yep, Eva, I do think that the witnesses for the defense will be allowed because Michael Proctor will not be testifying. I also want to give a Super Towel hug to Holistic Psychology. Oh, Deb H., the sunken grave. I want to give you all big Super Towel fluffy hugs. You are all Super Towels in every sense of the term, and it is great to see you. Oh, Monty, you are so kind to give hugs to your fellow Super Towels. That is what makes you a Super Towel, Monty. Oh, ladies and gentlemen, Macy, you have a good time at work, ladies and gentlemen. Always working hard here. We'll be here to update you as you're able to check in. Ladies and gentlemen, look at all the towel friends. They are wonderful to each other. We are getting caught up. We're just 50 minutes away from the start of session, ladies and gentlemen. Just 50 minutes away from the start of session. But even as I try to get caught up on all the comments, you can see, folks, they just fly by. They fly off the screen just to get us caught up to real time. I have to scroll. Mary Adams, I am so goodness, ladies and gentlemen. I could give you a hug, Mary Adams. It is great to see you. Trailman, it is great to see you as well. It is complicated. It makes more sense the more you listen to it. God bless you for being here. Just being nosy. It is great to see you, dear friend. Oh, and of course, Mary Adams was in there, and Murder by Maestro, the Super Towel themselves. Let us know you can now listen to Towel on mobile at 5x speed. Oh, ladies and gentlemen, Eddie Money, I love your username, but I don't know whether to make you a Super Towel or not. I don't know if you're friendly, but you can be a Super Towel if you want, my dear friend. 49 minutes to go, ladies and gentlemen. 49 minutes to go, and I will tell you right now, we are going to get caught up. What happened after lunch? Oh, Towel has it. We can skip through the whole lunch period and just go right into the next part. of Dr. Welcher's analysis. And remember, folks, Judge Cannoni is going to make a ruling at 10 a.m. this morning. Is Dr. Welcher going to be allowed to testify about his opinion that the data, the evidence in the case, all of John's injuries, Karen's statements, Karen's car, etc., all point to a collision sideswipe between Karen Reed and John O'Keefe, Karen Reed's Lexus and John O'Keefe's body around 12:32:04 to 12:32:09 on 1/29/2022, which is just seconds before John O'Keefe's phone stopped moving for the last time at 12:32:16 a.m. that morning on the lawn, where Karen allegedly left John to die from a traumatic brain injury and hypothermia. Ladies and gentlemen, my name is Grant Smith Ellis. We're going to continue listening to this testimony. Thanks so much for being with me. We're just 48 minutes from the start of court. Here we go, ladies and gentlemen. What will Judge Cannoni rule? How will it come down? We are watching the time. The moments are ticking away. We are waiting, and we are here, and we are cogent towels. Here we go. This testimony is incredibly important. Remember, Judge Cannoni herself said that she will be ruling based on what was testified about by this expert as to whether he can give this opinion. The conclusion, the crescendo. Ladies and gentlemen, the Reed defense, the good ship Hindenburg, is on the way to the ground. Oh, the humanity. I'm a towel. Give it a second. Come on now. Come on, little towel. We have faith in you, little towel.
Dr. Welcher, when we left off, you had given us your opinion on this slide. Could we proceed to slide 35, please?
Slide 35?
I believe the next slide is 35.
Correct.
Okay. Now, when we look at this slide, I'm going to ask you to zoom in, and if we can start from left to right, and we can identify each category as you discuss it and explain to us the importance of the columns.
So we already touched on this from left to right. The first column is the continuous running clock. Second column is where I converted it to minute and seconds. You can see we're on trigger 11:62:2. This is the second trigger. The particular boxes that are highlighted are where there's change. For example, in the upper right, when you're transitioning from drive to neutral to reverse. And then I already discussed this a little bit, but where the wheel is slipping, you can see you have high acceleration pedal application, increase in the RPMs. But when you look at the effects on the vehicle, you can see that it's accelerating less. So that's indicative of slippage of the wheels. And then I simply show at the bottom the math I use to derive all that. So again, we touched on most of this. It's the same slide you saw before, just to show how corrected for the speed.
If you could zoom in for a second, I want to ask you a question about the RPM column.
RPM column, go ahead.
If you could zoom in.
Oops.
You see in the last line, the last piece of data captured, the RPMs changed from 3,200 to 3,300.
Correct.
And the accelerator is fair to say, is that depressed? What's the way you characterize that?
Sustained.
How would you characterize 74? What does that mean?
I mean, it's 3/4 of full throttle. It's 74% of full throttle.
If above it's 74.5, it drops to 73.5 and then back to 74. Why is the RPM higher than above?
So there's, again, this data is referred to as being asynchronous. You're reporting it at particular times, but the computer's scanning the network for the data. So it's not all on exactly the same time step. Not only that, but there's frequently, I'm sorry.
Sorry.
There frequently is a delay from when you step on the accelerator pedal to when that translates to increased RPM at the engine. It takes a little time to build it up or take it down.
Okay, thank you.
You're welcome. So similar to what we did on the first one, basically what we did is we took all the text stream data that we had, which includes the shifting, the forward, the reverse, and the steering. Again, there was a tiny bit of leftward steer, and put that into a simulation program where we're simulating what the Lexus will do. So we've taken into account the mechanical characteristics, the steering response to the Lexus. So this is to show what it represents on the left-hand side. So each one of these little hash marks, a different color, represents 10 feet. The red lines show the extent of motion. Remember what I said, it initially pulled forward, then backed up past its initial spot, and then went backwards further distance. So what this shows is where we simulated this in a program called HVE. So that's the vehicle, the Lexus pulling forward. And then it accelerated in reverse past its initial starting position and came to rest right there.
Doctor, when you say it came to rest there, do you have data that the defendant's Lexus stopped there?
No, it did not come to rest. I misspoke. That's where the tech stream data ends. As you can see here, it's still going. It's still going approximately 23 miles an hour when that ends.
You'll have to zoom in on that so the jury can see what you're referring to. Please.
So again, as I mentioned, the tech stream's taking a window of data. It doesn't take anything outside the window. You can see that when we account for the wheel slippage, that the vehicle at the time of the last data point, again, is at 74% throttle, 3,300 revolutions per minute, and is going backwards approximately 23.9 miles per hour. And you can see it's traveled a total distance backwards of 53 feet back from where it initially started, or if you consider where it pulled forward 34 feet and then backed up 53 feet, add those two together from the point it pulled all the way forward. So this is 10, 20, 35, forward. And then it'll go 10, 20, 30, 40, 53 back for a total of 87 feet. So from the maximum point I pulled forward to where it backed up, again, that was 34 feet forward, then a total of 53 back, total travel distance of 87 feet. So went all the way forward where it stopped, it then backed up 87 feet. And when the tech stream data stopped, it's still moving. It's still moving about 23 miles an hour, and you're still at 74% throttle and 3,300 revolutions per minute on the tachometer, RPM gauge.
We could turn the light on for a moment. Dr. Welcher, in your analysis of the data and the information you acquired and the evidence that you relied upon, did you come to some conclusions and opinions regarding the defendant's Lexus that evening?
I did.
As part of that opinion, you mentioned that you considered mileage to map distances as one way of mapping the location of the vehicle. Do you remember that?
I do.
If you could provide us with slide I believe it's slide 25. And could you widen the left-handed box a little bit? And you mentioned you measured or you ran information about distances between different routes?
Correct.
Specifically regarding Fairview to Meadows, the first box. Do you see that?
I do.
There are 3 different mileage numbers.
Yes.
And then there's streets to the left. Can you explain what's set out in that box?
Sure. That's basically 3 different routes you can go. Sherman Street, Pleasant Street, Washington, and Sherman Street.
When you considered the shortest route, 2.3 miles on Sherman Street, did you attempt to determine how long it would take to travel 2.3 miles, how fast the car would have to be moving or how slowly it would have to be moving to travel 2.3 miles in 4 minutes and 15 seconds?
Yes.
And what did you determine?
So to go 2.3 miles in 4 minutes and 15 seconds, you would need an average speed of 32.47 miles an hour.
What if you took the longest route, 2.8 miles, and you considered 2.8 miles in 4 minutes and 15 seconds? Did you make a determination?
I did.
Could you share that with the jury?
It's 39.5 miles per hour.
Is that what the average speed of the Lexus would need to be to travel that distance in that
Correct.
time? Now, turning to your study of these tech stream events, do you have an opinion, to a reasonable degree of engineering certainty, how many triggering events occurred? How many triggering events occurred in that ignition cycle 1162?
Objection, Your Honor.
I'm going to allow that.
In 1162, the tech stream recorded 2 triggering events.
And do you have an opinion as to the type of triggering event, the type of movement of the defendant's Lexus in those 2 triggering events?
I do.
Regarding the first triggering event, 1162-1, do you have an opinion, to a reasonable degree of engineering certainty, what type of event the first triggering event was?
Objection, Your Honor.
I'm going to allow that.
The actual trigger was excessive rearward acceleration. The event was during the course of a 3-point turn.
And do you have an opinion, to a reasonable degree of engineering certainty, the time between triggering event 1 and triggering event 2 in that cycle 1162?
Yes.
And could you share with the jury your opinion, to a reasonable degree of engineering certainty, the time between those 2 triggering events?
Approximately 8 minutes and 5 seconds.
And do you have an opinion, to a reasonable degree of engineering certainty, as to the type and triggering event of the second event, 1162-2?
I do.
And could you share with the jury your opinion, to a reasonable degree of engineering certainty, the type of event to that second triggering event?
Objection, Your Honor.
I'm going to allow it.
It's, again, the trigger event itself was a transition into reverse and then high throttle application. It's a forward motion followed by a lengthy high-speed rear impact or rear motion.
Your Honor, I'm going to move to strike that portion of the answer.
Yes, I'm not going to highlight it.
I
So
appreciate it.
get the answer again.
Would you like me to ask the question again, Your Honor?
Yes, Mr. Lessie, yes, right. I'll strike the previous answer. Go ahead and ask the question again.
Okay. Do you have an opinion, to a reasonable degree of engineering certainty, as to the nature of the second triggering event, 1162-2?
Just for the record, Your Honor.
Yep.
Yes.
Could you share your opinion with the jury?
The triggering event was high throttle opening in a transition to reverse. It's a forward motion followed by a higher speed rear motion. And at the end of the trigger event, you're still at 74% throttle.
Do you have an opinion, to a reasonable degree of engineering certainty, the entire distance captured in that 10-second window during the back maneuver, or 1162-2?
Do I have an opinion about it?
Do you have an opinion, to a reasonable degree of engineering certainty, about
Yes.
the entire distance that is captured in that 10-second window of the second triggering event, 1162-2?
So it obviously only captures what's going on during the trigger. It doesn't capture before or after the trigger.
Understood. Do you have an opinion as to just what is captured as far as the distance?
Yes,
And what is your opinion?
that it's 87 feet. So again, the initial forward motion is 34 feet, followed by it backing, crossing the initial point, and then backing up an additional 53 feet.
And finally, regarding this part of your analysis, do you have an opinion to a reasonable degree of engineering certainty as to whether the defendant's Lexus was decelerating, accelerating, or remaining the same at the end of that data captured at the triggering event 1162-2?
It was accelerating at 74% throttle.
In addition to your analysis of the text stream data, one final question. Do you have an opinion to a reasonable degree of engineering certainty the relative time this backing maneuver occurred with the defendant's Lexus that you just spoke about?
Yes.
And could you share with the jury your opinion to a reasonable degree of engineering certainty?
Sure. It matches the window of the cell phone data for Mr. O'Keefe that puts it in front of 34 Fairview. So the backing event occurred somewhere between 12:32:04 and 12:32:12.
So I now want to turn to a different part of your study of this case.
Okay.
At some point, did you try to determine whether there was an intervening event?
Pause. Ladies and gentlemen, now we're going to talk about the 507 backup event, which is a fascinating part of the analysis. We're about 30 minutes before court starts. Ladies and gentlemen, however, I think I would be remiss if I did not bring up on the screen for you what is quite possibly one of the best videos I've ever seen in my entire life. It is from Bossy Texas Chick herself. Ladies and gentlemen, and let me just tell you, if you have never seen a towel, an honorary super towel cat, I'm going to bring this up on the screen. In fact, I am so in love with this little towel kitty, who is an honorary towel, that I turned my camera back on, even though it costs system resources, so that I can bring up this video of a kitty for you. And you might say, Grant, how amazing is this kitty? Oh, ladies and gentlemen, you will never see a more beautiful towel kitty than Bella. Look at that, ladies and gentlemen. It is a towel kitty. Oh, my goodness. Ladies and gentlemen, we're going to watch a video of a towel kitty. Oh, ladies and gentlemen, what a day. We have 30 minutes until court comes into session, and Bossy Texas Chick has a video for us, not just of a towel kitty who likes towel. Oh, ladies and gentlemen. Oh, true crime and some wine. It's great to see you. You came in at just the right moment. We're getting caught up on yesterday's testimony as we wait the 10 a.m. ruling from Judge Cannoni. But look what we have. Oh, ladies and gentlemen, it is a super towel cat named Bella. Hello, Danielle Sir Denu from Quebec. It is great to see you. We love our towel friends in Quebec. Oh, ladies and gentlemen, it is a towel kitty. How can you not get excited? We have to watch the video. Bossy Texas Chick. This is Bella's moment to shine, I tell you, ladies and gentlemen. Here we go. Bella, take the stage. Show us your glory, super towel. Come on, Bella. We're excited.
Bella, what are you doing? Bella.
Oh, it's a towel!
Bella, there's no catnip on there. Mommy doesn't believe in catnip. She doesn't like seeing a cat when he's all stoned and stupid. But here you got this washcloth, and for some reason... you make me laugh so much. What is it about... What are you doing? Bella!
No, it's like
You're silly. Every day, like, I'll wake up and there'll be the washcloth from the sink on the floor. And I guess this is what she does at night. Bella? Bella, you're silly. She's having a good old time. Who needs catnip? What are you doing, Bella? You're crazy. Bella, what are you doing? You cuckoo.
Oh, it loves the Bella loves a little towel.
Laugh. All
that's
right.
me.
I'm
I'm
gonna
a
end it now
towel.
because I don't think people will find this as funny as I find
I
it.
think
but
it's hilarious.
Hysterical. You're so
Wonderful. Oh, Bella, you are a super towel in every sense of the word. Ladies and gentlemen, oh, a kitty's on the stream. It is a special moment, ladies and gentlemen. What a beautiful kitty. Oh, Deborah Bessem, it's so good to see you. God bless you, dear friend. Thanks for being with us. Ladies and gentlemen, we're going to go back to the testimony. I know you were all quite enthralled and excited, but how can we not take a moment of levity to look at a towel cat? Now, ladies and gentlemen, let's look at the analysis from Dr. Welcher showing that there was no damage to John O'Keefe's car at Karen's stage backup event at 5:07 a.m. And if you're just tuning in, 27 minutes to go, ladies and gentlemen. Just 27 minutes to go until the beginning of testimony in today's John O'Keefe and Karen Reed retrial. And ladies and gentlemen, Judge Cannoni is going to issue her ruling. Hello, Greg James. You can be a wet towel. You can be a happy towel. You can be a fluffy towel. Maybe you're a wet and happy towel. It is great to have you with us, dear friend. Ladies and gentlemen, Ed Jobs is here. Ed Jobs is thrilled to see Bella likes towels. Now, ladies and gentlemen, here we go. Remember, Judge Cannoni is going to issue her ruling on the basis of whether the expert has laid foundation related to the collision between Karen's car and John being caused by Karen's vehicle. Ladies and gentlemen, and whether that opinion is grounded in the evidentiary record. So, ladies and gentlemen, let us look at, we're going to skip over the 5:07 a.m. crash because that was clearly not, it did not cause damage. The expert laid it out. Let's look at the most crucial part of the analysis, ladies and gentlemen. This is when Dr. Welcher explains the injuries to John's arms. John's arm perfectly lines up with the Sideswipe collision crash from Karen's Lexus. It's huge. Ladies and gentlemen, my name's Grant Smith Ellis. We'll get our ruling in 27 minutes. You tuned in at the right moment, folks. 27 minutes away. 27 minutes from the start of testimony today. Get ready, folks. Ready your towels for the peaceful invasion of Norman Towel, which is northern France, which is going to be occupied by the towel people peacefully in order to spread world peace. It involves kangaroos, koalas, peacocks, camels, and pandas. We haven't really figured out the full panda, koala, kangaroo, peacock, camel-based diplomacy plan, but don't worry, folks. We know it's going to be based in northern France.
Mr. O'Keefe's right arm, forearm, hand, and wrist. Anatomy, your arm is defined from your shoulder to your elbow, and then from your elbow to your wrist is your forearm, and then this is your hand. So technically when you say arm, it really means from your elbow to your shoulder. Most people call this whole thing arm. It's actually the upper extremity. Arm is from shoulder to elbow, elbow to wrist is forearm and hand. So you can see I wrote arm and forearm. So arm, elbow to shoulder, elbow to wrist is forearm. So looking at the injuries to Mr. O'Keefe's arm, forearm, as well as his hand. So this is me. I'm actually 6 feet, half an inch tall. What you see in the upper right is the coroner's examination report for Mr. O'Keefe. He's 73 inches tall. That's 6 feet, 1 inches tall. At this time, I was 220 pounds. Mr. O'Keefe, at the time of this incident, was 216 pounds. So I took measurements of myself. I'm actually wearing the same make and size shoes as Mr. O'Keefe, the same brand of jeans as Mr. O'Keefe, the same brand and size shirt of Mr. O'Keefe. You see the Lexus in the background. We have matched the height to the Lexus. What I'm showing here is both my height, and then keep in mind where the height of this wing is relative to my right eye. So now I'm wearing, in addition to the same shirt and shoes, same type of sweatshirt, and actually the same kind of baseball hat. We tried to determine the exact glass from the Waterfall Grill. Found out they were getting different ones at different times, but I ordered my glass from the same distributor that Waterfall Grill ordered their glasses from. So you can see in my right hand here, I have a glass. Here's a glass. It looks similar. It's from the same location. And then in the lower right photograph, what I've done is I've rolled up my sleeve, taken the sweatshirt off, and I'm going to look at how this contact pattern lines up. So the first set of slides, I'm simply standing next to the Lexus. We know we have a broken taillight. We know how scratches on Mr. O'Keefe's arm. I'm seeing how those may or may not relate to the height and position of the taillight.
Dr. Welcher, if you could back up one slide, I have a question for you. In the middle photograph, at the top of the Lexus, there's like a rim. What do you call that?
I call it a wind wing. I mean, it could be a wing.
Okay, thank you.
Air dam would be another. Okay, so I then set about to do a little bit of testing with the Lexus. The first test you're going to see is me just walking backwards, or actually sideways, into the Lexus. What I've done is I've painted the Lexus right rear tail light with what's called grease paint. Kind of sort of like paint, but it doesn't dry. And then I have backed up sideways, side shuffled into the Lexus with my arm out to see what the damage pattern looks like, or basically where someone of Mr. O'Keefe's height's arm would contact the rear tail light. So then what you see is I've shown the photographs again. I show the paint transfer onto my arm. The yellow grease paint on my hand was to show where my hand would hit the tail light. And so just kind of me walking slowly sideways into it, the approximate location of the tail light, and I'll line it up with the broken tail light in a second, lines up with the approximate location of the lacerations on Mr. O'Keefe's arm.
Dr. Welcher, let me ask you a question. When you're engaging in these demonstrations, are you attempting to try to show exactly how Mr. O'Keefe was struck?
No. So we don't know exactly how he was struck, and pedestrian impacts are extremely sensitive to exact angles. And so where exactly your foot is, whether your foot's off the ground, can have an effect on where you end up after that. We just don't have enough information in this case to determine all that information. We know the taillight was broken. We know the glass was broken. We know we have damage to the rear of the Lexus. We know we have lacerations to Mr. O'Keefe's arm. So I'm trying to see if there's any correlation between all those.
Well, can body posture on a clip or a side swipe collision change the trajectory or the injury?
Of course.
Can the way somebody moves or reacts before impact change it?
Objection, Your Honor.
Sustained.
What are other things that can change the trajectory of the person and the injuries?
So for example, if you get hit and knocked off balance, or clipped and knocked off balance, you can take additional steps. That'll affect how far your body travels. If you have one foot on the ground versus the other foot on the ground, affects how the body rotates. If your arm is at 90 degrees or 85 degrees, will affect the kinematics. We attempted to model different possibilities, and we're getting results that were all over the map. Small changes in the pedestrian position give you huge change in the output. And so from the tech stream data, we don't know exactly when in the tech stream data he was hit. So we don't even know the exact impact speed. In most pedestrian reconstructions, you typically have a point where the impact occurred, like where the person was, like in the crosswalk, for example, and they get hit and their tire leaves a rubber scruff. That's called the area of impact or point of impact. You then can look at how far they were thrown, and using some laws of physics, calculate how fast the car had to be going. Well, we don't have that in this case. We don't know exactly where Mr. O'Keefe was on the roadway when this happened. Sorry, I'm about to go to the next slide. Oh.
Without having an exact point of impact or an exact speed or an exact body position, are you able to specifically replicate the actual collision and the way Mr. O'Keefe's body would move?
Exactly replicate? No. And again, in terms of how he would move, again, we don't know where exactly on the roadway he started. So in terms of how he moved, that's a function of where he started. We don't know if when he was clipped, he took an additional step before falling backwards. So that will change how far you are off the roadway. So the impact, which you'll see in a second, even at 2 miles an hour, will induce rotation of the body. So depending on the speed, the higher the speed, the more rotation. So if I may, so slide 111, this is simply showing where I walk sideways, how this lines up with the location of the lacerations on Mr. O'Keefe's arm. Here's the post-contact scuffing on the taillight. Here's a picture of Miss Reed's vehicle on the right-hand side. So now I said, okay, that was me walking into the car. Let's have the car drive into me. I did this at very low speeds. And you'll see, and we'll throw this from 2 different angles. That's me showing I'm doing test 2. This is from a camera that we have pointing down at it. This is the speed. You'll see it's only about a 2 mile an hour impact. But even a 2 mile an hour impact redirects me back and causes me to rotate and take a step.
Yes.
All right, towel friends, you can see they go to sidebar. Sidebar. Ladies and gentlemen, they go to sidebar. Stay with little towel. Hello, friends, I'm here. It is so good to see so many of you. They go to sidebar here for a second, and then the expert's going to come back and testify more about that. There was a collision. Oh, yes, and then you hear little towel yelling. Oh, my word. Tenacious B. Now, ladies and gentlemen, it actually took a long time for this sidebar. Now I'm remembering what happened. But let me just tell you, folks, it all then crescendoed. If you missed it, this was the end of the day. This was the moment that led Robert Bobolesi and the Reed defense to just have an absolute meltdown. Now, my name is Grant Smith Ellis. If you're watching, you can obviously see we have a live look outside court. I'm going to back. I like to pause my camera sometimes because it saves system resources, but I'm going to come back with you because we're in the last 15 minutes of the horse race. Ladies and gentlemen, the horse race preparation. The horses are at the starting gate. Judge Cannoni is preparing your horse racing announcer, horse racing official gear. Ladies and gentlemen, my name is Grant Smith Ellis. We have a live look outside court for you right down there in the bottom of your screen. We're waiting to see who's going to arrive, when they're going to arrive. I think Karen's parents pull up here any second now, so stay with little towel. Yes, ladies and gentlemen, here's the arrival of Karen Reed's parents, I believe. Watch it down in the corner. Oh, we can even make it larger, ladies and gentlemen. Why? Because I am a towel. Oh, goodness, ladies and gentlemen, here, who is this arriving? That is Adam Lally. People think he's a koala. We agree that Adam Lally is a lovable koala, ladies and gentlemen. Oh, goodness, the ponies, the koalas. Oh, Grant Howard Cosell, David Attenborough, Towel Smith Ellis is on the scene, ladies and gentlemen. Well, I'm on the virtual scene. I'm monitoring. I'm being a towel. We should be into session any moment now at the top of the hour at 10 a.m. We're seeing who arrives on the scene. Apparently, you can now listen to YouTube on 5 times X speed according to Murder by Maestro, so I'm speaking as fast as I possibly can, so that when Murder by Maestro tries to listen to this on 5X speed, he's going to be completely and utterly baffled, and I'm going to think that's hilarious. Yes, ladies and gentlemen, the koalas, the ponies, the camels, the horses. Oh, there's Karen Reed's parents arriving at court. They get to walk. They don't have to walk the full way. It's a pretty arduous walk from the corner. Ladies and gentlemen, Karen Reed's parents have arrived at court. That can mean only one thing. Karen should be arriving in the next few minutes. And the greatest thing is I am a master of time and space, ladies and gentlemen. So I get to jump forward, ladies and gentlemen. I get to jump forward in time, ladies and gentlemen. Oh, I get to jump forward in time to when Karen Reed arrives. Or maybe we'll see Hank Brennan. Hank Brennan himself, ladies and gentlemen. We see it on Towel Stream. You could see him in Towel Horse Racing Announcer slash auctioneering announcer slash this man thinks he's an anthropomorphic towel announcer mode. And there's nothing you could do about it, ladies and gentlemen. We only have 14 minutes until court comes into session. If I'm not in horse racing announcer towel mode now, when will I ever be able to be in koala horse racing announcer towel mode, if ever? Oh, ladies and gentlemen, let me just tell you the humanity of it all. The man who thinks he's an anthropomorphic towel, who thinks he's a horse racing announcer, who thinks he's an auctioneering announcer, who is commentating on a criminal trial while we await the arrival of Karen Reed, who is not a towel. Oh, ladies and gentlemen, the humanity of it all. Oh, Alex, it's great to see you. You can redeem us from this just ship of fallen humanity that is the good ship Hinden Reed. Oh, ladies and gentlemen. Oh, my word, the humanity of it all. This is what happens as we get close to the top of the hour when court is going to come into session. I become absolutely invigorated horse racing announcer Towel. Oh, people absolutely get enthralled when Towel gets into horse racing announcer Towel mood, because that means something absolutely explosive is going to happen. And yes, ladies and gentlemen, Judge Cannoni's ruling could be huge. I project a win for Hank Brennan. My name is Grant Smith Ellis, and I am a towel. I tell you, first of all, I'm not a communist. Second of all, I'm a towel. Third of all, this is going to be quite a big moment. And furthermore, I am a towel. So just write those 4 things down. That will be our canon. I'm not really sure what we're going to do with it. People are going to be like, why is this man declaring himself a towel? He seems incredibly excitable. What is going on? Well, I will tell you, ladies and gentlemen, this is a very important moment. Judge Cannoni, in my opinion, is going to rule for Hank Brennan. The witness, Dr. Judson Welcher, is going to be able to testify about the sideswipe collision between Karen Reed's Lexus and John O'Keefe's body between 12:32:04 and 12:32:09 a.m. on 1/29/2022, which was just seconds before John O'Keefe's phone stopped moving at 12:32:16 a.m. on that very morning. Ladies and gentlemen, I am a towel. I'm not a communist, and I am a towel. Oh, yes, I am a towel. That's true. Allie 90211. Not only am I a towel, you can clearly tell what's going to happen at 10 a.m. is a very big deal. And so I am quite literally being a horse racing announcer towel. Oh, ladies and gentlemen, Karen is arriving. We got the moment. Oh, the good ship Hinden Reed. Oh, it's on its last legs, ladies and gentlemen. That is the good ship Hinden Reed arriving outside her fortress of doom. Oh, ladies and gentlemen. Oh, these are the moments that make men's souls. Oh, ladies and gentlemen, the humanity of it all. Karen Reed takes the walk. Guilty woman walking, I dare declare, ladies and gentlemen. Guilty woman walking. Oh, ladies and gentlemen, Marianne Nizio reinforces my sentiments. We are not communists. Someone's going to be like, no one accused you of being a communist. I know, I just want to make the point. On my tombstone, it will read he was a towel, he was an anthropomorphic towel, wannabe horse racing announcer, a guy who liked Chewbacca and the Stay Puft Marshmallow Man, but he was not a communist. Oh, ladies and gentlemen, the humanity. The humanity of it all. A man who thinks he's a towel trying to get you to 10 a.m. because court started late again. Oh, ready the ponies. Ready the ponies at the stables, ladies and gentlemen. Karen Reed's arrival on the Titanic. The good ship Hinden Reed is collapsing. Oh, all right. Hold on. So holistic psychology, I need to give you one little warning. It is very, very possible that in the 10 minutes before court starts, I become a horse racing announcer. Now, listen, I don't like horse racing announcing. I don't even like watching horses race. So I totally understand, because when I listen to it, I'm like, oh my God, why do people care so much about this? Do they have something riding on it? And then I get nervous. So I will do my best not to yell like a horse racing announcer towel, but I do want to give you just a little forewarning. There may be times when I get a little excitable, and I will declare it when I say, okay, I'm going into horse racing announcer towel mode. And then it is sometimes ideal, sometimes we can just give Towel like 60 seconds, and then Towel will come back into his regular mode, okay? So just give Towel like just a few minutes sometimes. I promise, holistic psychology, I understand the vibe you're sending. I will do my best to speak in a calming way. But yes, I do have a propensity or proclivity or an inherent predisposition, one could say, towards becoming an excitable horse racing announcer towel as the horses, the foals, and Judge Cannoni get to the starting line. I will admit it. Yes, Towel only had one energy drink today, and it tasted like Swedish fish, but I absolutely drank it all in about, 20 minutes. So as a result of all those chemicals going into little Towel's body, which I'm sure are not healthy, and I do not encourage any of you to drink them, that is exactly why I became an incredulous horse racing announcer towel. But yes, I also think that holistic psychology makes a wonderful, wonderful point. And as you can see, just by taking on that energetic vibe, I was able to reduce myself to a calm towel. Now, the other thing is, if you've ever watched the WWF in the 1980s, sometimes I get a little bit like Gorilla Monsoon, or in the 90s and early 2000s, JR. I get a little bit excitable about just mundane things happening. There's nothing decaffeinated in this 1,000 milligrams of Karen Pure, 200 milligrams of caffeine, 150 milligrams of alpha GPC 58, 100 milligrams of Neurofactor, and 4 daily vitamins. There is nothing decaf about that. Thank you, Modelo Macy, and also I appreciate, again, holistic psychology sending those very calming and appreciative vibes, because although this is a big moment, if I'm going to do the analysis right, I've got to be in the towel zone. So let's do our clip of Karen arriving. All right, towel friends, give it 1 second. Good morning, towel friends. My name is Grant Smith Ellis. It's a big moment in the John O'Keefe and Karen Reed retrial. 10 a.m., Judge Cannoni will render her decision as to whether Hank Brennan's expert, Dr. Judson Welcher, will be able to testify that a sideswipe collision was the cause of John O'Keefe's injuries. A sideswipe collision from Karen Reed's Lexus at exactly 12:32 a.m. 04 to 09 on 1/29/2022, just seconds before John O'Keefe stopped moving, his phone stopped moving for the last time on a cold lawn in a blizzard at 12:32 a.m. and 16 seconds. Ladies and gentlemen, let's watch Karen Reed's arrival at court. Will she be silent? Will she be stalwart? She is not a towel. I am a towel, though. Let us begin. The walk of a woman heading to the Titanic. For the Chip Hinden Reed, destined for collapse. Yeah, those sirens are what you deserve. Can't hear a word, just silence. Ladies and gentlemen, that is the walk of a doomed woman. Guilty woman walking. Oh, and Karen gets held up by court security and then allowed to go. Ladies and gentlemen, this is a weird moment. Looks like it's not time to go in. They got there a little bit early. That's awkward. Karen just standing around. I don't think we need to listen to the audio of the bird. Very quiet. Very quiet. Let's watch Karen Reed standing around with her lawyers chatting. Ladies and gentlemen, it doesn't look like they're letting them in right now. What a weird moment, ladies and gentlemen. What a weird moment. You can see Karen Reed standing there, a desolate figure, surrounded by only her lawyers, ladies and gentlemen. Surrounded by only her lawyers. Oh, goodness. The sirens do follow Karen Reed. An ominous, ominous entrance. And ladies and gentlemen, tune in the next few minutes, youtube.com/@GrantSmithEllis. You will be able to watch live coverage with the Karen Cam starting at 10 a.m. How will Judge Cannoni rule? Tune in. Find out. All right, little towels. Thank you so much for the opportunity to make that clip. I'm sure that part was actually in the end of the clip. This part might be in the end of the clip as well. Little towel is doing a lot. We are multitasking towels. We are being wonderful towels. We're being calm towels. So although some people appreciate horse racing announcer towel, we're going to give warnings when we do that, just in case people need to turn the volume down or want to catch the breath. And that is absolutely okay, ladies and gentlemen. That is absolutely okay. So let us jump forward a little bit. Oh no, it's going to be the fan, isn't it? Oh no. Ladies and gentlemen, I am so incredibly sorry. It is the fan. It is the fan. Ladies and gentlemen, we've just been decimated. Our hopes, our dreams for a better world, a fairer world, based on towels, camels, kangaroos, koalas, peacocks, and pandas, may not actually happen. We must watch the fan unless, ladies and gentlemen, Christina Towell herself, reporter Towell Christina, maybe, I'm not saying this is 100%, but maybe reporter Towell Christina, in her infinite wisdom, thought to herself one day, you know what my fellow towels would like? My fellow towels would appreciate the opportunity to see, oh no, hold on, little towels. Oh, ladies and gentlemen, that's why the Karen Cam is going live. We're going to the other stream. Okay, folks, we're going to set the Karen Cam up. You made it. You made it to the moment. Yeah, oh, I do need a fan replacement. I don't actually have an Xbox. I have an old PlayStation 3. That shows you how outdated Towel is with some of his technology. You all are like, oh, Towel knows what he's doing with these computers. I have a PS3 FAT version, PHAT, from 2008 or something that still works. I love everything about it. I use it religiously, not to always play games. I play like movies on it, but I do have some games I play on it. Ladies and gentlemen, I am an effective towel. Also, we are trying not to yell, even though this is a very big moment, because as we were talking about earlier, Towel does not want anyone to feel stressed. These are stressful moments, and I know some of you love horse racing announcer towel. I promise you, we may do occasional horse racing announcer towel mode, but we will let people know before we go into horse racing announcer towel mode. Okay, P. McKinley, I see you, dear friend. I will give a check. I will do that right now. We are getting things set up, folks. Look at this. There's, oh no, not the fan. You can't do that to us. I have a plan. Oh, ladies and gentlemen, it's Chewbacca and the Stay Puft Marshmallow Man. Oh, ladies and gentlemen. Oh, that is adorable. Oh my goodness, ladies and gentlemen, at the break, we have a picture of Chewbacca and a koala. Oh my God. I don't know if I can contain myself. It is the cutest thing I've ever seen in my entire life. All right, little towels, these are big moments here. These are big moments. We're about to come into session. How is Judge Cannoni going to rule? I think she's going to rule for Hank Brennan. Place your non-towel bets. Place your predictions. A prediction isn't a bet, ladies and gentlemen. How do you think? Oh, goodness, Chewbacca and Stay Puft Marshmallow Man in France. Oh, ladies and gentlemen, I just saw a post from Stacey Gardner. Stay Puft Marshmallow Man and Chewbacca in France. Oh, ladies and gentlemen. Oh, it's glorious. Oh, my goodness. Oh, my goodness, Stacey Gardner. That is just absolutely adorable. Oh, ladies and gentlemen, they're in France. How can you not love it, ladies and gentlemen? How can you not love it? Stacey Gardner, you are a special towel, dear friend. I think all the towel friends know it, and I just want to let you know that I know it as well. Oh, ladies and gentlemen, we're about to come into session. How is Judge Cannoni going to rule? Is Judge Cannoni going to rule for Hank Brennan as predicted by Towel? Is Towel going to continue to be a towel? Am I going to just continue to say things because I think they're hilarious? Absolutely. Are all of you towels? Yes, that's what makes us wonderful. We are supportive towels, and if you ask me to not to yell, I can even do that, ladies and gentlemen. Not because I think yelling isn't important, but because I want to make sure people feel comfortable here. We are a welcoming, wonderful towel fold. All right, so we are live on the stream, folks. We're going to turn this, we're going to turn the volume off. We're not going to pin the nub. We're going to turn the volume off. turn the volume on. Now, you listen, folks. When we come into session, you're going to hear it. All right, you're going to hear it. And Chewbacca and the Stay Puft Marshmallow Man are saving us from the fan. And you might say, sir, why do we have a Stay Puft Marshmallow Man and a Chewbacca who are covering the fan and seem to be very proud of themselves? Well, listen, if you manage to save viewers from having to look at the fan and get dizzy, and towel friends, wouldn't you also then be like, oh, we really appreciate our efforts? Yes. That is exactly why, ladies and gentlemen. Courtney Myers. Listen, Courtney Myers, I have a genius idea. Have you ever seen the film The Brave Little Toaster? Okay. Ange Whittick will tell you all about this. The Brave Little Towels. It won't be a sad movie. The air conditioner won't explode in the window. Well, ladies and gentlemen, we will make a movie called The Brave Little Towels. It will be a cartoon, and I will just travel to all the countries in the world, gathering towel friends on an adventure. Oh, my goodness, I got the plot of the book. Listen, Courtney Myers, we will make a movie and a cartoon. That it will be a movie, so we won't make a book. We'll make a movie, and it will be a cartoon about a brave little towel who travels around the world to meet his towel friends. And he has to collect people because they're on a journey to go to the different continents and get one animal from each continent. Okay? We got to get a kangaroo from Australia. We have to get a panda from China. We have to get a peacock from Europe. And then we have to, which is actually the subcontinent, but that's okay. We'll call it Europe. And then we have to get a camel from Africa and the Middle East. And then we have to get an elk from the Americas. And then we have to get penguins from Antarctica. Okay, and I think that covers all the continents. So if we just get a movie together about a brave little towel in cartoon form who goes around collecting animals for the purposes of a diplomatic mission to facilitate world peace and bring about the rise of a new digital-based epoch centered around the Aquarius the water bearer with a towel, I think it'll all work out. Courtney Myers, as you can see, I've thought a lot about this. Courtney Myers, Macy, yes, we need someone to go down to Maduro Station in Antarctica. So here's what you got to do. Macy, we need to put you on a plane and get you to Christchurch, New Zealand. Okay, that's going to be a bit of an effort to begin with. Then, once you're in Christchurch, you have to get on a military plane. It's a very special kind of plane. And you fly on the military plane, I think it's a C-130, to Maduro Station in Antarctica. Now, the problem is, I don't really know how you're going to... First of all, I don't think you can just take a penguin. You're going to have to negotiate with the penguin and ask it if it wants to come along on this diplomatic trip. Then, I don't know who owns Antarctica. I think it's owned by like 7 continents or different countries. You're going to have to talk to the people who own the land where you found the penguin, unless you found it in international penguin waters. And you're going to have to be like, okay, I'm taking this penguin. We are not breaking international law to get the penguin. Oh my goodness, the Karen Cam. We're about to come into session. Ladies and gentlemen, get ready. Here comes the ruling. Thank you for distracting me about that, penguins. I didn't yell. I'm sure holistic psychology is pleased. But seriously, it's not a joke. I don't want anyone to feel uncomfortable. So get ready. Get ready, little towels. Oh, nope, that's not the wrong one. I want Oh My Fan to go away. Well, I guess I don't want it to go away, but I just want us to come into session. Ladies and gentlemen, Oh My Towel. It is almost those moments. Yes, I will. Who wants to be in the movie? We can all volunteer. We could actually make a whole sustainable infrastructure. Ladies and gentlemen, if you want to be in a movie called The Brave Little Towels that is in cartoon form, I think you should raise your hand, and then we should all license our cartoon towel rights, and then we will have a movie, and people around the world will love the story of the little towels. And you can all be towelettes and washcloths and soap dispensers and flannels and hemp towels and beach towels and paper towels and microfiber towels and wet towels. Ladies and gentlemen, it is the perfect motif to bring about a new digital epic based on universal love, unconditional compassion, and small acts of service in the form of an anthropomorphic towel. Oh, ladies and gentlemen, I put it all together. This is my calling. I'm going to make a cartoon called The Brave Little Towels. Oh, it's wonderful. Courtney Myers, I think, is in. And then obviously Macy is in. If anyone wants to pick a continent, oh, I'm doing my best. You are. Listen, I'm doing my best, Allie 90211. It's not about being myself, though. It's like, Yelling, I get that the horse racing announcer motif is amazing, but just yelling into a stream, if it causes, like, maybe there are other people out there who would get, like, anxious from that. And anxiety is part of anticipation, but I don't want the tone of my voice to be why people are nervous. So that's very important feedback. I don't want anyone to think that I'm not being myself in fact, I'm being myself very true to myself by thinking about maybe not only the people who are saying, yelling is intense, but the people who might not be speaking. I like to think that one person saying something might be speaking for the voices of an untold number of people who can't or don't want to speak up for whatever reason. So that's why I think about that, little towels. Good. No, absolutely. No, and I understand it is not just, listen, I am not yelling, obviously, in an aggressive way. I'm not yelling because I'm mad at anyone. I'm doing it as a form of entertainment in the form of our educate, inform, and entertain ethos, the public information service principles I try to honor. And so using that entertainment as a hook to get people interested, engaged, and informed of a public discussion is what I like doing. But I'm not going to do that if it has an impact, because remember, yelling, even though I'm doing it in a playful way, can be taken by someone else as a reminder or a trigger, so I'm not going to do that. All right, folks, we're in session. Here we go.
All right. Good morning, everybody. All right, so Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied. In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application. However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe, because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling. All right, so the jurors are lining up. We should have them momentarily.
Thank you for the late call today.
Okay.
All right, so let's listen to that one more time, folks, because that was a big ruling. My name's
Is
Grant
Dr.
Smith Ellis.
Welcher right around?
Yes.
Why don't we bring him in if he's here before the jurors?
All right, one more time, folks. I'm going to listen to it one more time.
All right. Good morning, everybody. All right, so Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied. In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application. However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe, because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling.
Okay, folks, so what this means is that the expert can testify that Karen's car was involved in a collision, that John's injuries are consistent with a collision with a Lexus, exactly the make and model of Karen's car. It's just the expert can't say that Karen's Lexus collided with John's Lexus, with John's body. Do you understand? So it's the jury can draw an inference, the expert can't say it outright. So it's everything that Brendan wanted, except the way it will be phrased is Karen's Lexus was involved in a collision at the specific time. John's injuries are consistent with an impact, sideswipe impact, with a Lexus that's exactly the same make and model as Karen's, same plant produced, etc. And then that is the limit. So there you go. Brandon wins 85%. And then the only thing that can't be said is that Karen's Lexus collided with John that night. So there you go. It's saying it and allowing the jury to draw the inference. We're going to come live, folks. My name's Grant Smith Ellis. Tune in, youtube.com/@GrantSmithEllis. I'm here. We'll be monitoring. Court's going to come into session.
Justice have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. You may be seated.
All right, good morning again, counsel. Good morning again, Ms. Reed. Good morning, Dr. Welcher.
Good morning, Your Honor.
And good morning, jurors. I have to ask you those same three questions. Was everyone able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instruction and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their heads. Thank you very much. All right, Mr. Brennan.
Thank you, Your Honor. Morning, Dr. Welcher.
Good morning.
When we left off yesterday, I was asking you about some of your opinions. I'm going to ask you those questions again, but before we do, I'm going to ask you two other questions. The first is, I'd ask you to turn to your PowerPoint, slide 110.
You want me to display it?
Please. I'm going to ask you a question about a series of your slides regarding this effort. This is 110. Could you also follow through to 111, 12, 13, 14, 15?
You want me to play the videos?
You don't need to play the videos. I just want to acquaint you for the question.
111,
12,
112, 113, 115.
How many times did you engage in testing where your arm and forearm touched the rear right of the exemplar Lexus?
3 times.
In any of those 3 times, did it ever leave any paint on the underside of your arm or forearm?
No.
If you could turn to slide 130, please. What? There we go. Perhaps it's 131, Dr. Welcher. There we go. Could you explain the significance of this slide, please?
Your Honor, this is...
Oh, could you take that down, Dr. Welcher?
Sure. Mr. Brennan.
We're going to move forward. Yesterday, when we left off, I had asked you.
So we need to take this.
Sorry,
You can take the PowerPoint down, please.
that was in a different spot on this line. Hold on a second.
That's better.
Thank you. Sir, I had asked you yesterday about some of your opinions. I
Correct.
want to ask you about some of your opinions relative to that last effort that you made regarding testing between the Lexus and your arm.
Correct.
You had mentioned earlier on in your testimony that you reviewed a number of pieces of information and offered that you relied on some of those pieces for your opinion. Can you share with us, for this part of your analysis, what pieces of evidence or information did you rely on for the opinions I'm going to ask you?
Relative to the testing on the arm contact on the taillight?
Yes.
So it was the physical evidence at the scene, the photographs of Miss Reed's vehicle, to a certain extent, my analysis of the Ring doorbell and the One Meadows event, the nature and
Excuse me, Your Honor, pardon my interruption. I just want to know if he's reading from something or not reading.
Looks like he's counting on his fingers. Are you reading from something?
No, I am counting on my fingers.
Okay, thank you.
So I am counting on my fingers. The Ring video doorbell, Mr. O'Keefe's height, the type of shoes he's wearing, because I needed the same type of shoes, my exemplar inspection where I matched up the heights, and then the text stream data as well.
That information that you considered, in addition to the text stream data you considered, considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
So there's been two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles.
Based on the physical damage and your testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe.
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
In your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty, whether John O'Keefe's injuries on his arm, inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
Yes,
What's your opinion?
that it is. It is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
And does that specifically pertain to January 29, 2022 around 12:30 a.m.?
Objection, Your Honor.
I'm going to allow that.
Yes, it does.
To finish, I'd like to ask you a few more questions. You've written some papers on sideswipe collisions or clipping. Can you describe for the jury and explain what a sideswipe collision is or a clipping and how that may or may not differ from
Being contacts compared to, say, an inline impact or, say, a T-bone impact is what refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So, for example, if I rear end a car, that car will be accelerated up as a result of the contact, and they reach what's called common velocity, and then they separate. And so in a glancing hit, you can have a glancing hit and you don't have what's called complete momentum transfer, meaning the momentum from the car, because it's a glancing hit, doesn't completely transfer to the object being struck. For example, you can drive down the road at 100 miles an hour and clip the mirror of a parked car and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going because you don't have all that momentum transfer. So when you have glancing contacts, you can have much higher speeds without a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
You mentioned about potential damage to a car. How about potential damage to the pedestrian?
It's the same thing. So when you have a glancing hit to a pedestrian, this is referred to as a fender vault. In this case, they call it a fender. Fenders on the front of cars, because most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner of the car. Those are much more complicated because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted without a whole bunch of information in that type of crash. If the impact had occurred in the center of the vehicle and we knew where the point of impact was and the point of rest, we'd have a much better chance of determining how fast the vehicle was going. But when you have just a corner clipping or glancing, it makes it more difficult to determine, even when you have an area of impact, which is where the person was when they got hit, and a point of rest where they've landed, makes it more difficult for glancing contacts because you have that sideswipe problem where they don't obtain what's called common velocity.
And what are some of the other difficulties in attaining specificity in a sideswipe or being hit by a quarter panel as opposed to a fender?
So for a pedestrian, correct?
Yes.
So pedestrian impacts and how you move post-impact are very sensitive to your exact body position. For example, whether your right foot is on the ground or off the ground, whether your left foot is on the ground, off the ground, whether you jump up in response to the crash. Simply raising and lowering your arm changes the amount of rotation that's going to happen. Post-impact motion of the person. So cadavers, crash dummies don't have any muscle reaction. So the motion of a crash dummy will do additional activities that alters where they come to rest.
In your studies of direct pedestrian collisions by front or back bumper as opposed to sideswipe or clipping somebody, is there a similarity or difference in type of injuries that you see?
Yes.
And what is the difference?
So in direct centralized impacts, you tend to get much more severe injuries. Really what's occurring is you're getting that momentum transfer. So it's more, you're accelerating the person up to the vehicle. They can wrap onto the side in front of the vehicle at higher severities. Their head will hit the hood, their head will hit the rear of the vehicle. So when you have that direct contact, there's actually more momentum transferred to the actual occupant. There's more applied force to the occupant as well.
When you see direct impacts, is there ever the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the Accident Reconstruction Collision Safety Institute on pedestrian injuries, I went through all the literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures. It depended on how exactly the foot was loaded.
Is it uncommon in sideswipe pedestrian accidents to see no lower body broken bone?
No, it is not uncommon.
Have you had cases that you've studied or been involved with where you've studied the effect of a sideswipe or a clipping impact where there's an absence of broken bones in the lower body extremities?
Yes.
I'd ask you to turn to slide 139, please.
Oh, sorry. I fixed those other two slides.
Okay. Could you share with the jury what this represents?
Sure. So this was a trial that I was involved with in downtown Los Angeles. I've redacted the name at the top, but this was an instance where we had, this is a image from the police report. Well, let me see if I can. So AOI in this diagram stands for area of impact. That's where the pedestrian was when they got hit. AOR is area of rest. And you can see we have information on exactly how far the pedestrian was thrown. Then on the right-hand side, we have photographs showing the impact to the pedestrian. This was determined by experts on both sides of this case to be between a 25 to 35 mile an hour impact. And then what you see is a close-up on the bottom slide of where there was DNA transfers, hair and tissue samples on the vehicle from the individual that was hit by the vehicle.
Next slide, please. And what does this represent?
So this is the decedent in the case, the person that was hit. He was killed at the scene. What you see on the left-hand image, oops. On the left-hand image is he had a massive laceration to his right forearm, but it didn't break his arm. There was no broken bones in his arm. On the right-hand side of this image, you see the autopsy report. What you'll notice is he had red marks on his leg, left buttocks, but he had no leg fractures. And again, this individual was hit at between 25 to 35 miles an hour.
Can you expand that? I'm sorry.
Yes, yes, sure.
Do you want that expanded like other times?
There you go.
Thank you. I'm sorry to interrupt you.
Yeah, no, my pleasure, John. Thank you. So at the top, he had a severe brain injury, which again is the most common injury in pedestrian crashes. He did have fractures of the right 11th and 12th rib and a liver laceration. If you look at the extremities, it says right upper extremity. Again, that's from a shoulder to the end of the hand. Extremity wound with vascular injury, so no fractures. If you look where I was talking about the multiple abrasions, so when they're looking at the lower extremities, they're noting a number of red marks, but there was notably no fractures to the lower extremities.
Thank you. You can take that down, please.
Okay.
Dr. Welch, regarding your analysis of the data and the evidence in this case, do you have an opinion to a reasonable degree of engineering certainty whether the absence of lower body brakes to Mr. O'Keefe is consistent with the defendant's Lexus impacting in a sideswipe or a clipping Mr. O'Keefe?
Yes, you could definitely have this type of impact and not have anything beyond, say, red marks to the lower extremity.
Thank you, Dr. Welcher.
My
Your
pleasure.
Honor, I would move into evidence subject to redactions. Dr. Welcher's PowerPoint presentation.
That's by agreement, Mr. Wilson. With that
That is, Your
caveat.
Honor, thank you.
Put in both the flash drive and the notebook.
On representation, it's consistent with the same as that I am noted.
So let's put them both together now and decide later. Okay.
Those two slides are incorrect on the flash drive.
Yeah,
Okay, so we'll switch that.
that was
Thank you. Yes. What exhibit number is it? 206. Thank you.
Exhibits 206 A and B.
All right, Mr. Lessie, whenever you are ready.
Your Honor, if I could have a moment to set up.
Sure.
Oh, no, not Baba Leslie on cross. No, somebody save me, please. Oh, no. Oh, no. Baba Leslie, please tread lightly. This witness is going to rip you in half rhetorically. Oh, no. This is going to be brutal. Oh, Baba Leslie. Baba Leslie, you're going to be sacrificed to the cross-examination gods. You're not a bad person, but good luck, dear friend. Good luck.
Morning, Dr. Welcher.
Good morning. We haven't been formally introduced. Your whole name?
Robert Alessi, sir.
Robert Lessie. Nice to meet you.
Nice to meet you. Dr. Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct? Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in and giving scientific evidence in court applies to forensics. So my main job is action reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court. When it goes to court, that's generally forensics.
Right. So you're here today. That is my question. You're here today, at least in part, with regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of court or jury presentation. It's for law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics. It's in the court of law, I think is what you're asking.
That's exactly it.
Okay, yes, certainly for the court of law, yes.
It ends up to a court of law, and in forensics is a common term.
Yes, sir.
So it relates to, or it's used in, or it's suitable for a court of law, the analysis. You'd agree with that? It's a general principle?
Yes.
Not a trick question. Okay. And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in a criminal matter, correct?
Yeah, you're trying to apply as much as possible.
Right. And so the primary goal of forensic science is to uncover the truth and to provide objective evidence that can be presented in court.
That is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that truth and objective evidence is part of the presentation in terms of information for forensics in a court of law?
Certainly objective information. Truth sometimes, again, can be subjective.
Oh, so you don't believe truth? You believe sometimes truth applies and sometimes it doesn't?
If you know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's go to your direct examination that you just went through.
Please.
Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree of engineering certainty Is that correct?
Correct.
Have you used the word sometimes to a reasonable degree of scientific certainty?
I may have.
Right. So
I don't know.
in terms of your role as a biomechanical engineer and accident reconstructionist, is it important to engage in a critical analysis of the data?
Critical analysis? Yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand the goal is to try to look at it as objectively as possible, correct?
Correct.
Now, you stated with respect to your conclusions early on in your direct testimony and your analysis that you don't, and I think I've got it quoted, you don't have a dog in the fight. Is that what you said, sir?
I did.
And that you, quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning,
That
correct?
is 100% correct.
Now, you simply follow the data. Is that correct?
I try to do that.
You try to do that.
I'm not perfect. So
Okay.
I do my best. I believe I've done it here.
Okay. So, in terms of you've agreed that you apply the scientific method, so I want to see if you're in agreement generally so the jury can understand what the scientific method is. Are you familiar with NIST, National Institute?
Yes.
Yeah. So would you agree with this definition of the scientific method? The systematic pursuit of knowledge involving the recognition and definition of a problem, the collection of data through observation and experimentation, analysis of the data, the formulation, evaluation, and testing of hypotheses, and where possible, the selection of a final hypothesis. Is that a general fair statement of the scientific method?
So for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial, or things are in evidence. So frequently there's one or two versions, and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what I stated relative to NIST, you would agree that evaluation and testing of hypotheses, and where possible, the selection of a final hypothesis is the scientific method, correct?
Generally, yes.
Is it correct that a proper biomechanical injury analysis utilizes a sound scientific methodology that's been subjected to peer-reviewed and a publication that's been generally accepted in the engineering community?
Well, I can't. So this, I've done my analysis here, biomechanical analysis. I can't submit this analysis to peer review. I'm not allowed to give this to people outside the court. So there would be no way for me to submit my analysis for peer review. So this occurs forensics all the time. The forensic analysis in court generally never goes under a peer review process. The methodologies underneath it, and looking at, like, for example, I think I referenced 25 papers in my report. That goes to the issue of trying to follow the science. 26.
So I think you may have misunderstood my question, sir. I was talking about your methodology, your biomechanical injury methodology. The methodology that you use and apply is to be community. Is that correct?
So I have no way of publishing this analysis.
I'm sorry, sure,
to
to
get
interrupt
peer,
you.
I need to.
Go ahead and answer your question.
You're asked peer reviewed, like you said, means I give it to my peers. I send it out to somebody to review for the scientific method. That's what the peer review process is. So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
Sir, my question is not your analysis here in this case.
Oh.
My question regards the methodology that you used here. is the methodology, you said 26 references, right? My question is simply, is the methodology that you used for your analysis in this matter, is the methodology for a proper biomechanical analysis, should that methodology be generally accepted in the engineering community?
I think with the forensic application, yes.
Okay, that was my question, just the methodology. Thank you.
You're welcome.
Now, the scientific method that you've used in this case, part of the use of scientific method, the purpose is to avoid what is called bias in the scientific method, right? Not cultural bias, but just bias in terms of the application of methodologies and principles. You would agree that's a pretty fundamental purpose of the scientific method, is to avoid biases?
The purpose of the scientific method is to get the most logical and correct answer without bias.
Exactly. To do it apply the scientific method without bias being part of the application of the method, correct?
That's hopefully what you can do.
That's hopefully what you can do. That is the goal, right?
That is one of many goals, yes.
So, are you familiar with the term confirmation bias?
I am.
And that relates, confirmation bias is part of a larger term. Are you familiar with cognitive bias?
Generally, I'm not a human factors expert, though.
Pardon me?
I'm not a human factors expert.
All right, biases are, don't you agree that cognitive biases are not just for one category? You would agree it applies to medical analyses, it applies to doctors doing studies, engineers doing studies, and other scientists doing studies?
I'm not a cognitive expert. I think I would generally agree with it, but I don't want to step out of my lane. I'm not an expert on cognitive. I can talk to you about confirmational bias, if you like.
Let's talk about confirmation bias. Now, confirmation bias is actually when someone selectively gathers and interprets evidence to confirm one or another's beliefs, as well as neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that that is generally correct, what confirmation bias is. And an example of confirmation bias is not considering alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be, yes.
And confirmation bias is antithetical. It's against the scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
Are you familiar with the term failure analysis?
Generally, you might need to define how you're using it for me.
Sure. So, is failure analysis the enablement of a scientific examination of an alleged incident by beginning at the undesired consequences? Is that a fair use of that phrase?
I was thinking something different, like a piece of metal failing. I guess it could fall into that category.
Okay. And would you agree that the first question, or one of the first questions that are to be asked by a biomechanical engineer when conducting an analysis of, say, an injury, is how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you...
So hold on a second.
Okay,
generally what you want to do is gather data. You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or define is, given all that information, how did it happen? So that's the end.
I think you may have misunderstood my question. So I wasn't talking about the method or the process. I was talking about when you get to answering questions, whenever that is in the process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. One of the first questions is, where's the damage? What are the injuries? What's the evidence? What black box or text stream data do we have? What physical evidence was at the scene? So that is certainly not one. It is a question, but that question is at or near the end.
Isn't every one of the questions that you just mentioned part of the data gathering?
Correct, but,
Okay.
but when you're gathering data, you're always asking yourself questions along the way, like, what is this? Where did it come from?
But you would agree that for you at least some point, it's how did this happen, correct?
Yes.
And don't you ask that question to come up with hypotheses?
I generally have many working hypotheses as I'm working on the case, and then as the evidence comes in, I'm applying that to my hypotheses and either accepting or rejecting the hypotheses based upon the factual information.
Sir, how then is it just a matter of logic or a syllogism? If you don't ask the question, how did this happen, until the end, how do you then not get your hypotheses up front when, under the scientific method, you should be having different hypotheses up front? How is it that you ask the how did it happen at the end and not go through hypotheses in the beginning? Can you help me with that logic?
Sure, I guess I misunderstood. Like, I was trying to give you an answer to how it happened. So when you're answering how it happened, or you want to be able to answer that question, you want to make sure you've looked at the totality of the data, accepted, rejected, things as they came along, to be able to answer that final question, how did it happen? But along the way, like for example, a right eye laceration, you want to know how that happened. So you look for the evidence of how that may have happened.
So you would agree then that questions of how it happened, formulating and identifying hypotheses, does and can happen toward the beginning of the analysis. It doesn't happen at the end all the time. Would you agree with that?
So the ultimate question of how did it happen happens at the end. The questions about the elements of what occurred to make it happen, those occur at the beginning, middle, all along the way.
You would agree that creating hypotheses occurs more toward the beginning than toward the end of the analysis. Is that correct?
There are probably more hypotheses in the beginning, but I am continually forming, looking at hypotheses, either accepting or rejecting them upon the evidence.
So you would agree that the creation of hypotheses does occur more toward the beginning of the analysis. You would agree with that?
There are more towards the beginning. The process occurs throughout the whole investigation.
Right. I'm asking about the hypotheses, sir. You would agree that the hypotheses occur more toward the beginning than the end, just the hypotheses.
So I don't know if you and I are saying different things. More hypotheses in the beginning because you have more questions in the beginning. You continue to form hypotheses as the data presents itself, so you don't stop the formation of hypotheses. It's just as you get more evidence, you window down the number of questions.
Maybe I can, just this last question, and make it clearer for you, sir. You would agree, not analysis, which you added, as I heard it to the last part, just hypotheses. Mm-hmm. You would agree that even though hypotheses can be created and changed perhaps all the way up to the end, mm-hmm. you would agree that it's important in the analysis to create at least some hypotheses, plural, in the beginning, correct?
Yes.
And once you create these hypotheses, would you agree that those hypotheses should be tested?
So if you take the word testing to mean testing compared to testimony, compared to physical evidence, yes.
And when you test those hypotheses, isn't it often the case that, particularly in your line of work, the one that most consistently produces the same injury will emerge as the mechanism of injury?
I guess it depends on the scientific evidence behind it. Again, sometimes we get very unique injuries.
So my question, sir, is this. Isn't it the case that when you have multiple hypotheses, the one that most, out of all of them, it's a relative thing, the one that most consistently produces the same injury emerges as the mechanism of injury? Is that a fair statement?
I think generally, again, it's on a case-by-case basis. You have to look at the science and the facts of what you're basing it upon. I think as a general premise, what you're saying is accurate.
Okay,
but there's exceptions.
Fair enough. But as a general principle,
Sure.
with some exceptions, that's a fair statement, correct?
Yes, sir.
We're going to have several topics, sir, and what I'm going to try to do to make it a little clear is I'm going to say when I'm switching topics.
Oh, good.
So what I'd like to do now is switch topics.
Okay.
You're aware that the Massachusetts State Police has troopers who specialize in accident reconstruction, correct?
Yes.
And there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section who engage in accident reconstruction?
Just based on what I've seen in this case.
Right, based upon what you've seen in the case, that's a fair statement.
And I just know that those people are doing it.
Are you familiar with a Massachusetts state trooper named Joseph Paul, P-A-U-L?
Yes.
And you
Well,
know...
I'm familiar with his reports. I don't know the man.
Okay, familiar with Trooper Paul through his reports in this case, correct?
Correct.
And are you aware that he was assigned by lead investigator, former Trooper Michael Proctor, to be a constructionist in this case on January 29th of 2022, as evidenced by that report or those reports of Trooper Paul? Do you know that?
Well, you put a lot of things in there. I know he issued a reconstruction report. I don't know who told him to do it. So the first part of your question, I don't know, but I did see a reconstruction report from him.
You were retained, and so do you recall, is it the date, January 29th of 2022, is that a rough time period of him being assigned, or you don't know when he was assigned?
Don't know. That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
Do you know when, the date of the first report of Trooper Joseph Paul in this case?
I can pull it up. I do not know off the top of my head.
You know that the date of the incident in question is January 29th, 2022, correct?
Correct.
Yet your firm and you were retained for this case by the Commonwealth 2.5 years after the incident in question. You were retained, your firm, on September 23rd, 2024. Is that correct, sir?
No, I believe we were retained a couple days before that.
A couple days. Okay.
Right.
So...
Actually, I might be able to find out if you'd like me to look at the documents.
It's not all that important. You would say it's within a week of September 23rd, 2000. It was in September of 2024?
I believe it was in September, yes.
Right.
I would want to double check.
That's 2.5 years
from the date of the incident in question, if I did the math right, correct?
No, I never thought about it. Yeah, approximately.
And as we just discussed, and you stated on your direct examination, you have no dog in this fight, correct?
Correct.
On November 5th of 2024, your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office to conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea. I don't get the billing or the statements.
Do you recall whether Aperture has, well, do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that. No,
So
we're an engineering company. We bill for our time.
So you know that Aperture is getting paid for its work in this case, correct?
We are billing for our analysis work.
Well, you're not just billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume that we're getting paid, but I don't know that.
Sir, you are a senior vice president of Aperture, are you not?
I am.
You would know, wouldn't you, if your firm was not getting paid for work since September 23rd of 2024, wouldn't you?
No, probably not. Usually it takes, 9, 10, 12 months of not getting paid before the accounting department reaches out to me.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just go right to the bill. You, as you sit here today, do not have a recollection of whether Aperture has been paid. Is that your testimony?
It has nothing to do with recollection. I'm not part of that process. We have an accounting department. I don't have any involvement in that.
So is your testimony you have no knowledge about any contractual relationship between Aperture and the Commonwealth?
Oh, no. I was sent a contract by the Commonwealth to sign, so I'm aware of the contractual agreement, but the day-to-day or month-to-month invoicing and billing, I'm not involved in that.
Okay. So you're aware there's a contract between Aperture and the Commonwealth.
I signed it.
And you signed it. And wasn't that contract obligating the Commonwealth to pay for the services of Aperture? Isn't that the purpose of the contract, in part?
In part, sure.
Yeah, it's a legal obligation of the Commonwealth. Your firm does work, and the Commonwealth pays for it, correct?
That's the idea.
Right, and so you know about that contract because you signed it.
Correct.
Also, you testified on direct that there was a purchase of a Lexus exemplar for your testing.
Correct.
Who pays for that Lexus exemplar?
Aperture.
And is that then cost passed on to the Commonwealth?
No.
So you pay for the Lexus, you don't pass that cost on, correct?
So what we're doing is we paid for the Lexus, we're keeping it till the trial's over, we're selling it and charging the Commonwealth the difference in the price.
Exactly. That was where I was going, sir.
But they're only paying the difference. So, and in theory, if we sell it for more in California, then we'll reduce the bill.
Okay, I don't want to speculate. I just wanted to see what the obligation was. So
the obligation is the difference.
Exactly. So the obligation is the difference. Are you aware that on April 5th, 2025, the Norfolk County District Attorney's Office amended your contract. Are you aware of that, sir?
I am.
And isn't it the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
So the Commonwealth is obligated to pay at least $325,000, and is that correct?
That is you're asking me a legal opinion now about a contract. That is my understanding of how contracts work, but I'm certainly not an attorney.
And on top of that, are you aware that Aperture has been already paid $44,510 for its work? Are you aware of that?
The second time you asked me, no. I'm not aware of anything we've been paid.
And as you stated yourself, those amounts reflect, as you say, less than 6 months worth of work?
That's not what I said.
Well, no, my question is, you've been on the case, you said, since September of 2024, when we were talking about dates. You said that was about 6 months that your firm's been retained. Did I have your answer correct about how long you've been on it?
I guess it's closer to 8 months.
All right, so 8 months. So for 8 months of work, about $400,000. Is that correct?
So there's 3 offices working on the case. There's the Boston office, there's Mr. Burgess's office, and there's my office in Long Beach. I only know about the billing from my office.
But you signed the contract on behalf of all of Aperture, not just your office, correct?
That I don't know, but I definitely did sign a contract.
Would it refresh your recollection as to who you signed the contract on behalf of, whether it's all of Aperture in all offices, if I showed you the contract?
Sure.
May I approach you on it?
Yes.
May I approach you?
Yes.
Thank you. Sir,
could you direct me so we're not wasting time?
Well, what I'd like to do, with the witness, Your Honor, is just ask the witness a question with regard to it.
Why don't you just take a look at that, Dr. Burgess?
Thank you, Your Honor.
And then when he's done, Mr. Leslie, you can take it back to the podium.
Yes, Your Honor. Thank you.
There you go.
Can I have a few more questions before I do that, Your Honor, for foundation purposes, if I want to do more than refresh?
All right.
Or would you like me to start with refresh?
Go ahead and start with refresh. Go back to the podium, please.
Sure.
Thank you.
Thank you, Your Honor.
Dr. Welcher, does that refresh your recollection as to the contract you signed on behalf of Aperture with the Commonwealth?
So it lists the legal address as my office. So for my office, yes.
So you've been on this for 2. So are you saying that therefore, and did you see the amount that was in the contract? Did that refresh your recollection?
Oh, no, I didn't even look at that.
Do you recall the amount that of obligation?
I'm taking what you said to be true. So I was like $325,000. I have no reason to disbelieve that.
And is there also a total, do you recall the total maximum obligation for the contract that's listed in the contract? You
No.
recall it? May I approach, Your Honor?
Okay.
And Dr. Welcher, I am now going to, you asked me last time, I hope this is helpful.
Please.
You said please point to the applicable part so we can do it faster. I am now pointing to that part and see if you can just look at that and see whether this refreshes your recollection on the maximum obligation of the contract pursuant to this contract. Without saying what it is, just does it refresh your recollection?
No, but I don't have any reason to believe it's not correct. And that is my signature on it.
Right. And we got started on this conversation tying it to, well, we got started on this conversation with regard to a statement you made earlier in your direct that you didn't have any dog in the hunt. You recall that statement in the beginning of your direct testimony.
You misquoted me. I don't have any dog in the fight.
You don't have any dog in the fight.
Correct.
Thank you. Now, switching topics.
Okay.
You submitted an updated PowerPoint presentation, the one that you went over on your direct examination. You created that presentation quite recently, correct, sir?
The updated one was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
Okay, my question, sir, is this. The updated presentation, we'll get to the changes later, but the updated presentation, you created just how many days ago?
I'm going to say weeks ago.
Weeks? 2 weeks?
I don't actually know without looking at the documents.
Well, was it more than 3 weeks ago that you created it?
I still don't know without looking at the documents.
Do you know when the trial started in this matter, sir?
I do not.
Assume the trial started approximately April 22nd of 2024.
Okay.
Did you create your updated presentation before or after April 22nd of 2024?
I don't know.
Do you know when...
Hold on one second. Dr. Welch, I'd ask that you not do...
Not look at... Okay, I was going to try and answer his question. My apologies. I will shut it down.
Thank you.
You're welcome.
If I may, Your Honor,
Yes.
continue. Are you able to determine when you created the updated presentation?
I think so. That's what I was attempting to
Your
do.
Honor, may he do that?
Yes. I'm going to see counsel at sidebar while you pull that up,
Thank you,
please.
Your Honor.
Now, hello, my name is Grant Smith Ellis. We have a sidebar. Ladies and gentlemen, we have a sidebar. I repeat, there is a sidebar going on in the John O'Keefe and Karen Reed trial. Bob Alessi literally got the date wrong when Hank Brennan's expert testified as to the start of his work on the case. Alessi was so confident. The quote was, "So you've been on this case for 2.5 years. So it would take 9 months or 12 months if you weren't getting paid. You have been notified of that by now, correct? According to your own answer you just gave." The witness was like, "I haven't been on the case for 2.5 years. I've been on it since September of 2023. What are you talking about, Bob Alessi?" Oh my goodness, it was glorious. Glorious, ladies and gentlemen. Glorious, I tell you. My name is Grant Smith Ellis, and it was a glorious moment. A sidebar after a glorious moment. You can hear the sheep in my vocal cords, ladies and gentlemen. It was a glorious moment as we go into a sidebar. Oh, goodness. Ladies and gentlemen, the sheep emojis must flood the chat for the sidebar. We all enjoy a good old-fashioned sidebar. Ladies and gentlemen, I tell you there's nothing better than a sidebar, especially when you're with Little Towel and there's a picture of Chloe the dog in a wig at the defense table. The sidebar should be coming to a conclusion any second here now, ladies and gentlemen. My name is Grant Smith Towel Ellis. I am a towel. I am also a horse racing announcer towel, and we love all little towels. We embrace all little towels, and we love sidebars. Also, one of our unofficial mascots is definitely going to be Bella the cat. Oh, yes, ladies and gentlemen, we should be returning to session any second now. Take it away, Mr. Bobalesi. You confused man. You confused man. Good luck against this expert PhD
what I'm
witness.
going to ask you to do is get whatever information you need for Mr. Alessi's last question. Mr. Alessi, I need you over there. So, and once you get that answer, I'm going to ask you to shut your computer down, or at least put down the cover.
How about it?
Thank you. All right, so you can answer Mr. Alessi's question.
Thank you, Your Honor.
Could you give me the question again, please?
Yes. When did you create the updated presentation that you reviewed in your direct testimony?
So that addition I made was taken out. It wasn't in my direct testimony.
If you can just hear my question, it's this. The version of the presentation that you put on the screen, when did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday when the judge asked me to take off some of the headers. So yesterday.
Okay, good. Now, the version before that you created yesterday, when did you create that version?
The day before.
And then the version before that one, when did you create that?
I mean, I save it every day.
Understood.
So every day.
So you've changed the presentation every day since when?
No, I don't think I've changed the presentation every day.
That's my question. My question is, how many times have you changed it within the last 2 weeks, your presentation?
Let me try and cut to the chase here.
Sure.
That slide was added on May 13th, and then it was taken out before I presented it here. So it was not in my presentation here.
Right. So thank you for that answer. So
You're
here's
welcome.
the question. Your first version, as I understand it, of the slide presentation was January 30th, 2025. Is that correct?
Correct.
When was the next time after January 30th, 2025 that you changed that presentation?
May 13th.
Assuming the trial started April 22nd of 2025, you changed your PowerPoint presentation during this trial, correct?
Correct.
And how many times did you change your presentation after April 22nd of 2025?
Well, the last time I changed it was like 10 minutes ago. So in response to various discussions, I've been making continuous changes to it.
I want to make sure you finish your answer so I didn't interrupt you.
I'm not sure how much granularity you want to that answer.
Great. So you created on January 30th, 2025. You made your
13th.
Pardon me?
Oh, the original one. Sorry,
Yeah.
January 30th, modified May 13th.
Right. If I could finish my question, and I might be able to shortcut this. Thank you. So you created the original one on January 30th, 2025. You made your first amendment May 13th of 2025. And then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
That is correct. I was here yesterday.
Days get foggy when we're in a courtroom, but it was yesterday. How many times had you changed your presentation from January 30th, 2025 until when you first walked in the courthouse yesterday?
Do you mind if I count?
Not at all.
So there was the May 13th change. Half of that was in response to objections from the defense. I had to add all the paths to where everything was. Then when I got out here, Mr. Brandon asked me to take out references to evidence about statements that I was not allowed to present. So that would have been within the last 3 days. And then I've modified it a couple times today based on rulings from the judge.
Okay, let's break that down. You said half of the changes you made on May 13th related to what? Because I want to know about the other half. that
Sure,
you
there was
didn't
two
state.
changes. I added the extra path of 138, and then I was told that the defense was having problems with my PowerPoint, so I had to go in and add the paths to every single slide about where the evidence came from, because they were saying I didn't provide everything, and I had provided everything.
All right. So
That was the second half.
got it. I want to go to the first half, sir.
Sure.
And I'm going to try to shortcut this.
Please.
And if I'm not clear, you just let me know. I want to talk about the first half. You called it, I didn't hear it. It was like, did you say path?
Path.
P-A-T-H?
Correct. The path Miss Reed was driving.
Right. What you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
It was based upon her statements. Is she part of the defense?
All right, so that's what I wanted to get to. You changed the first half based upon statements you allege that Ms. Reed made. Is that correct?
It's because I changed one slide. There was 130 slides originally, or something like that. So half of the changes on that day, which was one slide, I added one line to them of the previous. No.
Well, then why did you make it in the middle of trial if it wasn't significant? Why didn't you just leave it off and then discuss it in terms of testimony?
So, A, it ultimately was left off. B, because it was insignificant and I didn't need to have it. So the way it got presented was exactly the way it was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible. So when I saw the path that I gave, the way she could drive, I gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
So you were striving. The clip that you used to make the change, you say you made the change based upon a clip you observed with regard to Miss Reed. Is that correct?
I believe that, yes, that is correct.
Do you know that clip has been in existence for months?
I don't believe I got it until April.
So a clip that has been, assume the clip's been in existence for months. You just got the clip.
Dr. Welch, I have to ask you not to
sorry.
refer to
I'm
that.
trying to be helpful.
Close your
Yeah,
computer.
let me close it. Sorry. I was trying to answer his question.
So I'm going to ask you to close the top.
Yeah, that's probably a good idea.
Just flat down. Thank you.
Thank you, Your Honor. So assume the clip that you said was the basis for changing your PowerPoint on May 13th after the trial started had been in existence for months. You just got that clip, you say, in April?
I believe so, yes.
What was tell me the circumstances by which you got the clip. Did you ask for it?
I was told there was a new interview.
Okay. Who initiated the conversation about the new interview?
I don't know if it was Mr. Brannon.
It was someone associated with the prosecution?
Yes, I wouldn't have known about it.
Exactly. So somebody affirmatively communicated with you when about this clip?
I need to look, but I remember it being about mid-April,
Mid-April.
if I'm thinking of the correct clip.
What were you asked to do, if anything, with regard to that clip?
When I got the clip, I wasn't asked to do anything.
What did you do with the clip once you got it?
So they then indicated there was this suggestion of an alternative route. So then I looked at the alternative route description and added the alternative route.
So it was suggested to you by the prosecution that you look at the clip and they pointed out that there was an alternative route they wanted you to look at?
So I took it to be, we have additional evidence. Please look at the additional evidence and add it to your analysis.
On the topic of additional analysis by Aperture, while this trial is going on, are you aware of Mr. Burgess submitting a report dated May 8th of 2025 in this case?
Yes, I received that report on May 8th.
Right, and so you were aware of the creation of that report on May 8th because you got a copy of it, right?
Correct.
Were you aware that Mr. Burgess was intending to submit that May 8th report to the Commonwealth?
Yes, we had a discussion before that he had found new information that changed the timing.
Oh, he had found new information. What is your basis for saying he found new information as opposed to the information always existed, it's just it was pointed out to him that should be looked at? What's the basis of your understanding that he found new information?
Objection to the question.
I'm going to allow the question, but you have to ask it differently.
I will, Your Honor. Thank you. What is the basis for the statement you made that Mr. Burgess found new information?
I guess it was his meeting in our discussions. He indicated that he had found new information.
Did you ask him, what do you mean by new?
No, I took it at what it said.
So do you, as you sit here today, have any basis to say that that information is new as opposed to it's always been in existence?
Yes.
What is that?
What he told me.
Oh, so you relied upon the representation of Mr. Burgess. You didn't have any independent document to determine whether, in fact, it was new.
I don't quite frankly care whether it's new or not. I just care what's in the data. Whether it's new, old, I don't care. It's not relevant to what I'm doing. I don't say this is new data, this is old data. I just care what the data is.
Sir, has Aperture ever submitted a report, a changed report in the middle of a trial to your knowledge?
I have no idea.
Do you know whether Aperture has ever submitted an amended report in the middle of a trial? You said you testified in federal and state courts. Can you recall one instance where Aperture has submitted an amended report in the middle of a trial?
So Aperture is like 290 people. I can only speak for myself. I have certainly done amended analysis. Only certain courts and certain legal systems require reports. But for example, rebuttal, analyzing testimony that comes up in court, getting trial transcripts. I very frequently have come up with new analysis during the trial.
Sir, my question is, as you sit here now, can you state one court case where you or Aperture has submitted an amended report in the middle of a trial?
I cannot speak for Aperture. I can only speak for myself.
Can you answer? Oh, speak for yourself, sir. Can you then, for yourself, recall any instance where you submitted an amended report in the middle of a trial?
Amended reports? No. Amended analysis? Yes.
Thank you.
You're welcome.
Mr. Alessi, is this a good time for a break or 5 more minutes?
It's a good time, Your Honor.
Okay. All right, folks, why don't we take 5 minutes recess again? Dr. Wilkie.
Oh, towel friends. Hold on. Hello, towel friends. How long did she say for recess? Oh, Courtney Myers launched a membership parade. Ladies and gentlemen, Courtney Myers launched a membership parade. Congratulations to DJ, House Long, Jubbs, Natalie B. and Mira Hardy. You all now have unlocked access thanks to the Super Towel herself. Courtney Myers, ladies and gentlemen, you have unlocked access to Super Towel emojis. Thank you so much, Courtney Myers. And look at that, ladies and gentlemen. Towel was like, oh, I'll go to get lunch. Nope. Nope, ladies and gentlemen, we are on recess and cross. My name is Grant Smith Ellis. Of course, come tune in. We will be back from recess very shortly, 5 to 10 minutes. It's just a morning recess. We will go until 1 p.m. Towel's going to wait to get his lunch for a little bit. You know why, ladies and gentlemen? Because I am committed to you, little towels. I will not just abandon the little towels. Absolutely not, ladies and gentlemen. Oh, God bless you, person with the name A, first letter A. God bless you. Oh, my goodness, we have another membership parade. Courtney Myers is just on a membership parade roll. LA Connection, Forensic RN, Beach Nance. I go by Stefio, Patricia Allman, Melanie, Carol C, Sunny T, Elway Boughton, Cy, and Lazy Susan. Congratulations, you also have unlocked access to exclusive towel emojis thanks to the wonderful super towel themselves, Courtney Myers. Oh, ladies and gentlemen, my name is Grant Smith Ellis. We all owe Courtney Myers an extended debt of gratitude for being a super towel. Not only is Courtney Myers supporting the channel, Courtney Myers has gifted out so many memberships. You all can make it rain towel emojis for the next however many long minutes because you all unlock them at the same time. Oh, ladies and gentlemen, it is a membership train of love from Courtney Myers. God bless the super towel, and God bless the person who just sent towel lunch money. Listen, I think I got a plan. I don't think I should actually leave, because if I go drive around, then I might miss something, and I don't want to have you here without on break without me. So I think what we'll do is I might be able to get lunch. I'm only doing it if I have a coupon. I kind of don't want to, but we'll figure it out. Maybe I should get up to go for a little walk. Hold on, ladies and gentlemen. Little Towel is here with you. We are paying close attention. We're waiting for court to come back into session. Oh, I will call you Steph for short. I go by Steph. Yo, I love it, Steph. I will absolutely do it. Okay, little towels, I will get food brought here so I can stay with you. I don't want to miss any breaks. Look at me, little towels. I'm in a sweatshirt. I'm in a cool environment trying to keep the computer doing what we need it to do. Computers and towels like it to be cold. If I could live in 62-degree weather year-round with a fan on me, I would be happy, little towels. But yes, ladies and gentlemen, let us extend a special towel, a note of appreciation. It rained memberships, ladies and gentlemen. We have towel emojis flooding the chat. Let's figure out how long we're on break for, ladies and gentlemen. Oh, it is just a towel day of love, ladies and gentlemen. Love, compassion, solace, gratitude, and towel friends. What more could you want when you're listening to a Bob Alessi cross? And of course, the super towel Val herself is here. Oh, Courtney Myers, we know, but part of our ethos is every time we get an opportunity, whether a towel friend had a moment at the beach with their service dog, whether a towel like Alana, whether a towel friend donated 200 tomato plants to their friend and had the tomato plants become honorary towels like Francis Futrell, we look for the opportunity to highlight small acts of service and compassion, not because it is an ego-driven exercise for the person who engaged in that compassion, but because it's a reflection of the wider ethos, the wider principles that this public information service stands for, with 1, educating, 2, informing, and 3, entertaining the public, while at the same time demonstrating a moral fiber, a interwoven towel fabric that is defined by small acts of service, unconditional love, and universal compassion. And that, Courtney Myers, the principle that you embody is what makes your summum bonum or your eudaimonia, the ancient Greek word for greatest good, the Latin word for greatest good, respectively, in backwards order. That is what makes you so special, Courtney Myers. It is the principle. And ladies and gentlemen, yes, it's not just that the act of service helps fellow towel friends, helps the channel, it's that it inspires other people. And it's not just about supporting this channel. Look for reasons to bring about these moments in your lives, little towel friends, as we're on a morning recess from court. Look for reasons to bring about these moments. You can do it. You can do it in your own lives. You can be that person for someone who might feel that there is no one who will step up for them. If I or this stream or any of the towel friends inspire you to do even one act of kindness in a way that changes a person's life for the better, then this stream has lived up to its purpose, I tell you, ladies and gentlemen. And I also tell you I'm more interesting in 5 minutes than Bob Alessi has been over the last 25 minutes or half an hour. Why? Because I am a towel, and I think think this is a wonderful place. Oh, Crime Cricket, I extend you a big towel hug. If you were right here, I would be like, hello, Crime Cricket, give me a towel hug. Look at all the towel friends in the chat, ladies and gentlemen. Now let's figure out how long this break is going to be. How about that? Hold on.
Time for a break or 5 more minutes?
It's a good time, Your Honor.
Okay. All right, folks, why don't we take our morning recess? Again, Dr. Wilkie,
Great.
Did anyone find out how long the morning recess is going to be? She didn't actually say it. She was just like, we're going to recess. The Judge Canone, come on now. Oh, goodness, I'm in a sweatshirt. It's getting warm out there. It's almost 80 degrees. Even an air conditioner can't keep little towel cold. Oh, goodness. Oh, ladies and gentlemen, I am sweating. I'm getting warm. I need to get my lunch. We can have a joint towel lunch ordering adventure. Let's see if I can Let's see. Yeah, Judge didn't exactly say the time. But you know what, ladies and gentlemen? I could talk for the next 6 hours. Oh, you know what we can also do? We are not going to sit there and watch the fan. Super Towel Courtney Myers has gifted memberships. And then we, of course, know that Reporter Towel Christina herself, ladies and gentlemen, Reporter Towel Christina herself has gifted us, blessed us, ladies and gentlemen, with this incredible, absolutely stunning picture of Chewbacca and the Stay Puft Marshmallow Man. Oh, ladies and gentlemen, now listen. I also have some news for you all during the break. We have an absolutely incredible report. It has to do with Chewbacca and the Stay Puft Marshmallow Man. Try not to get too excited. I'm not going to order my lunch before I do this because it would be sacrilege. Not really, but it is the greatest thing I've ever seen in my entire life. Now, ladies and gentlemen, you may be saying to yourself, Grant, did someone on the ground, the Reporter Towel Extraordinaire themselves, and I only have their Twitter name, so I want to make sure that we associate with them with their new YouTube name. So when you see this picture go up on the stream, Reporter Towel yourself, you come up forward and you come on and you let us know. Oh, my general cheerfulness and kind attitude has been really nice. Karen retrial might be kind of miserable, but I am not. Thank you, Steph. You're a super towel. I'm glad I can bring cheer to your day. That makes me so happy. And also seeing Chewbacca and the Stay Puft Marshmallow Man thrilled that they stopped the fan from spinning also makes me happy. Now, ladies and gentlemen, yes, definitely listen to Crime Cricket. Did you know you can support this stream? It costs absolutely nothing. All you have to do is click the like button, click the subscribe button if you haven't. Consider sharing the stream with your friends, letting your family know. We have towels in every country around the world. That's a little bit of an exaggeration. It's actually like 78 of 148 or whatever it is. But ladies and gentlemen, South Africa. Hello, how are you, South Africa? Germany, we see you, Germany. God bless you, Germany. Towels are with you. France, of course, the French towels. God bless you. The Italian towels, friends. Don't forget about them. The Slovenian towels. Ladies and gentlemen, we love Slovenia on Towel Stream. We love Croatia. Hello, Croatia. I've always wanted to go to Split. Bosnia and Herzegovina. We know you are there. We see you, towel friends. Singapore. We know you're watching. Malaysia. Ladies and gentlemen, the United States. Towels home. Towel waves the flag proudly. We love people from all countries. Not necessarily their governments. I am not a communist. We do not necessarily like communist governments. But ladies and gentlemen, we are a united towel front. Zimbabwe has been watching, ladies and gentlemen. Egypt is on the list. Oh, ladies and gentlemen, India. Hello to our friends in India. You are appreciated, little towels. And let me just tell you, ladies and gentlemen, Chewbacca, I think Chewbacca has found his true calling. Oh, ladies and gentlemen, look at this. Look at this. Chewbacca has found peace in his lawyer suit with a koala. Oh, ladies and gentlemen, he was a tormented soul. Oh, he was a tormented soul. And look at this, Chewbacca and his koala. I know, ladies and gentlemen, the koala feels safe. Chewy feels safe. P. McKinley, yes, this is you, folks. Please say thank you to Reporter Towel P. McKinley. They have shared with us this beautiful image, ladies and gentlemen. All right, Derek, get out of here. We don't need any of that nonsense. Goodbye, Derek. You didn't last very long in the towel stream. Ladies and gentlemen, look at this Chewbacca and the koala. That is the most adorable thing I have ever seen in my entire life. Oh my goodness. Ladies and gentlemen, would you rather watch a spinning fan or would you rather look at Chewbacca? A literally reporter towel, P. McKinley themselves found this exclusive image with David Yanetti's spaghetti on the table, by the way, of Chewbacca having found his summum bonum, his peace on earth in the arms of a koala. Did you ever think about it? It truly is the case. Chewbacca, who's actually Chloe the dog in a wig, has found their solace, and it was a Chewbacca-based spaghetti meal with a koala. Yes, ladies and gentlemen. By the way, there are literally so many people. It's a blue wall in this chat. However, no matter what you do, you're up against like hundreds of people. They're not going to be tolerant with you. We respect all sides of this case and all political views, etc., all different worldviews, cultures, people from different areas, etc., etc. But what we don't tolerate is 1, no being derogatory, 2, no being discriminatory, and 3, no sea lioning. If you don't know what sea lioning is, our blue wall of towel friends are very, very good and adept at picking up on what sea lioning is. It's when you try to engage in the chat in bad faith. We don't like it. We are towel-based diplomats here, and you can disagree without being disagreeable. Now, you may ostensibly on the surface be disagreeing in good faith, but if the towel friends come to feel, especially there are some of you who actually can remove other honorary towels, if they feel you're acting in bad faith, I promise you, whether it's Def Otter or Murder by Maestro or Jew Drops, there are people who know the ethos of this chat very well. They won't put up with it, and it's pointless to even bother because there are more of them than there are of you. Oh, ladies and gentlemen, we should be back into court any session now, any minute now. Here it's coming up on 11:40 a.m. on May 28th. Bob Alessi absolutely crashed and burned during his cross. Do you want to see the best moment of that cross, ladies and gentlemen? I know I don't want to take the koala and the panda off the screen, but, well, it's actually not a panda. It's a koala and a Chewbacca. I absolutely just misspecied Chewbacca as a panda. I am incredibly sorry. Chewbacca, you are not a panda. Please do not be offended. I still love you, Chewie. You are not a panda. You are clearly a 7-foot-tall Wookiee who lives on the planet Ewok. Yes, absolutely. It's very easy to pick out chat. Trolls in the chat, we love you. Deb H, you are appreciated, and a super towel. Ladies and gentlemen, let's take a look, though. Let me bring this up for you right here. Let me just click that little button. No, what is that? That is not what I wanted to click. I wanted to click. Oh, it's already up. All right, so let me get rid of. Well, you know what? We're not getting rid of the koala. We're adding it to the screen. Nope, the koala stays with us permanently, ladies and gentlemen. It would be wrong. It would be wrong, ladies and gentlemen, if we got rid of the koala. We are not getting rid of the koala. Val, I can't order lunch until recess is over. And then I get to eat lunch while we're watching until about 1 p.m. And then I get to talk with you all from 1 p.m. to 2 p.m. Now, isn't this great, ladies and gentlemen? We get analysis. We're going to watch Bob Alessi absolutely crash and burn on cross. And we added Chewbacca with a koala to the side of the screen. Oh, my goodness. We're going to run. Eventually, people are going to tune in and be like, 1, why is there a dog in a wig? 2, why is there a lawyer breaking a rock in half with the Chewbacca and the Stay Puft Marshmallow Man? 3, why is there a Batman towel? 4, which is how we summon Murder by Maestro. 4, why is there a Chewbacca with a koala? Oh my goodness, ladies and gentlemen, this is just the greatest thing I've ever seen in my entire life. Now listen, folks, here's what we're going to do. We're going to watch this video of Bob Alessi absolutely crashing and burning on cross because I think it's hilarious. I'm sorry, Bob Alessi, you're not a bad guy. You seem like a nice guy. You really care about your family. It seems like you care about America. It seems like you are just a general, all-around decent lawyer in the environmental deposition context or in front of a regulatory tribunal. I don't think you should try criminal cases because, Bob Alessi, this was hands down one of the stupidest questions I've ever seen a human being ask in my entire life. You literally got the date wrong. Trying to impeach someone's credibility, you got the date wrong and you looked like an absolute moron. Now, listen, I'm not calling you a moron. I'm just saying tactically, if you don't know how to cross, sit down. It is better to say nothing on cross. Have you ever heard of the old adage, folks? It is better to say nothing than to open one's mouth and be thought a moron. That I didn't get the exact quote, but that is literally what Bob Alessi should do. He should not talk very much. But let's listen.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? according to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just go right to the bill. You, as you sit here today...
As a law student, let me just tell you, if someone did that in class, I would laugh. Oh my goodness, I wouldn't be mean to them, but I'd be like, you can't do that. You can't try to impeach them on the date. You just impeached yourself. Oh my God, he literally impeached himself. Bobolesi was like, hey, Bobolesi, you don't know how this case, you don't know the timeline of this case, right, Bobolesi? And Bobolesi was like, yeah, I don't. Oh, yes, Bobolesi, I just made you look like an idiot. Oh, well, I'm Bobolesi. I appreciate that. Thanks, Bobolesi. Oh, Bobolesi, want to debate the Latin root of the word forensics? Sure, Bobolesi, I would like to talk to you all day. Bobolesi probably just stands in the mirror with a dictionary lecturing himself all day. Well, would you like to know what the term autodidactic means? Have you ever looked up the Latin root of eudaimonia? Oh, yes, well, back in 1993, I was clerking for an environmental law judge, and he was some administrative judge, and he really liked the word didactic. Sir, can you tell me a little bit about whether you like the word didactic? Oh, ladies and gentlemen, can we watch it again? Would you all be upset if we watched it again just so Towel can gratuitously laugh at Bobolesi? Would you all be mad at me if we watched that again simply so I could laugh at Bobolesi? I think that was the greatest thing I've ever seen in my entire life, and I want to watch it again. I want to watch it again and again and again.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just go right to the bill. You, as you sit here today...
Again!
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just go right to the bill. As you sit here today...
It gets better. It gets better every time you watch it. Oh my goodness, that was amazing. How do you even analyze that? I have no analysis of that other than just... Graham, what is your informed erudite lay towel perspective on that? That is my informed lay towel perspective. You don't understand. Listen, the only thing that rivals that in greatness is this. Ladies and gentlemen, you know you want to see it. You know you want it.
You as well, Mr. Brennan. Okay, sir, I will, Hank.
You as well, Mr. Brennan. Okay, sir, I will, Hank. Oh, wait a minute. Did someone just say, is court still on recess? Hold on. Did someone just say we should make a YouTube short? By the way, I already posted it on Twitter. Come on now. I'm a little towel. You don't think I posted this thing on Twitter like right away? Absolutely I did. It's already got a bunch of views. It's been up for like 10 minutes. All right, hold on. Who wants to make a YouTube short? I know we want to make a YouTube short. You know why? One, because we're hilarious little towels. And two, because there's nothing better than laughing at Bob Alessi. Oh my goodness. I could not be any happier right now. I am just having the most hilarious towel day. Apparently people find this energy very infectious. This is just what I'm like all the time. Yes, okay, hold on. Watch this. Mandy, my dear towel spouse, Mandy Strong, I can't even go and get lunch. I'm going to get lunch delivered. I'm getting my favorite cheeseburger. Don't worry. It literally makes me happy. One time someone was like, Grant, that cheeseburger is bigger than your head. Yes, and it tastes as good as it looks, although I don't think you should eat my head. Ideally, you shouldn't eat any of me. I am a human. Focus on eating cheeseburgers. Please do not eat towels. Towels are not food. Oh, no. No, you all may not start eating towels. Absolutely not. All right, we're going to put the short together. Hold on, little towels. This is going to take a little second. I got to put my efforts and energies into making this happen, but I'm going to do it. I'm a little towel. I'm an active little towel. I'm an effective little towel. I know how to balance the various things going on in the world of little towel in order to produce content, such as to upload it and promulgate it for the masses, such as to 1, laugh at Bob Alessi, 2, engender coach in public discourse, 3, ward off the usurpation of our representative forms of government, and 4, troll murder by Maestro when he listens to this at 5x speed later on in the day. Oh, ladies and gentlemen, yes, McCartney, it was Super Towel Courtney Myers herself who went on a membership parade. Ladies and gentlemen, it wasn't a towel march. It was a towel parade. We may as well have walked through the Arc de Triomphe, ladies and gentlemen, waving our towels. We have gone beyond just Norman Towel. I'm pretty sure that we are starting to develop towel friends in every corner of the globe. I think governments are starting to pay attention. I'm a little bit concerned, ladies and gentlemen, that the governments are going to be like, listen, I don't know if it's healthy for our populations to be listening to this man who thinks he's an anthropomorphic towel, who clearly has a photographic memory, who also thinks he's a horse racing announcer, who also thinks he's an auctioneering announcer. The fact that he thinks he's an anthropomorphic towel is dangerous enough. I don't know what we should do with him. Then listen, I'll just go to the governments of the world and be like, it's not really a problem. I really understand the nature of sort of top-down leadership. We just don't panic, people. We focus the culture on unconditional love and compassion, and we're not communists. And then most of the countries of the world will be like, that's okay. But then some of the countries, in particular China, are probably going to be like, why are you excluding us? And I'm going to be like, we like the Chinese people, ladies and gentlemen. What we do not stand for, I tell you right now, is we do not platform the Chinese Communist Party. Ladies and gentlemen, we fought a Cold War to put down the communists. I am not going to facilitate. I am a lot of things. I am a compassionate towel. I am a friendly towel. I am a fast-talking towel. Ladies and gentlemen, let me just tell you right now, I am a lot of things, but I am not a communist. And I will defend that principle to the day. I know a lot of you are like, oh, I really wanted him. Listen, I'm sorry. Your countries might be communist. That's very nice. We can talk diplomatically, but I am not a communist. And you cannot just be like, Grant, will you become a communist so that we can have some world peace? No, I'm not becoming a communist in the name of world peace. Where did you get that idea? Oh, goodness. I need to eat dewdrops. I know exactly how you feel. No! Oh, goodness. Oh, no, we have some communists apparently in the United States. Listen, I'm just saying, there are communists around the world who I'm sure are very, very nice, but it's the Communist Party, ladies and gentlemen. Okay, I have our YouTube short. Listen, who better towel to hang out with on break when we can make a YouTube short to laugh at Bob Alessi? Oh, let's do it. Ready for this?
Exactly.
Now, have you ever made a YouTube short, ladies and gentlemen? Do you know what you do? We did it yesterday. So here's what you do. So you want to take like the main video. You see how it's like a canvas that's a bit elongated, kind of like a inverted rectangle. So you want to take it and you want to make copies of the video. So the first copy of the video is going to have sound, right? But the second one isn't. You might say, why? Well, you don't want it running over itself. You just want one video with sound. So you're going to extract the audio from the second clip, okay? And then you're going to delete it from the timeline. Now grab that second clip again. It now has no audio. Just duplicate it, okay? Now ideally we want to take up the whole canvas. It kind of frustrates me. Oh, court's coming back into session. I'll make this YouTube short, folks. You enjoy court coming into session. I'll get the Karen Cam ready. I'll see you at the next break. Don't little towels. I'm with you. We're here. We're going into session. The Karen Cam is live. And they're off.
Court is in session.
All right, whenever you're ready, Mr. Lessie.
Thank you, Your Honor. And if I could please address an administrative matter that I wish I didn't have to address. Dr. Welcher was just using, at least my observation, his computer. He still has monitors on his desk. Could we have all that removed, Your Honor?
It was
Closed, yes.
Would he open?
So it's just, did you just turn it on?
No, but I will. I closed it. You like want the computer all the way off or just everything?
Is he going to need to turn his computer back on?
I do not see a need for the computer to be turned on. Do we have the ability to put the presentation and documents from our
So I'm going to see counsel at sidebar,
Sure.
please. Lunch break, I'll ask you to remove those monitors, okay?
I'm sorry?
During the lunch break, I know it takes you a while to set up in the
Yeah.
morning. I'm going to ask you to take all that down during the lunch break,
Thank you.
okay? Thank you.
May I, Your Honor?
Yes.
To your PowerPoint presentation. And in terms of the amendments, are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day? Are you aware of that?
No.
And you began testifying the day after yesterday, correct, sir? Day after Memorial Day?
I testified yesterday.
Yes. Are you aware of any activity in this trial of any kind before you testified yesterday?
Again, as I mentioned, I've been getting random emails, and then I've been seeing it pop up on my news feeds as well. But once I was aware of the reclusion, I made sure to not review any of that. But as recently as last night, I got an email that said biomechanical engineering job, or like applying for a job, and I opened it up and it was some internet troll.
Sure. I'm asking about emails from the prosecution.
Oh, no, there's been no emails about what's been going on. I mean, there's been scheduling, when am I going to come, things like that.
How then was it determined that you were going to be able to amend your power presentation if you weren't communicating with the prosecution?
I mean, they asked me about the witness statement of 138 right around May 13th.
How did they ask you about that, sir?
I don't recall if it was a Zoom meeting, a phone call.
So there was a communication with the prosecution. Might have been by Zoom, might have been by another method, but there were communications while this trial is going on relative to you amending your PowerPoint that ended up with an amended PowerPoint on May 13th. Do I have that correct?
I believe so.
Going to switch topics.
Okay.
One of the goals of Aperture's analysis and reconstruction was to determine the location and timing of certain text stream events, correct?
Correct.
EDR data.
I'm sorry, my role.
Your role, yes. EDR, and just for clarification, EDR is Event Data Recorder, correct?
Correct.
So I'm going to refer to that, as you have before, as EDR, Event Data Recorder.
Sounds good.
EDR data does not show the location associated with a text stream event, correct?
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely time associated with a text stream event, correct?
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question slightly different way. The EDR data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a text stream event, correct?
That is correct.
Instead, every text stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple text stream events in a single key cycle, right?
Correct.
And every time you start the car, this one you push the button, that's a new key cycle, right?
That will cause a key cycle.
And the EDR data indicates the number of seconds into the key cycle that the particular event occurred, correct?
The EDR data, no.
So EDR data gives you no information about the number of seconds into the key cycle that a particular event occurred.
You're confusing EDR data and text stream.
I'm not, sir, I'm just asking a question.
So
if it's yes or no, I'm fine with that.
EDR data will, depending on the vehicle, sometimes it has information about GPS date and time. Sometimes it has different ignition cycles versus key cycles in EDRs compared to text stream.
So let me ask it a different way.
Okay.
The text stream data indicates the number of seconds into the key cycle that a particular event occurs.
Yes.
Is that correct?
That is correct.
In order to properly determine the location and the timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
I think I'm going to say yes, that text stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a text stream event.
So the text stream tells you the trigger event and it tells you the key cycle. So I'm not determining that, I'm reading that from the text stream data.
Okay. So in order to properly read, to use your verb, the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
If you associate the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence in the text stream with the mileage, the overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again, you have to take the totality of the data.
My question is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So, again, the text stream event tells you the trip and it tells you the time. If you're saying I'm, say, associating that with the wrong infotainment information or vice versa, then that would be wrong. But the text stream data tells you how much time is associated with each trip. There's no difference there.
If you associate the wrong trip with the wrong key cycle, then your estimate of where the text stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
Let me try it a different way. Your analysis, or anyone's analysis, in conclusions regarding the timing and the location of the text stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No. Again, you need to take the totality of the data. So that is one element. You need to look, for example, at the mileage. You need to look at the timing of the events. So this is considered a tool in the analysis process. You need to look at the totality of data to see how it matches up with the physical evidence.
So are you saying that you can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location of text stream data?
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the text stream. If you are attributing an event to the wrong trip, which has a fixed key cycle, that could be a problem.
Exactly. So if we could go, if Your Honor, if we could publish a slide, please, that is in evidence.
Okay.
Thank you.
What are we looking at?
Pardon me?
What slide number?
I've got slide 9. Mr. Wolk, yes, I've got the correct one. Thank you, Your Honor. So I'm going to use the acronym VCH that you've used on your, do you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167?
Correct.
And in this screenshot, we can see 4 text stream events that are...
Actually, can you zoom in on the key cycle?
Oh, sure.
Because I think when I got to, no, scroll. So when I got to it, you can see it was that key cycle 1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So to answer your question, I got it at 1264.
So if we can go back so we can see the 4 text stream events, I just want to reestablish the foundation here. In this screenshot, we can see 4 text stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 text stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right. So you are aware that the Commonwealth had maintained up into your firm's engagement that...
Are you saying there's no basis for the question?
They're saying.
All right, I'm going to allow the question and I'll hear it.
You are aware that the Commonwealth has maintained up until your engagement in September of 2024 that all text stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
So the objection sustained. You need a foundation, Mr. Lessie.
Sir, as part of your work in your review of the many documents that you referenced on your direct examination, did you review the text stream events associated with the Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right, and did that, what you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, sir. I only mentioned 1164, 1165, and 1167. I purposefully skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing, etc. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess' analysis of the data.
In addition to Mr. Burgess' analysis, so in that analysis contained locations of where the Lexus had been.
It contained where it had been and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the SUV, the Lexus SUV, had been, correct?
Correct.
Now to the question. Based upon that review, that knowledge, that understanding, that those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were two reports of Trooper Paul. There was his original CARS report and then a supplemental report that were listed in the documents you reviewed. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir, that there were do you recall that there was a report of Trooper Paul?
Yes.
Okay, and you read that report, I assume, sir?
I did.
And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No. I did my own independent analysis. As a matter of fact, it'd probably be more important that I don't do that to avoid confirmational bias.
But you did read Trooper Paul's report.
Of course.
So, you therefore are aware that the Commonwealth has maintained up into your engagement.
Yeah, I'm going to see it sidebar on this.
Sidebar, ladies and gentlemen. We have a sidebar. We're going to do a special towel update recap at 1 p.m. of the morning session for special Super Towel Sis. And ladies and gentlemen, if you missed it, oh my word, ladies and gentlemen, if you missed it, I'll tell you right now, folks, it has been quite a day. Bob Alessi got humiliated on Cross. I'll play the audio for you. I made the YouTube short. Actually, I might be able to bring up the YouTube short for you. Hold on, little towel friends. I got a plan. I am the man with the plan. I tell you, ladies and gentlemen, I am the man with the plan. You are the man. You are the people with the plan. I am the towel with the plan. I'm going to use my own comment that I made to actually make this happen. Watch this, ladies and gentlemen. Going to open that over here. Going to open this over here. Yes, let's watch this. We can. Oh, we're not going to take the screen off Peggy O'Keefe. We love Peggy O'Keefe. God bless you, Peggy O'Keefe. God bless the entire O'Keefe family. This is what this is all about, folks. Justice for the O'Keefe family. Laughing at Bob Alessi as he crashes and burns on cross and makes his client's chances of convictions go way up. And Towel sending his well wishes and comfort and consolation, a warm, fluffy towel blanket of support enveloping the O'Keefe family. God bless them, ladies and gentlemen. Yes, ladies and gentlemen, we are at Sidebar. We are at Sidebar. Bob Alessi's cross is not going very well. Let's send our God bless wishes. Can you run through again one more time how you do the text thing? Oh, the captions, bossy Texas chick. Just go on Canva, upload your video on the left-hand side of the page, scroll down to the left under all the options, just click captions, then make sure the video you want to generate the captions on is selected, and just click just click generate captions. It'll generate them, and then just move them around as you need. And then as you saw, like, those are 3 videos running simultaneously on the YouTube short I made, and all I'm doing, ladies and gentlemen, is having those videos, 2 of them run without sound, 1 of them run with sound. They're all synced up, they're all the same length, you know what I'm saying? God bless the O'Keefe family, though, ladies and gentlemen. God bless the O'Keefe family. Our thoughts are with them. And let's watch. We don't get to see them very often, so we are going to watch the O'Keefe family, ladies and gentlemen. We are going to wait a second to watch the towel short where Bob Alessi gets humiliated. Actually, you know what? I think I can maybe do it. No, we're not going to do both of them at the same time, ladies and gentlemen. My word, there's just so much going on. There's so many things going on. I even forgot to keep the towel chat scrolling. Oh, ladies and gentlemen, I have disgraced the towel chat. I have offended the towel chat. I forgot to scroll the towel chat. But ladies and gentlemen, I have now scrolled the towel chat. There you go. We're caught up. Oh, very well done and very quick, Grant. Looks great. I'm going to send you mine. Don't laugh. Oh, I bet it's going to be amazing. Bossy Texas chick. Don't you worry about it. You know, Bossy Texas chick, you can just remix my sound. And I think it helps both of us. It gets a view when I get a view. I don't know how this whole view thing works, but I get a view on the short. I make like a penny on shorts, so I have no idea how shorts work. I make like 10 pennies on the other videos, so it's not like, I'm not saying your donations and super chats aren't appreciated. It's just I'm a very small channel, and I don't really understand. But I was watching some content creator who does Gorilla Tag videos last night. Gorilla Tag's a very interesting game. Anyway, Bossy Texas chick, if you click remix on the video, apparently what it does is it gives you a view when people view your video. It lets you use the sound and put whatever video you want over the sound that I have, and then I think you can even use the video itself, and then you get a view when people watch the remix. Now, I don't really know what that means, ladies and gentlemen, but I do know that we're going to sit here and look at the O'Keefe family because, ladies and gentlemen, we are towels and we honor the sacrifice and the plight of the O'Keefe family, and we send them our good towel wishes. Oh, God bless those little towels, ladies and gentlemen. God bless them. God bless the O'Keefe family. We are, ladies and gentlemen, standing up in defense of the O'Keefe family, and there is an extended side. Bah! Thank you for the comment, Mandy Strong, on the YouTube short towel. Appreciate you very, very much. Oh, I see, Bossy Texas chick. Well, you have very good songs. And Bella, Bossy Texas chick, I think your entire channel could be centered around Bella going on adventures through the world, perhaps becoming a character in the Brave Little Towel adventure series. Oh, ladies and gentlemen, it is going to be glorious. Also, I forgot Chloe the dog is on the defense table. Hi, Chloe the dog. You're a little towel. Oh, you're a little towel with your wig, little Chloe dog. Oh, I do my best, Noel. God bless you. Yeah, ladies and gentlemen, we're in extended side. Bah. We have an option. Here, let's laugh at Bob Alessi. We love the O'Keefe family, but let's laugh at Bob Alessi. Everyone likes laughing at Bob Alessi. Ready to do it? Who's ready to do it? I'm ready to do it. We're all ready to do it. This is the YouTube short that I made. Here we go, ladies and gentlemen.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's, what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just go right to the bill.
Ladies and
You,
gentlemen,
as
that
you
was
sit here
hilarious.
today-
Also, someone asked in the chat, oh no, the fan. So I think it was, hold on, who asked? Linda the AC Ninja. Linda, don't worry. I removed you, your blue towel, but don't worry. We don't actually admin. We just have a blue wall of justice to show support for towels and also the O'Keefe family. So, ladies and gentlemen, that is why, indeed, you are all super towels. We also do, a little light moderating, but just so you know, Linda, sorry, I want to make sure I get the name right. Linda the AC Ninja, being a super towel on this stream doesn't mean you actually need to administer anything. It's more just so when you comment, it's a blue wall of towel friends. You'd actually probably be the only person who isn't in blue in the comment wall, and that's really why you have the blue. So if you want to take the blue for that reason, Linda, that's absolutely okay. Linda the AC Ninja, you don't have to accept it. We will not force that on anyone, ladies and gentlemen. You know what, though? I want to watch the short again because I don't think there's any reason to just watch that fan spinning, so let's just watch the short. Oh, one more time, ladies and gentlemen, one more time. You know you want to see it one more time. We all want to see it one more time. Who wants to laugh at Bob Alessi while we wait for court to come back into session? Oh, ladies and gentlemen, there's nothing better. Hanging out with Towel, waiting for lunch to start. Courtney Meyer started another membership parade. Oh, goodness. Charlene, Tracy, Brandy B, AK Lady. Oh, goodness. Laureen, Ellen, Gessler, Brooklyn Rules, MBA, 1-800-Fraudbusters, Joyce Johnson, Trish C, JNJ Mom. Oh, ladies and gentlemen. Oh, as we wait for court to come back into session from the sidebar, and as Towel waits for his cheeseburger to arrive. Ladies and gentlemen, it has become a Super Towel Parade. Now, if you're wondering, oh my goodness, I just got a membership, what does that mean? Well, go ahead and click your emoji icon either on your computer or on your phone. Look at what you have just unlocked, ladies and gentlemen. You got a sweet towel emoji next to your name. And, oh, Courtney Myers, you are the best. We always love seeing you pop by, and I think your towel friends, not only do they appreciate you, but Courtney Myers, sometimes people pop up later and they're like, whoa, I have towel emojis. How did this happen? Oh, it's great. NH Canna patient, great to see you, dear friend. But yes, ladies and gentlemen, if you'd wondered what does the membership parade mean, not only do we say hello to our dear friend Courtney Myers, the Super Towel, but we also Super Towels among us ourselves, then stand together, get ready for court to come back into session, and use our new towel emojis. You even have Chewbacca and the Stay Puft Marshmallow Man with the fan in your emoji collection. Oh, ladies and gentlemen, it's glorious. Let us get ready for court to come back into session. I'm trying not to yell as much. I'm doing good.
May I, Your Honor?
Yes.
Thank you. Are you aware that over the course of the Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV...
So there's two words, just strike theorized.
Okay. Thank you, Your Honor. Are you aware that over the course of the Commonwealth's investigation and your...
Hold on, Mr. Leslie. The court reporter can't hear you.
Thank you. I will.
I'll object again to the question that's coming.
Can I
Go
begin
ahead
my
and
question?
ask an appropriate question, Mr.
Sure. Do you have knowledge whether there is one time or more than one time for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
Sustained. You can ask the question, remove part of it.
I'm sorry, Your Honor?
You have to remove part of that sentence.
Okay, understood, Your Honor. Do you know whether there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview.
Objection.
Sustained.
I'm going to ask for an instruction.
I'm not giving the instruction now.
Dr. Welcher, in terms of the analyses that you have reviewed in this case, is there one time that you understand there to be for a hypothesis for the time of the impact at 34 Fairview?
Objection.
I'm going to see you again, folks. I'm sorry about this.
Sidebar. Ladies and gentlemen, we have another sidebar. Ladies and gentlemen, Bob Alessi just can't help himself. He keeps doing stupid things on cross. Oh, ladies and gentlemen, we look in on the courtroom and we are little towels. My name is Grant Smith Ellis. I feel like I am carrying the day more so than Bob Alessi. Every time we go to sidebar, I'm here. I'm with you. I ordered a cheeseburger. It's going to be delicious. We all have towel memberships flooding through the chat, ladies and gentlemen. We have the Bob Alessi cam. We have the Karen cam. We have Chloe the dog in a wig sitting on the defense table. Oh, ladies and gentlemen, it is quite a day. It is painful, but you know what? We get to spend time together, ladies and gentlemen, during the sidebars. We even get to drop our special towel sidebar emojis in the chat. We know there is nothing more pleasant, ladies and gentlemen, than dropping a sheep emoji in the chat while watching a criminal trial. Yes, ladies and gentlemen, I think the O'Keefe family, I'm not sure they understand what's going on with the sheep, but they'll be like, well, at least those people are sending us good vibes, and they seem to think they are towels. Yes, ladies and gentlemen, the sidebar continues. My name is Grant Smith Ellis. We are watching the O'Keefe family as the sidebar continues. It has been a series of sidebar after sidebar after sidebar because Bob Alessi is not very good at asking questions during cross, ladies and gentlemen. That tends to be the analysis I see from most people across the interwebs. I was reading a great post from Matt Timpanic earlier, who pointed out that Bob Alessi just asked too many open-ended questions. He lets the witness control the cross, and it doesn't work out in his favor. All right, who wants to laugh at Bob Alessi again? Raise your hand, ladies and gentlemen. I know we are all raising our towel hands. There is nothing better than laughing at Bob Alessi. Yes, ladies and gentlemen, we're going to laugh at Bob Alessi. Try not to get too excited. It's going to be one of those moments who, instead of watching the Reed family sitting there, oh, Mr. Reed's not doing too well. Oh, Mr. Reed's hanging his head. We might not switch to Bob Alessi. We might not laugh at Bob Alessi just yet, ladies and gentlemen. How can we look away? Oh, ladies and gentlemen, how can we look away when we're laughing at Mr. Reed? Well, we can't laugh at Mr. Reed. He looks like he's struggling. Oh, he is a Mr. Burns-like figure, ladies and gentlemen. He would probably buy a nuclear power plant, drill under a school, take the oil, undermine the educational programs, and then be like, we're going to open a private college designed to help people trade stocks at the expense of the wider general public. And I love Alexander Hamilton and fiat currency. Yes, ladies and gentlemen, I got Phil Reed figured out. My name is Grant Smith Ellis. I'm a towel who clearly knows too much about too many things, ladies and gentlemen. A little bit of knowledge is a dangerous thing. A lot of knowledge is just overwhelming and agonizing. Oh, there's Peggy O'Keefe, ladies and gentlemen. We send our towel prayers to Peggy O'Keefe during these agonizing moments, as we tend to do during every sidebar. Peggy O'Keefe, the towel friends are with you. We may be a little odd. We may be a little bit eclectic. We may be an acquired taste, ladies and gentlemen. But my word, do we love hard, ladies and gentlemen. We care. We're compassionate. And the O'Keefe family is always in our thoughts and prayers. There's a guard next to Mr. Reed, I think, because he is looking at the jurors, ladies and gentlemen. He has a bad habit of looking at the jurors. Oh, ladies and gentlemen, Bob Alessi does tend to waste a lot of people's time. That's why he stands at sidebar, and we, ladies and gentlemen, are trying to console Miss Peggy O'Keefe as she is unfortunately made to wait for yet another sidebar. Peggy O'Keefe, the thoughts of the nation are with you. Oh, Miss Peggy O'Keefe, this nation turns its lonely hearts to you. We will, Miss Peggy O'Keefe, through our dedication to this case and our commitment to one another, uplift and engender the memory of John O'Keefe, whose name will never be said for the last time, at least on this stream, ladies and gentlemen. And may Peggy O'Keefe's dedication going to every hearing, every trial session, every single day, may that be rewarded, ladies and gentlemen, in the form of justice for John O'Keefe and a conviction for Karen Reed. And yes, ladies and gentlemen, this is why you watch Towel Stream, erudite, informed, witty, cogent, quick commentary, instead of listening to sidebars that are just literally just the white noise of the courtroom. You can listen to Towel do his erudite, prescient, and informed, cogent commentary, and it looks like the sidebar should be ending in the next 20 seconds here, or that could just be Elizabeth Little walking to the back of the courtroom because she had to get information. Wait, Karen's coming back to her seat. She sits down. Oh, she's feeling a little snippy today. Look at her, Karen, swiveling those chairs around, moving around, flipping papers. She can talk. She can move almost as fast as Towel can talk, although I'm sure there's only a few people in the world who can actually talk this fast, and I think in some sense this becomes an exercise for your brain and erudition, because if you can keep up with someone talking this fast, then you almost can process information at a more rapid speed, thus increasing the elasticity of your brain, facilitating the form of a wider understanding, and empowering you to engage with the wider world. And with that, we should be back into session. Here's Karen with the weather. My name is Grant Smith Ellis. Come on now. Oh, I thought I had it. Come on, little towel. Oh, maybe just Yannetti and Karen have been relegated to the table. The sidebar continues. Oh, ladies and gentlemen, I just want my cheeseburger. Please, Baba Leslie, this is the only time I've ever wanted you to come back and return it to session so I can go eat my cheeseburger. You want to keep a towel from his cheeseburger, Baba Leslie, because of your sidebar. Come on now. I am a human being who deserves his cheeseburger. Oh, won't someone think of the towels, ladies and gentlemen? Won't someone think of the towels? Oh, ladies and gentlemen, Karen's mad. Towel's frustrated. We're at sidebar. Oh, ladies and gentlemen, this has been quite a day in the John O'Keefe and Karen Reed retrial. You know what we're going to do? We're not going to watch Karen and David Yannetti talking. We're going to laugh at Bob Alessi. Oh, yes, ladies and gentlemen. What would you rather do than laugh at Bob Alessi? You ready for it? Play it again. Play it again, Sam. I am Sam.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's, what, less than a year ago?
Understood. I'm moving on to the next question because I want to move away from that discussion and just go right to the bill. As you sit here today...
How can you not giggle at that? Oh, hello, Paula. Yes, we're not on break. We're at a sidebar that has been quite extensive. And also, Bob Alessi, Karen Reed's lawyer, as you know, got humiliated on Cross today, and we were watching a short where he just forgot the timeline of the case, and then the witness humiliated him. It was glorious, ladies and gentlemen. It was glorious. Also, by the way, ladies and gentlemen, we will be watching a recap. Hank Brennan finished up his direct. He won 70% of his motion to start the day. If you want to get quickly caught up, what happened was Hank Brennan won the part of the motion allowing Dr. Judson Welcher, the crash reconstruction expert with 30 years experience, to testify that Karen Reed's vehicle was involved in a collision around 12:32:04 to 12:32:09 on the morning of 1/29/2022. And then furthermore, that ladies and gentlemen, that John O'Keefe's arms were John O'Keefe's injuries were indicative of sideswipe impact with a car, and then jurors were able to inductively interpret what that meant as to a collision occurring. Now Bob Alessi's crossing, and Bob Alessi got humiliated because he forgot details of the case. We should be coming back into session any minute here. My name is Grant Smith Ellis. I talk very fast. I can pack a lot of information, and I'm waiting for my cheese into a small amount of space, and I'm waiting for my cheeseburger. Yes, ladies and gentlemen, now let us get back into session. God bless America. Please let us get back into session. Why must you torment little towel? Here we go.
Yeah, Your Honor?
Yes.
Thank you. I'm going to move to, for the moment, we'll come back to the other topic a little bit later. As we discussed earlier, you've got on various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir? Is
Sure.
is biomechanical engineer something you consider yourself to be?
Sure. My degrees are in biomedical engineering. The discipline within biomedical engineering that I practice is biomechanics.
Right. And so is it accurate to say that you are a biomechanical engineer?
Yes.
And you say that much in your report, correct?
And the CV and resume I gave you.
Right. Now, in your report, and Your Honor, I have no issue if he refers to the
Thank
page
you.
of his report.
Do you have a paper copy or do you need your?
I do.
If you, sir, could turn to page 9 of your report.
Sure.
And on page 9, you state, as a biomechanical engineer, I have no opinion on any aspect of, and I think you're referring to Mr. O'Keefe's medical treatment or medical diagnoses. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Did I read that correctly?
You did?
In that statement, I assume, given you wrote it, is a fair representation of your professional role in this case?
Yes.
And you go on to add on page 9, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. Did I read that correct?
You did?
And on your direct examination, is it correct that you stated as a civil engineer, you made an analogy, you assessed the cables and beams of a bridge as you would assess the cables and beams of a bridge, you assessed the human anatomy. You made that analogy, correct?
The analogy that bones are my bridge elements, cables are muscles and ligaments.
Right. And you stated that it's the job of a biomechanical engineer to quantify the force acting upon a person to determine the cause of their injuries, correct?
That is part of what we do.
It's part of, but it is therefore something that a biomechanical engineer does, correct?
Given sufficient data, yes.
So, you know do you know what a force calculation is, sir, when I refer to that term?
I believe so.
What do you believe it to be?
Well, force is usually a physical measurement, but you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I wanted to get to. Newton's second law is, and sometimes referred to as the second law of motion. And in the second law is force equals mass times acceleration, correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when you're trying to determine, sir, you're pulling something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right. We're going to do that. We need to do it with the court's permission.
Sorry.
So if you feel you need to do that, just let me know.
You can just leave it right
All
there.
right.
So I just want to get the principles down first. So Newton's second law, force equals mass times acceleration, and force is oftentimes what you're trying to calculate in a force calculation, correct?
Calculate or measure, yes.
Yeah. And Newton's first law is the law of generally inertia. An object at rest tends to stay at rest. Object in motion tends to stay in motion. We're not talking about that in force. We're talking about Newton's just second law, correct?
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
Okay. And that Newton's second law is generally just a mathematical calculation, correct?
Yes.
So what I'd like to do is to turn to page 11 of your report. And on page 11, you discuss the force calculation in conjunction with the part of your report where you discuss your experiment where you dropped a test dummy backwards, correct?
Correct.
You determined that a fall of 69 inches At that fall, Mr. O'Keefe's head would have accelerated with 458 G's of force?
That's what we actually measured in the test.
And can you tell the jury what is meant by G's?
So G's is a measure of acceleration. If you usually acceleration is measured in feet per second squared. If you divide it by 1 G, which is 32.174 feet per second squared, that gives it to you in G's. People often heard about fighter pilots losing consciousness at 6 or 7 G's, basically because your blood's getting sucked away from your head, not because you're being impacted. But G forces, or G's as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by what we all feel when we're standing here, which is 1 G of gravity.
And you estimated Mr. O'Keefe's head weight of approximately 15.7 pounds. You used a percentage. Is 15.7 about right for the mass of the head? So if we apply Newton's second law, we keep F force open as the unknown. We take and apply the mass, which is 15.7, multiply it by the acceleration. You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
So that math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
And that 7,200 pounds is the previous unknown F in the Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds. Now you then go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
So you then, as I understand it, you go to the scientific literature and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry.
How many inches?
40. That's in your report?
Well, you mixed two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds, and then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone in an average force of 634 pounds.
No. 1,634.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,634.
My apologies.
And you compare that to the 7,200 pounds of force that you calculated. Surely you're going to have a fracture of the occipital bones through that calculation in that comparison, correct?
Correct. Falling on a hard surface can definitely fracture your skull.
So I'm not getting at the manner. I'm just applying the Newton's second law. Newton's second law doesn't look at manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
So it's a function of the surface. The A value is a function of the surface you hit.
So you're saying acceleration depends upon the surface?
Yes, of course.
Okay, all right.
For an impact, it does.
Now, let's go to the study you cited. Injuries to pedestrians in real accidents in their relation to collision and car characteristics. That's in your report, correct?
What reference number?
May I, Your Honor, grab the report?
Yes.
Thank you. If you can, it's in your report, sir. If you can find it, I'll do it in parallel with you.
Is it number 25?
That's the one I think it is. I just want to check your report.
Would you like me to actually pull up the paper?
No,
Okay.
just want to get to the... That's it, number 25. We're talking about the same one. Now, isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Or can the witness see the document that's being referred to?
Do you have your report in front of you?
I have my report, but reference 25 is not in the section he's referring to.
Why don't you show it to him, Mr. Russell?
I do not have with me a copy of the report he cites in his reference. He did... Can I ask another question, Your Honor?
Yes.
Thank you. Dr. Welcher, on your direct testimony, did you not discuss the percentage of pedestrian injuries and relate it to heads? Did you not, on your direct, talk about percentages of injuries that are head injuries in impacts of pedestrians with cars?
Yes, I did.
Okay, so you came up with a number. What I'm trying to do is to compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next question.
Can I go to my slide?
Whatever you can use to determine what was the percentage that's in the study that you cite in footnote 25 of your report.
Sure. That was also from my presentation that I gave. It's 61.5 for all injuries, 12.7 for fatal injuries.
Thank you.
You're
So I'll
welcome.
repeat my question, and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay, so doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
It's circled with a red box on my slide.
Did you mention that on your testimony on
I
direct?
thought I did.
This article was published back in 1979, correct?
I believe that's correct.
It's 46 years old, therefore, if I did the math correct, right?
That sounds correct.
Are you aware that given advancements in science since 1979, advancements in medicine, advancements in technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities?
I'd have to see the study. It wouldn't surprise me. Car technology, especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window and or bounce off, to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
So you would agree that as of January 2022, the most common injury as a result of a pedestrian motor vehicle collision is one to lower extremities?
No, I wouldn't necessarily agree with that date. And again, you have to look at frontals versus rears.
So you contest that the most commonly understood injury as a result of a pedestrian motor vehicle collision is injuries to lower extremities?
Maybe that's about a source.
I'll allow the question.
So I'd want to see the data. Again, most cars, for example, this Lexus has a pre-collision system in it that will start to apply the brakes if it senses a pedestrian at the front of the car. And so for frontal collisions, it's transitioning, taking what were head injuries, because they're more severe, higher speed crashes, making them lower speed crashes and shifting the injuries to the lower extremities. Just like airbags shifted the head injuries away from the severe ones, and we started getting more or higher ankle and lower leg injuries. So the change in the technology, but for backing, that may not be the case because you have different geometry on the vehicles and you have different safety systems.
I'll try it a different way. Do you have knowledge, as you sit here today, whether the most common injury from a motor vehicle accident is to the lower extremities?
I'd have to look at the literature. I have the article I gave you.
So the answer is you don't know the answer to that question. Is that correct, sir?
I don't know it off the top of my head.
All right. Newton's second law analysis that we went through, force equals mass times acceleration, where we came up with the 7,200 number. You didn't discuss that calculation on your direct examination, did you?
I don't think so. We didn't discuss a whole bunch of those things that were that wasn't necessarily an opinion, that was a sub-opinion or basis for my opinion.
You didn't discuss that Newton law calculation on your direct examination, did you, sir?
So in a way I did, because I said my drop testing shows that you can do this. So I didn't quote that number, but we are going through the specific numbers now. But I absolutely did say, as a matter of fact, I showed a video of my drop testing and talked about how falling onto a rigid surface, a hard surface, can cause a skull fracture.
Did you discuss on your direct examination applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
Those specific numbers, no.
Thank
the general
you.
concept of the drop testing and what it showed, yes.
So instead of that calculation, you referred to a flow chart comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me two questions. You said instead of, so that's no, it's not instead of. They're two completely different topics. So no, I didn't do that instead of.
Okay.
I looked at a force analysis, then I looked at 3 peer-reviewed publications that were attempting to differentiate whether an injury is associated with a fall or a blow, an assault, and they came up with a metric for doing that. Those things are completely separate.
Let's ask it this way. Did you, on your slide presentation that you presented to this jury, did you put the inputs into F equals M times A in your slide presentation with the numbers we talked about of 15.7 for the M and 458 for the G to come up with 7,200? Was that anywhere on your slide presentation?
So the slide presentation showed the 458 Gs. The rest of it was not on there.
Thank you.
You're welcome.
You also indicated that the laceration above Mr. O'Keefe's right eye is consistent with the shape and height of the fin on the top of the Lexus SUV. Do you recall that?
Correct. It's actually properly called a spoiler.
And so you would call it a spoiler instead of a fin?
Correct.
Fair enough. We'll call it a spoiler. You visited the scene at 34 Fairview, correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data?
I would use the word like, but we want to go to the scene to see the scene.
When you visited 34 Fairview, did you go into the garage at 34 Fairview?
No. I actually didn't set foot on the property.
You didn't set foot on the property?
No, I stayed in the street. It's my understanding there were new owners.
Did you consider the scene limited to the road?
So the access I had was to the road. The laser scanners and the photographs will extend further, but I didn't have access to the interior of the house.
Oh, so you didn't access the entire scene, correct?
In my opinion, I did access the entire scene. I didn't physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was. I didn't want to trespass.
Where did you understand the body of Mr. O'Keefe was located?
I know it was 7 feet in from the grass. I've seen cruiser cameras showing people around a body. It's slightly north and slightly south and a little bit west of the flagpole.
But you didn't access that part of the scene that you just described, correct?
I absolutely did. I took photographs of it. I didn't trespass and stand at that exact location, but I stood right there. We scanned the whole thing. The scanner uses a laser beam that goes out, 150, 200, 300 feet. So we scanned all that stuff.
Did your scan topography?
Yes.
Then you know that there is a berm raised above street level, correct? If you did the scan.
Correct.
Do you know the height of that berm?
I believe it's 4 inches.
Nowhere in your report, when you're comparing the height of Mr. O'Keefe to the spoiler, do you account for that 4 inches of the berm, do you?
So yes and no. As I indicated, we don't know exactly where the point of impact is, whether he was completely in the road or up on the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire will be at the height of the curb. So if he's standing on the higher part and the right rear tire of the Lexus goes up there and spins, then that would be at the same height. We don't know the exact point of impact. So I don't know whether he was on the road or in the street. Excuse me, on the street or on the side of the road.
Exactly, but when you did your depiction on your slide, and you remember you had the ruler and you measured the height? Did you
Absolutely.
know that?
Yep.
Where was it? It was you? Was it you in that slide?
It was.
Where were your feet?
On the ground.
Not on the berm, correct?
Correct.
Okay, so you chose a measurement which was the ground to the top toward the spoiler, and you took a measurement. And you said that approximates the height of Mr. O'Keefe, correct?
Of the laceration of Mr. O'Keefe.
Exactly, because what you were doing was you were trying to determine and present testimony on whether or not that laceration could be caused by the spoiler, and to do so you had to take measurements, correct?
Correct.
So, you chose to place Mr. O'Keefe in your simulation on the ground. You didn't choose to put him on a berm that would be 4 inches higher, did you?
Nor did I put the Lexus 4 inches higher. I didn't do
Correct.
either one of those.
So the point is, it's certainly possible that if there's 4 to 5 more inches, that would take that eye out of the ability to be hit by the spoiler. Isn't that correct?
No, because if it's 4 to 5 inches higher and he leans his head down or reacts to it, again, we don't know the exact position of his head.
Did you, in your slide yesterday, describe the possibility that his head could be down? As I understand it, you're positioned in that photo just like this. You're not positioned like that in any photo you presented to the jury, were you?
I'm trying to make it clear. We don't know his exact body position at the point of impact, nor do we know the exact position on the ground. So, which is part of the reason why I haven't tried to exactly simulate this, because we don't have enough parameters to do that. So I don't have that information. I'm showing the geometry relative to someone of Mr. O'Keefe's height.
So you don't have the information to do that properly, so therefore you can't conclude that he had a laceration to the eye from the spoiler by your own answer that you just gave, correct?
So it was done properly. We don't have absolute information to say where exactly he was. I'm pointing out that the physical evidence, the height, matches the height of the laceration. That is one data point of many data points.
So you would have to at least concede that the level of his eye could be non-contacting that fin or spoiler because you don't have information as you just described.
Sure, it could be from contacting the ground.
Pardon me?
It could be from contacting the ground. It could be from other things.
But you don't have the information necessary to conclude with any certainty that Mr. O'Keefe at the time of impact had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct?
We don't have that level of certainty. We have that the height and geometry matches.
And you didn't take into consideration the berm, and you didn't mention the berm at all when you were discussing this measurement with the jury yesterday, correct?
That is not correct. You asked me two questions. I absolutely considered the berm. And the second question when I presented it to the jury, I mentioned the berm when we showed the picture of the shoe in the snow, but that was it.
That's my question. I'll ask it a different way. When we were talking not about finding a shoe in the snow, and you mentioned a berm, I'm talking about when you did the measurement of whether or not the laceration could be caused by the spoiler. You didn't mention accounting for berm height when you discussed that measurement with the jury, did you?
That is correct.
Likewise, you didn't present any Newton's second law analysis regarding the front of Mr. O'Keefe's head with respect to whether his head was contacted by that spoiler, did you?
Correct. Again, it was a glancing hit. We wouldn't be able to do that.
Oh, so it's a glancing hit to the front of the head is your hypothesis?
This whole pedestrian impact is a glancing hit.
So you can have your arm to the side like this, with the back of the vehicle coming like this, and you could glance the right eye with the arm out? Is that what you're saying?
That's what my picture shows when I'm standing next to the car. I could probably find the slide for you.
So you didn't do a force analysis to determine how much force would be applying assuming a contact with the right eye, did you?
That's correct.
And force analysis is what biomechanists do, correct? That's what a biomechanist does?
That is part of what
they do.
So I lined up his anthropometry relative to the known height of the vehicle.
You attempted to line it up. That's one method, but another method is to apply Newton's second law like you did to the back of the head when he fell, correct?
Correct, if we had more information.
Mr. Leslie, why don't we break here?
Thank you, Your Honor.
So, juries, your lunches are here. We'll see you.
Did we hear how long the lunch is, Towel friend? 45 minutes? I'm here. My name's Grant Spendelis. Now, Towel friends, I'm going to be with you all through lunch. We are excited. My name's Grant Spendelis. They are done for the morning. That was horrifically bad by Bob Alessi. Hank Brennan did absolutely stellar on cross. And if you're wondering, Towel, did you get a cheeseburger and eat? Yes. Ladies and gentlemen, I ate my entire cheeseburger. There is nothing left except for a pickle, which I don't really like that much. Ladies and gentlemen, it was delicious. God bless every single one of you who support Little Towel. I promise you I'm doing good things, trying to be a responsible, erudite, cogent Towel. I'm trying to keep Towel fed. I'm trying to keep you all updated throughout the whole Karen Reed and John O'Keefe trial. We just got new copies of the exhibits. from the John O'Keefe and Karen Reed trial. Yes, ladies and gentlemen, brand new high-quality copies of the exhibits, including hundreds of pages of text messages between Karen Reed and the man she started an affair with, Brian Higgins, John's friend, to torment John as the relationship was breaking down between John and Karen before the end of John's death. Before John's death. Oh, ladies and gentlemen, it's bad news bears for Karen Reed all around. You know what we want to watch, though. You know what we want to watch. The moment of the morning. If you missed it, we're going to watch the end of Hank Brennan's redirect. We're going to watch how this day started. We're going to get everybody caught up because Hank Brennan won a big motion to start the day, and then his witness got to testify about Karen's car being involved in a collision right around 12:32 a.m. on 1/29/2022. John O'Keefe's arm injuries being consistent with a sideswipe collision. And ladies and gentlemen, it got worse from there for the Reed defense. But let's watch this moment where Bob Alessi literally got laughed at by so many of us, ladies and gentlemen. Oh, it was a moment for the ages. Oh, it was a moment for the ages. You can't do a question like this on Cross. Bob Alessi. Oh.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's, what, less than a year ago.
Understood. I'm moving on to the next question. I want to move away from that.
Yes, run!
Just go right
run,
to
Bob
the
Alessi.
bill.
You can't do it. Oh, goodness, ladies and gentlemen. That was great.
As you sit here
that was great
today,
in every sense of the term. Bob Alessi had a day. Oh, ladies and gentlemen, LA Connection, you have a great time getting yourself showered and all warmed up and ready for the day. Oh, goodness. My name is Grant Smith Ellis. I'm here with you, ladies and gentlemen. I can't wait. The Alessi clip, ladies and gentlemen, it has a formal name. Alex, the Super Towel themselves, has designated it the Alessi clip. Oh, ladies and gentlemen, it is forevermore known as the Alessi clip. Also, we're getting a lot of mixed reactions on the fact that Towel is going to speak like a horse racing announcer but try to not yell as much anymore. People are like, that's great, Grant. Some other people are like, but Grant, we want you to be your little towel yelling self. Listen, I can't please everybody, but I can try to make everybody feel comfortable. And as long as everybody feels comfortable here and safe, then Little Towel is living up to his eudaimonia or summum bonum on the earth. But yes, it's just after 1 p.m. We're heading into lunch recess in the John O'Keefe and Karen Reed retrial. And of course, ladies and gentlemen, you will not have to sit there and watch the fan. We don't do that, ladies and gentlemen. I'm not trying to knock other streams. They got a lot of trials to cover, but we don't watch the fan. We chat, ladies and gentlemen. We discuss with the Towel friends. We watch the overview of Hank Brennan's direct with Dr. Judson Welcher at the end of the direct. It was absolutely wonderful. You want to see how the day started, though, ladies and gentlemen? As a Little Towel, my name is Grant Smith Ellis, and I do my absolute very best to keep you all updated. This was how the day started. Oh, yeah, I even got 2 recordings of it so I could make sure I understood what was going on, ladies and gentlemen. Let's take a listen. Big win for Hank Brennan to start the day.
All right. Good morning, everybody. All right, so Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied. In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application. However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference, as is the expert. That is, the inference is not compelled by the application of any scientific method. So
everybody get how it worked out. The expert was allowed to testify, but it was kind of very specific. The vehicle, Karen's vehicle, was involved in a collision at a certain time, the 12:32 a.m. and 04 seconds, roughly to 09 seconds, and that John's injuries were consistent with a sideswipe from a vehicle. Ladies and gentlemen, my goodness, also welcome Joe Blow to the new honorary towel fold. We are glad to have you, Joe Blow. Welcome indeed, dear friend. Ladies and gentlemen, let me show you now, though, how that direct went. This was the Hank Brennan's direct. We only got a little bit of the Hank cam because I accidentally covered Hank up with John O'Keefe. But you know what? Maybe John O'Keefe was over Hank's shoulders in some ways, ladies and gentlemen. Let's watch. It was 15 minutes of glory. 15 minutes of glory for Hank Brennan. And what would you rather do during lunchtime, ladies and gentlemen, than watch Hank Brennan just absolutely dominate? So you saw what happened, ladies and gentlemen. Hank Brennan won the ruling to start the day, and this is how the direct, so that ruling was not in front of the jurors. This is how the direct played out. This is a special update for Sis, ladies and gentlemen. Sis, the wonderful super towel themselves, missed the morning, so we're getting Sis caught up. This was Hank Brennan's excellent direct, the final conclusion, the culmination of the direct of Dr. Judson Welcher.
Ask you those questions again, but before we do, I'm going to ask you two other questions. The first is, I'd ask you to turn to your PowerPoint, slide 110.
You want me to display it?
Please. I'm going to ask you a question about a series of your slides regarding this effort. This is 110. Could you also follow through to 111, 12, 13, 14, 15?
You want me to play the videos?
Hold on. Hold on, little towels. Let's figure out what's going on here. Hold on. I think it's just a Twitter video player. I like the Twitter video player, but it doesn't always work great unless you actually load into the video. So let's start again, folks. Let's start again one more time. Hank Brennan's final conclusion of his direct of Dr. Jordan Welcher. We're going to jump forward to 48 seconds here. 1 second. Pick up right where we started
also follow through to 111, 12, 13, 14, 15.
You want me to play the videos?
You don't need to play the videos. I just want to acquaint you for the question.
111.
12.
112. 113. 114. 115.
How many times did you engage in testing where your arm and forearm touched the rear right of the exemplar Lexus?
3 times.
In any of those 3 times, did it ever leave any paint on the underside of your arm or forearm?
No.
If you could turn to slide 130, please. What? There we go. Could you go back one, please? Perhaps it's 131, Dr. Welcher. There we go. Could you explain the significance of this slide, please?
Your Honor, this is...
Oh, could you take that down, Dr. Welcher?
Sure. Mr. Brennan.
We're going to move forward. Yesterday, when we left off, I had asked you...
So we need to take this slide
down. You can take the PowerPoint down, please.
That was in a different spot on the slide. Hold on a second.
That's better.
Thank you. Sir, I had asked you yesterday about some of your opinions. I want to ask you about some of your opinions relative to that last effort that you made regarding testing between the Lexus and your arm.
Correct.
You had mentioned earlier on in your testimony that you reviewed a number of pieces of information and offered that you relied on some of those pieces for your opinion. Can you share with us, for this part of your analysis, what pieces of evidence or information did you rely on for the opinions I'm going to ask you?
Relative to the testing on the arm contact on the taillight?
Yes.
So it was the physical evidence at the scene, the photographs of Miss Reed's vehicle, to a certain extent, my analysis of the Ring doorbell and the One Meadows event, the nature and
Don't worry, little towels. Don't worry. Twitter is not being cooperative today. The video is just struggling. It's not even me. It's not even us, I think. The Twitter video is literally just struggling. But ladies and gentlemen, I shall not be deterred. Oh, ladies and gentlemen, I shall not be deterred. I am a little towel. Oh, I hate gambling. Oh, ladies and gentlemen, I am a little towel. I am a little towel. Oh, goodness. All right. Ladies and gentlemen, we are going to take a look at this film again. Sorry about that. We were 3 minutes and 36 seconds in, and it was not your fault, little towels. It is literally
my
the Twitter
analysis
video.
of the Ring doorbell and the One Meadows event, the nature and
Excuse me, Your Honor, pardon my interruption. I just want to know if you're reading from something or not reading.
Looks like he's counting on his fingers. Are you reading from something?
No, I am counting on my fingers.
Okay, thank you.
So, I am counting on my fingers. The Ring video doorbell, Mr. O'Keefe's height, the type of shoes he's wearing, because I needed the same type of shoes, my exemplar inspection, where I matched up the heights, the locations of the lacerations, and then the text stream data as well.
Oh, towel friends. I have never run into this kind of issue. Oh, I see. It's just that there are certain parts of this video that Twitter really doesn't like.
In addition to the text stream data you considered, considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
So there's been two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
And do you have an opinion whether, based on the data and based on the physical damage and your testing, whether that is consistent you an impact or collision with Mr. John
Collision is like,
or a impact with Mr. John O'Keefe?
it is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
In your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty, whether John O'Keefe's injuries on his arm, inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
Yes.
What's your opinion?
That it is. it is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
And does that specifically pertain to January 29, 2022, around 12:30 a.m.?
Objection, Your Honor.
I'm going to allow that.
Yes, it does.
To finish, I'd like to ask you a few more questions. You've written some papers on sideswipe collisions or clipping. Can you describe to the jury and explain what a sideswipe collision is or a clipping and how that may or may not differ from a direct hit on a pedestrian impact?
Sure. So what generally differentiates, say, sideswipes or clipping contacts compared to, say, an inline impact or, say, a T-bone impact is what refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So, for example, if I rear end a car, that car will be accelerated up as a result of the contact, and they reach what's called common velocity, and then they separate. And so in a glancing hit, you're going to have a glancing hit, and you don't have what's called complete momentum transfer, meaning the momentum from the car, because it's a glancing hit, doesn't completely transfer to the object being struck. For example, you can drive down the road at 100 miles an hour and clip the mirror of a parked car, and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going because you don't have all that momentum transfer. So when you have glancing contacts, you can have much higher speeds without a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
You mentioned about potential damage to a car. How about potential damage to the pedestrian?
It's the same thing. So when you have a glancing hit to a pedestrian, this is referred to as a fender vault. In this case, they call it a fender. Fenders on the front of cars because most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner. Type hit. The impact is kind of because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted without a whole bunch of information in that type of crash. If the impact had occurred in the center of the vehicle and we knew where the point of impact was and the point of rest, we'd have a much better chance of determining how fast the vehicle was going. But when you have just a corner clipping or glancing, it makes it more difficult to determine, even when you have an area of impact, which is where the person was when they got hit, and a point of rest where they landed, makes it more difficult for glancing contacts because you have that sideswipe problem where they don't obtain what's called common velocity.
And what are some of the other difficulties in attaining specificity in a sideswipe or being hit by a quarter panel as opposed to a fender?
So for a pedestrian, correct?
Yes.
So pedestrian impacts and how you move post-impact are very sensitive to your exact body position. For example, whether your right foot is on the ground or off the ground, whether your left foot is on the ground, off the ground, whether you jump up in response to the crash. Simply raising and lowering your arm changes the amount of rotation that's going to happen. Post-impact motion of the person. So cadavers, crash dummies don't have any muscle reaction. So the motion of a crash dummy is just going to be like you're hitting a dead body, to where people will step, try and regain their balance if possible, will do additional activities that alters where they come to rest.
In your studies of direct pedestrian collisions by front or back bumper as opposed to sideswipe or clipping somebody, Is there a similarity or difference in type of injuries that you see?
Yes.
And what is the difference?
So in direct centralized impacts, you tend to get much more severe injuries. Really what's occurring is you're getting that momentum transfer. So it's more, you're accelerating the person up to the vehicle. They can wrap onto the side in front of the vehicle at higher severities. Their head will hit the hood, their head will hit the rear of the vehicle. So when you have that direct contact, there's actually more momentum transferred to the actual occupant. There's more applied force to the occupant as well.
When you see direct impacts, is there ever the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the Accident Reconstruction Collision Safety Institute on pedestrian injuries, I went through all the literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures. It depended on how exactly the foot was loaded.
Is it uncommon in sideswipe pedestrian accidents to see no lower body broken bone?
No, it is not uncommon.
Have you had cases that you've studied or been involved with where you've studied the effect of a sideswipe or a clipping impact where there's an absence of broken bones in the lower body extremities?
Yes.
I'd ask you to turn to slide 139, please.
Oh, sorry. I fixed those other two slides.
Okay. Could you share with the jury what this represents?
Sure. So this was a trial that I was involved with in downtown Los Angeles. I've redacted the name at the top, but this was an instance where we had, this is a image from the police report. Oh, let's see if I can. So AOI in this diagram stands for area of impact. That's where the pedestrian was when they got hit. AOR is area of rest. And you can see we have information on exactly how far the pedestrian was thrown. Then on the right-hand side, we have photographs showing the impact to the pedestrian. This was determined by experts on both sides of this case to be between a 25 to 35 mile an hour impact. And then what you see is a close-up on the bottom slide of where there was DNA transfers, hair and tissue samples on the vehicle from the individual that was hit by the vehicle.
Next slide, please. And what does this represent?
So this is the decedent in the case, the person that was hit. He was killed at the scene. What you see on the left-hand image, on the left-hand image is he had a massive laceration to his right forearm, but it didn't break his arm. There was no broken bones in his arm.
Hold on, little towels. Hold on. Let me get through this last jump. A little buffer in the video here. It's right at the end. That was basically the last
arm, but it didn't break his arm. There was no broken bones in his arm.
And then Alessi stands up and gives his cross. Now, if you're wondering how bad did it get for Bob Alessi during cross, ladies and gentlemen, oh my goodness. I mean, you may have seen a little bit of it, ladies and gentlemen, to start the day, But let me just tell you, it was so bad. This thing, literally, it was so bad, it's become known as the Alessi clip. Oh, by the way, does anyone want to watch Karen clips? We should be coming back into session somewhere between 1:30, 1:40 or so. Oh, my goodness. Murder by Maestro. You missed all of today? Yes, this was today. All right, you know what? We're going to do a special towel double recap. We're not going to watch Karen clips. We're going to do a special towel recap for McCartney and Murder by Maestro. Murder by Maestro, the day started with this ruling, okay? It started with this ruling from Judge Cannoni as to what Hank Brennan's expert could testify to. You can watch the last 15 minutes if you want to actually see the testimony, but here's what Judge Cannoni ruled.
All right. Good morning, everybody. All right, so Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied. In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application. However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue because in Massachusetts that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling.
There you go. That was the ruling, ladies and gentlemen. Now, you want to see Hank Brennan filed two motions. One was a motion, one was a memorandum related to Alessi's argument about Welcher's ability to testify. The first motion that came down this morning, ladies and gentlemen, was it appears there's more Rule 14 violations. Basically, during Alessi's cross of the witness from Aperture, Shannon Burgess, Alessi tried to do trial by ambush related to like an out-of-date LinkedIn profile. It was just a stupid moment. It was really, it really offended Hank Brennan. You can tell, like, it wasn't Alessi playing by the rules of the game, and it was out of context. Now, Hank Brennan rehabilitated the witness. Anyone who has a LinkedIn profile knows you like put an expected graduation date. It's not the same as CV. But yeah, so up on your screen you can see the first motion here, ladies and gentlemen. Let's see if I can. It's kind of hard to zoom in on these, but what if I do this? All right, and then we can zoom in on this just a little bit more. Oh, how's that, ladies and gentlemen? So you can see here it's Commonwealth's motion to preclude the attempted use of any information not produced in violation of Rule 14. Both the Commonwealth and defense are bound by Rule 14 obligations during the course of this trial, notably during Shannon Burgess' testimony. Oh, I guess you don't use the Shannon Burgess is with a comma after it or with an S after that. You just put the apostrophe on the S. The defense presented documents that were not previously provided, which eliminated the ability to review and vet the documents. Oh, they didn't give it over to the prosecution. Can't do that. Notably, the defense presented a CV provided in 2023 that noted a graduation date of 2024. The effort of providing documents as a witness is being confronted with documents is improper, trial by ambush, a violation of Rule 14, and creates needless delay resulting in objections, unnecessary sidebars, and a waste of time for the jury. The Commonwealth seeks a ruling precluding the use of any material that were not noticed by the defense other than materials in the witness's CV referred to during presentation or discussed during testimony. Respectfully submitted. So there you go, ladies and gentlemen. That was just the first thing that Hank Brennan put up today, and I think he's going to win, ladies and gentlemen, because that was absolutely ridiculous for Reed's team to do that. And then there was a second motion which had to do with Welcher's testimony. It was basically the argument we talked about yesterday. Hank Brennan really went through and kind of made the argument for why Alessi's argument about restricting Welcher was so nonsensical. And so Hank Brennan says the Commonwealth intends on asking Dr. Welcher based on his hold on a second. The Commonwealth intends on asking Dr. Welcher, based on his review of all the evidence analyzed and reviewed, a number of opinions, including but not limited to: 1, whether his opinion of whether the lacerations on John O'Keefe's right forearm and arm are consistent with contact with the Lexus right rear tail, with the Lexus's right rear tail light, whether Dr. Welcher's opinion is that the Lexus collided in a clipping or side swipe manner with John O'Keefe, and 3, whether the collision occurred at substantially the same time as the reverse maneuver which he identified from the Lexus's trigger event 1162-2. Quote, expert testimony on matters within the expert's field of expertise is admissible even if the expert's opinion touches on the ultimate issue that the jury must decide. See Commonwealth v. Mendrala, quoting Simon v. Solomon, also Commonwealth v. LaCourte. Questions which call for an opinion, a question which calls for an opinion which is the domain of the expert's professional knowledge is not necessarily to be excluded merely because the conclusion of the witness reaches or approaches the ultimate issue before the jury. Oh, that's a great thing for me to know. Commonwealth v. Rodriguez, 462 Mass 415, 429 is the pin site, 212. Summation, trial court did not abuse its discretion by allowing expert testimony, even though testimony touched on the ultimate issue. Expert never offered opinion as to defendant's ultimate innocence or guilt, and expert's analysis was confined to the mechanism by which injuries were suffered, but did not speculate as to the circumstances or ultimate responsibility for injuries. Mechanism by which injuries were suffered, but did not speculate as to the circumstances or ultimate responsibility for the injuries. The only limitation is that the subject matter discussed be within the witness's field of expertise, and that the witness did not directly express his views on the defendant's guilt. See Commonwealth v. Lodge, a general expression of an opinion of guilt followed by a recital of all the evidence against the defendant is not permitted. Yeah, I would say that's probably reasonable. And then let's read the second page. All right. Okay. Expert was permitted to testify that anger, sadness, and rage, not mental illness, motivated defendant's actions. Such testimony was not an opinion as to whether defendant was criminally responsible. The Commonwealth is not asking Dr. Welcher to provide his opinion whether the defendant was under the influence, negligent, reckless, or had malice. The Commonwealth's expected opinions are admissible because they are within Dr. Welcher's field of expertise based on the evidence he relied on, and they are not directly expressing or opining on the defendant's guilt. Additionally, but separately, these opinions directly rebut what was said by defense counsel repeatedly, that there was no collision. The scientific evidence, specifically Dr. Welcher's opinions, directly refute defense counsel's opening statement. For example, the defense asserted that the evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision. Similarly, John O'Keefe, quote, did not die from being hit by a vehicle, period. Because at the end of the day, folks, there was no collision with John O'Keefe. You will learn that John did not have a single injury consistent with being hit by a car. What? Alan Jackson said that during opening? Let me say that again, said Alan Jackson. The evidence will establish that John did not suffer a single injury on his body consistent with having been hit by a car. Not one further. This is still Alan Jackson. Nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV, not a bruise. Dr. LaPosta will tell you with medical certainty, and in fact, John was not struck by a vehicle. Dr. LaPosta will tell you with medical certainty, and in fact, John was not struck by a vehicle. Medically and scientifically, not could have been struck by a vehicle. Therefore, as Alan Jackson said, there was no collision. Folks, the science will not lie. The physics cannot lie, and that science will tell you with certainty, said Alan Jackson. There was no collision with John O'Keefe. So Hank Brennan's quoting that. The defense cited Commonwealth v. Coleman without providing a copy of the case or a summary. Citing a case name does not make the case relevant or applicable. Oh, Hank Brennan was in a mood, ladies and gentlemen. Hank Brennan was in a mood. In Coleman, the medical examiner testified that in his opinion, the cause of death was homicide. The court referenced Commonwealth v. Lannon. We looked at this yesterday, ladies and gentlemen. Opining the better course was to exclude such opinion testimony, but here it was innocuous. In the Lannon case, accident was offered as a defense, and homicide could be taken to contradict the defense theory. Here, homicide does not seem to have such a contradictory implication as to the defense theory of self-defense, i.e. justifiable homicide. That was quoting Lannon. In Lannon, the medical examiner went into detail about... Hold on, ladies and gentlemen. Let me get you the third page. I uploaded these all because I'm a good little towel. Here we go. autopsy procedure he had followed to reach the conclusion of death by gunshot wound to the chest, massive hemorrhage, and homicide, and the jury could not have imagined he was expressing an expert opinion on how the shot came to be fired as opposed to the results of the shot. Based on the data, physical evidence, and expertise of Dr. Welcher, it is his opinion to a reasonable degree of scientific and engineering certainty that there was a collision between the defendant's SUV and John O'Keefe that occurred around the time of the defendant's backing maneuver in front of 34 Fairview Road on January 29, 2022. You go, Hank Brennan. Oh, you go, Hank Brennan. You hit it out of the park, Mr. Brennan. You hit it out of the park, Mr. Brennan. Towel is proud of you, Mr. Brennan. Now, you might be saying, oh, ladies and gentlemen, I'm trying to get caught up. My name is a various form of towel, and I want to get caught up on what happened today. Well, ladies and gentlemen, Bob Alessi got embarrassed. Bob Alessi got embarrassed. Look at this, ladies and gentlemen. Murder by Maestro. I want you to laugh along with us here. Look at this.
So you've been on this.
I want to just preface this by saying Bob Alessi literally did not know when this expert was retained in the case, tried to impeach the expert about how long the expert had been involved in the case, and then fell flat on his face. Oh, ladies and gentlemen, it was the Bob Alessi clip seen around the world. I'm telling you, this was one of those moments I could have gone into horse racing announcer towel mode. Ladies and gentlemen, it was truly incredible. Watch it in real time. Murder by Maestro. Get ready to belly laugh. Try to compose yourself, my friend.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's, what, less than a year ago?
Understood. I'm moving on to the next question because I want to move away from that discussion and just go right to the bill. You, as you sit here today...
Ladies and gentlemen, for Lefties Gaming Lulz, I love your username. We're going to watch the clip one more time. I hope you're ready for it. It's so great. Bob Alessi tries to impeach the witness with the timeline, and the witness is like, excuse me? It was great. Oh, Bob Alessi, crash, burn, crash, burn, towel laugh, crash, burn, towel laugh. Oh, it was great. One more time.
Exactly. So you've been on this for 2.5 years. So if it would take months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was detained in September. That's, what, less than a year ago?
Understood. I'm moving on to the next question because I want to move away from that discussion and just go right to the bill. You, as you sit here today...
That was for you, I want you to know, all of your fellow towel friends, the hell out of that, my dear friend. Thank you for having us watch that. Oh, Murder by Maestro, we also have exhibit documents, my dear friend. Exhibit documents in the John O'Keefe and Karen Reed trial. All 100 and something pages of Karen's text during the affair with Brian Higgins. The picture of Karen's taillight clearly broken at 8:23 a.m. Yes, we got exhibits 1, 2, 3, 6, 7, 8, 10, 11, 12B, 13, 16, 18, 19, 20. Exhibits 24, 25, 26, 28. Exhibit 123 and Exhibit 132. Oh, ladies and gentlemen, Little Towel is on it. Little Towel is on it. Little Towel is absolutely on it. Yeah, I'm just a little towel. I try to create a welcoming, friendly environment. And you know what, ladies and gentlemen? Who is feeling like we may need to watch Karen clips? I just got this feeling in my soul, ladies and gentlemen. We haven't seen Karen clips in a few days. And I was thinking to myself, you know what the towel friends want, ladies and gentlemen? The towel friends during lunch, as we wait for court to come back into session, yes, they want to watch Bob Alessi getting absolutely humiliated because it's hilarious. But what they really want, what the people really want, is Karen clips. Now, before we do Karen clips, I think there's actually one more clip for Colleen Henry out there. Ladies and gentlemen, if you don't know Colleen Henry is just a wonderful super towel. And Colleen Henry always has just one simple request. If I can brighten someone's day by something like this, you know I'm going to do it. Colleen Henry, there is a specific clip that Colleen Henry likes. You know it's coming, ladies and gentlemen. Before we watch the Karen clips, before we get caught up, before we have the moment leading back into lunch, we should be done back into session sometime between 1:45 and 2 o'clock. But ladies and gentlemen, yes, absolutely. I absolutely agree. Murder by Maestro, Bob Alessi was. Let's just move on. Let's just move on. Let's just ignore that, Dr. Welcher. But yes, ladies and gentlemen, you know what I'm about to play. It is lunchtime. You're spending towel lunch with me, and there's only one clip that Colleen Henry would want to see, and I think so many of the other towel friends are going to want to see. Oh my goodness, ladies and gentlemen, it is that clip. It is that moment. It is that towel. It is the super towel himself, Mr. Hank Brennan. Let's take a look, ladies and gentlemen.
You as well, Mr. Brennan. Okay, sir, I will, Hank.
One more time.
You as well, Mr. Brennan. Okay, sir, I will, Hank.
Everybody loves the "You Can Call Me Hank" clip, ladies and gentlemen, as we get ready to return to session in the John O'Keefe and Karen Reed trial. Yes, we should be back into session. I'd say somewhere in the next, probably 20 minutes here, 15 to 20 minutes, and I'm a little towel. I'm with you. I'm watching. I'm monitoring. I got a collection of Karen clips I want to show you. You know why, ladies and gentlemen? Because my name is Grant Smith Ellis, and there is nothing better than putting together a compendium of Karen clips and watching it with the towel friends. That's literally my eudaimonia. Some people have a certain calling on this earth. You know what my calling is? To play Karen clips for the towel friends. Ladies and gentlemen, and you can say, sir, that is a very strange thing to want to do. But you know what, ladies and gentlemen? When the people demand the Karen clips, I rise to the moment, ladies and gentlemen. I will never fail to rise to meet that moment, especially because I've already talked through through 40 minutes of the lunch break, and we should be coming back into session just any moment now. So as we get ready for Bob Alessi to get humiliated again on Cross, ladies and gentlemen, and for Karen Reed to continue to lose the color from her face, quite obviously, ladies and gentlemen, I'm going to play us a collection of Karen clips. We haven't seen any Karen clips in a while. Is Hank Brennan going to play more Karen clips? Ladies and gentlemen, before the end of the day, what if Bob Alessi can't go for a full 2 hours on Cross? Well, I shouldn't say that. Oh, goodness, I jinxed us. Bob Alessi is going to talk until sometime in mid-July, ladies and gentlemen. He does not know when to quit. Oh, but that's right, folks. You know exactly what we want to see. We want to see the Karen clips, the compendium of Karen clips, as you may call it, ladies and gentlemen. You may want to call it a collection, a compendium, just a towel. I'm just generally a towel being a towel. But yes, ladies and gentlemen, I'm absolutely going to grab that compendium of towel clips for you. There's been so much going on this week. We will continue with the afternoon session of the John O'Keefe and Karen Reed trial at the conclusion of today, ladies and gentlemen. But you know, ladies and gentlemen, that what the people want to see, the towel friends want to see, the world wants to see, it is the compendium of Karen clips. And I may have to scroll back for you, ladies and gentlemen, but it is a labor of love. Just to go back to May 22nd, 6 days towel post. Oh my goodness, it's Baby Lucky. Ladies and gentlemen, can we take a pause and just say hello to Baby Lucky? Hi, Baby Lucky. Murder by Maestro got that.
I needed to get into my truck and get that prepared to go out. It's called the Franken truck. It is a truck that has a lot of different parts than what it's required.
No, Wild Roses. TV is not in the courtroom today. He couldn't get in.
It's not parts that were
Baby Lucky
made
can
for
get
that
in.
specific
Baby Lucky can get in, though.
Specific truck. It was a truck that was very uncomfortable at the beginning to use, so they tried to make it as comfortable as possible. Franken truck has an air ride suspensions, an air ride seat, so the seat is raised so I can see over the hood, and I can see about 5 either side of the passenger side, driver's side.
Towel loves Baby Lucky. Ready for Karen clips. You know you want to see Karen clips, ladies and gentlemen. Karen clips, Karen clips. Karen clips, Karen clips, Karen clips. Say that 5 times fast. Oh my goodness, it's Bob Alessi, Chewbacca, and the Stay Puft Marshmallow Man. Look at this adventure through Towels X feed, ladies and gentlemen. Oh, it's Chewbacca, the Stay Puft Marshmallow Man, and a bunch of towels. Oh, ladies and gentlemen, I'm a little towel. I'm a little towel, short and stout. I'm actually not short. I'm 6'2" and about 175 pounds, and I'm a cute little towel. Yes, ladies and gentlemen, I am a cute little towel, and I know it. You know why I know it? Because I walk around and I smile and I say, I'm a cute little towel. And then people are like, oh, he's such a handsome, cute little towel. And then I'm like, oh, I am a handsome, cute little towel. and also do a really good job of collecting Karen clips. A compendium of Karen clips. Who's ready, ladies and gentlemen? Are you ready? Ready your towels. We begin the peaceful invasion of northern France while walking with Karen clips on the march now.
So we approach from the north, we actually missed the turn, and John says to me, it's Fairview, we just passed it, it's back there, it's on my left. I said, all right, so I pull nose into a driveway and back out onto the street, which I now own as Cedar Crest, and then come from the north onto Fairview.
Like the next play, clip 25.
At 12:41, I leave a voicemail to John. You can clearly, and this will probably be played on Monday, you can clearly hear me pull into John's garage. You can hear my car sensors beeping as I come close to the sides of the garage. And then you hear the car go off, and then you hear the sled ding, ding, ding as I open the door, shut the door. I had high heels on that night. You hear me walk in, go into the stairs up into the kitchen, shut the door. You hear me walk in the kitchen. It's like a full minute long. That's at 12:41.
And finally, clip 24.
I do. I mean, I'll tell you, John and I argued the morning of the 28th, Friday morning. So we think we died right around 12:25, 12:30 on the early morning of January 29th.
Thank you.
Hey. Very good. How are y'all? Any reaction to the clips, Karen, that are being played?
No. So John's laying there, his left and his right, and I approach John from the left. That's where the street is. And he had a piece of glass, like, perched on his nose, like, just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face. Totally more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
Any window here that you guys have really been going at it. This was sort of had like a last date element to it. Was that going on?
That was not going on. John made it clear to me, I'm never breaking up with you. You know, not never that we're in this good or bad, but you're the best person I've ever.
The Commonwealth would ask to show clip 19.
Okay.
I don't see how John would have known about my text with Brian. And I'm not sure if he knew he would have reacted very strongly. I think we would have broken up, but I don't think John would have lost it and caused a fight. I didn't feel like John's emotions with me got really strong. He didn't look mortally wounded as far as I could see, but could I have done something that not
and drunkenness and in the cold didn't come to again.
And this was the moment you dropped them off at the party.
Yeah, would have had to. And his mother leans over the kitchen island and says to me, I think it looks like you got hit by a car. It looks like you got hit by a car.
All right, who's your next witness, Mr. Brennan?
Next witness is Jean Demoulas.
Karen, did you see John go in the house? I did. You saw him go in the house? I saw John go in the house.
Can you describe him going into the house? Which door and how and when?
No, I have, though, and I'm sure the prosecution will play it. John looked like a buffalo on the prairie. It was just a lawn and a heat that it wasn't a bush or a hydrant or a dog. It was a weird shaped lump at that time in those elements. And I was looking to find him on the side of the road. I was expecting I'd find him. And I was looking to find him on the side of the road. I was expecting I'd find him. So when John got out of the car at Brian Albert's house, he took my full vodka soda, which is sitting in the cup holder.
Thank you.
Comment?
That.
Thank you.
All right, your next witness.
One more, please, Your Honor. The Commonwealth moves into evidence and seeks to play clip number 17, please.
Okay.
I gave an interview with ABC with Matt Gutman. I think this was whom I gave the interview to, and I said, he asked why was I saying, could I hit him, did I hit him? And I said, yeah, my first thought was, I've been out late, I've been drinking, and he's in the general vicinity of where I last saw him. I mean, they talk about the left side of the property and the right as if it's, Hammersmith Farms. It's a postage stamp. It's 50 feet. So he's in the front yard to the left of the front door, and no one's coming out of the house. Jen's telling me nobody's seen him. So I'm thinking, Jesus, was I starting to pull away and I ran over his foot? Like, he's roughly where I left him. So yeah, when I found him, I was thinking, did I clip him somehow?
Anything more to say about the clip that was played today?
No, thank you.
What about the clip that's inaudible? Can you say what's in that clip?
I'm sorry, Matt. Just hit you.
How about the, do you remember making those phone calls, Sam?
Yes.
What was your emotion?
All right, Ms. Roberts, please. Okay, thank you.
We'd like to play this first and then call Ms. Roberts.
Oh, okay, I'm sorry.
Thank you, Your Honor.
I remember it, but I question, do I remember it because it's been relived so much? I mean, when I see the video of me driving from the waterfall, like what I just described.
All right, got to break in, friends. I'm seeing the Karen cam. It looks like we're about to come back into session. Who's ready, little towels? We're ready. We ready, little towels. I tell you right now, I'll switch over to the other screen. You stay right here, little towels. We're about to come back into session. Bob's going to crash and burn. I'm going to continue to be a little towel, and you are all wonderful little towels as well. It was great spending the lunch hour with you. You know my name's Grant Smith Ellis. I want to tell you, folks, if you benefited from this lunch hour, if you enjoyed this content, feel free to like and subscribe to the channel. It really helps Little Towel Stream if you like and subscribe to the channel. And more so than just that, ladies and gentlemen, I'll even come back on camera to give you a little hello. I'm a towel. Oh, you wonderful towel friends. I'm going to miss you so much during the afternoon session, but I promise you, court is on lunch, but as soon as court comes into session, you're going to get to see the special towel coverage, ladies and gentlemen. Oh, there we go. I switched over. Now, ladies and gentlemen, we just have to wait for the Karen Cam to come back into session. You wait up 1 second. You just wait for Little Towel, and I will be here ready for you. I actually got to set the Karen cam up, ladies and gentlemen, so you watch in real time as Little Towel gets that done. And if, for whatever reason, the court audio does come on first, we also have that up and ready. We are prepared towels, ladies and gentlemen. God bless all spending some time with Little Towel during lunch. Didn't that feel like it went by like it was nothing? That was 55 minutes, Little Towels. We spent 55 minutes together, but when we do that, it feels like 5 minutes. And yes, Wicked Uma, be with us, Lord, for Bob Alessi's cross. It's going to be ridiculous. But ladies and gentlemen, this witness is brilliant, and Bob Alessi is outmatched in every sense of the term. So we'll have the Karen cam ready to come up and ready to go as soon as it is live. And while that is happening, I'll continue to talk to you. Now, ladies and gentlemen, I am a towel, so I just have to be my little towel self. Sometimes I get excitable. I turn into horse racing announcer towel as we come back into session. I pray your forgiveness for that. I don't mean to make you excitable or otherwise interrupt the ebb and flow of your day. I just am a horse racing announcer towel. I don't know what you want me to tell you. If I wasn't a horse racing announcer towel, I wouldn't be interested in horse racing announcing, but I am very interested in horse racing announcing. I am more interested in horse racing announcing than Bob Alessi is in asking didactic questions during cross, ladies and gentlemen. Yes, you may as well call me Grant, Howard Cosell, David Attenborough, Towel Smith Ellis, because of my affinity for being a horse racing announcer towel. Now, you might say, sir, I don't think any towels anywhere have actually done horse racing announcing. Well, you know what? Ladies and gentlemen, history is defined by the towels, and I thus will become a horse racing announcer towel. Oh no, The Fan. We are not watching The Fan. As you know, reporter towel Christina has one rule for us on this stream, ladies and gentlemen, and I enforce this rule very strongly. We do not watch The Fan. The Fan is illegal in the world of towels. Instead, we get Chewbacca and the Stay Puft Marshmallow Man to pop up out of nowhere with their super fan powers. And look, oh, they stopped the fan from spinning, ladies and gentlemen. Look. Yes, sis, I know. I have a bunch of different motifs and characters that come up on Towel Stream. There is horse racing announcer towel, auctioneering announcer towel, lay legal commentator towel. Sometimes I also talk about kangaroos, pandas, koalas, peacocks, and camels, and then also creating sustainable towel production to protect the petrodollar and ward off the rise of the BRICS. Now, there's also a picture of a dog in a wig, a dog named Chloe in a wig on the stream. You might be wondering why, while I'm watching a trial, is there a picture of a dog named Chloe in a wig? Well, listen, it gets a little bit complicated. It involves a multi-layered story that really traces back to Chewbacca. Now, if you want to figure out a little bit about the Stay Puft Marshmallow Man and Chewbacca, who are a very interesting duo, it's a very interesting subplot in the John O'Keefe and Karen Reed retrial, then you can figure out a little bit, ladies and gentlemen, about why Chloe the dog in a wig is actually Chewbacca. Now, you might be saying, isn't Chewbacca a 7-foot-tall Wookiee who lives on the planet Ewok? Well, or lives on the planet, lives on a planet with a bunch of Ewoks. Well, yes, ladies and gentlemen, that is technically true, and that may have nothing to do whatsoever with the trial, but that's kind of the point. Karen Reed's defense is just nonsensical, and it involves a dog in a wig who thinks she's Chewbacca. So once you figure that out, ladies and gentlemen, once you figure that out, oh, everything just starts to align right up. Bob Alessi's nonsense makes a lot of sense. Me being a towel makes a lot of sense. The Stay Puft Marshmallow Man, that was actually Alan Jackson's fault. He was describing a fluffy coat during cross-examination in the early days of the retrial, and he asked the first responder if a person in a fluffy coat looks like the Stay Puft Marshmallow Man. And I was like, well, you did it now, Alan Jackson. I am never going to stop talking about the Stay Puft Marshmallow Man. In fact, I'm pretty sure Alan Jackson and Karen Reed probably had a conversation where Karen was like, do you realize that you saying the three words Stay Puft Marshmallow Man, or that might be 4 words, do you realize just saying those 4 words means that Grant for the next 6 weeks is only going to talk about the Stay Puft Marshmallow Man? And I'm pretty sure Alan Jackson was like, yeah, I realized that. I knew I walked right into that one. And then she was like, walked into it? No one asked you to bring up the Stay Puft Marshmallow Man, Alan. That was completely unnecessary. Oh, goodness, ladies and gentlemen. I appreciate that people like the little pic of Chloe, the dog, in a wig. I think all of 19 who, if they're out there listening, helped us find that wonderful pic of Chloe the dog in a wig is a super towel. And my name is Grant Smith Ellis. We should be coming back into session in just the next 1 or 2 minutes here in the John O'Keefe and Karen Reed retrial. As you can see, we don't have to look at the fan spinning, and also Towel's practicing his syntactical precision. I'm working on expanding the elasticity of your brains by simply packing so many words and letters into my speech per minute that it forces you to literally evolve into a new state of being to be able to take in all this information. I think it will create some kind of symbiotic benefit where I can speak faster. I learn how to pace my syntactical delivery in such a way as to confound Murder by Maestro when he listens to this at 5x speed on replay, while at the same time informing you all and also expanding the elasticity of your brain, such as to facilitate you taking on the form of learning this information at a rapid pace and thus going out into the world, spreading unconditional love, being absorbent towels, and bringing about a new digital epic, not just defined by the water bearer, but defined by the water bearer carrying a towel. Now, you might be saying, sir, does that all of that actually fit into the motif that you talk about on this stream all the time? Yes, absolutely. Somehow it absolutely does. And I also have been practicing speaking really fast because I think I'd like to be one of those people on the radio who says the very fast part at the end of commercials where there are warnings and disclaimers. That or a horse racing announcer towel. Oh, Colleen Henry, don't worry. We already did the CW filings. You can find them up on my Twitter, or if you go back roughly 50 minutes in this stream or so, maybe a little bit more or less, so somewhere around 110 to 120 in this stream, you'll see we read them out. I spent about 10 minutes reading over the filings. It's a one-page filing where Hank Brennan says that the Reed defense ambushed witness by trying to bring up stuff that wasn't turned over in Rule 14, reciprocal discovery, which is true. That's what Bob Alessi did with that nonsense LinkedIn stuff during the Shannon Burgess testimony last week. And then the second motion wasn't really a motion. It was a memorandum of law to supplement Hank Brennan's oral argument during yesterday's oral argument related to the testimony of Dr. Judson Welcher. Judge Cannoni ruled in Hank Brennan's favor on 2 of the 3 issues this morning. Welcher was allowed to testify about the collision involving Karen Reed's Lexus, John O'Keefe's injuries being consistent with a sideswipe collision, etc. And then the jury was allowed to draw an inference that the collision between Karen Reed's car and John's body caused those injuries. So, ladies and gentlemen, that's basically your update on the Commonwealth's filing. I'm happy we already looked at those filings, ladies and gentlemen. Literally, those were the two documents we read earlier in the stream. It was actually one filing. It was a Rule 14 motion. We literally already went over it on the stream, so I don't want anyone to get overwhelmed. It was literally the document we read earlier during lunch. That it was the Rule 14 one-paragraph motion, and then it was the memorandum of law in support of Hank Brennan's oral argument from yesterday. So the one page, the only thing that's left to be ruled on is the motion from Brennan related to the defense not using documents outside of that haven't been turned over in Rule 14 reciprocal compliance. And then the other memorandum of law was related to what Judge Cannoni already ruled on at 10 a.m. this morning before Dr. Welcher concluded his direct examination. I hope that makes everybody happy. Yes, so another thing is I really do appreciate all you towel friends because I feel bad. A lot of the other streams, yes, I think they have, towel friends or their own version of those towel friends that help in the chat. But this is one of the only chats where people don't even bother because what are you going to do in this chat? Literally every single person that talks can just remove your comment. So a lot of people are like, oh, it's just a wall. Why would I even bother? Now, I do feel bad for other channels and that's part of the reason, folks, that I really appreciate this community. I put so much effort into these streams. I stick with you through every break, through every sidebar. We never, unless I'm going to get water or a lunch or whatever, we never have any really drops off in the coverage at all because you all are so dedicated to this channel. You're always chatting with each other. You're so friendly, and your support of the channel, I think, insulates it from a lot of that toxicity that invades and is pervasive throughout this case, in particular in the digital arena. But also, listen, I like John DePetro. I like Kevin from Yellow Cottage Tales. I don't think he likes me very much. I don't really care. But I like some of those people. But when you hang around Kate Peter, I mean, what happens is that people will look at you as an extension of Kate Peter, and they'll be toxic to you. It's like when you hang around Aiden Kearney. Like, people are like, why do I get a bad rep because I know Aiden? Like, some of those Aiden supporters are salt of the earth, good people. Some of Kate's friends, salt of the earth, good people. But you become a proxy for Kate's toxicity. You become a proxy for Aiden's toxicity, whether you want it or not. So, that's how I feel about it. So Deb H, yes, that's very true. The working human memory is about plus or minus 7 to 9 items, or plus or minus 7 items. So I think the human mind can keep track of 5 to 9 things. The average human mind can keep track of 5 to 9 things at once. If you're doing more than that, if you can remember more than that, that's incredibly impressive. If you're remembering less than that, it's not a problem. Just means you can work, and it might not even be your fault. You could have some kind of trauma or otherwise impacting your memory. But the average human's working memory has 5 to 9 items memorized simultaneously at any one time. So yes, ladies and gentlemen. So Kate Peter, just so folks understand, that's Mafia Masshole. She used to work with Aidan Kearney until 2019, depending on whose side you believe. They had a falling out over money or something. So, or Kate tried to go off on her own, Aidan wouldn't let her. It's just this weird situation. But anyway, Aidan and Kate both are facing felony witness intimidation charges related to the orbit of this case and their interactions with each other, and Aidan interacting with the Karen Reed trial witnesses, some of whom know Kate. It's just this weird, like, overlapping high school-esque social circle that resulted in a bunch of felony witness intimidation charges for Aidan and Kate. And so both of them, if you ever wondered, like, why is the atmosphere around the Reed and the O'Keefe case so toxic? For a long time, it was because of Kate and Aidan. Oh, and folks, the court comes back into session right there. It's like, it was like, Grant, all right, that's enough. I said my piece, ladies and gentlemen. It's true, though. Kate Peter, Aidan Kearney, more so than anything else, responsible for the toxic atmosphere around this case, in my opinion. Oh, folks, you H-Towel, it's so good to see you, Sheffield Flanu. You came right in time. The Karen cam literally just turned on. Oh, you are an impeccable timing, Super Towel. Ladies and gentlemen, we're going to get into session any second now. As you can hear, the court started to beep up. We're just waiting for Judge Cannoni to call the horse racers to their positions, and they are
Mr. Leslie, whenever
off.
you're ready.
Just take a moment, Your Honor, to reorient. I'll be right. Good afternoon, Dr. Welcher.
Good afternoon. Nice to see you again.
Same. We had left off talking about some examples of Newton's second law and the application of it in the parlance of force equals mass times acceleration. And I now want to continue on with that discussion. It is correct that you can conduct a force analysis on any part of the body, correct?
I mean, it's more difficult on internal with live people. Like if you wanted, like my appendix, I really necessarily couldn't.
Let's talk about the musculoskeletal system, the outside bones. You can conduct a force analysis
So
on
the
any
bones are
bone.
on the inside.
Sir, if I could finish my question, please.
Okay.
You can conduct a force analysis on any bone in the body, correct?
More or less, yes.
So the force analysis I use as a synonym with Newton's second law is not exclusive to the head, correct? You can do it on other bones in the body, correct?
Correct.
On direct examination, your direct examination here, you did not present a force calculation representing what you allege to be contact between the vehicle and Mr. O'Keefe's right arm, did you?
Correct.
And nowhere in your report do you present a force calculation for Mr. O'Keefe's right arm, do you?
Correct. We didn't have enough information to do it.
We're going to get to that.
Okay.
Now, given that you stated that, quote, determining the effects of physical forces on the human anatomy, end quote, is the job of a biomechanical engineer, you must have conducted several force calculations related to accidents involving humans in your career, correct?
Hundreds.
Hundreds. Now, you didn't present a force calculation in your materials, as you've stated on direct, with regard to the arm, and I'll include in the right arm going from the shoulder all the way to the tip of the hand. Okay, so that's my definition of a right arm. You didn't present any force calculation on that part of the body of Mr. O'Keefe, did you?
Correct.
Assume, and we're going to apply Newton's second law. Assume Mr. O'Keefe's hand weighed 7 pounds. So that's the M in the F equals MA.
That's not a good assumption.
Well, what number would you like to apply for an M for the hand of Mr. O'Keefe? I'll take any number you got.
Just the hand?
Just the hand.
Oh, the whole arm of Mr. O'Keefe weighs approximately 12 pounds.
Okay, fair enough. So the whole arm is either from the shoulder down to the tip of the fingers is about 12 pounds, right?
Correct.
Okay. So assume that the Lexus SUV was traveling at 20 miles an hour. All right? Under your theory going backwards, 20 miles an hour. And the third variable I'd like to give you is to assume an impact window of 10 milliseconds.
Okay.
Can you calculate the G's of force from that data?
You need more information.
Well, let me ask you this. What more information would you need?
So we talked about the glancing impact?
I'm talking about a force calculation of an impact, not as to whether it's glancing or not.
So you want a direct head-on impact in the arm, not a glancing hit to where the Lexus comes in, hits the arm, and they continue off together?
I'd like to start with that, but just so we can hopefully expedite it for the jury.
Okay.
I'm going to want to get to what you have depicted in your diagram of holding the arm out. And that's not a glancing impact. Is that, sir, with the right arm in parallel with the back of the Lexus?
Yes, it is. So really I'm sorry, let me finish, please. What you're concerned about is where the center of mass is. With the center of mass out towards the corner of the car, that becomes a glancing contact. So you don't have a center of mass contact, you have a glancing contact.
Okay, fair enough. So let's start the first force calculation.
I need my calculator.
I'm going to let him use his calculator.
Sure.
Okay.
Tell me when you're ready, sir.
Go ahead.
So let's take a scenario where it's a center of impact.
Center of mass.
Center of mass impact, right?
Okay.
Impact to the right arm.
Okay.
Let's start with that one.
Okay. And you want me to use like a 10 millisecond?
Yeah, be conservative. Yeah, let's use a 10 millisecond for the impact window.
Okay, question?
What do you get for F of force in the F equals M times A calculation?
About 2,188 pounds. I made a triangular crash pulse assumption.
Right, and if you took the milliseconds in half, become less conservative, would you end up doubling the 2188 number?
If you cut it in half, you would double, yes.
Exactly, through a simple mathematical, semi-algebraic application of the numbers, correct? You divide.
Correct. We're doing a little simplification in terms of the crash pulse shape, but generally, yes.
Right. So, but let's take the conservative number, the lower number, 2188, that you came up with. Do you know from the literature, as you did with the head, you went to the literature and said, this is how much pounds of force the F you would get to have to cause a break at the occipital bone. Do you know from the literature how much force it would take to break an arm bone?
I have an idea, yes.
What is your idea?
So for a distributed load, such as this, not a concentrated load, you're going to need somewhere between, I've seen, and this is for cadaver tests, a low of like 2,500, maybe a little lower, to a high of 7,000.
Sir, you have switched, haven't you? We're talking about center mass impact. Did you in your calculation just switch to a side swipe impact to do your calculation?
No.
I'm asking about a center of mass impact. How much force would you need? Let's start with the hand. Maybe it's a simpler one. Do you know how much force it takes to break, any of the hand bones, you know what I'm referring to, the phalangeals,
yes,
the metacarpals?
Correct.
How much pounds of force do you need to break any one of those bones?
Actually, I didn't find any distributed loading on the amount of force. I don't know.
Well, no, I understand. But I'm asking, do you know from the literature, not a calculation? Doesn't the literature tell you? Can't you go to the literature like you did with the head and you say, okay, to break the occipital bone, the literature says you need a minimum amount of force of this. I'm asking you the same question for the hand. If you don't know, it's okay. But do you know what the literature says for how much force is needed to break a bone in the hand?
So for a distributed load across the hand, there are distributed load tests that show you need over 300 Gs on the arm to do that. So it would depend on the mass of the hand.
What is the range of force that you would need to break a bone in the hand? Do you know from the literature? If you don't, that's okay.
I could probably figure it out.
How long would it take you to figure it out? Do you know from the literature what that number is?
Not off the top of my head, no.
Is 300 to 400 pounds of force sound right from the literature that it would take to break a bone in the hand?
For a distributed load,
yes,
such as the taillight? No.
No, not a distributed load. A load from a motor vehicle going backwards.
Right, that's a distributed load.
Right. So you're saying 300 to 400 pounds of force would not be enough to break any bone in the hand. Is that your answer?
So for a flat distributed load, like hitting the taillight, you're going to need higher.
How about another part of the back of the vehicle?
I guess if you hit on the very corner and it wasn't a distributed impact, like if you had a more concentrated impact,
yes,
that could increase or decrease the amount of force required.
How much would it decrease it from the number you gave?
Depends on what you're hitting, what it's made out of.
The
contact
Lexus
area.
SUV. Let's assume. I'm sorry.
Mr. Les, can you repeat the question, please?
Absolutely. Thank you. Let's assume we're talking about this Lexus SUV, right? But let me back up. You don't know where exactly, under your theory, that there was a contact. You don't know, you testified to on direct, you don't know exactly where that point of contact is.
Correct.
You don't know.
Except it's on the taillight.
Well, you're saying it's on the tail light, but you didn't observe any impact yourself personally, right?
Did I see Miss Reed's Lexus?
You didn't see the impact, correct?
That is correct.
So, and there is no first-hand witness that saw, under your view, that a collision occurred. There's no witness to say where the arm was, correct?
There's no person that saw it.
Right. And you have chosen a point of contact, okay? You chose that for your analysis, correct?
Correct.
And you picked that location, but it's also possible that under your theory that a collision occurred, that that arm could have been impacted any part of the back of the vehicle. That's possible, isn't it?
That's not probable, no.
I'm asking, is it possible?
Anything is possible. I don't deal in possibilities, I deal in probabilities. It's not probable.
So, but you don't know exactly where the point of impact was, correct?
So within the range of the light and the exact angle of the hand, no, I don't. What I do know is at the rear tail light area.
So your assumption is that it had, that because there's a tail light that is altered, it must have been by Mr. O'Keefe's arm. That's your conclusion, correct?
My conclusion is there are tail light fragments, a broken glass, lacerations to his arm, and his DNA on the back of the vehicle in the area of the taillight.
Sir, and Your Honor, I'm going to move to strike the DNA part of that answer for obvious reasons.
I'm not going to strike it.
Okay, so you're making assumptions. You're taking what you view to be certain data, and you're coming to a conclusion, but that is based upon circumstantial information, correct? Is that fair?
Are you calling like pieces of the taillight at the scene around his body circumstantial information?
Sir, let me go to the force and go back to the force analysis. Let's go back to the numbers. I want to stay on, if we can, just the calculation. So let's go back to the minimum amount of force you understand from the literature that it takes to break any bone in the arm from the finger up. Let's start with a hand. What's the minimum amount of force that can be applied to break a bone in the hand?
So it depends on the loading. So I don't actually know. In terms of the forearm, I can tell you there's data that shows up to 300 Gs of loading, you will not get fractures. There's one up to 750 Gs showing no fractures for a male of similar height and weight of Mr. O'Keefe.
Thank you.
You're welcome.
So let's take those numbers, okay? You said 300 and 750. Did I hear it correctly?
You did.
Okay, that's the numbers you gave that would break a bone, correct?
So the 300 actually didn't break any bones, I believe. The 750, the one example, didn't break a bone, but as you got above 350, you started to break bones.
So
300.
You got above 350.
300.
Above 300, yeah, because that's what I thought you said the first time. You got above 300, you start to get breaking bones, correct?
Correct.
And so if you take that 300 number and compare it to the 2,188 pounds of force, you have 7 times the amount of force necessary to break the bone, correct, in the force analysis?
No. If you take 300 Gs times a 12-pound arm, you get 3,600 pounds. The calculation you asked me to run earlier gave you 2,188 pounds.
Right.
So you are 1,412 pounds above the force required, like the tolerance is 1,412 pounds above the force you would say get in a 20-mile-an-hour impact in terms of the fracture forces.
Let's do it this way.
I'm sorry?
Let's do it this way.
Okay.
The force that you calculated from my hypothetical of this Lexus SUV going backwards, you came up with the F number of 2,188, correct?
I'm sorry, I didn't. What was the? You said
2,188.
You said dyslexic. Or do you say Lexus? I didn't understand what you said.
The Lexus
My apologies.
SUV that you've been talking about.
Gotcha.
Okay.
I didn't hear it.
You came up with a number for F for force of 2,188. Are you changing that number?
Nope.
Okay, so let's go with your number of force from this vehicle of 2,188. I'm just simply asking, how much force does it take to break a bone in the right arm of a human being? How much force, not acceleration, how much force does it take to break a bone in the right arm?
Sure. So somewhere between 2,500, the one cadaver tested the distributed load of someone of similar size and weight, and actually close in age to Mr. O'Keefe, showed about 7,000 pounds of force to break it.
Let's go to the hand. Do you disagree that the literature shows it only takes 300 to 400 pounds of force to break a bone in the hand? Do you disagree with that?
Your question's too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point. But if I distribute the load and a broader load, such as hitting a taillight, it takes much more force because the load's distributed across it. It's like if I sit on the corner of my bed. I might sink in this far when I sit on the corner of my bed, but what happens when I spread my load out, when I lay on my bed like this? I don't sink in as far. Has my weight changed? And weight is basically force. No, but I've distributed it over a larger area, so for a given force, you get less sinking into the mattress. So if you hit a broad surface like a taillight or a wall like this, it takes much more force than if I were to take a singular small round object and jam it into the hand. That hurts. This does not.
Okay, if you can hear my question, if it's unclear, you tell me. For not a pen, not your bed, but for a Lexus SUV of 6,000 pounds, is there any part of the back of the Lexus in any manner where you can get a break to the hand from 300 to 400 pounds of force?
Any part on the back of the Lexus?
Yes.
Probably.
Okay. So probably, your words, you can get a break to the hand from just between 300 to 400 pounds of force. That's what you just said, correct?
So you're taking the totality of the back of it? Like if you got it stuck in the bumper? Potentially, yeah. But from a taillight or a broad flat surface? No.
I'm not asking about a taillight. Any part of the back of an SUV, you agree that it is probable that you can get a break of the hand bones from just 300 to 400 pounds of force.
Your question is incomplete, right? You said any part of the back, but then you wanted me to not include taillights or not include the rear body panel. If you hit a very narrow part of the car, like say the edge of the tailpipe, that creates much more of a narrow contact. So force divided by area is pressure. So if you have a very tiny area, you have very high contact pressures. And so, but if you distribute the load over a larger area, the number on the bottom of that fraction is much bigger, so your contact pressure drops. So hitting the edge of the exhaust pipe is going to have a much higher likelihood of causing a fracture than hitting flat against the taillight.
Okay, what we're going to do to make this more efficient, excuse me, sorry. Mr. Wolk, can you pull up a slide from Mr. Wolk's, or Dr. Welcher's presentation for the back of the Lexus, please? The back hatch, and Your Honor, may we publish that?
Sure. Do you know what number, though, Mr. Leslie?
Mr. Wolk does, and
And
I
then
know
he'll
you
tell
need it,
us.
so he'll tell me before I publish, and then we'll give you the number.
Your Honor, may I look here?
Yes, I'm going to let Dr. Welcher look at his slide.
Oh, sure.
Here
Yeah.
instead of just up there.
The back hatch, yes. Do you have one of just the rear gate? The one measuring the height, maybe? There we go. Thank you. Part of the back of the Lexus SUV that has that more concentrated area where if the hand hit it, 300 to 400 pounds of force could break it. Is there any part, for example, the edge of the license plates, above the license plates, the L symbol that sticks out that would be concentrated? Anything you see there, could 300 to 400 pounds of force contacting at any of those points cause a fracture of any of the bones of the hand?
So, I don't know how to show this because in the middle photograph, right where the 2 is on the license plate,
yes,
there's a vertical edge. That area is recessed in. So if you hit right on that vertical edge, that could potentially do it.
That could do it. How about the L of for the Lexus symbol if the hand is there?
No, it's not deep enough. The compliance of the hand is just going to sink into the car.
Is there any other part other than the license plate that the force applied, you would only need 300 to 400 pounds of force to break the hand?
Maybe the exhaust pipe, and potentially if you hand your hand up near the spoiler.
Right, so now let's go from 300 to 400. Let's go to the 2188, which is your number. Use 2188. Is there any place where in 2188 force you could have a fracture of the hand on that back gate?
Just to be clear, 2188 is the number I calculated for you. It's not, quote, my number.
I understand, but we did. I understand, but we did the calculation. Is there anywhere on the back of the vehicle where 2188 could cause a fracture of the hand?
So that was a forearm fracture tolerance I thought we were talking about, because we used the weight of the whole arm for that.
We did. And my question is there anywhere in the back of the vehicle, in your opinion, that could cause a fracture with that?
I'm sorry, what, to the hand? Just the hand or the whole arm?
I'll take any part of the right arm. You call it the hand, the forearm. Is there any part that could cause a fracture?
So probably similarly, if you got your forearm down near that transition, like, I don't know if you can see the little dot. I'm talking about this area.
Yes, yes.
Right here.
Yep.
So that transition between the two body panels.
Yes.
That could potentially do it. That's back where the reverse lights are. I'd have to look at whether, that would take it before breaking the plastic. And then, again, maybe if you hit the exhaust pipe as well. It's a much more narrow loading condition.
How about the corner of the tail lamp?
The corner of the tail lamp. I suppose if you had just your hand on the very, very corner, potentially.
Potentially. But you didn't do any of that force analysis for this case, did you?
For the hand, no.
But you did it for the head, correct?
Correct. Because that I'm able to quantify.
Mr. Leslie, that was slide 108. I just want to
I'm
keep
sorry,
track.
Your Honor. Yes, Mr. Wolk. Yes.
All right, thank you.
Thank you. You are aware, Dr. Welcher, that Mr. O'Keefe suffered no fractures of any kind in his hand, correct?
So there were no fractures noted in the autopsy report, but they didn't actually x-ray, from the records I've seen, either his hand or his arm. So there was, at least according to the autopsy report, no overt fractures, but the x-rays I saw, none of them were the arm, and the autopsy report said no sternum, spine, I think it said torso. They didn't say that there were no fractures there.
Was there any evidence in the medical records that you reviewed of any indication whatsoever of a fracture in Mr. O'Keefe's hand?
No.
Was there any indication whatsoever in any of the medical records you reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
Not that I saw. Again, it wasn't x-rayed.
Was there any indication in the medical records and the autopsy that you say you reviewed of any fracture of any bone anywhere in the body of Mr. O'Keefe?
Yes.
Other than the occipital bone or the skull?
There's a couple bones in the skull that were fractured, but other than the skull, no.
Correct. So, are you aware that the medical examiner for the state of Massachusetts, Dr. Shorty Bello, performed an autopsy on Mr. O'Keefe? Are you aware of that?
Yes.
And you're aware of it because you read the autopsy report, correct?
Correct.
Are you implying, and it's a question, that Dr. Shorty Bello missed a fracture or didn't look properly for a fracture on Mr. O'Keefe?
No. I'm simply indicating that, for example, a hairline fracture, I didn't see any evidence that they actually x-rayed the structure, so there would be no overt evidence of that.
There were wounds on the right arm of Mr. O'Keefe, correct?
Correct.
And you are saying that the medical examiner should have x-rayed that to determine whether there was a hairline fracture? Is that your testimony?
No, you're asking me about evidence and proof of absence of fracture. So I would look for an x-ray to see if that was the case. I haven't seen any evidence of an x-ray of the arms.
So it's your position that on every autopsy, there should be an x-ray of every bone in the body, and that the clinical judgment of the medical examiner should not be accepted, and there should be an x-ray of every bone before a conclusion can be drawn that there's no fracture to a bone in the body of a deceased. Is that your testimony?
Absolutely not. Like, I'm an engineer. You're asking me about proof. And so proof is somebody looked at it, somebody took an x-ray, some proof.
Sir, I didn't use proof in my question.
You asked me about the opinion of a medical examiner. I'm not a medical.
Hold on. Only one person at a time. Mr. Leslie, let him finish, and then you can ask the question.
Your Honor, I hadn't finished my question.
Okay, then finish your question, Dr. Welcher. Wait for the question. Then let Dr. Welcher respond. It's a nightmare for Madam
I
Clerk.
understand, and I think I've been doing that, but I'll redouble my efforts. Dr. Welcher, I didn't use proof in my question. I'm going to repeat the question. Is there any indication in any medical record, autopsy report of the deceased of any fracture of any bone in the body?
That was not your original question, but to answer your question, no. Except for the skull.
Except for the skull.
Correct.
Do you understand whether the absence of any fractures other than the skull of Mr. O'Keefe was of significance to the medical examiner, Dr. Shorty Bello, in the conclusion she reached in the autopsy report that you read?
System.
Did you read the conclusions of Dr. Shorty Bello in the autopsy?
I believe so.
Are you aware of whether Dr. Shorty Bello has analyzed whether the injuries to Mr. O'Keefe are inconsistent or consistent with a motor vehicle impact. Are you aware of any analysis to that effect?
Objection.
So I'm going to see you on this one.
Sidebar. Ladies and gentlemen, we have a sidebar. My name is Grant Smith Ellis. Oh, my goodness. Some of those moments, folks. Look at Bill Reed. He's like, oh, no, Bob Alessi. Oh, no, Bob Alessi. Oh, no. Oh, ladies and gentlemen, it's bad. Bob Alessi was literally just going for, because he knew he had dug himself in a hole. That Dr. Welcher, was just ripping Bob Alessi to shreds from the beginning moment when Bob Alessi literally got information wrong about how long the doctor had been working on the case. Got it wrong by years. Alessi got it wrong and the doctor had to correct him. To some of those moments where the doctor was like, you don't have bones on the outside of your body. Oh my goodness. And then the other question, what did he say? He just said that was not your original question. And then there was another moment where he was like, I don't deal in possibilities, I deal in probabilities. And then the witness answered the question about his methodology and the evidence of Karen hitting John on cross. 7 pieces of evidence. Alessi was like, I moved to strike the DNA part for obvious reasons, Your Honor. And Judge Cannoni was like, I'm not going to strike it. Oh, ladies and gentlemen, I hope you're all enjoying this. This is the most funny cross I've ever seen. Oh, Bob Alessi, quit while you're very, very, very far behind. Oh, yeah, it's literally hilarious. It's not even like something you can debate on substance. It's so bad, it's funny. Yeah, I don't know. If you are not embarrassed by this, like, I would be literally laughing in the courtroom. Oh, my goodness. Yes, tell me, by the way, if the audio is not coming through, folks. Just tell me. I will attempt to make adjustments in real time. And it's also very possible, ladies and gentlemen, that I am moving away from the microphone. So it's not that my sound is going in and out. It's just I am literally turning my head at so many different things and laughing so hard at Bob Alessi right now that I'm pulling my mouth away from the microphone. So yes, I'll be more cognizant about that. And I will also try to save you from this spinning fan. Oh my goodness, that was bad. It was so bad. That was worse than his other cross. I think this defense has given up. Like, that was not, there's nothing substantive to this cross. Alessi isn't really making a point. He's just kind of up there just practicing his trial skills. I think they've given up, folks. I think they've given up. This is just embarrassingly bad. This is like someone who's right out of law school trying a criminal case for the first time. I mean, it's not a cross. It's so bad. It's literally as bad as you possibly can imagine. I can't put it into words. It's that brutal. This is hands down one of the worst cross-examinations I've ever seen. And MJ Jaker, they're not wrong on Twitter. It's like someone who just learned how to do a cross and they're just practicing it for the first time in a high-stakes criminal trial. This was way too important, way too far of an important witness to just experiment with your cross. Oh, yeah, it's over. I think Alan Jackson and David Yannetti are checked out. This Alan would have done this cross, folks. David should have done this cross. Instead, they give it to the lawyer who just joined the case. Oh, yeah, this is bad. I mean, listen, you don't want to be, if you're a Karen Reed supporter, you don't want to be in court today. I've never seen it this bad, folks. I've never seen a cross this bad before. I'm trying to put it into perspective for you. I can't analogize it because there's no comparison to this. This isn't the kind of thing like you see from an unprepared attorney or from like an attorney who doesn't know what they're doing. This is the kind of thing that you'd have to have false bravado. You'd have to be overly confident in your abilities and completely out of your depth. And it never happens because there's this whole screening process so that lawyers don't get to this point. I just can't believe they let Bob Alessi do this to himself. I can't believe they let Bob Alessi do this to Karen Reed's defense. This is so bad. This is such an important witness. They can't do this. I'm telling you, folks. Yeah, no. What I'm saying is, I already know from being in there observing some of the jurors, folks. They take notes on everything Hank Brennan says when he's up there on direct. They turn their heads like watching a tennis match when Hank Brennan's talking, the witness is talking, and then when Alessi or whatever gets up there on cross, they just stop paying attention. Oh, ladies and gentlemen, I'm telling you, this is really, really brutally bad. I mean, I know that some of you are really enjoying this, but I've never seen a cross go this badly in my entire life. Like, in some sense, you are actually witnessing moments that are somewhat impossible. Yeah, no, jurors are definitely exhausted, bored. Alessi isn't actually making any big points. He's just kind of going into jargon. It's very kind of, like I mentioned, Socratic, didactic. He likes learning, but he's not making a point. And this is really bad because Alessi will then try to make like subtle points, and the doctor just humiliates Alessi. Alessi's credibility has been impeached more than the witnesses. That's what I'm going to say. I'm going to say this, folks. You're going to listen to me say this right now. I don't know how this is possible, but I think Bob Alessi has conducted the worst cross-examination during a criminal trial of all time. Alessi has somehow managed to impeach his own credibility and memory more so than that of the witness. It is shocking. I mean, literally, I don't even know how to, that's what's happening. It is shocking, folks. I've never seen anything like it in my entire life. We're at a side bar, and there's still time left. This is going to get worse. I know Bob Alessi is in word salad territory, and Dr. Welcher is just eating it up for lunch. Oh my goodness, ladies and gentlemen, I know that sometimes I get excitable. This isn't one of those kind of like bombshell moments where obviously this witness is a very good witness for the state. There were a lot of bombshells on direct. It's not like there's lots of bombshells on cross other than Alessi being like, I'd like to keep that, strike that DNA statement. No. Okay, well now you just made the jury realize how important the DNA is, Bob Alessi. Literally comical, ladies and gentlemen. Literally comical. One of the most ridiculous, absurd crosses. If I were Bob Alessi, I would literally be abandoning ship. Someone hit the button. What is the button you hit when it's time to abandon ship? Ring the bell. I don't really know how, I don't know how to be a ship captain, ladies and gentlemen. I am a towel. I'm at best a horse racing announcer and occasionally an auctioneering announcer towel. Now listen, we need to hit the button on the good ship Hinden Reed. Ladies and gentlemen, oh, the humanity of the good ship Hinden Reed just collapsing to earth in a just calamity, calamitous crescendo of chaos. Oh, ladies and gentlemen, the sidebar is about to be over. We're going to get rid of the Stay Puft Marshmallow Man and Chewbacca. Oh, my, ladies and gentlemen, Bob Alessi, will he manage to get off the good ship Hinden Reed before it reaches the ground? Oh, Bob Alessi, abandoned ship. Oh, the humanity, ladies and gentlemen. Oh, the humanity.
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, I would like to talk now about your paint exercise. You did not present, as you have stated, a force calculation with regard to the arm. You did a paint exercise. And what I want to do is to reference, and if we need to bring it up, sir, to refresh you, slides 103 to 120 of your PowerPoint presentation in this trial. I'll just call it the blue paint exercise. Is that descriptive enough for you to know what I'm talking about?
No, it's not an exercise, it's a test.
Okay, you want to call it a blue paint test?
Sure.
Okay, let's call it a blue paint test. I just want to try to expedite things and use parlance that we can agree on.
Okay.
So your blue paint test involved painting the right rear tail light blue, correct?
Correct.
Positioning the test subject behind the tail light, correct?
Correct.
With the arm held out, correct?
Correct.
And at a right angle, correct?
Correct?
And then the vehicle, the Lexus SUV, is backed into the test subject, correct?
So I ran 3 different tests.
I know. Well, let's just do each one at a time, okay?
Okay, so you're starting with the last one.
I'll start with whatever one you want.
Okay.
How about if we start with the one at 1 mile per hour?
None of them are at 1 mile an hour.
2 miles per hour?
2 miles an hour.
Let's do 2 miles per hour. Let's start with that one, okay? Now, did you conduct that test in an attempt to show that the injury patterns on Mr. O'Keefe's right arm are consistent with being struck by the Lexus tail light on that arm?
So generally, I wanted to show that the location, area, and span over which that headlight covers matches the location and area of the lacerations on his arm.
That's what I want to get to. So you discussed data that you say shows that that you say shows the Lexus SUV was traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is that correct?
No. Where'd you get that from?
Hold on. Okay. The answer is no. So did you do a test involving 20 miles per hour?
I did some other backing tests.
Yes.
I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
Let me ask you this. Mm-hmm. Would you agree that you did a blue paint test with the vehicle going at 2 miles per hour? Did you? Of course. Do that? Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct. Okay. I was not going to hit myself with a Lexus at 20 miles an hour.
You could have done other tests where the vehicle was going at 20 miles per hour if you used a crash test dummy, correct? You could have done that.
If you used the right crash test dummy, right, and then to set up the test, because generally you only get 1 or 2 shots at it because you damage the car, you have to know everything about the parameters. And so, again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information to be able to conduct that testing.
Exactly. Mm-hmm. So, your assumption, as I understand it, is that the Lexus was going 24 miles per hour in reverse and made contact with Mr. O'Keefe. That's your analysis, sir?
No. There is not one single slide I have that says this is the speed he was hit at 24 miles an hour.
Do you know, do you have a hypothesis at what speed you believe there was impact? Do you have the point of impact speed?
I do not know the exact speed. We don't know the initial point of contact. We don't know where exactly he was on the road. We don't have enough information to determine that.
Exactly. Let's talk about the other information you don't have.
Okay.
You don't have the information as to from your alleged point of contact to where Mr. O'Keefe landed. You don't have that information, do you, sir?
I'm sorry, where is my alleged point of contact?
You allege that there was a point of contact between the Lexus, the back of the Lexus, and
correct.
Mr. O'Keefe, correct?
Right, but I don't know where that is on the road.
Yeah. You don't know that. I want to go through the information that you don't have.
Okay, dope.
So you don't have that. You don't have the point of impact. You don't have where in the road there was impact under your allegation.
Those are the same thing.
Right. You don't have where under your view, the body of Mr. O'Keefe landed precisely. You don't have that information, do you?
What do you mean by precisely? We know it's 7 feet off the road. We know it's near the flagpole. We don't know where it started. The problem isn't where it landed. The problem is where it started.
Right. And you don't have that information.
I don't have where it started.
The paint tests that you used, aren't those used?
That test was to show the contact width and location of how someone of Mr. O'Keefe's height, which happens to be me, contacts and where it would contact where the broken taillight was. So no, that was the focal point of the testing. That's why I did the testing. That's why we're calling it paint transfer testing.
Right, but my question, sir, I understand you use paint tests as the focal point, but aren't paint tests in accurate accident reconstruction not used as focal points? They're used as supplements to other tests to get more accurate information. Do you agree or disagree with that?
You didn't give me enough information. I can't agree nor disagree. It depends on what you're trying to do.
Let's go to, on direct examination, you testified that after the 1162-2 trigger event, Ms. Reed's vehicle traveled a distance of 87 feet. Do you recall that?
You are mixing up two things. Remember, the trigger is in the middle of the event.
Give me the chart, please. Your Honor, I'll give you the, as soon as Mr. Wool gives it, the slide 23, I believe it is.
I'm sorry, what slide?
Well, I want Mr. Wool to go through it to check. Let me ask it this way, see if we can get to it quicker. Do you remember talking on direct about a calculation of 87 feet where you added, there was like a 30-something number and a 50 number and you came to 87? Do you remember that in your slide presentation, sir?
Slide 37, yes.
Right. So if we could bring up that slide, please, Your Honor, with your permission.
Okay.
That's 36, but okay.
Are you on 33, sir?
No, I'm on 36.
Mr. Wolk, do you have 33? If you could go to 33, sir.
Oh, sorry.
Yeah, because that's where your 87 number is, not on the other.
It's on a bunch of slides.
Yep.
Go ahead.
Alrighty. So if you could zoom in, Mr. Wolk, so Dr. Welcher can see the numbers in the column.
You're going the wrong way.
Yep. To the farther to the right.
Oh, I'm not the only one that has problems.
Okay.
You still
Sir, do
don't
you
have
remember testifying about this? To the farther to the right?
Farther to the right.
Yep.
Keep going. Keep going. A
Is
little
that
more.
53 number down there? That column?
Right.
So
Can we scroll up a tad so you can see the headers? There you go.
Okay.
No, okay, go ahead.
So am I in the right column relative to start? Is that the column?
So there's two columns. Like Z is relative to where it started, and then positive is forward, and then as you back up, once you go past 0, it becomes negative.
Right. So what I want to do is have you direct us to the column where you calculated 87 feet.
It's in two spots. It's at the end of column Y.
Right. We go all the way down. Is that in the yellow there? Is that 87, sir?
It is.
Okay. Is that the 87 number you were referring to?
Hold on a second. You asked me to identify. So then it's, see where the one next to it says minus 53?
Yes.
0.429. If you go up, so it's not a little bit down, a little bit, and add, see where it's changing directions at 34.157?
Yes.
You add those two together, that gives you the same result. So it went 34 feet forward and then 50-something feet backwards.
Right. And what is the 87 feet traveled, is that what you're indicating is the distance traveled during the trigger? Is that what the 87 represents to you?
That is so 87 represents the total rearward distance traveled during the trigger.
Okay. So you believe 87 represents the total rearward distance. Did I hear you correctly?
Correct.
Now, can you
hold on, to be clear. So it starts, it pulls forward, then it backs up, passes where it initially started, and goes 53 feet further back.
That's what I want to get to. How many feet did you say on direct, and did you just say now that it went 87 feet in reverse?
Correct.
Okay.
From its furthest point forward.
Well, that's what I want to get to, because I want to have this point clear. How many feet do you believe the Lexus went in reverse based upon your PowerPoint presentation? Not when it went forward and then came backwards. How many feet do you believe that vehicle went in reverse?
Your question doesn't make any sense, because when it went forward, then it went in reverse.
How many feet do you believe the Lexus went during the trigger?
So it went a total of 80, it went 34 feet forward, then it came back 80, or another 53 feet past where it went.
Exactly. So, you've testified that the 1162-2 trigger event represents a backwards maneuver, correct?
So again, if I was clear, it initially pulls forward and then backs up.
I would like you to define, so it's clear to the jury, do you consider the event of 1162-2 just backward movement, or do you consider the trigger to be forward movement and adding to it backward movement? Which one?
So can we pull the slide up?
Sure.
Could you zoom in? There you go. No, go back to the left. So that T in the third column for data ID represents the trigger. If you scroll over a little bit to the right, where the highlighted yellow blocks are, you can see 1 is a forward drive gear, 0 is neutral, 2 is reverse. So that's where it's switched from forward to reverse. I mentioned the brake. So you have it on the brakes coming in, slowing, stopping, going into reverse, and then backing up.
So you conclude that the vehicle for this trigger went 34 feet forward, is that correct?
Correct.
How do you know the vehicle didn't go 150 feet forward? How do you know it just went 30 feet, 4 feet forward? How do you know that?
So the only data we have is this 10-second window. And so we have the velocity when it's going forward. We know how much time it took to do that. So that tells us how far it would travel. Velocity times time is distance.
So are you saying that it is a certainty that it went forward 34? You're absolutely certain of the 34 number?
No. Again, if you look, see where it says vehicle speed?
I see it.
So at the start of this event, which is the trigger -5, so the trigger is actually where it's triggered, and it takes 5 seconds before, 5 seconds after. But when the trigger happens, it's actually stopped. But the 5 seconds before, it's going 13.6 miles an hour forward. So at the start of the data, it's still going 13.6 miles an hour forward, but it's slowing down. You can see you have the brake, where it says brake SW, which is short for switch. The brake switch is a 1, which means it's on. So when this event data started, it's going 13 miles an hour.
I'll ask the question a different way. Are you certain that the distance traveled forward during this trigger event was 34 feet? Are you certain?
Yeah, I'm pretty certain during this trigger event.
Pretty certain or certain?
Well, I've checked the math. I've had people check my math. So I try to be as accurate as possible. I would say I'm certain,
okay,
but I'm an engineer.
Okay.
So there's no absolutes. There's no 100% in my job.
So you're certain of the 34 feet, and is it correct that You're certain of 53 feet going backwards. Are you certain of that, sir?
So backwards from its initial starting position?
Yes.
Correct.
Okay. And therefore you are certain of a total of 87 feet traveled that you have at the bottom in that yellow-orange. You're certain of that as well?
87 feet of backing, correct.
Okay. Now, you also testified on direct, as I understand it, in slide 23, that different numbers represent different gear states of the vehicle, correct?
Correct.
And a 0 represents neutral?
I think it's either neutral or park, but I'm pretty sure it's neutral.
A 1 represents drive?
Correct.
A 2 represents reverse?
Correct.
Or a 2 can represent slowing down, is that correct?
Not for a gear shift number.
So you didn't say on direct that 2 could represent reverse or slowing down?
God, I hope not. It doesn't. So those numbers simply represent, is the transmission in drive? Is it in neutral? Is it in reverse? It doesn't tell you anything about whether it's slowing down or not. But the brake switch and the brake pressure and the longitudinal accelerometer data gives you some information on that.
Okay. So if Your Honor, we could go to slide 30, please.
Okay.
Mr. Wolk. And I want to do it generally. There's not a need to read any specific number. I just want it clarified.
Mr. Lessie, so is this 30 or 31?
I'm sorry, Your Honor, you are correct. It's 31 in the most up-to-date presentation. Thank you. You see all the numbers in blue font on that slide, sir?
I do.
Those are all numbers that you have placed on that slide. Did I have that correct in your direct presentation?
You do.
Okay. So this Excel spreadsheet, there's also numbers in black, correct?
Correct.
So all the ones that are in blue, those are numbers that you have placed into the spreadsheet. Correct?
Correct. The one exception is column N, where it says ship position.
Yes.
I changed green to forward and red to reverse.
So the data in the columns in blue are not from the original data that was downloaded from the vehicle, correct?
Like, for example, if you look at column H, I simply did a unit conversion. So it's the same number, it's just in different units. But the black numbers represent exactly as it comes out of the vehicle, but it's the same number.
All right, that's what I wanted to get to. So for clarity for this slide, when you download this data from the vehicle, what is in black, those numbers just come right out, correct?
Correct.
As they're stated. But the blue numbers, they don't come out like the numbers in blue. You have to do something, some calculation, some application to get to the blue, correct?
Correct.
Okay, thank you.
You're welcome.
Now, we're going to keep that up, Mr. Wolk, please. Thank you. And when we need to get to the specific numbers, we'll be fair and make sure you can see them. Now, in these columns, do I understand it correctly that you attempted to account for wheel slippage in the revolutions per minute speed values produced by the car?
Not here. You're looking, this is 1162-1. The wheel slippage occurred in 1162-2.
Okay, and so if we go to a slide with 1162.2, we will then go to the slide you believe represents wheel slippage, is that correct?
There are data points in that represent slippage.
That's my question. In which slide, sir, would you like to pick?
35.
Thank you. So we will go to slide 35. So
I've highlighted the slippage.
Exactly. So you agree that there is data that shows that there is wheel slippage with the Lexus SUV during trigger event. Let's enlarge it for this one here. The trigger event, the number. 1162-2, correct?
Correct.
And as I understand it, you testified that this trigger event was caused by a depression of the accelerator pedal at more than the 30%. Is that correct?
It's a transition into reverse and then a quick acceleration exceeding 30%.
So let's
in reverse.
Okay, got it. So the accelerator pedal being depressed to this degree, more than 30%, can be the result of wheel slippage, correct?
It doesn't necessarily work that way. I mean, you can have wheel slippage at any acceleration, technically, depending on the roadway. It's just what is in the data that shows that it's slipping. It isn't necessarily because of the accelerator. Normally, that's what causes slippage. But it's the data. When you look at the data, you're like, well, that doesn't make sense. It's increasing in speed, but yet the longitudinal acceleration is dropping.
My question, again, doctor, is you can have an accelerator pedal depress greater than 30% and it be caused by wheel slippage. That can occur, correct?
The wheel slippage does not cause the accelerator pedal.
I'm not saying a cause and effect. I'm just saying a correlation. You understand what I mean by a correlation?
Let me, if I may, try and straighten this out. So, applying heavy acceleration can cause the wheels to spin. Is that what you're asking me?
Yes.
Yes.
Okay, that's all I wanted to get at. Alrighty. So in your review of the materials that are related to January 29, 2022, did you become aware of whether there were, and you said you extensively reviewed documents, did you become aware whether there were people at 34 Fairview?
Yes.
And approximately how many people, without regard to names, just number, how many people did you become aware were at 34 Fairview on January 29th, 2022, the early morning hours? How many people approximately did you become aware were present?
It depends on which time, but there could be as many as 16.
As many as 16. And let's talk about the time period from midnight to 1 a.m. Do you have an understanding of how many people could have been present at 34 Fairview at that time period?
So I'm going to see you at sidebar on this.
Looks like he's going down the third-party Oprah defense line, and Judge Cannoni's going to stop him. Oh, I hope he brings a dog. Oh, ladies and gentlemen, if Bob Alessi brings up the dog, well, Chloe the dog is at the podium. Chloe the dog in a wig. Ladies and gentlemen, do you think Chloe the dog in a wig ever thought she'd be at the podium asking questions of Dr. Judson Welcher? It's a sidebar, ladies and gentlemen. But listen, Chloe the dog in a wig was not allowed to go to the sidebar. She is stuck at the podium with the court officer. Oh, ladies and gentlemen, we figured it out. The court officer isn't watching Mr. Reed. The court officer is watching Chloe the dog in a wig. Listen. Chloe the dog in a wig being involved in this cross is no more ridiculous than any of the things Bob Alessi is saying. Chloe! Yes, ladies and gentlemen, Chloe, as a revered member of the bar, Chloe has rights. Ladies and gentlemen, Chloe the dog is going to protect the O'Keefe family. She's going to ask good questions on cross. Chloe is at the podium, ladies and gentlemen. I repeat, Chloe the dog has taken over the podium during Bob Alessi's cross. Bob Alessi just lost it, so we decided that Bob Alessi was instead going to be replaced at the last minute by a pitch hitter. Her name is Chloe the dog in a wig. She thinks she's Chewbacca. And I'll tell you, ladies and gentlemen, it is just gone off the rails in here. Bob Alessi has lost his mind, ladies and gentlemen. It has gotten to the point where we have a dog at the podium asking questions of a witness, ladies and gentlemen. Oh, ladies and gentlemen, listen, I don't even know what is going on anymore in this trial. Bob Alessi has literally lost his mind. Oh, goodness, ladies and gentlemen, the only way we can get through this is if we have fully put it all together and we realize that it wasn't Bob Alessi up there. Karen disguised Chloe the dog in a wig as Bob Alessi and sent Chloe up there to do the cross. Ladies and gentlemen, Chloe isn't the third-party culprit. Chloe is Bob Alessi. Oh, ladies and gentlemen, it all makes sense. That's why Bob Alessi's tanking the case. He's got a dog in the fight. He's tanking it from the inside. Oh, my word, ladies and gentlemen. Oh, Bob Alessi is Chloe the dog in a wig. I put it all together. Someone call the Associated Press. We should be coming back into session any minute. You go get him, Chloe. Chloe, we're all behind you. You wear that wig loud and proud.
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, am I correct in my understanding that you believe under your theory, the Lexus for event 1162-2 backed up 53 feet? Am I correct?
No, it backed up a total of 87 feet.
Okay, let's take your 87. It backed up a total of 87, okay?
Correct.
And your further theory is that it did so and reached 24 miles per hour, correct?
Correct.
And you stated you have an understanding of a certain number of Fairview between roughly 12 and 1 a.m. Do you have an understanding of that, sir? Approximately.
I believe I do.
And what is that number?
Do you want them, people that were there for that entire window of time, or just?
Yes, 12 to 1.
Oh.
So, Mr. Alessi, just move to the last question.
Right, sure. So, sir, did you assume that there were cars parked out front of 34 Fairview at that 12 to 1 o'clock window? Did you assume any cars parked out front?
The entire time?
No, I'm just talking 12 to, any time between 12 and 1. Did you make any assumptions whether there were cars parked out front on the roadway at 34 Fairview? Did you make any assumptions with regard to that?
At a point in time, there was a vehicle behind it.
I'm sorry?
There was a vehicle behind it.
Just one?
That is my understanding. In terms of on the street, is your question?
Street, exactly. Yes. And what to whether there was a Jeep vehicle on the road at that 12 to 1 time period?
I had seen testimony somewhere to that effect, but the majority of the testimony was there were no other vehicles.
But you did see testimony that there was also a Jeep type vehicle on the front, out the front of 34 Fairview between 12 and 1. Is that what you're recalling?
Yeah. So I'm going to let that answer stand, what he's just testified to. Just go ahead and...
Okay. So, Dr. Welcher, what I want to do is to have you, using your data, you say 87 feet for the backup, correct?
Correct.
1162, up to 24 miles per hour. Isn't there a likelihood, if there is at least one vehicle out in front of 34 Fairview, that there would be a collision of the Lexus SUV with a vehicle out front?
No, the vehicle had left prior to the end, or prior to event 1162-2.
What information do you have with regard to how many vehicles are in front of 34 Fairview at between 12 and 1?
So I have Miss Reed's interview statements. I have statements of a number of witnesses. I don't know if I'm allowed to say the names.
Let's not.
I was just going to say, let's not just number of vehicles.
Okay, so I have a number of witness statements at different, multiple statements from the same witnesses at different times indicating the path and following the Lexus to the house and then leaving before the event.
Assume that there were vehicles, at least one vehicle, parked out front of 34 Fairview. Is there a likelihood that given 24 miles per hour over 87 feet, is there a likelihood that there would be a collision given the weather conditions as you knew them to be at that time?
Well, the weather I don't think necessarily plays into whether there would be a collision or not, but we know it backed up 87 feet. So again, it goes forward like 35-ish and then back like 60 something. And so if something is within 65 feet of the rear of it, or whatever the numbers are, I would need my slides.
It was 50.
50,
okay. Yeah,
57. If something is within that window, then it would hit it.
All right, good. So now let's look at another scenario. If it's going as you describe it, is there a likelihood that the Lexus would also go upon the lawn in front of 34 Fairview?
It depends on where it starts.
You have an opinion, don't you, as to where it starts?
No, I do not. That's actually why I have that diagram showing it off to the side. I'm simply showing how far it moved forward, how far it moved back.
Exactly.
We don't know where on the roadway it started.
Exactly. You don't know where on the roadway it started. And therefore, all you have is the distance covered, correct?
Correct.
So, but you're saying the distance is 87 feet, correct?
87 feet backwards, yes.
So backwards, 24 miles an hour. Have you ever driven a vehicle backwards 24 miles an hour, sir?
Yes, I think I've driven this Lexus backwards 24 miles an hour.
So if anybody who's driven a vehicle back, have you ever driven any vehicle back 24 miles an hour at 1 o'clock, 12 o'clock in the morning?
Probably not since I got out of high school.
Have you ever done it when there's a storm that is beginning?
No.
Have you ever done it when there is less than clear visibility?
No and no.
And have you ever done it when there's low lighting?
Oh, maybe when I've been up skiing in the snow, I've done it. But again, that's been decades.
Right. So 87 feet, 24 miles an hour. Are you saying that in every instance that vehicle will stay on the road and for 34 Fairview it wouldn't go up on the lawn?
When you mean every instance, mean like every possible location on the road it starts from?
Correct.
No, there's some spots, if you start here, it's going to go up on the road, on the yard. If you start too far on the other side, you're going to go over into the neighbor's yard. So it depends on where you start.
Right. And so in given the conditions that we've just described, right?
Conditions
the weather
have nothing to do with where you start.
Finish my
Hold
question,
on.
sir.
Only one at a time.
Yes, ma'am.
Let him finish his question, please.
Given the conditions that you've described, it is reasonable to conclude that that vehicle, under your parameters, would have gone up on the lawn. Is that a reasonable conclusion?
No.
So you don't think there's any possibility that could occur, a vehicle going 24 miles an hour at this location, 87 feet backwards, in the dark, with wet pavement at a minimum, and low lighting, you don't believe it's possible for the vehicle to, under your scenario, to have gone up on the lawn? That's not possible.
So your first question was reasonable, and I said no. Now you're asking possible. It, of course, is possible. Whether it's reasonable or not, I'd have to know the starting position.
Right.
If it's very close to the side, then it could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible. It's possible it could have shot off into space as an engineer, but not probable.
Oh, you think it's possible that it could have been shot off into space, sir?
As an engineer, it's a possibility.
It's a possibility that
Absolutely.
this Lexus could have been shot off into space?
Yeah. Highly, highly unlikely. But
All
again,
right.
you're asking an engineer about possibilities and probabilities.
Let's get back to reality. So in terms of the Lexus itself, because you, under your method of analysis, don't have the starting point, you can't rule out that under your scenario, the vehicle would have gone up on the lawn. You can't rule that out, can you, sir?
I cannot. No, it could have.
Okay. Now let's go to the next topic. If we could, Your Honor, have Exhibit 168 published in evidence, which is now under the 167. Now, as I understand your testimony, Dr. Welcher, you believe that it's possible that the Lexus taillight could have caused these wounds to Mr. O'Keefe's right arm. Is that correct?
Correct.
And more specifically, it's your belief that the lacerations would have been caused by the vehicle scratching Mr. O'Keefe's arm as it drives past him. Is that correct?
I don't know, I'd characterize it that way. What happens is, this 6,000-pound vehicle is coming and he's standing on a, icy, snowy roadway area, and it's going to contact him and move his whole body and induce rotation.
Right. So it's going to contact him and, under your theory, induce rotation. So wouldn't such a movement of the car relative to his right arm result in horizontal injuries to Mr. O'Keefe's arm, as can be seen on his bicep above the elbow?
So could we pull up one of my slides to address this issue?
Sir,
I'd like to answer your question with a slide that I have that addresses this exact point.
I'd like to stay with this slide, Dr. Welcher, and see if you can answer my questions off of this slide. So I'll repeat it.
Sure.
Do you agree that the injuries up at the upper part, where you're familiar with the bicep brachialis?
I am.
And aren't those two up at the top, right over the bicep brachialis?
They're actually about midway between the biceps and the triceps.
Right. So you know which two I'm talking about, the two up there. Can you just use your laser pointer just so we're talking about the same two? Do you have one?
I'll give it a try, but the upper ones...
I know it's not your fault, but
on the
sometimes
image,
it doesn't
the
show.
upper left.
Yes.
I mean, technically the ones right to the right of that are also on the biceps and triceps.
Right, but
the
I'm talking...
biceps goes all the way to the elbow, so do the triceps.
Right, so I'm talking about the two that are the farthest up.
Correct.
All right. Would you agree that those are in a horizontal orientation?
Generally, yes, which is what you'd expect with your arm like this and the tail light coming across like this, which is what I showed in my slides.
My questions are trying to keep this moving. I just asked if those are in a horizontal orientation.
Yeah,
yes
more or
no?
less. They're angled down slightly, but more or less horizontal.
Okay. Isn't it true that if Mr. O'Keefe's arm were to be flexed like it was with the test subject in your blue paint test, the lacerations on Mr. O'Keefe's forearm would be oriented in a vertical direction?
Absolutely not. If you pull up my slide 117, it'll show exactly that it is like perfectly horizontal. When you're standing like this, and this is the tail light, the laceration, when it comes across here and pushes my body, it's going to make a horizontal laceration because the 6,000-pound vehicle is going to push me out of the way. As this pushes me out of the way, it's going to drag and create a horizontal laceration across my arm. This is exactly what you'd expect.
So let's talk about the forearm, sir. We may have miscommunicated. I'm talking about the lacerations on Mr. O'Keefe's forearm now.
So we're switching from the arm to the forearm.
Correct.
Gotcha.
Wouldn't those be oriented in a vertical direction?
No. Again, you have the vehicle. If this is me and this is the car, it's pushing and pushing across like this. And with your arm bent like this, it's going to cause laceration as it pushes my arm away. It pushes like that.
Okay, I got it.
My slide shows this quite clearly.
So you disagree. You do not agree that the injuries to Mr. O'Keefe's forearm, under your theory, would be oriented in a vertical. You disagree with that. It's just want to get that on the record.
I disagree with that.
Okay. Now, also, do you understand that under your theory of injury here, that there would be injuries caused in two different directions by the same movement of the car? Agree or disagree?
I'm going to say I disagree. You need to give me a little more. You're going to have, again, this is a glancing or a clipping type impact. And so it's going to be it's going to sweep across the arm, which is what causes the horizontal lacerations.
We're talking about a flat surface, right, sir?
Approximately, yes.
And therefore, you would have to maintain contact with the arm as the car moves. Am I correct about that?
Maintain contact with the arm? I'm unclear what you mean.
What I'm trying to do, sir, is to get under your theory, right? Given the contact that you've described, what would you expect to be the orientation of the wounds to the upper part of the arm and to the lower part of the arm?
Just like it's shown in this photograph.
Okay. Isn't it the case with your theory that the tail light would have to break and after the break the arm would have to maintain contact with the arm as the car moves?
So that is what happens in pedestrian contacts. There is a contact duration. For example, you asked me earlier in that calculation you had me ran, you said 0.01 seconds. That was the contact duration. So when you have things like this, and that's why you have to allow, if you do testing, the body to move, because the car is going to hit the body, it's going to cause it to move, the body's going to rotate away, and the car is going to continue on in that clipping type impact. So the arm is definitely in contact with the rear of the car for some time.
That's what I wanted to get to, is simply that under your theory, the taillight would break and also the arm would need to maintain contact with the taillight area as the car moves. Is that your supposition?
So at a point in time, it'll stop contact. But the 6,000-pound vehicle is going to want to continue moving on. It's going to push. It's going to initially contact the arm and then push the arm away as it rotates the body. So yes, it's going to maintain contact until the clipping is over and the vehicle continues on.
So my next question is simply, how long do you believe the arm needs to maintain contact with the taillight after, under your theory, it breaks, to produce those types of wounds that you say came from a taillight?
We don't have enough information to determine that.
Right. You don't have enough information to make that determination, do you, sir?
Correct. But we know because of the laws of physics that it has to be some amount of time. It doesn't occur instantaneously.
So now we do apply the laws of physics to the right arm that weren't applied before because you applied a paint experiment. Is that correct? You're now applying the laws of physics to the injury to the right arm. But you didn't do that in your report.
Nope. Always applied the laws of physics. The paint experiment, as you're referring to it, was to look at basically the orientation of the scratches that matched this. So that was an engineering experiment to correlate height, position of the taillights relative to height, orientation of the lacerations on Mr. O'Keefe's arm.
You just said, sir, if I heard you correctly, you, to answer my previous question, applied the laws of physics. That's what you just said, correct?
So the laws of physics cover more than Newton's second law. There's a whole law of physics. The whole field of physics is a broad subject. So a simple measure
Not you, towel friends. It's not you. It's the stupid pool feed. Don't worry. I cannot believe it's happened again. It's not you, towel friends. It is the pool feed. Let's jump ahead. Let's see if it'll come back up. As we know, folks, law and crime, this does tend to happen from time to time. It literally happens at like the most important moments sometimes. But hold on, towel friends. We'll go to the backup stream. And by the way, we can get audio very quickly. Watch this, little towel friends. Did you know that I can literally get you audio on the fly? You're going to have to just stare at Dr. Welcher, who's like buffering, but I can get you the audio. Watch.
Would write a report that said, these are the laws of physics. I would say, these are the numbers. But for example, the timing in
things
GPS.
like that. I didn't apply Newton's second law, as we already went through. But again, those simple positions, arm angles, the possible physical arm angles, those are all generally governed by the laws of physics. The laws of physics are very broad.
Sir, I'll ask it this way. Where in your 14-page report do you even mention the laws of physics related to the right arm of Mr. O'Keefe?
So, in terms of applying the laws of physics.
I'm not asking applying, just where in the report is it mentioned law of physics relative to the right arm? Can you point me to where?
Would write a report that said these are the laws of physics. I would say these are the numbers, but for example, the timing in GPS, how a clock times, the concept of a second. What does that mean? To a Roman numeral number 5.
Sir, I followed all of it, but what I'm asking about is where in all of what you just mentioned is the word right arm? I'll take what you just said. Where in 2A and all of those is the word right arm? Where is it?
Oh, sorry, it's in number 3.
So let's go to 3. You state the location and orientation of the laceration on John O'Keefe's right forearm and right arm are consistent with the geometry and orientation of the right tail light of the Reed 2021 Lexus LX 570. Where?
Can you read the next sentence?
I'm sorry. Is it C PowerPoint slides 102, 120, correct?
Correct.
All right. I want to just start with the report. Did you apply any force
analysis? But in terms of, say, the contact pattern, I obviously had to apply some force, even at 2 miles an hour, to do that.
So the answer is, what you cited, number 3, you did not use a force analysis, correct?
So force was applied to my arm in the paint test. I didn't do an F equals MA force analysis.
Thank you.
You're welcome.
So now let's go to the horizontal movement we were talking about with regard to the car. And you can agree or disagree.
Sorry. The picture's done.
I'm sorry, we'll take that down. Do you agree or disagree that given a horizontal movement of the car, vertical...
So horizontal motion generally will cause a horizontal laceration. You can get what are called stellate, which are a blunt force, and it causes a splitting of the skin as well. But generally, when the vehicle is clipping or running horizontal across it, it will generally cause horizontal lacerations. But when you have a fractured taillight, you can get pieces going off in other directions. So it's not necessarily going to be perfectly horizontal.
So my question is, not with clipping, you clipping into my question. My question is this. If you're given a horizontal movement of the car, do you agree that it's more likely than not that vertical lacerations would be...
You got to give me more. So, like, is it a clipping contact or is it not a clipping contact? Is it a direct in the center of the car impact?
Okay, are there only two variables you need to answer the question?
But this is a good start.
All right, so let me do it this way. You can't answer the question on a general basis of whether there's horizontal movement of a car, whether vertical lacerations would be an inconsistent injury pattern. You can't answer that question without more information. Is that your answer?
So generally, again, horizontal motion should cause horizontal lacerations. But again, it depends on what's being hit.
Okay.
So for example, if I have something that bends as a result of the impact, it could bend up and create a vertical laceration.
So you would agree, based upon what you said, that generally horizontal movement of a car would be expected to cause horizontal lacerations.
Generally.
Okay.
Yes.
Now, during your blue paint test, the blue paint was featured more predominantly on your upper arm than your forearm. Is that correct?
I think it depends on the tests.
Do you want, we bring up a slide? Will that help you?
I'd love to bring up a slide.
We're going to be running the thing, so we'll just bring one up and you tell me whether this slide works for you, sir.
Do you want me to tell you the slide I want?
If we could take a shot at it first, and then we may ask you for it. But I think we've got a slide for you. And what number? 111 is on the screen, sir. Is the blue paint more predominantly on your upper arm than your forearm? Is there more blue paint on your upper arm than your forearm?
Probably. This is the one where I actually walked sideways into the back of the car. The one where the car is moving is probably a little better representation.
Sir, I'm just asking you a question about this slide. If you could just focus on this slide here, and if you can't answer it, so be it.
I just answered it.
Is the blue paint featured more predominantly on your upper arm than your forearm?
It sort of looks like it. I didn't actually measure the total area of it.
Alrighty. So on direct, you stated that in order for the injuries on Mr. O'Keefe's forearm to have been caused by an impact with a taillight, his arm would have needed to be held outstretched as you did in your demonstration, correct?
You would need some degree of outstretch, yes.
Yes. So isn't that an example of confirmation bias?
No, that's matching the contact pattern to the injuries.
But don't you have to select among other choices this outstretching of the arm? You had to make that selection from among others, correct?
So that was matching the physical evidence on his arm to the physical evidence on the car, and then running a test to see if dynamically those matched up. So it's, I didn't have it hit the exhaust pipe, for example, because there was no assertion it hit the exhaust pipe. There was no damage to the exhaust pipe. So it was based upon the evidence and the testing was done to test, to use your vernacular, the hypothesis that that's where it came from.
Sir, have I ever asked you anything about a tailpipe in any of my questions today?
Yes.
I have not. I've never
Yes,
asked.
you have. You asked me about the totality of the rear of the Lexus, which includes the tailpipe.
All right. I am not going to be asking any questions that involve the taillight in any fashion. So what I'd like to do is to go back to the question that I'm asking, which is, did you consider, as part of the scientific method, in terms of more than one hypothesis, did you consider in your analysis any other orientation of Mr. O'Keefe other than the one you selected for your paint test?
Yes.
And where is that consideration of other hypotheses stated in any report?
It's not. I was just looking at the damage that was up on the sheet metal.
Okay. So, are you saying that you considered other orientations of Mr. O'Keefe relative to the vehicle as part of your analysis?
In terms of where exactly the hand would be, some
Alternative orientations?
no, I think I just included photographs of that damage.
Do you have any proof at all that you considered those other orientations? Anything you write?
No, I don't believe so.
Did you consider any other locations of Mr. O'Keefe under your theory relative to the back of the SUV?
Sure. In the beginning of this, I started about, hey, it's all over. Could be anywhere on the back of it. Then whittled it down based upon the evidence, started eliminating various hypotheses based upon the evidence, and came to this conclusion, eliminating hypotheses based upon the taillight fragments near his body, the lacerations, his height, the height of the taillight in a Lexus. So it was an iterative process.
Did you mention any of these supposed hypotheses in your direct testimony?
No, because I was able to reject them. I didn't come in here to tell these people what didn't happen. I came in here to tell them what I believe happened.
Would you agree, sir, that the various hypotheses go with the data that supports it, but you show your math as to why you're rejecting hypotheses? As you said, you rejected them. I'm asking for proof that you considered other hypotheses. Do you have anything in writing, any notes at all, any videos, any tests that you did, documentation of other hypotheses other than picking this one? Do you have any documentation of that?
So I did. The rear system worked to see if it would autonomously brake. I confirmed it did not, so I eliminated that as a hypothesis. I tested the steering. I tested the transmission, what 1, 2 represented. So I did a whole bunch of tests on the vehicle.
I understand you say you did a bunch of tests on the vehicle. My question is, did you ever take the vehicle and position yourself in various locations to determine whether or not your hypotheses could be properly rejected? Do you have any documentation that you did that?
I mean, I did do 1 static and 2 dynamic tests in very similar positions, though. So I did a total of 3 tests relative to the arm.
Where is the documentation for that, sir?
It's in the file. I gave it to you. Some of the slides are some of it.
All right, so Mr. Alessi, I think if we're going to...
I'm going to move on, Your Honor.
So...
Okay, Mr. Alessi, hold on. We're going to do that voir dire.
Can I ask, I just have one other...
Voir dire?
Your Honor, I can do it.
Why is she
in short
announcing
order
the
if I
voir
can.
dire in front of the jury?
I wasn't finished my...
Go ahead, finish your answer.
So slides 109, 110, 111, actually through, I guess, 121 deal with the testing of the hypothesis.
We'll come back to this at another time, Dr. Welcher. So what I want to do is to finish up on this point. So is it your testimony that no part of what you did in selecting this area, no part of it is confirmation bias? You say there's no confirmation bias at all in what you did. Is that your testimony?
That's certainly my goal. I try and eliminate all confirmational bias. I didn't start out at this particular location. This is where the physical evidence led me to. So I would say the conclusions are supported by the science.
My question is, did you engage in any confirmation, and this will be my last question, did you engage in any confirmation bias in terms of how you approach the issue that you have testified about in written reports?
The answer is still no.
It's a good
All right, so, okay, thank you. All right, so jurors, we're going to send you home because we still have work to do here and we don't need you waiting.
Voir dire incoming.
So, tomorrow is a half day. We'll see when exactly that half day ends, but we won't be here we won't go until 4 tomorrow. Those 3 cautions: do not discuss this case with anyone, don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. The 4th admonition: please be very careful with your social media use. We'll see you tomorrow morning.
Rise to the jury.
One of the jurors laughed.
Stay here? Yes.
It might have been Welcher who left. All right, we're doing a voir dire. Stay here, folks. Stay here. The jurors are going home, but the Karen Cam is back because we're doing a voir dire. Oh, it's a voir dire. Everyone loves an end of the day voir dire, ladies and gentlemen. I heard Judge Cannoni say voir dire. That's how good little Towel's ears are, friends. You don't have to go anywhere because Towel heard voir dire very earlier, and I was like, we're going for a voir dire. Tomorrow's a half day, ladies and gentlemen. Stick around. Here we go. All right, voir dire time. Towel loves voir dire.
You may be seated.
Okay, Mr. Alessi, it's your voir dire.
If I could have a moment, Your Honor, to switch.
Your Honor,
Yes.
can I load up my slides?
Yeah, can you do that while you're sitting here answering questions? Yes.
I'm going to start, Your Honor, with regard to the true fall.
Okay. And we're on a very limited schedule here. Okay.
Okay, Your Honor. Mr. Wolk, with Your Honor's permission, if we could pull up the January 30th, 2025 PowerPoint of Dr. Welcher in slide 36. You see that, Dr. Welcher? Do you recall that from your January 30th, 2025 PowerPoint?
I thought I had replaced the video on the left-hand side by the time I produced
Sir,
it.
I got to
don't
go through
recall
this
that.
quickly. That image is a drone image on the left, correct?
Oh, correct.
And you had that in your original report, but you removed it in subsequent reports, correct?
Correct.
Where did you get that drone image from?
It was in the file.
Wasn't it in the CARS report of Trooper Paul?
I believe it was.
So you took that drone image from the CARS report of Trooper Paul, correct?
Correct.
Let's, if we could, Mr. Woke, go to diagram 1. Do we have that electronically of Trooper Paul's report? Do you recognize that as diagram 1 from Trooper Paul's report?
Yes.
So, and that's the diagram that you took that image and you put it in your January 30th, 2025 PowerPoint, correct?
I'm pulling up my version of PowerPoint. Yes, it's correct.
Okay, if we could take that down, I'm going to go to the next example. We could go to Dr. Welcher.
I'm sorry, actually, can we go back to that?
Yes. With Your Honor, why do we?
Well,
I have limited. Go ahead.
So that particular diagram I did not use. If you notice, the diagram I used has different cars and doesn't have all the writing about the position of things on it.
I am going to now, Your Honor, have to take the time to go to Trooper Paul's report. We have the hard copy of Trooper Paul's.
Could you turn the lights on, please?
May I approach, Your Honor?
Yes.
I'm going to.
Show Mr. Brennan.
Yes, Mr. Brennan. This is. May I approach you, witness? Excuse me, Dr. Welcher. You see this first page? Do you recognize this as the cover page for the Trooper Paul report that I was referring to?
I think so. Can you show me the signature?
You want to look at the report, sir? I'm not so sure there is a signature on the report.
Signature block right here. Yes.
Yeah.
Trooper Paul, page 16.
I have that.
Yes.
Thank you.
You're welcome.
Now, what I want to do is to go to diagram 1, and if I could, Your Honor, republish what was just up. I'm showing you diagram 1, sir, and I'm asking you, is that the image from Trooper Paul's report that you then used to put into your January 30th slide presentation?
No. See all the writing on here, the glass cup, all the dimensions here. Here's my January 30th one. None of that stuff's here. There's different. None of this stuff is here.
Isn't it the case that this is cropped more and there's a larger picture of the same image, or not?
See this tree?
Yes.
See these trees?
Yes.
See all these measurements by the trees? All
Yes.
these? That's right here.
Okay.
Those do not show up on my image.
Let me go to a different method then to do this. You have an image. Can we go, Mr. Wolf, to the January 30th presentation?
Slide 36.
Correct. Where did you get that image from that's in your PowerPoint presentation on the left?
I think it was from the file, a satellite image from the file.
What part of the file, sir?
I actually don't know at this time.
How close is the image on diagram 1, the drone image, to the image that you can't now recall where you got it from for your slide presentation? Are they similar?
So that one has a whole bunch of measurements and ID on it, but the underlying image is very similar. It's probably the same one.
Right. Yes. You're welcome. Do you know of any other place you could have, let's put the presentation back up on the slide presentation. Do you know of any other location other than Trooper Paul's report that you could have got that drone image from?
No, I'm not sure I got it from the report. I recall getting it from the file.
My question is, do you know of any other source other than Trooper Paul's report that you could have gotten that drone image from?
So this image is not in that report.
It's not my
Yes, it is. You asked me anything but the report. That image is not in that report.
Did you get the drone image from any file from the Massachusetts State Police?
Yes.
Okay. Did Trooper Paul work on any drone images to your knowledge with respect to 34 Fairview?
I don't know.
But you would agree that the drone images are from the Massachusetts State Police file, correct?
Give me 1 second.
Sir, let me know you've had a fair opportunity to answer that question.
Yeah, give me a second. Yes, it came in a file called cars-trp.jopal.
Okay. So it came from, and that's the report of Trooper Paul, correct?
No, these are drone images that are not in the report.
No, I'm saying what you just read. Can you repeat it again, what you just read, where it came from?
I read you a folder that contains a bunch of things, including the report.
Understood.
That image is not in his report.
Can you read the file name again that you just read?
The folder name is cars-trp.jopal.
Okay. And did you get the drone image from that file folder?
I did.
Okay. Thank you.
You're welcome.
Now let's go on to the May 26, 2025 PowerPoint that you created. And I'd like to go to slides 25, 26, and 27. Have you discussed with anybody today at all the source of what is depicted up on this slide?
No.
Okay. So let's now go to where did you get the, you see the larger chart to the left there in the, looks like mostly a rectangle. Do you see that, sir?
What slide are you on? What slide is that?
25, I
25,
believe.
okay.
Okay. And then if we could click to 26, because it looks like it's the same. If we can go to 26 and 27, looks like it's the same one. You tell me.
Similar.
Similar. Okay.
Yeah.
In 27.
Correct.
See the same or similar one there. Okay.
These are all from Google Maps.
Well, my question is, may I approach, Your Honor?
Yes.
Thank you. Well, let me ask you this so I don't have to keep going back and forth. Do you have access, sir, to the CARS report of Trooper Paul on your computer?
Think so? You remember the name of it?
I don't. We'll do it there with a hard copy. Mr. Brennan, I'd like to show this one. Thank you. So, if I could approach, Your Honor?
Yep.
So, you see what I'm pointing to right here, which is page 10 of Trooper Paul's CARS report. Do you see that?
I do. Is this the same report? It's dated 1/29/2022?
I believe so, sir. Let me just take a peek. This is, you can just compare, this is the one I have in my hand. Take it and look for any identification that gives you, right? We got the same one.
Yeah, mine's broken.
Okay.
So let's do paper.
Okay. So we have that report, and I now am referencing page 10 of that report, and I'm looking at the chart on page 10. Is that chart on page 10 the same or substantially the same as the chart that is up on your slide presentation right now?
So it's not the same. I did not use this data at all, but we both use Google Maps.
Okay. Alrighty. Now let's go to your, continuing on the same slide. If Mr. Wolf, we could go to slides 22 and 23.
Okay, and this will be the last on this, Mr. Lessie. If you want to get to the autopsy photo, we're wrapping this all up at 4:10.
Okay, Your Honor. You see these photos?
I'm sorry?
Those photos. Do you recognize any aspect of those photos? Be doing this type of analysis other than Trooper Paul?
Someone else took the photographs?
No, I'm talking inside the vehicle.
I'm sorry?
Inside the vehicle doing what's depicted here.
Someone is inside the vehicle taking the photograph.
What's your best conclusion as to who that is?
Trooper Paul.
Thank you. Your Honor, that is...
Okay, so next topic.
Yes,
Go right
thank
ahead.
you. And I just need to reload, if you will, with regard to that topic. If you could, if Your Honor, we can go to slide, and I think I can do this fairly quickly.
Okay. If
If you can go, Mr. Woke, to slide 131 of Dr. Welcher's PowerPoint presentation. And it's now 132. I don't believe that's the right one. It's the...
One before that.
Yep. I think you're... Yeah, okay. So this is slide 131 from your slide presentation, correct, sir?
Correct.
And if you look to the far right, I'm sorry, Mr. Woke, you go to the other one. Yes, that one, and scroll down so we can see what's in green. For that depiction, that is from Dr. Scorty Bellows' autopsy report, page 3, correct? Is that where you got that from?
It's from the report. Take your word for it on page 3.
So, but it is from Dr. Scorty Bellows' autopsy report, correct?
Correct.
Now, if you could go to, if we could zoom back out and go to the multicolored image in the center, up at the top. Yep. Yep. I got it. Yep. Okay. Thank you. If you can go to the very top line, it says autopsy report performed by Irene Scorty Bello, MD, PhD. If you could scroll back over, date of autopsy, January 31, 2022, and then you see final diagnoses. That is all directly from the autopsy report, is it not, sir?
Yes.
And that is in your slide presentation, correct, sir? This is page 131 of your slide presentation, correct?
Correct.
That's all I have, Your Honor.
Okay. You are all set, Doctor?
Thank you, Ron.
All right. Oh, did you have any questions, Mr. Brennan?
If it'd be helpful to the court, I have a couple quickly.
Okay.
Can I keep under 2 minutes? Dr. Welcher, you were shown a photograph of the street of Fairview Road. Did you know that didn't come from Trooper Paul? It came from the CERT report, and Trooper Paul then took it from the CERT report and put it in separately in his presentation. Did you know that?
I had no idea. I just was given it as a folder.
And the photo you were using, it didn't have the markings that Trooper Paul put on his report, did it?
It did not.
When Trooper Paul, when you used that photo, was it because you were borrowing, relying on, or using any of Trooper Paul's reports for your conclusions or any of your, and that was different than what was used in Trooper Paul's report because it had absent in it all the writing. Isn't that fair to say?
That's fair to say.
Did you rely on Trooper Paul's analysis or conclusions in this case for your conclusions and your analysis?
Not at all.
Is that why you went and downloaded the information and looked at the car and did everything individually, separately, and uniquely from Trooper Paul?
I wanted it to be independent in my analysis.
Regarding Dr. Scorbello, did you ever consider her conclusions regarding manner or cause of death as a basis for your analysis and conclusions?
Yes.
And when you considered her analysis, did you consider the conclusion of undetermined cause of death? Was that part of your analysis?
Oh, no. I was using like the skull fractures, the description of the injuries.
So you were considering the information in her autopsy report?
Correct.
How about her conclusions? Did you rely on her conclusions to do your studies or any analysis in this case as far as cause of death or manner of death?
Only I thought I said blunt force trauma and hypothermia.
Okay. Regarding her conclusions about whether this was caused by a car accident or not, did you consider that as the basis of your opinion?
No, I wouldn't take a person like that's opinion for that.
Did you ever have a conversation with Dr. Scorbello about her expertise limitations?
No, I would want a biomechanical analysis.
Was your opinion regarding the collision in this case, did it have anything to do whatsoever with Dr. Scorbello's conclusions regarding cause of death, whether it was accident, undetermined, or homicide?
No.
Okay.
Thank you.
Yeah, Your Honor.
All right, one question. Can we just wrap it up? I'd like to hear you argue, but we don't have time, so I'm just going to...
I have
Decision.
two questions, Your Honor. You put in your slide presentation information from the autopsy report of Dr. Scorbello for a reason, correct, sir? And that reason is because you considered the autopsy report as part of your analysis, correct?
So I considered portions, which are the portions I included here for the autopsy report.
And part of those considerations were the final diagnoses. We can put that back up, Mr. Wope. But you recall the slide that you had has the final diagnoses of Dr. Scorbello, and you put that in your slide presentation because you considered that as part of your analysis, else it wouldn't be in there, correct?
So the final diagnosis is in there. There's a line, then it says cause of death, and then manner of death.
Right.
The things I highlighted are the things I thought were important. So the highlighting on slide 130. So the final diagnosis, again, does not include cause of death. It does not include manner of death. There's that horizontal line demarcating those. The important things that I was looking at are the under or highlighted, which is why I highlighted them.
Exactly. So the ones that you highlighted, you considered are from the autopsy report. That's why you're highlighting them, right, sir? You considered them.
Correct.
Thank you. No
You're
questions, Your Honor. I
All
appreciate
right.
that opportunity.
So I'm not going to let you argue now. I'll hear you very briefly tomorrow before we stop. But Mr. Alessi, how much longer are you going to be tomorrow?
If I could have a motion, Your Honor,
Yes.
I'll give you my best estimate.
I'm about halfway through, Your Honor.
I think it will take up, we'll look for it tomorrow. If we can get through things quicker, I would like to do that, but given today, that's my best estimate.
So
This is actually the reconstruction.
we're half a day tomorrow.
Oh, that's right.
So it may be that we have a 20-minute break tomorrow, and we finish up by 1:30 by going straight through. We've got a juror who has an appointment that we told her she'd be able to make. So I'd like to do everything we can so that Dr. Welcher doesn't have to come back or stay here another day. So let's just see what we can do, and we will do the same thing for your experts as well.
No, I understand, Your Honor, and I respect everything that Your Honor is saying. I must say, Your Honor, to state the obvious, this is a key aspect of the case, and we've got to be able to proceed through to the questions. He covered a lot on his direct and he properly.
And I'm not asking you to curb it. I'm just hoping that we can do it. So I will ask you tomorrow at a certain time to see whether we're able to do it with the 20-minute break and finish.
Fair enough, Your Honor.
Okay.
I'll give you my answer at that particular point.
Okay. All right. Thank you.
All rise for the court, please.
Thank you, Dr. Welcher.
Thank you, Your Honor. May I step down?
Hello, folks. I'm here. What unique moments. What unique moments as we look at Karen. What a unique view into the court. Oh, folks, that was rare. You don't see that all the time. I got an extra long look into court there. Those were some moments, ladies and gentlemen. No ruling for now. It looks like Bob Alessi just wants Judge Cannone to allow him to ask some extra questions on cross, but Bob Alessi also just told us, and I'm sorry to tell you, friends, we are only halfway done with the Bob Alessi cross. Oh no, ladies and gentlemen. Oh no, that was absolutely agonizing. And yes, Karen and her dad absolutely were strategizing. You're going to see Little Towel pop up on your screen just 1 second here now. My name is Grant Smith Ellis. That did not go well for the Karen Reed defense. That was bad. We're going to be able to do that recap relatively fast, but one thing I want to do with you Little Towels is, firstly, I want to watch Hank Brennan's part of that voir dire again, because he just ripped Bob Alessi to shreds. Hank Brennan was in a mood, ladies and gentlemen, and if you missed today's testimony, we don't even have to watch that much. I do want to go through and clip out the best parts of the cross from Bob Alessi, but it was really start the day with the ruling. Hank Brennan won a majority of the motions overnight related to his expert testifying about the collision between Karen's Lexus and John's injuries being caused by a collision. And then, ladies and gentlemen, it was the brilliant end of Hank Brennan's directive. Dr. Willis knew more about the timeline of the case than Bob Alessi. Bob Alessi right out the gate got the witnesses, the time the witness started working on the case wrong. Bob has been working on this case for 2.5 years. The witness was like, no, I haven't. And then Bob Alessi was like, oh yeah, and the witness was like, yeah, you're wrong. And that happened over and over and over. It looks like Karen Reed is running her defense. I don't understand, folks, why Bob Alessi is operating as Karen Reed's lead attorney, seemingly. The only thing I can make up, the only way I can understand is that they're actually doing all the legwork for free. It's just he's getting trial experience, and Karen is really the one calling the shots. It looks really bad. I really get the sense that the money's all gone. Paul Doherty, I think he's absolutely right. Hot Coffee Chats, you do belong here, dear friend. You can come by anytime you want. I'm sorry if I missed some of your questions. I really hope it wasn't that you felt unwelcome here, but dear friend, you go where your spirit calls you, and just know you are always welcome here, at least in Little Towel's eyes. I find you very friendly and cooperative and engaging. Ladies and gentlemen, as I mentioned, it's just past 4:15 p.m. on Wednesday, May 28th. We just heard we only have court tomorrow until 2:30 p.m. There will only be a 20-minute break. Bob Alessi said he's only halfway done with his cross, so he started sometime in the morning, so he could have as much as 3 to 4 hours left. Oh, ladies and gentlemen, Modelo Macy, we had an end of the day voir dire. We got a ruling in the morning. It's not really an important substantive issue. It's just the scope of Bob Alessi's cross of Dr. Jordan Welcher. Alessi said he should be done with his cross hopefully tomorrow. A juror has a issue tomorrow afternoon, not an issue, an appointment. So court's ending at 1:30 p.m. tomorrow, but we're only going to take a 20-minute break tomorrow morning. So Bob Alessi was told by Judge Cannone to try to get his cross of Dr. Welcher ready tomorrow. Now, we are going to listen to Hank Brennan's statements there, folks. That was a very interesting part. If you missed that, I thought it was really, really interesting. So let me bring it up for you, Little Towels. Give me 1 second here. I got a plan. I am the towel man with the plan. Yeah, I think that they're trying to not just bring in the report, they're trying to bring in questions about the report, ladies and gentlemen. So that's really what I think is going on. It's a very narrow, small issue. It's more like dilatory tactics from Bob Alessi. I didn't really get the sense that he was actually trying to bring this up. I got the sense more that he just didn't want to let Hank Brennan crescendo on how it had crescendoed. So that was kind of the opinion that I got of that. It was like a very sort of, I was like, why did it go on? It was because the lawn crime feed ended. I got the sense that it was kind of a very just delay tactic, but Alessi wasn't really crossing. He was more just talking to the guy. And I don't think it's necessarily will the report come in. It's more, can Can Bob Alessi ask questions about the report? And I think the answer is going to be no, because he didn't really use the report. He used this package of evidence that had been collected by the CERT team that had nothing to do with Trooper Paul's report. So no, I'm leaning no on that, folks. And that's what I'm saying. I don't think he's really trying to bring in Trooper Paul's work. I think he wants one witness to talk about the other, the report. But again, you didn't have Trooper Paul testify, and I don't think this witness relied on Trooper Paul's report at all or for any purpose. So I think Alessi's going to lose that voir dire. It was a desperation move, by the way, folks. I know what desperation looks like, and that's what desperation looks like. Bob Alessi was literally so in over his head there. This man doesn't know what he's doing. This is not a cross. This is just kind of an exploration and kind of like getting trial practice. It was not good. Like, I'm trying to be somewhat like gentle here, but that was not good. It wasn't like there was nothing. It wasn't like I was watching that like, oh, like if only he asked that a different way, maybe he could have made a good point. Like, no, that was absolutely deplorable. It just wasn't good. I'm just telling you right now, and you can see the towel poll, hundreds of votes on the towel poll, and most people are voting down goes Alessi, down goes Alessi. Yeah, Beach Nats, we are going to keep going. We're going to do our recap stream. Absolutely, my dear friend. We tried to do the recap. I think today's recap we're going to be able to do relatively quickly in a truncated fashion, because outside of watching Hank Brennan's a stellar oral argument during the voir dire, and then looking at some of the Bob Alessi cross highlights, there isn't really much of substance that happened today. It was more just Bob Alessi getting embarrassed. And me, there were literally points, I don't know if you all watched this. We are going to watch a moment, ladies and gentlemen, from earlier. Oh, you're seeing double towel. I feel a little bad for you. Meta towel. This is a very meta situation, ladies and gentlemen. We have multiple towels on the screen. I feel very meta. But just look at how this started, ladies and gentlemen. I just want to show you, not how it started, I want to show you just like the apex of Bob Alessi's cross if you missed it. If you're just tuning in, you didn't really miss much. It's only going to take us a little bit to get caught up. But let me just tell you, Bob Alessi's cross, like, it started with this moment, and it did not get better for Bob Alessi.
So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's, what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just go right to the bill. As you sit here
understood.
today,
I'd like to move on from that discussion.
Exactly.
I bet you would, Bob Alessi. The Alessi clip, as Alex says, ladies and gentlemen, it has a name. You know you done screwed up when your clip has a name, ladies and gentlemen. The Alessi clip. You either screwed up or you are heroic. It's either the You Can Call Me Hank clip or the Alessi clip. And let me just tell you, I don't think the Alessi clip has positive connotations, ladies and gentlemen. Oh, goodness. I loved how the witness answered that. And, folks, if you liked that, let me just tell you, there are going to be a lot more interesting moments. But the one thing we have to watch first is just that glorious moment at the end there with Hank Brennan during the voir dire. Hank Brennan, ladies and gentlemen, had some things to say to Bob Alessi. Oh my word, did he have some things to say. It wasn't like directly to Bob Alessi. I just think Hank Brennan was like, this is absurd. Why am I involved in this charade? Like, it was hilarious, ladies and gentlemen. Hold on, we got to see what part we're not going to listen to Bob Alessi again. We're only going to listen to this for Hank Brennan. Hank Brennan is the only reason that we're listening to this. So hold on, I have to wait till when Hank Brennan actually gets up. Sit down, Bob Alessi. Sit down, for the love of God, please. I'm not even going to make people listen to Bob Alessi's voice again. I'm not actually going to unmute this until Hank Brennan steps up. All right, hold on. Hank Brennan is now up during his part of the voir dire. Literally, folks, if you missed this, Hank Brennan was on fire during this section of the voir dire. It was incredible. So let me just, I'm not listening to a single second of Bob Alessi's part of it. So hold on. Let's get to the part where Hank Brennan starts speaking. Sit down, Bob Alessi. Sit down. Okay, I think he's about to be done. All right, hold on.
Date of autopsy, January 31, 2022, and then you see final diagnoses. That is all directly from the autopsy report, is it not, sir?
Yes.
And that is in your slide presentation, correct, sir? This is page 131 of your slide presentation, correct?
Correct.
That's all I have, Your Honor.
Okay. You are all set, Doctor?
Thank you, Your Honor.
All right. Oh, did you have any questions, Mr. Brennan?
This part is so great. Hold on, let me get a recording of this. Hold on. It might not actually record great. I'll just wait until after we do the recap. So 4:26:20. All right, let's watch this part. This part is just absolutely glorious. 4:26:20. Brennan voir dire. All right, thank you. This part is glorious, ladies and gentlemen. Just glorious. Hank Brennan was furious.
That's all I have, Your Honor.
Okay. You are all set, Doctor?
Thank you, Your Honor.
All right. Oh, did you have any questions, Mr. Brennan?
If it'd be helpful to the court, I have a couple quickly.
Okay.
Can I keep going in 2 minutes?
Yes, Amber Am, I have that part. Don't worry, we'll watch that too. I have a lot of timestamps.
Of the street of Fairview Road. Did you know that didn't come from Trooper Paul? It came from the CERT report, and Trooper Paul then took it from the CERT report and put it in separately in his presentation. Did you know that?
I had no idea. I just was given it as a folder.
And the photo you were using, it didn't have the markings that Trooper Paul put on his report, did it?
It did not.
When you used that photo, was it because you were borrowing, relying on, or using any of Trooper Paul's reports for your conclusions or any of your decisions or analysis? And that was different than what was used in Trooper Paul's report because it had absent in it. Fair to say?
That's fair to say.
Did you rely on Trooper Paul's analysis or conclusions in this case for your conclusions and your analysis?
Not at all.
Is that why you went and downloaded the information and looked at the car and did everything individually, separately, and uniquely from Trooper Paul?
I wanted it to be independent in my analysis.
Regarding Dr. Scotabello, did you ever consider her conclusions regarding manner or cause of death as a basis for your analysis and conclusions?
Yes.
And when you considered her analysis, did you consider the conclusion of undetermined cause of death? Was that part of your analysis?
Oh, no. I was using like the skull fractures, the description of the injuries.
So you were considering the information in her autopsy report?
Correct.
How about her conclusions? Did you rely on her conclusions to do your studies or any analysis in this case as far as cause of death or manner of death?
Only I thought I said blunt force trauma and hypothermia.
Okay. Regarding her conclusions about whether this was caused by a car accident or not, did you consider that as the basis of your opinion?
No, I wouldn't take a person like that's opinion for that.
Did you ever have a conversation with Dr. Scotabello about her expertise limitations?
No, I would want a biomechanical analysis.
Was your opinion regarding the collision in this case, did it have anything to do whatsoever with Dr. Scotabello's conclusions regarding cause of death, whether it was accident, undetermined, or homicide?
No.
Okay. Thank you.
Yeah, Your Honor.
That was it.
One
Hank for one, and then Judge Canoni was like, one question, Alessi, and then he went way more than one question. All right, folks, hold on though. We are going to do our recap. Listen, I know Hank Brennan was like, Hank Brennan said more in 2 minutes than Alessi said in 4 hours. I love it. Listen, I can talk pretty fast, okay? I can process a lot of information. Hank Brennan, oh my goodness. He's not just talking. He's asking questions, getting answers, going on to the next questions. He's just like, my name is Hank Brennan. I have something to say. I have a point. I had to sit here all day and listen to this nonsense from Bob Alessi. Oh my dear God, my witness did great, but I have some things to say. Oh, it was great. Oh, goodness. Yes, a day of listening. I think Bob Alessi's entire job is to just wear people out, ladies and gentlemen. But let me tell you, my opinion, okay, of just what's going on now that we're very close to the end of the state's case. It's almost over here, folks. The defense isn't really going to have much of a case. Brandon's going to absolutely dominate Archon Cross. That's going to be amazing. But listen, there is not much left here, okay? And this was a big witness for the state, and Reed's defense doesn't really have anything. They're not using Alan Jackson to cross this this main witness. Are you kidding me? They're not using David Yannetti. I'm telling you, like, I don't know why they put Bob Alessi up there for this cross. They keep doing it. They must be out of money. Alessi's the one who's working for free. Listen, I'm telling you right now, I am not a lawyer. I'm a lay towel. I'll give you my analysis. I've watched every minute of this trial. I know all the documents. My analysis of this is that my analysis of the state of the Reed defense is that they're completely out of money, that Karen Reed is basically the one calling the shots now. It's just Karen Reed. And that Bob Alessi is the only one who's actually willing to do this for free. David Yannetti and Alan Jackson are still around because they don't want to abandon Karen, but they're not going to do much work because they're not getting paid. And so, yeah, no, I don't think they are working for free. I know that Karen had to pay a bunch of money out to Yannetti in the beginning. I've seen the emails I've seen an email about that where Karen was talking about her fee agreement with Yannetti. Listen, I've thought about this a lot. I think she's out of money. There's no amount of money that she could raise at this point that would cover getting Alan Jackson and David Yannetti to actually be able to do legwork on this case. So they're just there for show. Bob Alessi isn't really like a sharpened criminal lawyer, and he's up against Hank Brennan, and that's why AJ and Yannetti look so mortified, because I bet they thought, based on how Alessi talked and his credentials, he'd be able to handle this a little better. So the whole team was comfortable. The Reed defense probably was comfortable with being like, okay, even if AJ and DY just only do behind the scenes stuff and they don't put in a lot of legwork and just sit there, Alessi can handle this burden. But yeah, no, I'm telling you, I agree with you, Mass Mama. I think 100%. Welcome to the Honorary Towel Fold. Just to give you my direct analysis of the case to this point before we do our daily recap, it's bad. It's so bad for the Karen Reed defense that I think it literally can only mean that she's out of money. And I will tell you, yeah, Colleen Henry, the more I think about it, the more sense it makes to me. Because why would you listen? If I were, let me just put you in the shoes. I'm not going to give the defense any advice because we're looking ex post facto now. But let me just tell you what I would have said. I'm not a lawyer. I'm a towel. I'm a lay towel, and none of this is legal advice. Let me just tell you what I would have said hypothetically in that room if after some of those Bob Alessi initial crosses. Mind you, I am someone who's actually been in the courtroom. I have notes on what the jurors are like, how they're reacting. I would have said, like 2 or 3 weeks ago, we cannot keep putting Bob Alessi up there for these crosses. The jurors are not taking notes when he's asking questions. They're tuning him out, okay? They're getting upset. They're getting frustrated with him. That's then going to be reflected in how they think about Karen. The jurors really like Hank Brennan, okay? And we're in this terrible position. We cannot continue to put Bob Alessi up there on cross. Maybe pick our spots, put him up there for 1 or 2 technical crosses, but you cannot put him up there for the big show moments because, one, it has to serve a dual function. When you're doing a cross, you have to be both speaking to the audience on the camera, okay? You have to be speaking to the jury, right? So you have to be doing this simultaneously, and you have to be on merit winning the case for your client. So you're doing 3 things at the same time. And let me just tell you right now that Bob Alessi is doing absolutely none of those things. He's not capable of arguing in a showmanship style way on cross to make a point for the cameras. He's not capable of arguing in these nuanced, very specific ways to make a point to the jury because he so belabors everything that he says. And the only reason that this is why it blows my mind, because if I were part of that defense team, just hypothetically, and I'm not a lawyer, none of this is legal advice, but weeks ago I would have said, we have to stop putting him up there. No, it's over. It's too late. The state's case is over. But I would have told them, we can't keep doing it. And listen, this is also why I'm willing to give these insights, because there's no way they would have done this. I'm telling you, no competent lawyer, no reasonable, intelligent human being would sit in that discussion room amongst the Karen Reed defense team and say, after those first few crosses from Bob Alessi, we should keep putting him up there. The only way that it makes sense is if they're out of money. It's not just that they think the Karen clips are sinking them, it's that the Reed defense team is out of money. That's the only thing that makes it make sense, because you cannot keep putting Bob Alessi up there. It's destroying your case. Quite literally, folks. It's destroying her case, okay? It's hurting Karen directly. Every time he gets up there on cross, you can see it in Jackson and Yannetti's faces. It's bad. It's as bad as can possibly be. So the only reason you would keep putting Bob Alessi up there to do this, to humiliate himself, is one, maybe he's going to be the fall guy when she's guilty, like Jackson and Yannetti are thinking, oh, we'll just blame him. But two, the other thing is, it's so obvious that this is someone getting trial experience in a very high-profile arena. Hank Brennan doesn't need trial experience. He teaches it, okay? Advanced trial practice, I'm sure. In fact, I saw someone post about that, so he definitely does. Ladies and gentlemen, Bob Alessi is trying a high-profile criminal case. I think he has more experience in like civil depositions and environmental law. It does not make sense to have him up against Hank Brennan over and over and over again. So the only reason you wouldn't pull him off, as I said earlier, is if there's no money left, and so Alessi's the only one who actually put in the legwork to do all this. Yeah, the team, I think the legal team is helping Alessi, but what would make sense is he's the only one that's really doing it for free. But that's what I'm saying, ladies and gentlemen. God bless you, Super Towel Jew Drops. That was my wonderful analysis. You had a long day today, friend. You get some rest. We got a half day of court tomorrow. We'll be starting at our regular time, 7:30 a.m. We're going to do our recap in just a few minutes here. But I think some of you probably benefited from that analysis. And by the way, everyone give Super Towel Jew Drops a big hug as Super Towel Jew Drops goes to bed. And is it Riki and Kiki? Did I get it right, Jew Drops? Tell the Super Towel girls that they are loved and appreciated, and we hope you all get a wonderful night's rest. Oh, God bless you, Jew Drops. You didn't have to do that, you Super Towel. Jew Drops, ladies and gentlemen. I do take a moment to put Jew Drops' name up on the screen here. But just know that Jew Drops, there are very few people who are in the chat with me like before the stream starts, because so just so you know, we do our recap, okay? Then I end the recap. Then I have to clip the recap. Then I have to upload it. Then I have to download it, render it. Then I have to upload it to YouTube, Twitter, and 2 different Facebook groups, okay? Then while it's uploading, I'm writing up all the things that happened today. And then I'm preparing tomorrow's stream. I have to make a Canva image, and then I have to prepare it for the stream so I can put up tomorrow's stream, so there's a placeholder. The very first person, ladies and gentlemen, in that placeholder stream while we wait for tomorrow's stream to start is always Jew Drops. And you have no idea, after I've exhausted myself, it's like 8 at night, I'm in delirious after a day of streaming. Oh, ladies and gentlemen, Super Towel Jew Drops is a superhero. And I just want to say before Jew Drops goes to bed, we appreciate you. You are a super towel, my dear friend, and you are a super towelette, in fact. And I hope you get some good rest. Now, the one thing is I can't do Jew Drops in the autocorrect. I can't do Jew Drops in the voice to text because it spells out the word Jewish every time. I'm not saying Jew Drops. I'm saying J-U Drops. But yes, God bless you, Super Towel Jew Drops. And my favorite part is it's in pound sterling. I may be an American, but I value the Anglo-American special relationship. I'll bring us back to a time of Jack and Mac. God bless you, Jew Drops. Towel appreciates you more than words can ever express. Big Super Towel hugs to you, Jew Drops. And ladies and gentlemen, I think you know what's coming next. I didn't even mean to scroll on because I didn't want to go past saying our wonderful thank yous to Jew Drops. But look, first of all, look at all the wonderful towel friends wishing Jew Drops well. And then, ladies and gentlemen, look at this, ladies and gentlemen. Look at this. Pat Brooks, and I don't mean to just highlight, I'm not trying to, and I would never just highlight the people who are supporting this channel, but Pat Brooks, friends, so many days, I can't even tell you, Pat Brooks comes through and will either leave supportive comments for their fellow towels or say something supportive to Towel, and then Pat Brooks always uses an orange themed super chat, and I just want to say, and I'm going to read it, it says, Grant, heart smiles, and all my awesome, wonderful towel friends. I have been so angry because of RAKRAJ that I have no words to describe my disgust today. Love and gratitude to all of you. Justice for John and his family. God bless you, Pat Brooks, and have solace, have faith, my dear friend, my towel friend, and let me reassure you that today was a bad day for the Karen Reed defense. Towel has a very keen ear for listening to directs and cross, and that was the Karen Reed defense on very, 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 very last gasp death throes and life support. It's almost over, dear friends. God bless justice for John O'Keefe. God bless the O'Keefe family. And Pat Brooks, you are an appreciated human being. And it's not just the support of the channel. It's who you are. It's the fact that you put so much thought into all of your comments and to how much you care about your fellow towels and how much you care about Little Towel. It means something to me, and I will never not take the opportunity to say that. So, and I also want to say God bless. I will look down, I promise, at my phone. God bless all of you Little Towels. We didn't even do donation reads today. I haven't been doing it because I only feel comfortable doing that if, like, I literally don't have food to eat tomorrow. So all of this support, like, you're just doing it because you want to see this place thrive and become a public information service. I don't know if we're ever going to get there, but I'm working on it, ladies and gentlemen. I'm going to try. It brings a tear to Little Towel's eyes. Oh, God bless you, Pat Brooks, truly. And I think, ladies and gentlemen, I have to do this as well because it is part of my towel tradition. Murder by Maestro has me using my voice to text. God bless you, Pat Brooks. You are a super towel in every sense of the word, and you are appreciated and loved by this towel. I sometimes wonder if the voice to text is like, this man seems to think he is a towel. The predictive text is like, we should probably note that this man thinks he is a towel because for some reason he constantly talks about towels. At first, ladies and gentlemen, I will tell you that the text-to-speech would refuse to write the word towel. It was like, this man cannot be saying I am a towel. But yes, I was. So let me just scroll through some of the chats while we get ready to do our recap. I know all of you are getting ready. You all also give me a little indulgence, by the way, because at the end of our... Oh, my goodness, it's Pilgrim Shadow. Oh, God bless you, dear friend. Yes, Pat Brooks is such a generous daily supporter and just friend. Hugs to Pilgrim Shadow for saying that about Pat Brooks. It's not just me. It's the way you talk about each other. You remember each other. Bob Alessi is an SNL skit. Yeah, I think SNL needs to take on the Karen Reed trial. I should write an email. Should be like, listen, Lorne Michaels, I have something to say. Oh my goodness. Oh my goodness. Oh, ladies and gentlemen, the honorary towel spouse herself, Mandy Strong, she didn't just come through with support for the channel, ladies and gentlemen. That is a pair with a headband giving me a cup of coffee. Oh my goodness. Wait a minute. Where did you get that cup of coffee, you little bear? Oh, thank you so much. I would love to take that. Thank you very much. I will have some of your coffee, except it will become water. Towel does not drink caffeine after 9 a.m. It becomes a very dangerous proposition. Do you want me like this at 1 in the morning, ladies and gentlemen? That's what happens when I have a little bit of caffeine. I think I have a hypersensitivity. But God bless you, little towel pair. Towel appreciates you in every sense of the term. You have a headband and a cup of coffee. People are like, great, we want to do the recap. I know, but could you... It is a little pair with a headband and a cup of coffee. You tell me that you're going to just be like, oh, I'm going to scroll. No, I want to say hello to that little pair. I'm not just going to scroll on. I'm going to say hello to it. Oh, I know. We have to do the recap. Can't I just hang out with the pair for a little bit, ladies and gentlemen? Don't you understand my childlike joy when I see emojis? Come on now. We need to give Little Towel a little credit. Oh, ladies and gentlemen, we are all so friendly to each other here. Oh, it's great to see you, Pilgrim Shadow, from the Finger Lakes region of New York. Well, you know what? From Massachusetts to New York, you are appreciated. Yes, I absolutely try to talk things out, Suzanne. I do try to drink a lot of water. I try to eat healthy. We have a lot of towel friends who are trying to give towel positive advice. I've been eating good food recently. I've been trying not to eat junk. I did eat trail mix yesterday. I got in a little bit of trouble with Murder by Maestro. He said that is not towel food. I replied back that he is a 1001-year-old towel in binary. But we're all 27-year-old towels anyway, ladies and gentlemen, and so... yeah, I don't drink alcohol either. I've been a teetotaler since the day I turned 21, and I don't intend on ever going back. Yes, I think Alessi is a little bit of the fall guy as well, friends. All right, who's ready to do the recap? I got timestamp notes of our funny Alessi moments, and then we're going to start the day we're going to start the day where it started, ladies and gentlemen, which was with the ruling from Judge Cannone, and then we go right into Hank Brennan's direct, and then we get to look at the funny moments from Bob Alessi's cross. All right, so we're going to start with that moment that Brennan came through with the big victory. So I got to actually timestamp the moment that we start the recap. So we're going to start at about 4:45:30. Hold on one second. No, I want to give myself a little bit more time. 4:45:45. How about? Oh, that's great. All right. So, towel friends, you know what to do. Get ourselves collected. Take a breath. And hello, towel friends. If you missed day 23 of the John O'Keefe and Karen Reed retrial, well, you missed Bob Alessi absolutely bomb on cross, and it was quite a moment. I am so glad, ladies and gentlemen, that I got to see it. You got to see Bob Alessi impeach his own credibility on cross, but of course the day started with a momentous win for Hank Brennan, who was after an overnight review by Judge Cannone. Brennan's witness, Dr. Judson Welcher, a crash reconstruction expert who had started testifying Tuesday, was allowed to finish up his direct on Wednesday morning by telling jurors his opinion that Karen Reed's Lexus was involved in a collision around 12:32 a.m. and 4 seconds to 12:32 a.m. and 9 seconds on 1/29/2022. And furthermore, ladies and gentlemen, perhaps more importantly, that John O'Keefe's injuries were the very classic result of a sideswipe type collision with a vehicle of that nature. Now, ladies and gentlemen, let me tell you, it didn't just start there, though, because immediately after that, Hank Brennan got to do the direct. We're going to get to listen to that testimony. We are going to get to hear the ruling from Judge Cannone. We're going to get to do it all right now during the recap. My name's Grant Smith Ellis. I'm glad you are here with me today. If you weren't, now's your chance to get caught up. We're going to be able to do this relatively quickly because there wasn't much substance to Bob Alessi's 5-hour cross. It was just the witness humiliating Bob Alessi over and over and over again. Oh, ladies and gentlemen, the witness even got out of his chair at one point during cross just to re-emphasize his testimony about Karen hitting John with her car, and he reenacted it. It was quite a moment, ladies and gentlemen. But yes, folks, here we go. We're going to start with the ruling that began the day from Judge Cannone. Let me just bring that up for you little towels right now. All right, little towel friends, appreciate your patience. Sorry about that. I by accidentally put the towel comments down, so I'm going to scroll them back just for the point that we may have missed any of them. And now we are going to watch.
All right. Good morning, everybody. All right, so Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied. In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application. However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe, because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling.
That was the ruling. So you're wondering, okay, how did that actually play out? Well, remember, dear towel friends, this is a recap, so we actually get to see how it played out, because Hank Brennan's expert immediately then got up on direct and did his voir dire, and we are going to watch it right now, because I'm a little towel and I keep these kind of things archived and ready for us to watch. Now, Twitter's video player is being a little weird today, so I can't make it better quality. Hopefully it buffers throughout the video, but more listen to what is being asked, folks. Listen to how Hank Brennan crescendos this for the jury.
Ask you those questions again, but before we do, I'm going to ask you two other questions. The first is, I'd ask you to turn to your PowerPoint, slide 110.
Display it,
please. I'm going to ask you a question about a series of your slides regarding this effort. This is 110. Could you also follow through to 111, 12, 13, 14, 15?
You want me to play the videos?
You don't need to play the videos. I just want to acquaint you for the question.
111,
12,
112, 113, 114, 115.
How many times did you engage in testing where your arm and forearm touched the rear right of the exemplar Lexus?
3 times.
In any of those 3 times, did it ever leave any paint on the underside of your arm or forearm?
No.
If you could turn to slide 130, please. What? There we go. Could you go back one, please? Perhaps it's 131, Dr. Welcher. There we go. Could you explain the significance of this slide, please?
Your Honor, this is...
Oh, could you take that down, Dr. Welcher?
Sure. Mr. Brennan.
We're going to move forward. Yesterday, when we left off, I had asked you...
So we need to take this.
Sorry.
You can take the PowerPoint down, please.
That was in a different spot on the slide. Hold on a second.
That's better.
Thank you. Sir, I had asked you yesterday about some of your opinions. I want to ask you about some of your opinions relative to that last effort that you made regarding testing between the Lexus and your arm.
Correct.
You had mentioned earlier on in your testimony that you reviewed a number of pieces of information and offered that you relied on some of those pieces for your opinion. Can you share with us, for this part of your analysis, what pieces of evidence or information did you rely on for the opinions I'm going to ask you?
Relative to the testing on the arm contact on the taillight?
Yes.
So it was the physical evidence at the scene, the photographs of Miss Reed's vehicle, to a certain extent, my analysis of the Ring doorbell and the One Meadows.
You yesterday.
I am counting on my fingers. So I am counting on my fingers. I am counting on my fingers. The Ring video doorbell, Mr. O'Keefe's height,
I'm back, Little Towels. All I was telling you is we are right back into the testimony. If you missed those last few seconds, all I was letting you know is I have pulled up the exact moment in testimony. We're switching over from the X feed to the Twitter feed, YouTube feed, because the YouTube feed got a lot more stable recording of Dr. Welcher's testimony, and we are now picking up at the very second we left off, which was 10:16 a.m.
Effort that you made regarding testing between the Lexus and your arm.
Correct.
You had mentioned earlier on in your testimony that you reviewed a number of pieces of information and offered that you relied on some of those pieces for your opinion. Can you share with us, for this part of your analysis, what pieces of evidence or information did you rely on for the opinions I'm going to ask you?
Relative to the testing on the arm contact on the taillight?
Yes.
So it was the physical evidence at the scene, the photographs of Miss Reed's vehicle, to a certain extent, my analysis of the Ring doorbell and the One Meadows event, the nature and
Excuse me, Your Honor, pardon my interruption. I just want to know if he's reading from something or not reading.
Looks like he's counting on his fingers. Are you reading from something?
No, I am counting on my fingers.
Okay, thank you.
So I am counting on my fingers. The Ring video doorbell, Mr. O'Keefe's height, the type of shoes he's wearing, because I needed the same type of shoes, my exemplar inspection where I matched up the heights, and then the text stream data as well.
That information that you considered, in addition to the text stream data you considered, considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
So there's been two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles.
Based on the physical damage and your testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe.
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
In your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty, whether John O'Keefe's injuries on his arm, inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
Yes.
What's your opinion?
That it is. It is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
And does that specifically pertain to January 29, 2022 around 12:30 a.m.?
Objection, Your Honor.
I'm going to allow that.
Yes, it does.
To finish, I'd like to ask you a few more questions. You've written some papers on sideswipe collisions or clipping. Can you describe for the jury and explain collisions or clipping? Can you describe for the jury and explain what a sideswipe collision is or a clipping and how that may or may not differ from
being contacts compared to, say, an inline impact or, say, a T-bone impact? Is what refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So, for example, if I rear end a car, that car will be accelerated up as a result of the contact, and they reach what's called common velocity, and then they separate. And so in a glancing hit, you can have a glancing hit and you don't have what's called complete momentum transfer, meaning the momentum from the car, because it's a glancing hit, doesn't completely transfer to the object being struck. For example, you can drive down the road at 100 miles an hour and clip the mirror of a parked car and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going because you don't have all that momentum transfer. So when you have glancing contacts, you can have much higher speeds without a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
You mentioned about potential damage to a car. How about potential damage to the pedestrian?
It's the same thing. So when you have a glancing hit to a pedestrian, this is referred to as a fender vault. In this case, they call it a fender. Fenders on the front of cars because most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner of the car. Those are much more complicated because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted without a whole bunch of information in that type of crash. If the impact had occurred in the center of the vehicle and we knew where the point of impact was and the point of rest, we'd have a much better chance of determining how fast the vehicle was going. But when you have just a corner clipping or glancing, it makes it more difficult to determine, even when you have an area of impact, which is where the person was when they got hit, and a point of rest where they landed, makes it more difficult for glancing contacts because you have that sideswipe problem where they don't obtain what's called common velocity.
And what are some of the other difficulties in attaining specificity in a sideswipe or being hit by a quarter panel as opposed to a fender?
So for a pedestrian, correct?
Yes.
So pedestrian impacts and how you move post-impact are very sensitive to your exact body position. For example, whether your right foot is on the ground or off the ground, whether your left foot is on the ground, off the ground, whether you jump up in response to the crash. Simply raising and lowering your arm changes the amount of rotation that's going to happen. Post-impact motion of the person. So cadavers, crash dummies don't have any muscle reaction. So the motion of a crash dummy will do additional activities that alters where they come to rest.
In your studies of direct pedestrian collisions by front or back bumper as opposed to sideswipe or clipping somebody, is there a similarity or difference in type of injuries that you see?
Yes.
And what is the difference?
So in direct centralized impacts, you tend to get much more severe injuries. Really what's occurring is you're getting that momentum transfer. So it's more, you're accelerating the person up to the vehicle. They can wrap onto the side in front of the vehicle at higher severities. Their head will hit the hood, their head will hit the rear of the vehicle. So when you have that direct contact, there's actually more momentum transferred to the actual occupant. There's more applied force to the occupant as well.
When you see direct impacts, is there ever the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the Accident Reconstruction Collision Safety Institute on pedestrian injuries, I went through all the literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures. It depended on how exactly the foot was loaded.
Is it uncommon in sideswipe pedestrian accidents to see no lower body broken bone?
No, it is not uncommon.
Have you had cases that you've studied or been involved with where you've studied the effect of a sideswipe or a clipping impact where there's an absence of broken bones in the lower body extremities?
Yes.
I'd ask you to turn to slide 139, please.
Oh, sorry. I fixed those other two slides.
Okay. Could you share with the jury what this represents?
Sure. So this was a trial that I was involved with in downtown Los Angeles. I've redacted the name at the top, but this was an instance where we had, this is a image from the police report. Oh, let me see if I can. So AOI in this diagram stands for area of impact. That's where the pedestrian was when they got hit. AOR is area of rest. And you can see we have information on exactly how far the pedestrian was thrown. Then on the right-hand side, we have photographs showing the impact to the pedestrian. This was determined by experts on both sides of this case to be between a 25 to 35 mile an hour impact. And then what you see is a close-up on the bottom slide of where there was DNA transfers, hair and tissue samples on the vehicle from the individual that was hit by the vehicle.
Next slide, please. And what does this represent?
So this is the decedent in the case, the person that was hit. He was killed at the scene. What you see on the left-hand image, oops. On the left-hand image is he had a massive laceration to his right forearm, but it didn't break his arm. There was no broken bones in his arm. On the right-hand side of this image, you see the autopsy report. What you'll notice is he had red marks on his leg, left buttocks, but he had no leg fractures. And again, this individual was hit at between 25 to 35 miles an hour.
Can you expand that? I'm sorry.
Yes, yes, Your Honor.
Do you want that expanded like other times?
There you go.
Thank you. I'm sorry to interrupt you.
Yeah, no, my pleasure, Your Honor. Thank you. So at the top, he had a severe brain injury, which again is the most common injury in pedestrian crashes. He did have fractures of the right 11th and 12th rib and a liver laceration. If you look at the extremities, it says right upper extremity. Again, that's from the shoulder to the end of the hand. Extremity wound with vascular injury, so no fractures. If you look where I was talking about the multiple abrasions, so when they're looking at the lower extremities, they're noting a number of red marks, but there was notably no fractures to the lower extremities.
Thank you. You can take that down, please.
Okay.
Dr. Welch, regarding your analysis of the data and the evidence in this case, do you have an opinion to a reasonable degree of engineering certainty whether the absence of lower body brakes to Mr. O'Keefe is consistent with the defendant's Lexus impacting in a sideswipe or a clipping Mr. O'Keefe?
Yes, you could definitely have this type of impact and not have anything beyond, say, red marks to the lower extremity.
Thank you, Dr. Welcher.
My
Your
pleasure.
Honor, I would move the evidence subject to redactions. Dr. Welcher's PowerPoint presentation.
That's by agreement, Mr. Wilson. With that caveat.
Thank you.
Now, if you're wondering, Grant, that seemed absolutely devastating from Hank Brennan. How is it possible? Yeah, exactly, H. Towel. If you're wondering, how is it possible that it could be that devastating and Bob Alessi would go down that bad in flames? Oh, ladies and gentlemen, we're going to take a look. And H. Towel, if you could tell me the time on the screen in time on the screen in Eastern time. It's right below the Law and Crime logo on my stream. You'll see I put a clock there for when that moment happens. It's probably, I can probably figure it out. We'll get to it at the end of the day. But if someone yells out, "Oh my God," when Alessi said he's going to take another 5 hours, ladies and gentlemen, let me just tell you, Bob Alessi's cross was that bad. I don't really know how to explain this cross to you. I think the best way for us to do it, I think the only way for us to do it is to just sit here and do this together. It's not like there was a lot of substance. 5:14 p.m. Eastern. H-Towel, you did give it to me in the perfect timestamp. Oh, ladies and gentlemen, we're going right to that then. Listen, H-Towel, Sheffield Flannel, is a super towel, ladies and gentlemen. I want to preview for you how bad Bob Alessi's cross was. Then I have a bunch of timestamps for us to look at. It was so bad, apparently. Murder by Maestro. Oh, my goodness. You know, if Murder by Maestro is coming by, then we're celebrating something, which was Bob Alessi just crashing and burning. Oh, my goodness. So we're going to 5:14 p.m. Wait, it can't be 5:14 p.m. Hold on, H-Towel. It can't be 5:14 p.m. because that was the court ended a little bit before that. But listen, apparently one of the court reporters says, "Oh, my God," when Bob Alessi is asked how long he's going to take tomorrow. Let's see if it was this moment.
So we're half a day tomorrow.
Oh, that's right.
So it may be that we have a 20-minute break tomorrow, and we finish up by 1:30 by going straight through. We've got a juror who has an appointment that we told her she'd be able to make.
So there is a moment there where someone apparently says like, "Oh my God," in response to Bob Alessi saying a half day, but I don't know. Oh, 4:14 p.m. Thank you, H-Towel. Yep, we got it right there. Let's listen to it from 4:14 and just see if we can hear it a little better. By the way, the Turtle Boy can't take other people's passes. He just sits there and waits and hopes that the alternates don't get in, and it does not work for him. He didn't get in today.
So we're half a day tomorrow.
Oh, that's right.
So it may be that we have a 20-minute break tomorrow, and we finish up by 1:30 by going straight through. We've got a juror who has an appointment that we told her she'd be able to make. So I'd like to do everything we can so that Dr. Welcher doesn't have to come back or stay here another day. So let's just see what we can do, and we will do the same thing for your experts as well.
No, I understand, Your Honor, and I respect everything that Your Honor is saying. I must say, Your Honor, to state the obvious, this is a key aspect of the case, and we've got to be able to proceed through to the question. He covered a lot on his direct
and I'm not asking you to curb it. I'm just hoping that we can do it. So I will ask you tomorrow at a certain time to see whether we're able to do it with the 20-minute break and finish.
Fair enough, Your Honor.
Okay.
My answer is that the point.
Okay. All right. Thank you.
All rise for the court, please.
Thank you, Dr. Welcher.
Thank you, Your Honor. May I step down?
Oh, I listened. I listened really hard, H-Towel. I couldn't hear it, but I trust you. If it's there, it might have been hiding. Oh, folks, we're doing a recap, though. We're about to watch the best moments of Bob Alessi crashing and burning on cross. There wasn't even substance to it. It's not even like reviewing Dr. Welcher's testimony, which took us an hour and 25 minutes yesterday. We are going to just laugh at Bob Alessi right about now. I also made my chair, the back of my chair, at an incredibly uncomfortable angle, and it's one of these fancy chairs that's 6 years old, and I don't know how to fix it. And I just want to note that I'm frustrated. But I'm not frustrated by Second Beach Gal, who is a super towel in every sense of the term. God bless you, dear towel friend. Thank you so kindly for your support, and thank you for supporting all your fellow loving towels. You are a super towel, my dear friend. It missed the word you, but I'm learning to use my voice to text. Murder by Maestro said it makes me a more efficient towel. Thank you so much for all your support of your fellow towel friends, and also for being a super towel in every sense of the term. Didn't I say that earlier? Yes, and also for being a wonderful human. See, ladies and gentlemen, we're anthropomorphic towels, which means we also have human sides. God bless you, dear friend. Oh, no, what do you mean it's no longer available? I tried to send the chat as quickly as I could. Oh, God bless you, though, Second Beach Gal. You are a super towel. Towel appreciates you. Towel thanks you for your support. Now, ladies and gentlemen, let me just show you. I do try to set a tone of love. God bless you, Mandy. Excuse me, I saw Mandy Strong. God bless you, too. God bless you, Beach Nance. You are a super towel, and I did look down at my phone, and I want to extend to you a special towel hug. You are appreciated. You are noticed. Thank you so much, ladies and gentlemen. I can't tell you how much it means to me. We haven't done any really breaks during this. How long have we been going? Almost 9-hour stream. I just do this as kind of a labor of love. I don't really think of it as really much of anything other than informing people. So the fact that you all have found a home here, that you all have so many friends here, it means so much to Little Towel. I can't tell you how much I appreciate it. But yes, I wish I could say that, in fact, I actually am glad there wasn't too much substance to analyze, because Bob Alessi just went down in flames on cross, and we are going to watch it together. Ladies and gentlemen, if you missed it, this basically sums up Bob Alessi's entire cross today. This one moment, it was so humiliating. I've never seen anyone try to impeach a witness about when the witness started working on the case and literally get it wrong. As a lawyer, you cannot make the jury think that you don't have a lot of credibility. Oh, ladies and gentlemen, oh goodness. Jeff Williams, hello. It is so great to see you. Yeah, I do think it is going to go worse for Alessi tomorrow, Pat Brooks. It couldn't possibly, but I think it might somehow happen. But yes, Jeff Williams, and also great to see you, dear friend, and H-Towel, Sheffield Flannel. I think you have a serious point there, friend. I will listen again with closer ears. But can we laugh at Bob Alessi first? You can't, as a lawyer, impeach your own credibility and knowledge about the case in front of the jury. And Bob Alessi managed to do it, ladies and gentlemen.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just go right to the bill. You, as you sit here today, exactly.
That was so great. That was so great. Can you believe that? That was just the beginning of Bob Alessi's humiliation. Yeah, exactly. And he was trying, Jeff Williams, he was trying to impeach the witness's credibility, and all Alessi did was end up impeaching his own credibility. Now, ladies and gentlemen, H-Towel has posted some audio. I'm gonna play it. I'm not gonna post it up on the screen, but I'm gonna play it. Sheffield Flannel has posted some audio, ladies and gentlemen, and I am going to hold on one second. Let's see. All right, H-Towel. Let me just click this. Now let's see. I'm gonna grab it for you. I'm looking for it, H-Towel. I can't find it. Can't find it though. Hold on. H-Tel said they posted it on X, so I'm taking a look for it. Let's see if I can find it. I really want to hear this audio of the court reporter potentially saying, oh my God, but I may not be looking in the right place, H-Towel, so I may... Oh, I found it. Hold on.
How long are you going to be tomorrow?
Oh! That's glorious! H-Towel, do you want me to cite you for this? Am I allowed to cite your Twitter for this? Oh my goodness! Oh, I can't believe H-Towel found this moment. It's as glorious as humanly possible. Ladies and gentlemen, H-Towel, am I allowed to cite you for this? Oh, all right, I'm bringing it up on the screen. Ladies and gentlemen, look at this moment. Look at this moment from H-Towel. Oh, ladies and gentlemen, listen to this. Look at the court reporter react to Alessi say that he's going to have to spend another 5 hours on cross.
But Mr. Alessi, how much longer are you going to be tomorrow?
Oh, I love it. Oh, that's amazing, ladies and gentlemen. We are all that court reporter. Listen, I want to get this clip so I can repost it. Hold on. That's hilarious. H-Towel. Oh, my goodness. That is the greatest thing. Ladies and gentlemen, if you have not met Sheffield Flannel, folks, please take a second to say hello to Sheffield Flannel. They just posted that video. That is amazing. We are all Madam Court Reporter. Ladies and gentlemen, oh my goodness. Oh, I love everything about it. Yes, H-Towel, you found it. You knew it, dear friend. You not only did you know it, you nailed it in every sense of the term. And then when Little Towel couldn't find it, you came through. Listen, this is like ladies and gentlemen, this is like Sheffield Flannel knocking one out of the American baseball proverbial park. We'll have to bring Sheffield Flannel over to Fenway. You can ignore the Liverpool connections. Oh, my word. You can see this is like going over the green monster, ladies and gentlemen. Oh, I love it, Sheffield Flannel. I love it so much. And you know what the best part is? We might be able to sync this with the moment that it occurred. With the moment that it occurred, ladies and gentlemen. So we can actually get the Karen Cam moment of that as well. Oh, Sheffield Flannel, that was absolutely glorious. So and I know why we might not have been able to catch it because I think the feed went out for a second, but that's even better, Sheffield Flannel. That is even better, ladies and gentlemen. So watch this. We're going to do our famous, we're doing it mid-recap, ladies and gentlemen. Sometimes on Towel Stream, we have a little bit of an inclination, ladies and gentlemen, and I just want you to watch this court reporter's reaction again to Bob Alessi saying that he's going to need another 5 hours. Madam Court Reporter absolutely loses it. She's like, oh, no. Oh, and so it was about 4:13:54, so it was right at the turn. All right, perfect, H-Towel. So we can actually grab that very easily from Towel Stream, and we can sync this to the whole image. Hold on one second. So let's grab this, okay? So we're going to grab this. And now, if you've never been here for towel editing, first of all, super shout out to H-Towel, by the way. H-Towel absolutely found this moment. They're getting a repost. I think this is going to lead to like 100,000 views on their Twitter. Oh, my goodness. And then what I want to do is I want to get, since we're going to use a still video here, we need like a 12-second clip from Towel Stream during that exact time. So hold on. Let me go into my towel videos here, and let me go into my recordings. We're doing this in real time, Little Towels, so we need that last little segment there, right? So we need right around 4:13 p.m., was it? 4:13:55. So we're going to get that, Little Towels. Oh, God bless you, Pat Brooks. Oh, I have it. I have it. Oh, I have it. Perfect. Perfect. I have it right here. Look at this, little towels. Why? Oh, Pat Brooks, first of all, God bless you. I needed that little towel pair because we are about to do some serious work. Ladies and gentlemen, we are about to put in some serious work right now, and I apologize. Your comments are frozen. I re-uploaded them. So just give me a second to get them to re-scroll because a lot of you were talking. I apologize about that. Ladies and gentlemen, first of all, a huge thank you to Pat Brooks, by the way, ladies and gentlemen. Not just coming through with support for the channel again, but it is an emoji that towel needed right now because we're doing mid-recap video editing, and I just want to say that that little towel pair is adorable. I needed it. Oh, my goodness, you little towel. I'm going to give you a little rub on the towel head. God bless you, little towel pair. And God bless you, super towel Pat Brooks. I'm just giving that little towel pair a little rub on the head. Now I have to get back to work. I love you, little towel pair, and God bless you, Pat Brooks. Now, ladies and gentlemen, if you've never done towel video editing before, let me just show you what this is like. It's an actually absolutely incredible experience. What we need to do is we need the 12 seconds. So let me just show you. All right, let me bring it up for you on the screen. This is one of those things that you may as well get to see in real time, and then we're going to retweet the Super Towels post, Sheffield Flannel himself. So do you see here how I have the background video of the moment that this happened roughly on the stream? So then what we're going to do is we're going to send that to back, okay? And you might wonder why we're doing that, ladies and gentlemen. Well, we're going to send it backwards because what we want is this clip to be on the front. Now, we want this clip to basically replace, okay, where this was. And it's okay if it stretches out a little bit. Now, we don't want to get rid of John's face, but we also want to make sure we keep the court reporter. So let's do a little compromise. We may actually have to lose John's face for this, unfortunately, because, oh, that's unfortunate. But also, what we really need to look at is we're looking at the timing of this clip, okay? So this clip starts. We can see it's a 12-second clip, and we want the audio. This is of the court reporter rolling her eyes. And we get a little clock view at, hold on, give us a clock view, 4:13. When is it? 4:14. Okay, so that means it starts at 3:50. Now, the Karen cam is about 20 seconds ahead, okay, of the regular clock. So that means we're going to remove the audio from this video. So you see how we extract the audio from this, and then we're going to delete it. Now, we only want a 20-second clip of this clip, but we want it to start 20 seconds after 3:50. So we want it to start at 4:10 on the running clock in that bottom image. So let's see what it's at here. That's 14:10, right? Okay, so right there. That's roughly when this is happening, and then we want 12.2 seconds, right? So 12.2, thank you very much. Okay, then we click done. Now watch this, ladies and gentlemen. We actually bring this up here, and we click duration. Look at this. We're going to get the synced Karen cam. This is Karen reacting to that moment. Hold on a second.
Mr. Leslie, how much longer are you going to be tomorrow?
Hold on one second. So there you go. It's just I don't really love that that weird flashing in the background, but I think that was actually on one of the source videos on my end, so I'm sorry about that. So I'm just going to cut this part off. Okay, and then we're going to do that. All right, and then we're going to drag this out a little bit. Okay, there we go. And now let's watch this real-time video editing. Oh, this is glorious.
Mr. Leslie, how much longer are you going to be tomorrow?
Ah! Oh, that was great. Now, Sheffield Flannel, watch this. All you do is you grab those two combined videos, and now we have the full recording of Karen's reaction. Ladies and gentlemen, if you have never been on Towel Stream before, I want to let you know that some of the best moments that we have there, even during the daily recap, are when we're doing things like reacting to Bob Alessi's cross that just went down in flames, and we do real-time video editing of a court reporter literally having the best reaction I've ever seen. There's no question in my mind that that court reporter is a towel. Also, Pat Brooks, thank you for that wonderful emoji contribution. We absolutely needed that during the middle of that difficult work. And also, your comments will continue loading. I apologize. What happens is when there's so much going on the screen, Little Towel Computer is like, okay, we should prioritize here. So first of all, let's just go back and say, hello, Little Towel Pair. That was adorable. And then, hold on one second. Hold on 1 second. My apologies, little towels. But yes, oh my goodness. Look at this. You towels were chatting. I froze the towel chat. I'm very sorry about that. I'm having it scroll through. Ladies and gentlemen, you got to see some real-time video editing there. The file should be downloading any second now. And I cannot wait to repost Sheffield Flannel. I can't tell you. We had a fun time getting Kitties1993 on Twitter to 26 followers. You have no idea how much pleasure I'm going to take from reposting Sheffield Flannel and hopefully this getting like 100,000 views. If Sheffield Flannel gets 100,000 views, I'm just going to laugh my little towel heart out, ladies and gentlemen. That is the kind of thing that would make little towel extremely happy, especially because Sheffield Flannel was the person who discovered this, which makes it even better. Now, ladies and gentlemen, as you can see, it is done. The video has downloaded, so you know what we do, ladies and gentlemen. We go over here. We click like on this video. Oh, ladies and gentlemen. Oh, ladies and gentlemen. Then we grab this. We grab this, okay? And so we're going to want to, hold on, we're going to want to quote that, okay? So then does it actually? I don't think it actually shows that. Hold on. Nope, so we're going to grab what I need. Hold on, wait. You can just see her head rolling back over and over and over and over and over again. I love it. That is hilarious. Oh, ladies and gentlemen. Oh, I love it. And so we grab our version, right, with the synced. Now this is synced to Karen's reaction. So this was real time. And now we have to think about how to write this up. So how do we write this up? I think all of us watching the John O'Keefe and Karen Reed retrial can sympathize with Madam Court Reporter's reaction to Bob Alessi announcing he has at least 4 more hours of cross to go on Thursday. How do I even end that tweet? Oh my goodness. It's just such a great thing. Oh, ladies and gentlemen. How do we say it? Oh, don't worry, I'll play it again, Forensic RN. It's great. Look at the court reporter. She leans her head back.
Mr. Alessi, how much longer are you going to be tomorrow? Yes.
The towels feel your pain, Madam Court Reporter. And then I have to say credit to the super Sheffield Flannel himself. Hold on, what is this? So Steve H. for the find. Oh, ladies and gentlemen, this was a moment. The towels feel your pain, Madam Court Reporter. The towels feel your pain. Listen, I don't think she was necessarily reacting to Bob Alessi. I think she was just reacting to the fact that it was going to be 5 more hours. Oh, goodness. Yeah, I feel, listen, I feel a little bit bad, but also, like, come on. It was on national TV. We weren't the only people to see it. And she's not reacting to Bob Alessi. Do you realize she has to say every word that the witness and Bob Alessi say, and they talk over each other constantly? Yeah, she's going to get scolded for that, though. Listen, it's too late. The people have already seen the stream. There's nothing I could do. I have to make this post. I'm sorry, Madam Court Reporter. She is going to hate me for the rest of my life. Madam Court Reporter, we love you. It's not your fault. It's Bob Alessi's fault. Oh, my goodness. No. And it's not like that comment was just staying up there, folks. There were a lot of other comments that were flying by. And this is literally during the recap. Oh, my goodness. This was literally during the recap. Yes. Oh, I'm sure John DePetro will see this, folks. I am sure. It was, no, Alessi had no gotcha moments. It was the opposite of gotcha moments. It was so bad that literally the expert at one point, like Murder by Maestro said, Alessi asked the expert to discuss the musculoskeletal system outside bones. And then Welcher was like, your bones are on the inside. But literally it was just a syntactical joke. It was like a pun because Alessi was saying like discuss it like outside of the bones, and then Welcher was like, you don't have any bones outside, but Alessi was saying other than bones. So he's talking about like the central nervous system, the joints. It's not as funny like in context, but it's hilarious in the response. Like just out of context, the response is like your bones are on the outside. Oh my goodness. So that's what I'm saying, ladies and gentlemen. There were no gotcha moments. I don't know how to summarize this. I really don't know how to summarize this beyond what I've been talking about. This recap has mostly just been me doing that live edit and us laughing about Madam Court Reporter and Bob Alessi just getting owned. But if you missed it, ladies and gentlemen, let me summarize for you what Bob Alessi's cross was like, and then what I'm going to do for you is we're going to play. I have some of the timestamps of some of the funny moments. Then we're going to wrap up, and then tomorrow's a half day. All right, so let's get this done in a little bit. I don't have anything to do after this, but like this has been a ridiculous day, and this was the highlight, folks. If you missed this, if you are just tuning in for the recap, oh my goodness, it was a hilarious day. Hank Brennan made his point on direct. It only took about 15 minutes. The direct was a carryover from yesterday. The jury knew that Karen Reed collided with John O'Keefe, and the data pretty much proved it, as did John's injuries. But ladies and gentlemen, Bob Alessi just going down in flames on cross in a laughable way was even better. Just watch this.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just go right to the bill.
No, I just want to tell you, this is what it was like all day. Alessi would try to do this. Oh, of course, Mike, I'm happy to do the recaps after a long day. It's a labor of love. Towel appreciates all of you, and this is a public information service. If you're learning something, if you're becoming educated, if you're becoming informed, if you're becoming erudite consumers of information in the public sphere, such as to ward off the usurpation of our representative form of democracy, then by God bless you, and I'll be here to help you, ladies and gentlemen. But yes, that was, if you want to know what was the cross like? Oh, goodness, ladies and gentlemen. If you want to watch it back just for your own vicarious catharsis, if you want to play the role of Miss Havisham, if you want to reprise Great Expectations, if you want to treat Bob Alessi like Pip and be your own Estella, oh, I mean, if Dr. Welcher is your Estella, ladies and gentlemen, rewatch that cross. If you like vicarious catharsis, vicarious humiliation, although I'm not really into that, but if that's your thing, more power to you. Oh, ladies and gentlemen, rewatch this cross. We're not going to watch the whole thing because it was for 5 hours, but I have some timestamps we can watch. I did the research, and by doing the research, I mean some of us little towels together, we managed to get through it. Ladies and gentlemen, we managed to get through it, and I'll tell you right now, I have some timestamps. I know, we're not going to watch the whole thing. It was that bad. It was that bad. Alessi would have something horrible happen, and he'd be like, oops, well, oh, that didn't happen. Let me just move on. Move on. Give up. It's over. You undermined your own credibility, Mr. Alessi. Oh, dear goodness. Oh, the humanity. The good ship Hinden Reed sank before our very eyes, ladies and gentlemen. The good ship Hinden Reed. Oh. How do I do it every day? Oh, yeah. So I looked this up, ladies and gentlemen. The upper range of the human larynx is 3.5 hours. So the fact that I can continuously do streams for 10 to 12 hours, I think it means that I am at some kind of superhuman level of speaking ability. And I therefore should go on the political stump and just travel around the country and preach to people about my towel-based diplomatic philosophy. Then we can get Towel elected and I can put Hank Brennan on the Supreme Court. Now, 97%. So here is my political platform. 1, Navy sailors can drink up to 2 glasses of American-made wine or beer as long as they're away from port and on ship every day. If the French can do it on the Charles de Gaulle, then we can do it in America. Number 2, we're putting Hank Brennan on the Supreme Court. Ladies and gentlemen, this is non-negotiable. My political platform is primarily centered around putting Hank Brennan on the Supreme Court. Number 3, no texting or using your cell phones in movie theaters. I don't go to movie theaters, but I hear that this is a thing that people want, so no texting or cell phones in movie theaters. Now, you might be saying, sir, why is it that you're now talking about going on the political stump based on a Hank Brennan putting Hank Brennan on the Supreme Court as a primary component of your political platform, tangentially also centered around warding off the rise of the BRICS, protecting the petrodollar, ideally, what was I talking about earlier? Oh, giving Navy sailors access to 2 glasses of American-made wine or beer per day because the French can do it on the Charles de Gaulle, and then also tangentially banning texting in movie theaters. Yes, ladies and gentlemen, I'm talking about this because if I can talk for 12 hours and my human voice is able to do this, then I must use this skill for good, and I think we should put Hank Brennan on the Supreme Court. Yes, ladies and gentlemen, I appreciate it. But also, we need to go to the marks that I have here. So 2 hours and 2 p.m. and 20 minutes. Okay, so 2:20 p.m. Eastern. There is apparently a moment where the witness says, I don't deal in possibilities, I deal in probabilities. And I want to rewatch that moment because I think it's hilarious.
Take the conservative number, the lower number, 2188 that you came up with.
Got to jump forward a little bit, but we got the right point. Hold on. It's harder than you think to nail down exact timestamps on a 10-hour stream.
No first-hand witness that saw, under your view, that a collision occurred. There's no witness to say where the arm was, correct?
There's no person that saw it.
Right. And you have chosen a point of contact, okay? You chose that for your analysis, correct?
Correct.
And you picked that location. But it's also possible that under your theory that a collision occurred, that arm could have been impacted any part of the back of the vehicle. That's possible, isn't it?
That's not probable, no.
I'm asking, is it possible?
Anything is possible. I don't deal in possibilities, I deal in probabilities. It's not probable.
So, but you don't know exactly
Boom.
where the point of impact was.
So within the range of the light and the exact angle of the hand, no, I don't. What I do know is at the rear tail light area.
So your assumption is that because there's a tail light that is altered, it must have been by Mr. O'Keefe's arm. That's your conclusion, correct?
My conclusion is there are tail light fragments, a broken glass, lacerations to his arm, and his DNA on the back of the vehicle in the area of the taillight.
Sir, and Your Honor, I'm going to move to strike the DNA part of that answer for obvious reasons.
I'm not going to strike it.
Okay. So
I told you, I wasn't kidding. It was like that over and over. He opened the door, the witness gave a dominating answer, and Valesi was like, move to strike the DNA part. Judge Ganoni was like, no, I won't be striking that. Oh, my word, ladies and gentlemen, it was such a good day for the Commonwealth. I don't understand that Bob Valesi could screw up a cross that bad. Oh, my word. Folks, if you missed it, that was just one of the highlights. That segment right there from 2:20 p.m. until 2:21 p.m. was just a nail in the heart of Bob Alessi's soul. Oh my goodness, Dr. Welcher took Bob Alessi's soul. It just went right up, and but Dr. Welcher just ate it alive. And then Bob Alessi made himself look desperate. When you move to strike and lose, the jury's like, oh, DNA. Defense lawyer doesn't want me to know about that, and now I get to know about it. Oh my goodness, it was a moment. Ladies and gentlemen, it was a moment, and I told you I took timestamps. Why? Because, ladies and gentlemen, when you watch Towel Recap, I pull out the best moments. You don't have to watch 5 hours of Bob Alessi going down in flames, the good ship Hinden Reed collapsing to the ground, the shelled craters of the once strong Free Karen Reed seaport bunker, riddled with Hank Brennan's artillery cannons. Ladies and gentlemen, the Dan Bar, the river around the good ship Free Karen Reed, which is also a castle, is no longer holding back Hank Brennan's artillery. Oh, the guns are firing on all cylinders, although they are metaphorical, ladies and gentlemen. And Karen Reed's blimp is going down in flames. I'm not really sure why we've turned this into a blimp, but ladies and gentlemen, you saw it right there. That was just a stunning blow by blow. Just, oh my goodness, down goes Alessi. Down goes Alessi. Welcher may as well have been throwing haymakers. Just boom. Oh my goodness, come around with the verbal haymakers, ladies and gentlemen. Oh my word, you don't understand how brilliant it is to have a witness get up there on cross and just humiliate it. Oh, okay, I'm going to let this play for another 15 seconds. All right, Joe Blow, you got it. I'll make sure I do. You got it. Hold on. Here we go. We had a request from Joe Blow, ladies and gentlemen.
Assumptions. You're taking what you view to be certain data and you're coming to a conclusion, but that is based upon circumstantial information, correct? Is that fair?
Are you calling like pieces of the taillight at the scene around his body circumstantial information?
Sir, let me go to the force and go back to the force analysis. Let's go back to the numbers. I want to stay on, if we can, just to calculate.
Oh, body blow! Oh, devastating body blow!
Understand from the literature.
Oh, just a devastating body blow!
From the finger up. Let's
1 second.
start with a hand. What's the minimum amount of force that can be
yes,
applied to break a bone? Yes, I understand.
So it depends on the loading. So I don't actually know in terms of the forearm.
Muted that tab. Why is it still playing?
There's data that shows up to 300 Gs of loading. You will not get fractures. There's one up to 750 Gs showing no fractures.
That was absolutely hilarious.
Mr. O'Keefe.
Thank you.
You're welcome.
So let's take those numbers. Okay. You
How
said
is that audio still playing?
And 750. Did I hear it correctly?
You did.
Okay. That's the numbers you gave that would break a bone, correct?
So the 300 actually didn't break any bones, I believe. The 750, the one example, didn't break a bone, but as you got above 350, you started to break bones.
So you got above 350.
All right, hold on.
Above 300, yeah, because that's what I thought you said the first time. You got above 300.
How is
it
possible?
Breaking bones, correct?
Correct.
All right, I fixed it, little towels. I fixed it. I was like, how is it possible? You're going to have to see the back end window for a second. How is it possible that the audio is still playing after I closed the tab? It just absolutely infuriated me, little towels, but I figured it out. I fixed it. I managed to get the audio to stop playing. Now, listen, I am glad that we watched that. Who was it that suggested it? Joe Blow. It is the Hindenburg. I'm so glad that we watched that because after that, Alessi is like, circumstantial. Are you saying that is circumstantial? Like, it was great. That was a great answer. Now we have a few more minutes, a few more clips to watch. One of them, the doctor's like, Dr. Welcher is like, I'm not going to hit myself with a Lexus at 20 miles an hour. I just want to let you know, ladies and gentlemen, that was what the whole, I hit my funny bone. That is what the whole cross was like, ladies and gentlemen, over and over over and over again. It was quite a moment. It was absolutely hilarious in every sense of the term. I was there to watch it. Some of you were there to watch it, and I'm going to show you the recap now. Oh my goodness. And we hit 12K. We probably went way above that over on the Twitter. The Towel Twitter stream hit 16,000 views today. Oh my goodness, little towels. I may have hurt my towel wrist because I dropped my water bottle, but you know what? Those are the kind of things that happen when you mess up your chair and the chair keeps pushing me forward. It's infuriating, ladies and gentlemen. People are like, Grant, you clearly don't even know how to operate a chair. You are in a lot of trouble. Yes, ladies and gentlemen, I am willing to admit that. I have no idea how to operate a chair. It is a very convoluted chair, and I will be the first person to admit it has completely thrown me off. All right, now let me get your comments back up on the screen. Give me 1 second here because we have a few more moments to watch of, oh, I fixed my chair. Ladies and gentlemen, my chair is no longer throwing me forward. I would like to announce to you that it was a setting on the side of my chair that I incidentally messed up, and it was completely ruining my day. Look at that. Your comments are back. Yes, don't forget to hit the thumbs up icon. I think Karen and her team are over at the Applebee's in Dedham. They're taking a night off from the Capitol Grill to save money. It was quite a day. Now, give me 1 more second here. I have to pull up one more window for you here. All right. So, oh, it wants to bring up that one, huh? Well, that's going to be annoying. All right, let me see if I can get this working for you, little towels. Oh, I see what it wants to do. Hold on. Give me a second, little towels. So let me bring that up. You can see the back end. Yes, a lot of you watch this stream. Over 5,000 of you today, and a lot of you watch it for an exceptional amount of time. Decent amount of towel friends watching on the YouTube. We've been building this YouTube channel up and almost hit 400 viewers the other day. The towel stream is definitely gaining popularity, ladies and gentlemen. Give me a second here. Let me see if I can get this reset for you, ladies and gentlemen. That is not, why are you doing that? But yes, we're going to watch a few more absolutely hilarious moments of the day, and you can also see that a lot of you watch and then kind of stay for the trial into the recap, and that's the part I find the most interesting. But yes, all right, I think I got it. I think I fixed it. Can you please just put up what I'm asking you? Yes, ladies and gentlemen, I finally got it fixed. All right, so the next timestamp are we going to, hold on. Well, folks, please spare a thought for Lucy Conley, wife and mother, who was jailed for 31 months after an angry tweet. All right, H-Towel, we will do that. I don't know who that is. I will look into the story. I mean, I, of course, trust you, but yes, sometimes in countries without the First Amendment, ladies and gentlemen, the government can be very strict. Towel loves America. Towel respects America, and Towel also respects governments of other countries, but Towel can be a friend and a critic simultaneously. So, and I don't know what the issue is in that case. All I know is if it's important to H-Towel, it's important to me. All right, now we are going to 2:50 p.m. in 45 seconds because we are not sitting through that entire cross. Let me just tell you, I'm saving you all, even though it seems like we're going through each of these clips. Sitting through that 5-hour cross was agonizing. It was so boring. He was just struggling. So let's go to 2:50:45. Hold on.
You could have done that.
Hold on.
The Lexus S. You did a blue paint test with the vehicle going at 2 miles per hour. Did you? Of course. Do that? Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct. Okay. I was not going to hit myself with a Lexus at 20 miles an hour.
There you go. There you go. I was not going to hit myself with a Lexus at 20 miles an hour. Now, ladies and gentlemen, we've also had a request. I'll go over the motions from earlier. We also had a request to see if there's any video of Karen leaving court. As you know, this is a collaborative effort. While we're going through the last remaining sort of hilarious moments of Bob Alessi's cross of Dr. Jordan Welcher, which was just a humiliation ritual for the Reed defense. Please let me know, ladies and gentlemen, if you see any clips of Karen leaving court anytime we get a request like this. Sometimes it does help to crowdsource, so if you take a look at any of the reporters, sometimes WJAR posts the clips up on their YouTube, sometimes Law and Crime will have them. It really just depends, ladies and gentlemen. We're looking for anyone who might happen to have a clip of Karen Reed leaving court. But then, hold on one second, the next thing that I have for us is at 2:59:30. Your question doesn't make any sense. So let's figure out why at 2:59:30 Dr. Welcher said your question doesn't make any sense. Hold on one second. Oh no.
Do you believe the Lexus went in reverse based upon your PowerPoint presentation? Not when it went forward and then came backwards. How many feet do you believe that vehicle went in reverse?
Your question doesn't make any sense, because when it went forward, then it went in reverse.
Oh, awkward silence. Unless he just gives up. He's like, okay. Oh, folks, I forgot the best moment. The doctor was like, it's possible. Unless he was like, is it possible this happened? The doctor was like, well, it's possible the Lexus went into space. Oh, I forgot about this. Oh, my goodness. This cross wasn't just glorious. It was actually hilarious at parts. Unless he got outwitted by that doctor.
As an engineer, it's a possibility.
Oh, this is the space part. Oh, I forgot about the space part. Listen, you don't understand how funny this is. You don't understand. It's glorious.
Is possible. Whether it's reasonable or not, I'd have to know the starting position.
Right.
If it's very close to the side, then it could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible. It's possible it could have shot off into space as an engineer, but not probable.
Oh, you think it's possible that it could have been shot off into space, sir?
As an engineer, it's a possibility.
It's a possibility that
Absolutely.
this Lexus could have been shot off into space?
Yeah. Highly, highly unlikely. But
All
again, you're asking an engineer about possibilities and probabilities.
Let's get back to reality. So in terms of the Lexus itself, because you under
How hilarious is that? How hilarious is that? I'm telling you, it actually happened that way. It's possible the car went into space. Oh, ladies and gentlemen. Hello, Kitties 1993. Yes, Welcher was brilliant. I agree with you, dear friend. Oh, my goodness. This is the first time I've done a recap where I've just been laughing during a cross. Oh, my goodness. Oh, ladies and gentlemen, now we have to watch the 3:28:25 moment where Welcher's like, absolutely not. Apparently that's also hilarious. Wait, have you all ever seen, can we also say goodbye to Second Beach Gal? God bless you, Second Beach Gal. You have a good rest of your day, dear friend. Ladies and gentlemen, have you ever seen this comic strips that are like Poland cannot into space? Can we make a car that's like Karen Reed's Lexus cannot into space, like a Poland ball meme? We need it.
Could have been shot off into space, sir?
Hold on. We need it.
To know the starting
vehicle to, under your scenario, to have gone up on the lawn. That's not possible.
So your first question was reasonable, and I said no. Now you're asking possible. It, of course, is possible. Whether it's reasonable or not, I'd have to know the starting position.
Right.
If it's very close to the side, then it could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible. It's possible it could have shot off into space as an engineer, but not probable.
Oh, you think it's possible that it could have been shot off into space, sir?
As an engineer, it's a possibility.
It's a possibility that
Absolutely.
this Lexus could have been shot off into space?
Yeah. Highly, highly unlikely. But
All
again, you're asking an engineer about possibilities and probabilities.
Let's get back to reality.
Okay, hold on. I just need to show you all this because I've had a question about it. Have you all ever actually thought about Poland being able to into space? Listen, have you never heard of Poland not into space? Ladies and gentlemen, it's not Poland. I just want to be clear. It is the country of Poland. So the meme, and Murder by Maestro being a 23-year-old binary-speaking towel, is probably familiar with this. Now, it is apparently offensive. I didn't know it was offensive to people from Poland. I didn't know this. But listen, okay, it's apparently offensive. I think this is some kind of meme site. But basically, this is the comic, okay? And it has in the top left a meteor coming to destroy Earth. So Russia's like, oh, a meteor's coming to destroy Earth. And then America's like, that might be Georgia, actually. I can't tell. And then Germany's like, we must leave the planet. And then all the countries go off into space. And then Poland's like, oh, Poland cannot into space. And then Poland is crying. Oh, little Poland, I feel terrible for you, little Poland. Oh, ladies and gentlemen, so I just want to let you know, Karen Reed's Lexus cannot into space. Do you see what I mean? All the other cars are going to go off into space, and Karen's Lexus is going to be sitting there crying because Karen's Lexus cannot into space. Oh, those of you who have been on the internet for a long time are going to be like, oh, dear God, he knows about the Poland ball meme. Everybody run for the hills. I am hilarious, and I find myself hilarious, and you are never going to be able to do anything about that, ladies and gentlemen. That's what I'm saying. I've had more fun laughing at Bobolezzi than Bobolezzi made points on Cross. All right, let's go to 328.25. Yes, we love the Polish people. We will get them into space, ladies and gentlemen. Poland can, in fact, into space. We will leave Karen Reed's Lexus behind and send Poland into space. We got to go to this next clip. Hold on. This one's at 328.25.
See if you can answer my questions.
This one's apparently hilarious. Hold on. All right, let's listen.
That if Mr. O'Keefe's arm were to be flexed like it was with the test subject in your blue paint test, the lacerations on Mr. O'Keefe's forearm would be oriented in a vertical direction.
Absolutely not. If you pull up my slide 117, it'll show exactly that it is like perfectly horizontal. When you're standing like this, and this is the tail light, the laceration, when it comes across here and pushes my body, it's going to make a horizontal laceration because the 6,000-pound vehicle is going to push me out of the way. As this pushes me out of the way, it's going to drag and create a horizontal laceration across my arm. This is exactly what you'd expect.
So let's talk about the forearm, sir. We may have miscommunicated.
That was the demo. He did a live demo. Get in the van, Karen. Get in the van. Oh, my word. He did a live demo. Oh, my word, ladies and gentlemen. And now the tailpipe. Oh, the tailpipe exchange. Ladies and gentlemen, I told you I wrote the timestamps. Look at me. I'm an erudite little towel. I even know that Poland cannot into space. But Poland can into space. All of our Polish towels, we are going to combine together. We are going to build some kind of rocket, and we are going to send Poland, not the country. Well, I guess we could try to send Poland into space. I don't know if we should do that. Just skyhook Poland up into space. I think that would cause some kind of hole in the earth. I don't think we should do that. But maybe we could send a Polish person up into space. But also, yes, Murder by Maestro is right. Memes are a manifestation of mimetic transmission, which has to do with the way in which culture ripples outwards and amalgamates into various unifying perspectives through shared cultural norms. And if you think about it, ladies and gentlemen, the way we think about the American legal system is highly codified, but if you actually pulled out and looked at it anthropologically, it's a bunch of people in robes who make rules, and then people who study to learn about these rules and apply them, and then becomes part of some special club where the elders tell the, rising elders how the rules are applied. It's a very weird system, ladies and gentlemen. Get in the van, Karen. Also, we're going to 344, and we're listening to this tailpipe segment. If I had to listen to Bob Alessi for 5 hours, I can be ridiculous and talk about Poland and Lexus is going into space.
Stretching of the arm. You had to make that selection from among others, correct?
So that was matching the physical evidence on his arm to the physical evidence on the car and then running a test to see if dynamically those matched up. So it's, I didn't have it hit the exhaust pipe, for example, because there was no assertion it hit the exhaust pipe. There was no damage to the exhaust pipe. So it was based upon the evidence, and the testing was done to test, to use your vernacular, the hypothesis that that's where it came from.
Sir, have I ever asked you anything about a tailpipe in any of my questions today?
Yes.
I have not. I've never
Yes,
asked.
you have. You asked me about the totality of the rear of the Lexus, which includes the tailpipe.
All right. I am not going to be asking any questions
Oh!
of the taillight in any fashion. So what I'd like to do is to go back
Oh,
to the
and you can
question.
see Alessi misspoke there. He's like,
Which includes the
Alessi meant to say I'm not going to be asking any questions about the tailpipe, but he said tail light, and Welcher was like, what?
Tailpipe.
All right. I am not going to be asking any questions that involve the taillight in any fashion. So what I'd like to do is to go back to the question that I'm asking, which is...
That was funny. Oh, Kim Cordeau, God bless you, dear friend. Ladies and gentlemen, that was an amazing, amazing performance by Dr. Welcher on cross. Just humiliated Alessi on every turn, didn't give an inch, just absolutely dominated him. And then was funny to boot and just embarrassing Alessi. But also, ladies and gentlemen, Kim Cordeau shared at the end of a long day. We've been going for almost 10 hours now. Little Towel is pushing, giving his all for you. We're doing our summary. I love you all, Little Towel, so much. I get one of my favorite things in the world, ladies and gentlemen. It is a super towel pair with a headband dancing saying #1 fan. Oh, ladies and gentlemen, it is a glorious day to be a towel. It is a glorious day to be a towel universe. Oh, my word, you super towel pair, you. God bless you, Kim Cordeau. The super pair is my #1 fan. No, I'm your #1 fan, Super Pair, and I'm your #1 fan, Kim Cordeau. God bless you for your first super on the channel. Thank you so much for supporting Towel Stream, and God bless you, Little Towel Pair. Oh, ladies and gentlemen, folks, please say thank you to Kim Cordeau for supporting the channel. That was absolutely wonderful. Kim Cordeau, I absolutely will put it towards my dinner. I'm gonna get some, I think, slices of pizza, and just know that is the world to me. I save it up so I have like a pizza fund. I don't have enough to get 7-Eleven pizza for weeks, and just knowing that I can go there. I've been getting some cheeseburgers on days where I can't get out of the house, but knowing I can get 7-Eleven pizza and not have to worry about it for just a long amount of time. You, Mary Adams, Courtney Myers, so many other people have made it possible. Jew Drops, Eva, ladies and gentlemen, Jack D65. We will go through the list at some point one day. You all have made Little Towel not be as anxious about if he's going to eat or his medicine, and so as a result, I can dedicate myself to giving you as much information. And if you want to know where it comes from, the 10-12-hour streams, it's because I feel like you all care about Little Towel. You're learning. I feel supported and loved for the first time, really, in a long time, and I'm going to return that to you. That this energy comes from a place of pure sort of gratitude and compassion, and that's how we're going to do it. Oh, God, ladies and gentlemen, I love so many of you. God bless you, Tenacious P. God bless you, my King of Kings. And ladies and gentlemen, we also had a request earlier, and I would be remiss if we did not do it. There were 2 new motions that came up on the docket. One really was a memorandum that was decided when Judge Cannoni made her decision related to Dr. Welcher being able to testify early in the morning when Hank Brennan finished the direct. But we will take the 2 motions, so I uploaded them here. You can take a look, ladies and gentlemen. One of the filings has to do with a Rule 14 violation. This was when Karen Reed's attorneys tried to ambush one of the witnesses in the Reed and O'Keefe case, Shannon Burgess, last week. So you can see the filing from Hank Brennan went up on the docket today. There's no ruling yet. It says the state's motion to preclude the attempted use of any information not produced in violation of Rule 14 Both the Commonwealth and the defense are bound by Rule 14 obligations. This is reciprocal discovery and discovery obligations. During the course of this trial, notably during Shannon Burgess' testimony, the defense presented documents that were not previously provided, which eliminated the ability to review and vet the documents. So literally, the prosecution was not given these documents that the defense tried to use on cross until literally they were being brought up during cross. This was during Burgess' testimony last week. Notably, the defense presented a CV provided in 2023 that noted a graduation date of 2024. The effort of providing documents as a witness is being confronted with documents is improper, trial by ambush, a violation of Rule 14, and creates needless delays resulting in objections, unnecessary sidebars, and a waste of time for the jury. The Commonwealth seeks a ruling precluding the use of any materials that were not noticed by the defense other than materials in the witness's CV referred to during presentation or discussed during testimony. Oh, God bless you, Forensic RN. So, folks, just so you realize, this is the state asking to make sure that the Reed defense can't ambush people with these nonsensical things at the last minute out of context that the state can't vet ahead of time. It's trial by ambush, it's unfair, it's wrong, and that's what Hank Brennan's arguing. Well argued, Mr. Brennan. And ladies and gentlemen, can we all just take a moment? I want to load the comments up here. They'll pop up on your screen in a second. First, Kim Cordeau, I just want to say thank you so much for that. But then also, ladies and gentlemen, want to scroll past a little bit further. And then I also, my King of Kings, thank you so much. Hugs to you, Murder by Maestro. Can we also say a special towel thank you to Forensic RN? God bless you, dear friend. God bless you, Forensic RN. You are a super towel in every sense of the word, and I am grateful you're here with us each day. It means so much to me, and your comments and questions are all noticed and appreciated. I have to change it to appreciated because I ran out of space. But look at Murder by Maestro, going to be proud of me for using my voice to text. God bless you, Forensic RN. You are a super towel in every sense of the term, and I am so grateful for you. Thank you so much for your support of the channel. Now, ladies and gentlemen, we did our analysis. There was also, there was one more thing. As much as I want to go, I refuse to. I'm not just going to go. Hank Brennan then also filed this memorandum of law. We had a request to take a look at what the other filing was. This memorandum of law had to do with Dr. Welcher's ability to testify about the collision. And so you can see Hank Brennan spends a good amount of time, ladies and gentlemen. It's 2 pages. We don't have to read the whole thing. Hank Brennan details why Welcher was able to make the opinions that he did earlier in the morning, the lacerations being consistent with contact with the Lexus rear taillight, the Lexus collided in a clipping manner with John O'Keefe, and whether the collision occurred at substantially the same time as the reverse maneuver, which Dr. Welcher identified from the Lexus trigger event, which is at 12:32 a.m. and 4 seconds to 9 seconds on 1/29/2022. So Brennan makes his memorandum of law, and then that was the decision that Judge Cannoni rendered early this morning. Brennan writes really strong motions. Like when Brennan is upset, like you can hear it, he writes motions where he just lets it out. So Brennan makes a very strong argument. He ends up just tearing apart the cases that Alessi tried to cite, Coleman and Lannon, which we actually shepherdized on this stream last night. And then Brennan ends up closing up his argument by asking for what he basically got today, which was that Welcher be able to testify that, in his opinion, to a reasonable degree of scientific and engineering certainty, there was a collision between the defendant's SUV and John O'Keefe, and that the injury occurred around the time of the defendant backing maneuver in front of Fairview Road on 1/29/2022. So that was what Hank Brennan ended up arguing this morning. But if you missed it, ladies and gentlemen, really the culmination of the day was the motion hearing at the end. But more so than the motion hearing, it was just Bob Alessi going on for so long while making so little points and simply getting humiliated. And this, ladies and gentlemen, this had to be the moment of the day. Please join us again tomorrow. I'm going to go back to talk to the Towel Friends. YouTube.com/@GrantSmithEllis. See the Karen Cam. See moments like this, ladies and gentlemen. Literally, where else will you get to see Bob Alessi try to impeach a witness, get a fact wrong, a key fact wrong about the case, and end up impeaching himself? Oh, it was glorious.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I have not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just go right to the bill.
Yeah, I bet you do, Bob Alessi. Oh, folks, it was a bad day for the Reed defense. It was a great day for the state. I'm going to go talk to the Towel friends. Join us tomorrow bright and early, 7:30 a.m. Eastern, youtube.com/@Grant-Smith-Ellis. We started this, when did we start? At 4:45, and we ended the recap. Let's see, how about 6:13 and 45 seconds? So in about 15 seconds, 6:13:45. Thanks again. Join us on the Towel YouTube. Join the chat. It's been great. You can see these recaps every day, the Karen Cam. My name's Grant-Smith-Ellis. youtube.com/@Grant-Smith-Ellis. Thanks for being with me. All right, folks, we finished up the recap. Now let's go back to the Towel friends. We don't even have to end the recording. I just have to hit it at a certain amount of time so I can then go clip it. So there you go, about an hour and a half recap. Not too bad for today. Yeah, it's definitely a cross that you want to watch again if you just want to laugh at Bob Alessi, but it is a lot of Bob Alessi talking. Now, ladies and gentlemen, I think we heard a little bit that there was footage of Karen Reed leaving court. She literally only said no comment. So I'm going to try to bring it up for you, but I heard we got a report. Ange Whittick, God bless you, dear friend. We got a report, ladies and gentlemen, that Karen Reed did leave court and simply said no comment at all to anything. So that is quite telling in some sense, ladies and gentlemen. It was not a good day for Karen Reed. I am taking a look now to see if I can see any of the clips of Karen leaving court. Not seeing anything off the top. Hold on, though, ladies and gentlemen. I'm taking a look. Nothing so far, so I don't see any clips right off the top, but we will. It was literally Karen Reed just saying no comment. But you know what we're going to watch. You know what we have to watch. Colleen Henry might be here, ladies and gentlemen, sending good night to you and super hugs to you, Mike, but you know what we have to watch to end the day, whether Colleen Henry's still with us or not. There's no better way to end a good day for the Commonwealth, ladies and gentlemen, as we hang out here on Towel Stream. There's four things we like to do to end the day. Number one, it's becoming a new tradition, but it is our favorite tradition. We end the day, the Towel Stream day, with the clip of all clips. You as well, Mr. Brennan. Okay, sir, I will, Hank. One more time. You as well, Mr. Brennan. Okay, sir, I will, Hank. The hero, Hank Brennan himself, ladies and gentlemen. You can call me Hank. One of the greatest moments in Little Towel's life, I'll tell you, ladies and gentlemen. It was a moment for the ages. Colleen Henry, I know it's your favorite clip. Oh, God bless you, dear friend. Yes, Bob Alessi has met his match in Hank Brennan. Oh, goodness. Now, Little Towels, we have one thing we got to do. If you've been on the stream for a while, you know I like to do one thing here. So I like to go through. I'm not going to get all of your names because it was for some reason loading top chat today instead of all chat. But we're going to go through. Oh, that's the thing. So if you have just been joining, we've been going for almost 10 hours. We do these 10 to 11 hour to 12-hour streams like it's nothing. But it really helps the channel if while you're watching, if you click the like button, if you click subscribe. If you want to do that, that means a lot to Little Towel. But yeah, no comment from Karen Reed leaving court. She just scurried away today, ladies and gentlemen. But yes, I want to say, if you liked this content, you please feel free to let your friends know, share it. It helps the channel. It means so much to me. I also want to say, now we do our second part of the goodbye, which is Colleen Henry, Linda A., my King of Kings, Cat in a Hat. I love it. Cat in a Hat. That's what your name is. I thought it was Cat in the Lat for a long time, but it's Cat in a Hat. Oh, that's even better. Cat in a Hat. You are amazing. Lisa Cox, Eva, Forensic RN, my King of Kings, Pat Brooks, a again, you super towel. Colleen Henry, Jennifer Ray, oh, Stacy Gardner, Deb H, Eva, Mike, Ange Whittick, Kitties 1993, Stacy Gardner, Eva Pilgrim Shadow, my dear friend, my king of kings. Oh, Forensic RN, you are such a super towel. All of you. Tenacious P, Murder by Maestro gave us towel hugs. Oh, ladies and gentlemen, look at all these towel friends. Kim Cordeau, God bless you. DJ, Def Otter, Karen, get in the van to space. Oh, 65 CJ5, God bless you, dear friend. Oh, Kim Cordeau, God bless you. Chris, KHRIS, I appreciate you. Oh, giving you all. Bossy Texas Chick, God bless you, giving you a super towel hug. Jill D, it was great to see you. Tenacious P, great to see you as always. Nancy from the 508. Oh, ladies and gentlemen, look at all you towel friends chatting away. Logins.rn, God bless you. Logins.m, God bless you. Cinnamon Buns, you were in the chat. It was great to see you as always. Allie 90211, you wander off wherever you need to go. You have no responsibilities. H Towel, Sheffield Flannel, God bless you, dear friend. Super towel hugs to you. Oh, Vicky's Mom 06, it was great to see you. Enjoy all your new towel memberships. Thank you to Super Towel, Dewdrops, and Courtney Myers and others for all their wonderful membership parades recently. Joe Blow, it was great to see you. Jennifer Ray, No Stray Ents, I saw you pop up in there. Oh, ladies and gentlemen, so many towel friends. Even as I continue to scroll, you all just had a lot to say. Amber Am, it was great to see you, dear towel friend. Mandy Strong, the honorary towel spouse herself. Jeff Williams, it was great to see you. Tay Marie with the American flag emoji. Towel loves America. Mike, I'll say hello to you again. 65 CJ5, God bless you. Care Ann, so glad you got to catch the recap, my dear towel friend. You are wonderful and amazing. Marianne Nizio, is great to see you as always. Thank you so much for all your questions and comments and links. You are so helpful. Joe O'Keefe, God bless you, dear friend. God bless you, dear Joe O'Keefe. We're so glad to have you with us. Oh, ladies and gentlemen, I didn't even realize that my phone could keep a chat scroll log for that long. You all were just chatting up a storm. And now, ladies and gentlemen, my Mountain View 1036, thank you for the reminder. We got to almost 20,000 views on the Towel YouTube today. Ladies and gentlemen, I want to say a super thank you again to Forensic RN, to Kim Cordeau. Kim Cordeau, first of all, Forensic RN said, we love you, Grant. Take care of yourself. We need you. I need you all. I appreciate you. And I'm not just talking about from a emotional support, from a day-to-day support perspective. It's you all wanting to learn, wanting to empower your fellow towel friends and learn about their lives and be friendly. That's what keeps me doing this. That's what empowers me. So God bless you. Kim Cordeau, my dear friend, that #1 fan, towel pair emoji. I loved everything about it. It made me giggle like a little towel. Pat Brooks, God bless you, dear friend. You sent a pear emoji along with a wonderful message that said, Grant and all my awesome, wonderful towel friends, I have been so angry because of RAKRAJ that I have no words to describe my disgust today. Love and gratitude to all of you. Justice for John and his family. God bless you, Super Towel Pat Brooks. God bless you so much, my dear friend. You are such a super towel in every sense of the word. Oh, my King of Kings, Def Otter, look at all of you, Forensic RN, Colleen Ray, saying goodbye to each other. And Second Beach Girl said, thank you, Grant, and thanks to all the loving towels. Thank you, my dear friend, you super towel. Mandy Strong, that towel emoji with a coffee was the greatest thing in the world, ladies and gentlemen. Oh, God bless you. And God bless the super towel Dewdrops herself, who came through with a wonderful super towel chat before bed. I hope you and the girls, ladies and gentlemen, Dewdrops has 2 girls. She tells us about all the time. And let me just tell you, I have their name. Hold on, ladies and gentlemen. I think it is Kiki and Riri. So we want to send a special towel message of love to the sleeping Kiki and Riri. And we hope they and their mom, Dewdrops, are having a great day, a great night's sleep. Courtney Myers just made it rain memberships, ladies and gentlemen. We had so many Towel members join the channel today. We are at the hundreds of Towel channel members. Enjoy your emojis. Bossy Texas chick. Bella, what a wonderful day to start the day with Bella the cat. I can't wait to see a video of Bella again in the morning. I want Bella to be one of the mascots of Towel Channel. I don't know what that role entails. I think it might entail talking to kangaroos and koalas and other such animals. We'll talk about it more. Oh, God bless you, Monty, who said, thanks, Grant, for your kindness, time, and efforts you show through your channel, attracting like-minded towels of all shapes and colors. Thank you, mods and super towels. Thank you, Monty. God bless you, my dear friend. I appreciate you so much. Eva, God bless you. Small acts of kindness today. Help homeless vets, dear friends. That's what Eva said. And Eva also sent a fist bump towel emoji. That is the most adorable thing. Oh, God bless you, little pear towel emoji giving me a fist bump. And Mandy Strong with the I'll be back emoji. Oh, ladies and gentlemen, there is nothing that makes me happier than being able to spend time with you. And as you know, there is an actual way we like to close these streams. And I want to say it like this. I want to take a drink of water because I want to make sure that I am clear as I say this. As you know, this is a public information service. It's designed with the values that Lord Reith had in mind for the BBC. It's designed to educate, inform, and entertain. So entertainment is a hook to get you to educate, to become educated and informed about the important matters of public discussion. But ladies and gentlemen, more so than anything else, if you learned something today, if you benefited from this stream, if you found friends within the Towel stream, if you had moments of happiness, moments of levity, look for reasons to do small acts of kindness. That is the way you can pay it forward to Little Towel in a way that will truly uplift my Little Towel heart and make me feel like I'm living up to my greatest good, my eudaimonia in the ancient Greek or my summum bonum in the Latin on this earth. Look for reasons to do things like donate to homeless veterans. Or, ladies and gentlemen, do something like shake the hand of a neighbor on the street, call a friend you haven't talked to in a while, go visit a family member, donate 200 tomato plants like Francis Frutrell did once and have those tomato plants designated honorary towels. Look for reasons to be a beacon of light in the world, to uplift those around you. And, ladies and gentlemen, maybe then, through that unconditional love and that spirit of compassion and toleration and small acts of service, there can be, through 6 degrees of authentic, non-Chewbacca-based separation, a change from the current realpolitik defined based on preserving, expanding, and demonstrating our power to a new age where the world will be based on preserving and demonstrating and expanding our capacity to show universal love by way of small acts of service for other people. And that, ladies and gentlemen, let that be our legacy. Let the new digital epoch with Aquarius the water bearer standing tall, waving a towel in northern France be defined by small acts of service and unconditional love. We can do it, ladies and gentlemen. The world is going to be heading towards a brighter and better future, and it's partially because of so many of the wonderful Towel friends that join in on this chat, have discussions, and continue to support each other. That means so much to me. So, ladies and gentlemen, I know you all have more chatting to do. We are going to be back at 7:30 a.m. tomorrow. Let Towel get at least a little bit of sleep. I got to put together the recap. I got to summarize it. I got to get those videos out. I want to do a greatest hits compilation of Bob Alessi getting embarrassed during Cross. I appreciate every single one of you. We sign off on the X first, so let me say to the X friends, thanks for being with us. Join us again tomorrow. Almost 20,000 views on the X today. It was great to see you over there. YouTube.com/@GrantSmithEllis if you'd want to join in on the chat. So, friends, let me start with saying goodbye to the X friends. And yes, God bless you, Forensic RN. Be safe and take care out there, friends, says Forensic RN. And I hope you are able to make it tomorrow. We'll be around, and you know we'll be happy to see you. All right, Towel friends on the X, you be safe. You be careful out there. God bless you. Be well. Going to spend a few minutes with the Towel friends on the YouTube because, well, you got a few minutes in the beginning extra on the X. All right, Towel friends, the Towel YouTube is shut down. Excuse me, the Towel X is shut down, and now we're just on the Towel YouTube. Now, as you know, I like to say, I like to spend a few minutes with the Friends on the Towel YouTube. God bless you, honorary towel spouse Mandy. You have a good rest of your night. I like to spend a few minutes, just a little bit of time at the end of the stream here to say, Towel friends, this community here is very special. I watch the chat throughout the day. I watch how many of you keep track of what's going on with each other, asking about each other's lives. It's such a beautiful thing. It's such a wonderful demonstration of compassion. It means so much to Little Towel that I was able to be part of this and to watch it grow, and that I get to sort of be part of the symbiotic energy you've created. I'll never forget it. I'll never take it for granted. And just know that when I lay my head down at night and when I wake up in the morning now, I think I'm starting to see a brighter world. And I think I'm coming out of a very dark period in my life for many, many years since I became very sick and disabled in 2014. I don't think we're fully there. My physical vessel is always going to be very broken, but maybe with the right support and with the right structures in place, I can be more than just this broken body. And you've reinvigorated that faith and that trust and that hope in myself. So God bless you for that, ladies and gentlemen. It means so much to me. If I could give you all a hug through the towel screen, I would. But just know how precious it is to me. But listen, we're going to see each other in just over 13 hours, 7:30 a.m. Eastern tomorrow. So I got to get some work done. I got to go put in the real effort now, make the overview clip, and then I got to clip out the best sections of Bob Alessi's Cross where he got humiliated, and then I got to upload that as well. So let Little Towel get to work. God bless all of you, ladies and gentlemen. Enjoy the rest of your Wednesday. We'll see you tomorrow, Thursday, May 29, 2025, for another day of testimony in the John O'Keefe and Karen Reed trial. My name's Grant Smith Ellis. I'm a Little Towel. I love each and every one of you. God bless you all. Be safe out there. Go to bed knowing that you are surrounded and enveloped by a warm, fluffy towel universe, and we all care about you very much. I can do it, Forensic RN. I know I can. Karen was asked by Christina Rex outside the courtroom if she reversed 24 miles an hour in reverse, and Karen said the data is what the data is. Yeah, that was yesterday. It's true. That's true, Joe Blow. All right, towel friends. God bless you. What a day. I'm signing off. I love you very much. You are all wonderful towels, and my name is Grant Smith Ellis. Be well. Go with God. Be at peace, and lay your head down knowing you are supported and loved out there, towel friends.